Gachagua. Here is what you need to know so far. As of last night, lawyers of the impeached Deputy President Rigathi Gachagua have signaled that they will appeal the High Court ruling that found that Deputy Chief Justice Philomena Mwilu had properly appointed a 3-judge bench to handle petitions touching on his ouster. The court rejected an assertion by Gachagua's lawyers that Mwilu lacks the constitutional authority to constitute benches under Article 165 of the Constitution, a function they argued is exclusively reserved for the Chief Justice. But the court ruled that DCJ Philomena Mwilu acted within her authority when she empaneled the 3-judge bench to hear the cases challenging the impeachment of Rigathi Gachagua. And so while delivering that ruling, the 3 judges, Justices Eric Ogola, Frida Mugambi and Anthony Mrima, also dressed down the lawyers representing the impeached Deputy President for what they say is casting aspersions against the bench. Now, this even as allies of the impeached Deputy President now talk tough amid a talk of a looming purge from parliamentary leadership positions, with the axe allegedly touching or targeting Gachagua's allies in the Senate and the National Assembly. It is a development that could trigger further discord within the ruling coalition, and we'll be putting it all into context for you, both from the legal point and the political perspective, as we bring you live coverage from the courts this morning. In studio with us is lawyer Titus Mahano, who will put it all into context as we await the 3-judge bench there at about anytime from 9 a.m. to come and agree on the consolidation of the more than 36 cases that are challenging the impeachment of Rigathi Gachagua. Titus, a very good morning to you. A lot still happening on the legal ground. So put it into context for us. What do Kenyans expect today? Because we have 2 appearances there by the High Court in the morning session and the afternoon session. What do we expect?
Yeah. Good morning, Michelle. Thank you for having me in studio. My name is Mahanu. I'm an advocate of the High Court. And just as you've asked me, there's a lot of action that is taking place in court today. And what we basically expect is that there are a number of things that were raised yesterday in court that we all saw. First, there's an application for recusal of this bench that is handling this impeachment case. And that application has, of course, it's predicated on the fact that counsels for the Gachagua team have intimated that there seems to be biasness from the part of the bench. The reason being is that the bench is so dedicated on listening to the application by the AG and the government side to lift the conservatory order quicker than their own application that they have made in court. And then number 2, there is also the issue of consolidation of all the petitions and applications by other parties that have not been brought on board as such. Remember, there are so many other interested parties that have filed applications seeking to be enjoined in the matter. So I have seen that it appears in the morning the court will be listening to the consolidation of all these applications. Then in the afternoon, the court will be listening to the application for its recusal in this matter.
It seems a little bit like putting the cart before the horse, having the court determine the consolidation of the cases in the morning session and then determine, the application for the recusal in the afternoon session. What impact will the recusal, especially the hearing of the recusal, have?
It would appear so, because ordinarily what will be the wisdom of consolidating the matters if there is an application for you to recuse yourself? So I do not know why they reached that decision, but all we can do is wait and see. But perhaps on the flip side, probably they are of the view that in the event they rule that they do not have to recuse themselves, then they will straight away now proceed to start listening to the substantive matters. Remember, the mere fact that litigants have raised or have filed an application for recusal by any judge or any bench does not necessarily mean that the court or the bench is going to recuse themselves. The court can decide to recuse themselves, or the court may decide not to recuse themselves.
All right. Talk to us about the significance of the High Court's order halting the appointment and even swearing in of what we're now calling the Deputy President designate, Kithure Kindiki. There are those of the school of thought then that those conservatory orders seemingly lapse today because the case was to be heard and determined today?
Not really. The conservatory orders, the way they were framed, is that pending the hearing and determination of the applications and the petition, those orders will continue being in place. But then again, the mere fact that the matter is coming up today, ordinarily it will be expected that if the orders are lapsing today, any good lawyer out there will definitely seek extension of the order. Mm-hmm. So those orders, it's going to be very, in the unlikely event, I do not see a situation whereby the orders are going to be lifted just merely because they are lapsing today and the application is coming today. Ordinarily, any lawyer will seek extension of the orders and they are going to be in place. And of course, the effect of that is that Kithure Kindiki will have to wait until that application is heard and determined before he can even think of assuming office.
Right, and in the meantime, of course, yesterday we saw that confusion over who really is the deputy president. The courts, of course, did pronounce themselves on that, but the confusion sort of found its way in Parliament when we had the Senate waiting for the now deputy president designate to appear before it to answer on matters interior. So we'll be talking about that in just a moment. But let's take a look at what the courts really will be determining today. So the High Court will decide on whether it will lift orders barring the swearing in of deputy president designate Professor Kithure Kindiki today. Now, the government side has already made an application before the three-judge bench seeking to have the conservatory orders that were issued by a court in Kerugoya set aside. And as NTV's David Mudhoka reports, should the High Court lift the orders, Kindiki could be sworn into office on Friday, a move that will force impeached Deputy President Rigathi Gachagua to fight for his political survival while effectively out of office.
In the next few hours, Deputy President nominee Professor Abraham Kithure Kindiki, whose swearing-in ceremony at Uhuru Gardens was stopped in the 11th hour last Friday by a court in Kerugoya, will know his fate. A three-judge bench comprising of presiding Judge Eric Ogola, Judge Freda Mugambi, and Judge Anthony Mrima has received an application from Attorney General Dorcas Oduor that seeks to set aside orders issued by the Kerugoya court blocking Kindiki from taking his oath of office, and will on Thursday afternoon from 2:30 p.m. decide whether to set aside the orders or keep them in place. But before determining whether to pave the way for Kindiki's swearing in, the three-judge bench will hear another application from impeached Deputy President Rigathi Gachagua's lawyers that calls for the recusal of the three judges. Rigathi's lawyers have insisted that they will submit the application even after the three-judge bench on Tuesday afternoon ruled that it had been properly empaneled by Deputy Chief Justice Philomena Mbete Mwilo.
As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government.
Kindiki's side will be hoping that the judges will throw aside the application for their recusal and further set aside the conservatory orders that slammed the brakes on his relocation from the office of the Ministry of Interior to the adjacent office of the Deputy President along Harambee Avenue. Almost a week after the National Assembly rubber-stamped President William Ruto's selection of Interior CS Professor Kithure Kindiki as his next deputy, leaving Kindiki with one hurdle to skip before assuming the second most powerful office in the land, and which is his swearing-in ceremony, Kindiki is likely to know tomorrow whether he will be sworn in soon or he will still have to keep his campaign on ice. David Mudhoka, NTV from the Milimani Law Courts, Nairobi.
Many thanks. That is David Mudhoka there. So Titus, just judging from that report there by David Mudhoka, are we moving too fast in terms of anticipating or talking about the swearing in of Kithure Kindiki? Because from the legal front, there seems to be an uphill battle with regard to the court cases that the three-judge bench has to determine and the timelines that they have.
obviously, the swearing in of Kindiki can only, we can start discussing about the swearing in of Kindiki once the court processes have been concluded. Right now, we have conservatory orders which bar Kindiki from assuming any office. And the conservatory orders continue keeping Rigathi Gachagua as the deputy president. So until this process is done and dusted, it will be premature to start talking about Kindiki taking office tomorrow. Because ordinarily, if the court has scheduled its program in such a way that this morning it's going to hear the issues that concern consolidations of all the petitions, then in the afternoon it's going to hear an application for whether it should recuse itself. Ordinarily, it would be expected that we are looking at probably a ruling to that effect earliest tomorrow, probably in the afternoon, because the court has to retire and consider all the arguments and the issues that have been raised by the parties and render a ruling. Writing a ruling is not an exercise that you can just sit and do it within 1 hour. No, that's why you see an application as to whether the bench was constituted as per the law had to take some time before we could get a ruling. So ordinarily, I expect that if there is an application for this bench to recuse itself, the earliest I will expect that they will render a decision or a ruling is tomorrow in the afternoon.
All right. And even as we follow what's happening within the corridors of justice, a huge ripple effect is also happening on the political side of things. Yes. And so, as we speak, you know, information points to a looming purge within, you know, for parliamentary positions, for allies, or those who are deemed to be allies of the impeached Deputy President, Rigathi Gachagua. What are your thoughts on this conversation coming before the completion of the court cases? And what is the likely implication for the Kenya Kwanza administration?
Ordinarily, it appears from the way things are happening, there seems to have been deals that were entered into prior to the impeachment of Gachagua. I saw the dailies yesterday, and it appears that ODM as a party must have had a very serious role in the impeachment of the deputy president. That's why they are now demanding for more positions in the government, because it appears their role was to assist in the impeachment of the deputy president. And having achieved that, ordinarily it's expected that they are given their consideration. And for them to come out at this time and demand for those positions, it's not by mistake. It is deliberate, it is by design. So what we expect in the political scene is that a lot of individuals are going to probably lose their positions, because there has to be that political reorganizations. And out of these political reorganizations, we are probably looking at political formations as we head towards 2027.
Right, of course. Yeah. And some of the names, of course, we've heard is the likes of... Yes, the likes of Senator Thangwa there, who chairs the Senate Roads and Transport Committee. We also have Nyandarua Senator John Methu, who is the chairman of the Lands, Water and Natural Resources team, who are among the 44 who essentially, you know, members of parliament and who sided with the impeached deputy president. What, in your view, then, would be the political implication should the High Court uphold this impeachment, paving way for the swearing in of Kithure Kindiki? What is likely? What kind of realignments are we likely to see within the Kenya Kwanza alliance itself?
I may not really anticipate what is going to happen within Kenya Kwanza, because I do not have any affiliations with them. But ordinarily, those who are closely related to the impeached deputy president are going to be rendered orphans, because now their master is not there. But most importantly, there's going to be a lot of pressure and demand from those people who participated vehemently in the ouster of the deputy president. And if I'm speaking about the people who participated vehemently, I mean ODM. ODM has been very critical in the impeachment process. I was looking at the proceedings in the Senate, and I saw the footprints of ODM all over the impeachment process. I saw senior lawyers who had been sent to cross-examine the deputy president. And definitely, amid all these issues and amid all these engagements that we are witnessing formations. Definitely, these are individuals and these are formations and parties that are going to demand a lot based on this. Yes.
All right. The legal complexities surrounding Kithure Kindiki may not be very clear right now. Like, the court did pronounce itself that Rigathi Gachagua remains the deputy president substantively. But yesterday we saw the Senate there awaiting Kithure Kindiki to appear before them to answer several questions on matters interior. And he did not show up. A letter was sent, of course, indicating that he wasn't able to show up. But what are the legal complexities surrounding his dual role as Interior Cabinet Secretary and now Deputy President designate, in your view?
Now, I was looking at the requirements that before someone is nominated as Deputy President, there are certain requirements that someone has to meet. At the time of the nomination, first of all, that person ought not to be holding any public office. They need to meet Chapter 6 of the Constitution. They need to have obtained clearance from all the relevant authorities, EACC, KRA, and so on and so forth. So it appears, based on his demeanor yesterday, failing to show up to answer questions that concern the Ministry of Interior, it appears that probably Kithure Kindiki ceased holding the position of CS Interior. Because if he still is, why would you miss attending summons by the Senate to answer to critical questions that have been raised concerning that ministry? Just the same way, we do not understand how he was cleared within a record of less than a day with this, by these relevant authorities. Probably, it's also possible that he resigned before he was nominated, and that's why he knows very well that he no longer holds the office of the CS of Interior, and he's waiting probably to be sworn in. That could be the only explanation that I can find around that explains the reasons why he did not turn up yesterday. Yes.
And of course, so what is in court right now is the process, the constitutional process of the impeachment of Rigathi Gachagua, and whether it was all a fair and just process. Let's bring in lawyer Suleiman Bashir joining us now on NTV. Bashir, a very good morning to you. Thank you for joining us. A lot expected to happen in the corridors of justice today as the three-judge bench there determines the consolidation of over 36 cases now challenging the impeachment of Rigathi Gachagua. How do you expect this to pan out in the course of the day amid political talk of the swearing in of Kithure Kindiki possibly tomorrow should the High Court lift the conservatory orders?
Well, good morning, Michelle. Allow me to first say that the scenario that we are faced with is one whereby one side are enjoying court orders already. They have conservatory orders that are in place. And on the part of those who are pro-government at the moment, they are so much hell-bent on having this particular court orders lifted. However, before the court ends up pronouncing itself whether or not it should lift those orders, there are those key applications that go to the aspect of procedural justice in terms of where a party files a recusal application, that has to be given a priority, and that is what we have just seen. And also today what we are looking at is the aspect of consolidation. Again, this particular consolidation question is coming in the midst of more and more cases that are being filed in other courts. So the big question is, if all these particular matters, over 20 or so matters, are consolidated, what happens to today, yourself or myself is able to file a new matter? What will happen to that particular matter? In the event, again, these will be issues that will be predicated on what is going on in the country. So I think these are key issues that the court ought to consider in terms of if it decides to proceed with all the cases in totality as one, they have to actually guide the country in terms of key directions on what will happen in the event future applications are filed. Are we going to anticipate a scenario of another judge bench, another three-judge bench or so? The other issue is, at this particular moment, can we say that, are we looking at a very short time whereby Kithure Kindiki, the professor, can be sworn into office? I think, for me, I will not go that way because there are so many applications that are in court. These are supposed to be argued out. And you know, courts are not supposed to rush to just lift court orders. especially where the substratum of the petition will be lost. The key issue will be lost the moment the court orders are lifted. So the court has to do some balance in terms of those who want the orders to be enforced against, vis-a-vis those who want the orders to be lifted. Those who want the orders to be lifted must come up with cogent reasons and demonstrate in the interest of the public why those particular court orders should be lifted. Those who want these particular orders to be enforced equally have to show and prove to the court why these orders have to be in place. And we should not forget that these particular two courts, the one in Milimani and the one in Kerugoya, when they were given these orders, on the prima facie, on the face of it, there must have been good reasons as to why those particular learned judges have granted these conservatory orders. These were not orders that were just shopped for. These are learned judges, equivalent to this three-judge bench, who have decided, and these are the ones who have granted these particular conservatory orders. So these particular three have to be considerate of what those two particular equal judges have been considerate about, because if they just wake up and lift it, it will, justice is supposed to be felt. You have to feel. When we talk about the aspect of feeling justice, it has to be, from point A up to point B. When you see Muite talking about senior counsel saying every party must be given time to talk. And I think this is one of the courts that has been so much easy on advocates. They were given that because they are trying to show and prove that whatever decision they are going to make is one that will befit faith and confidence in the people who are following these particular proceedings.
Absolutely. And it's a huge litmus test for the judiciary to strike a balance between upholding the law and really, so to speak, interfering in the very political nature of the impeachment process of Rigathi Gachagua. Many would say that, those who say that the courts have, the delay within the justice system itself, then is interfering with the governance of the country, because, well, the courts have pronounced themselves on Rigathi Gachagua remaining as a substantive deputy. We've, of course, seen his staff being told to stay away from office, so nothing really is happening within the office of the deputy president. What are your thoughts on that conversation?
You see, Michelle, if we say the courts are being a bit of a delay to the people or to those who, to that particular designate who was supposed to have been sworn into office, that is Professor Kithure Kindiki, when you look at the Constitution has given a total of 74 days for us to have a new deputy president once one is removed from office. And there's a reason as to why the Constitution is giving us this particular amount of time. And what we have seen is a very rushed process whereby within 2 days we have had a new name whose name was gazetted, who was actually at the brink of being sworn into office. So in short, there's nothing called delay. It is about ensuring that the justice is served to all parties, including the ousted or the impeached deputy president, so that in light of what has happened in the country, at the end of the day, you and I can sit back and say, both the courts and our parliament must have conducted themselves properly. That is where we are getting to. It is not about the court waking up and saying, owing to the question of time and public interest issue, we have to dispose of or determine this issue. It is true. It is important to be done with this particular matter because we need to have a substantive deputy president in office who the Constitution designates as being the principal assistant to the president. In as much as we appreciate that particular constitutional provision, on the other side, the litigant, these particular parties who are in court, deserve justice, time, and I think procedural fairness in terms of how the court has to conduct itself. So let's not say the court is taking so much time on this. However, the court ought to proceed within a reasonable time. Also, the court must not entertain unnecessary applications. The court has to go to the substantive motion so that it's able to consider whether or not the question on the procedural issues which are being questioned in terms of the rights of the ousted deputy president have been contravened or not. Then we can move on as a country. It is not the end of things, however, but it's an important thing both to law scholars, to law students, to citizens, to everyone. Because how this particular issue is being handled is the same way in the event we are having, in the event in future we may have a scenario whereby our president or a future president shall be impeached. There is a lot to borrow on how this particular deputy president's impeachment has been conducted. So let's have a lot of legal knowledge being built around this by the courts.
And Michelle, just to add on that, it cannot be said that the court is being sluggish in the manner in which it's processing these petitions. Just to point out specifically on the 74 days that my colleague here has said, the 74 days actually point to the president nominating a deputy president and Parliament, through Senate and National Assembly, approving. So they are given a total of 74 days. However, when a case or a petition has been filed in court, the Constitution or no law has given a specific timeline within which that petition needs to be processed.
Right.
Remember, this is not a presidential election petition. So, for those who are saying that the court is being sluggish, they may have to be a bit patient even more, because assuming the counsels for Gachagua proceed to the Court of Appeal and appeal against the decision concerning the constitution of this bench, that will then mean they obtain stay of the High Court proceedings as we wait for the processes in the Court of Appeal. So we should brace ourselves for long days and probably even months before these petitions are processed, because the minute one of the parties rushes to the Court of Appeal and obtains a stay order, that will be the end of the High Court proceedings until the Court of Appeal proceedings have been determined. So let us not be, the insinuation that the court is being sluggish is neither here nor there.
Right. Again, with regard to, I beg your pardon, the issues that the court has to consider before them, outside of the issue of recusal and consolidation of cases, just about 2 days ago, the Solicitor General filed an application to the effect that President William Ruto says that the High Court has no authority to hear and determine the petitions challenging Rigathi Gachagua's impeachment. Now, of course, the case is before the three-judge bench. What was the premise of this application by the Solicitor General, in your view?
I think probably either whoever filed that application, either they misadvised the president, or the president was advised properly and decided to ignore the good advice. Because if you look under the Constitution, what Gachagua is raising is that he was impeached in absentia, that he was impeached without his counsels being present. You know? So that is a constitutional issue. And if you look at the Constitution, the court with jurisdiction to determine interpretation of any constitutional provision is the High Court. Right. This is not a presidential election petition. And if you look at Article 163 of the Constitution, it provides matters that are supposed to be taken to the Supreme Court. Constitutional interpretation is not one of them. An issue of constitutional interpretation starts in the High Court. So that application by the Solicitor General on behalf of the President was a misnomer at best. It's dead on arrival because it's based on misadvice.
Right. Now, before all this happened and when the impeachment trial was taking place within the Senate, the impeached deputy president was very confident, asking Kenyans to be calm and that, he had full trust in the courts and in the judiciary to dispense justice. Suleiman, taking those sentiments of the impeached deputy president then and the sentiments of his legal team now that is alleging bias from the judges, what do you make of the situation? Is it simply a political process of stalling what is happening, or do they have merit in the argument?
You see, Michelle, for those of us who are always in court, the question on when you find a party talking about a biasness in terms of how the court is conducting itself, unfairness and all that, we are used to this. These are various things parties from different sides throw in. It's normal. So when you see a party who is now talking about biasness on the part of the judges, which has actually prompted them to file a recusal application, there are certain tests or requirements before a court recuses itself. What the court will consider is if there is anything of substance, if there's anything in support of those particular bias issues that they're talking about. You can't just wake up and come before court and tell the court that you are being biased because of A, B, C, D without any proof. I have seen very many times when parties have put in recusal applications, the court was able to throw it out. So when we see his advocates talking about biasness and all that, it's also not fair, because when the conservative orders were issued, which is now in their interest, quote unquote, as the court has put it yesterday, the court is now trying to expedite in determining the substance that is before it in relation to whether or not this particular court order should be lifted. But now the scenario we are seeing is a scenario whereby the counsels for the deputy president are a bit slow in terms of move into the key issue on whether or not the conservatory orders should be in place. That's a very important thing. However, now when the question of biasness and all that is raised by court, I mean by them before court, they must prove that, and the judges will have an opportunity to make a determination on that. But again, what kind of a signal is it sending on their side? It shows, and it majorly shows many a times, that when you find a party who is now losing the point in terms of the key issues to focus on, when you find a party talking about biasness and what have you before the court, trying to blame the court, and or maybe sometimes make unfair or derogatory remarks before the court, it points to the weakness of their case. It shows how much reluctant they are for them to have a substantive motion being determined. There's a key question also raised. The question on whether or not the court has jurisdiction. You know, the procedure in terms of how the deputy president should be removed is provided for in our constitution. However, the big question on whether or not the court has to entertain this particular case is also found in court. The court itself, it's also found in the constitution. It is the same constitution that provides for the procedure for the removal of the deputy president that also provides for what happens in the event your right is contravened. So it is the same constitution that outlines how the deputy president should be removed, that says in the event any party who feels his right has been contravened or being wronged in a way, it is this high court that shall have the jurisdiction to entertain and make a determination on that. It is not a strange issue. Both issues are in the constitution.
Right.
So we all agree that impeachment is a political process, but the procedure, the legal procedure, is encapsulated in our constitution. And where that particular procedure is contravened or there's a fear, alleged fear of contravention as required under that constitution, the same constitution empowers you or the deputy president to move to court to challenge how that particular thing has been done, which is why we are saying what the court is going to determine is whether the requisite procedure has been complied with. The court will not care about how many senators, whether a senator from Nyandarua or Garissa has voted in particular manner X. Okay. It's about the procedural aspect that
remains a political process. Let's take a break here on NTV. I'll come back with you, Titus. Okay. We must take a break here as we bring you live coverage of the court proceedings of the impeachment of Rigathi Gachagua, even as the political process also kicks off. Just last week, we had over 180 staff at the office of the DP sent on compulsory leave, even as talk of a shake-up targeting MPs and senators allied to Gachagua is in the offing. We'll be back with that and much more after this break. Just stay with us.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu. Kenyans will be shocked. Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Babies play around and then, oops, Morphix ina absorb like whoop. Imagine, haiwezi leak in 50 different movements. Makofi to both babies and Morphix. Renewed Morphix, ultimate quality.
Karibuni! Hii ndio base ya the best local entertainment.
Sitakubali ukalie kiti cha umiliki katika kampuni ya mume wangu.
Tell me where my money is, and I'll make this quick and painless.
You don't know what they do to girls like you.
I think it's a very unfair. Nakujua vizuri sana. Najua mdosi wangu vizuri sana. Hauwezi akakuandika kazi.
Pata taarifa teke na e-paper. Stay in the know on the go. Getting the full story bilangori. To sign up, choose your preferred subscription. Use the promo code SUBZ22 to get 20% off and pay. Get your favorite newspaper and enjoy the truth anywhere, anytime. For inquiries, email epaper@ke.nationmedia.com or call 0790 111 111. Subscribe today and get your taarifa teke.
Angela is pregnant?
Yes, she is, sir.
Is Alvaro's or Leonardo's?
It's Mr. Alvaro's.
The last thing I want is to have a baby with Angela. Goodness.
I mean, you don't even know if it's yours.
It's my baby, of course. Who else would it be?
It could be Leonardo's.
No way, she barely knows that guy.
You don't have the slightest idea about the situation. You don't know that Alvaro has a wife, do you?
He has now. But what about later on?
Listen, you must learn to play your cards for the long term, just like I do. Cleverness should be your only guide. And soon, Leonardo will fall for you. You almost have him.
From Hamlet. So this is where the magic happens. This is for you kids.
Taste the magic with our festive cakes from DPL Festive Bakery. Delight with every bite.
Unahitaji msomaji habari aelewaye matukio na matokeo ya matukio?
Michezo hutegemea hewa safi.
Msomaji habari mweledi wa majimbo
katika kaunti ya Turkana.
Msomaji habari mweledi wa masuala ya kanda.
Nataka nisikie vile wewe kwanza unasikia.
Msomaji habari mweledi wa masuala ya ulimwengu.
Hapa jijini New York nchini Marekani.
Msomaji wa mtagusano, mvuto, mnato na haiba ya kuaminika. Habari zako za NTV ya dhuhuri zimepata sura mpya.
Mimi ni Lois Wangoi. Kila siku, kila wiki, kila tukio. Saa 7 adhuhuri kwa taarifa kuntu, tendeti na za kuaminika ni NTV adhuhuri.
Get ready to have your mind blown.
Hey, what's up, my good people? This is your girl, Avril.
We're bringing you the hottest show in town.
The king of gospel, and I represent for Kwetu Mix.
Yo, Butrus, aka the sharp god up in the mix, you know what I'm saying? NTV, shout out to you, bro.
From exclusive interviews with the biggest names in the game. And snippets from your favorite live performances. Don't miss out on the fun. Tune into Kwetu Mix every weekday from 5 to 6 p.m. only on NTV.
New Panadol Extra Soluble dissolves twice as fast versus standard paracetamol tablets.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Good morning and welcome back to NTV as we bring you live coverage. All eyes on the court this morning as the court process over the impeachment of Rigathi Gachagua continues before the 3-judge bench. And we'll be having the judge this morning determining the consolidation of over 36 cases challenging the impeachment of Rigathi Gachagua. And later in the afternoon, the 3-judge bench will be determining the matter of recusal as the counsel, lawyers representing Rigathi Gachagua, allege bias and say they will not get justice before this particular 3-judge bench. And of course, the justices Eric Ogola, Frida Mugambi and Anthony Murima yesterday dressed down the lawyers of the DP for casting aspersions against the bench, saying that the allegations of bias are completely unfounded. Well, in studio with us this morning is lawyers Suleiman Bashir and Titus Mahanu to help us put into context all the legal jargon that is taking place today, even as many in the political sphere talk about the possible swearing in of Deputy President-designate Kithure Kindiki anytime from tomorrow. Now, gentlemen, we have established that it's quite an uphill, task really to expect the swearing in of Kithure Kindiki as early as tomorrow. But yesterday we saw the Deputy President, in court, and many noted what they would say was the changing fortunes of the Deputy President, or the impeached Deputy President, because the courts did say status quo remains. He remains Deputy President. Titus, why, in your view, then, did the DP show up without any security, as you would expect of a Deputy President? Is that a sign of the state frustrating Rigathi Gachagua?
Without doubt, it's admitted that Deputy President Gachagua remains as the Deputy President of Kenya. And that being a fact, he's entitled to all the privileges and perks that come with that office. So for the action of the government trying to withdraw his security, the act of government sending all his staff on compulsory leave and trying to curtail his privileges that come with that office are actually in contempt of these conservatory orders, because they themselves, by the mere fact that they have gone to court now challenging those conservatory orders, confirm that they admit that he's still the Deputy President of the Republic of Kenya. So to me, from where I sit and from a legal standpoint, in fact, the government is in contempt. And if the lawyers of Gachagua were able to observe that aspect, they ought to also be pushing that the government needs to comply with that court order before they can be entertained, because they are already in contempt, yet they expect the same court order to lift those very orders that they are disobeying. Yes.
Suleiman, I'd like to hear your thoughts on what's happening on the political front. We are hearing talk now of a looming purge from plum parliamentary positions for allies of Rigathi Gachagua. And many say they expected this. I mean, the Kiambu Senator Kanungo Thangwa there says if he is to lose his position for standing with truth and justice, then so be it. We've had talk of members of parliament who voted for Gachagua's impeachment, unable to go back home because he consolidated, quite a huge support base, especially within the Mount Kenya region. What is your prediction of what is likely, the political realignment is likely to come after this, with this looming purge in parliament?
There are certain consequences that obviously will follow this impeachment process. Let's say, we can look at it in two fronts. The first fact is that it is not in dispute that Deputy President Rigathi Gachagua was impeached. Actually, it's in office courtesy of a court order that has suspended the implementation of the resolution of the impeachment proceedings. Now that we have an impeached Deputy President, on the other hand, we have a Deputy President who was voted on by Parliament, who is just awaiting for this particular court process to end so that he is able to assume office. Once we are faced with these two particular scenarios, what are the next possible or probable issues? Right. In the event this particular court order is lifted, Professor Kithure Kindiki will assume the office of the Deputy President and the country will move on. Assuming, which in my view is an impossibility, which I don't see it as a possibility, in the event, let's say the court agrees with the pleas by Deputy President Rigathi Gachagua, we know that he's been serving as a Deputy President. If the court questions the constitutionality of the impeachment process, and just for example, let's just say it finds it as sham, an illegality, null and void ab initio, meaning the court shall have questioned the impeachment process. Where does Rigathi Gachagua, what office does he want to serve? Who does he want to deputize? Will he continue being the Deputy President to President Ruto? That's the big question. The other issue is, the impeached Deputy President Rigathi Gachagua, I think, has messed up everything post his impeachment. The day he came to address the media, especially when he contradicted the position of the government, in the sense that when he talked about the question of state operatives who were sent to, quote-unquote, poison him, when he talked about his differences with President Ruto in terms of the question of the social health scheme that was started, the social health cover, the question of the national housing program. These are government programs that he has now openly and publicly contradicted. And when you are the Deputy President, you're always supposed to be working with your boss. So I feel this is a person, even if the worst, let's just say the impossibility happens, and he's taken back to office, which office will he serve? What kind of Deputy President will he be? Will he be a substantive Deputy President who we shall think or expect to be executing certain mandates because he's supposed to be given duties by his boss? The Constitution hasn't defined specific duties, save for one or two that are in statutes. Now, on the flip side, these particular senators who have realigned or who have always been supported or were standing by him, the issue or the consequences of their support for the impeached Deputy President is what has happened previously to the supporters of former Prime Minister Raila Odinga. There are certain political consequences or certain privileges at parliamentary level, such as being the chairperson of a powerful committee or the vice chairperson of a certain parliamentary committee or even a member of key committees that come with being loyal to your party, because these are party positions that are given to you by dint of you being subservient to the dictates and wishes of those party ideologies. The moment you contravene or you go against that, of course, you will remain as a senator, but it's a political choice that the heads of that particular political party shall exercise. However, for me, other than being a legal practitioner, if I put on the shoes of a Kenyan or as a citizen of this country who is looking at the issues that are happening right before us, we have a deputy president who was impeached. And actually, it's just about time before he is in totality removed from that office. Ideally, for now, he's practically out of that office. This is just an office that is trying to fight tooth and nail to the last minute, which he knows he has lost, by the ideally, without going into how that particular court is going to determine. But in totality of what is happening to us, you cannot be the deputy president who is not wanted by your boss. You cannot be a deputy president who doesn't have the blessings of the houses of parliament. This is a deputy president who, by majority, both the National Assembly and Senate has impeached him. They have impeached him. They have shown that they have no faith. And these are the people we have given the powers to represent us at that particular level. So there are certain realities we must face.
Right.
Deputy Gachagua remains impeached. It is only a matter of days or even a week before we regard him as the impeached or former deputy president, because I feel as a country in the next few weeks we shall have a substantive deputy president. That's just what I think in my view.
Right. And of course, many Kenyans looking to get back to less politicking, more development. But Titus, judging from what Suleiman says, then, you know, we're obviously expecting some plum parliamentary positions to be up for grabs after the, what is being called a looming parliamentary purge. And in comes Raila Odinga and the broad-based government and the ODM party now asking for more positions, as you mentioned earlier. What does this mean for the so-called broad-based government? How is it likely to look like at the end of this impeachment process?
Now, this idea of broad-based government, you have to be very careful when you are trying to assess its status. Because anytime the chieftain of the broad-based government, or the architect, that is Baba, when asked whether he's in government, he's always saying he's not in government. He has reacted to the request by the president to donate his experts to assist and stabilize the government. But then again, I see that as a very cautionary move from Baba. And remember, Baba has got extensive experience in politics. And I remember when President Ruto formed his government, he did commence by saying that in his government, never will he allow a handshake. In fact, to our surprise, it was so easy for Baba to get into this government. So you are discussing and looking at someone who has got extensive and several templates that he has manufactured on how to get into government, regardless of who becomes the president. So this idea of a broad-based government, it could be a fallacy in my own estimation. And probably it's a big setup for the president to emasculate him, to incapacitate him to a level whereby he will be left at the whims of the chieftain of the broad-based government. Because right now, by the ouster of Gachagua, a significant vote from Mount Kenya has indeed left the president's camp. The people who are voting, and if you get the reaction of the voters, they are saying they have got nothing to do with the president because he has betrayed someone who helped him get in government. In as much as he has got his own reasons why he has commenced this process of oustering him. So it may get to a position whereby the chieftain of broad-based government may demand more and more and more. And it is, unfortunately and very sadly for the president, it is demands that come from someone who cannot be held responsible or accountable for the demands he's making, because anytime he's asked, he will tell anyone, I am not in government. I only donated my experts. And he can continue with this aspect of saying, I can continue donating my experts to this government for purposes of stabilizing. And therefore, that can end up being a vicious cycle that can never end. Right. So it's a very tough road for the president, and he needs to think that probably this broad-based aspect was a big setup that could end up making him a one-term president.
Right. You know, when you go back to the legal process, there seems to have been so many gaps in this process, Suleiman. There are those who say that the gaps may make it easy for the courts to even nullify the appointment of Kithure Kindiki and, you know, maintain Gachagua as the bona fide deputy president. But let's discuss that, because at the end of the day, there are those who say the Constitution is silent on the timelines within which the court should, you know, determine this process. After the High Court, which has jurisdiction to hear the matter on the impeachment process rules, the aggrieved party still has a right to appeal at the Court of Appeal, which can pronounce itself, and the decision of the Court of Appeal is still subject to being challenged at the Supreme Court, which at the end of the day then will be the final destination for this matter. So even as we, look at what may happen today, what is the possibility of this matter escalating to the Court of Appeal and later to the Supreme Court?
Well, when the High Court makes a determination, or rather pronounces itself on an issue, indeed, let's say the High Court, for example, decides to lift the conservatory orders. What we expect is for those who are counsels for Gachagua and the rest who are interested in having those particular conservatory orders being in place shall move to the Court of Appeal as we expect. But moving to the Court of Appeal as such is not just a ground of stay. The Court of Appeal has to have a look at what you have, that particular appeal you have lodged before it, and it must make the requisite directions that shall affect the issue in question. The only way, in the event the High Court sets aside or lifts the conservatory orders, the only way Gachagua shall have a continuity in the issue is if the Court of Appeal grants a stay of the finding of the High Court. If that particular stay is granted at the Court of Appeal level, this particular issue shall have a continuity in terms of the litigiousness or in terms of what is happening before courts, and we shall end up entertaining the situation that is right before us. But you see, there are many appeals that are in the Court of Appeal whereby orders were not granted, but these are appeals that are still awaiting determinations at the Court of Appeal. And by such time, if the Court of Appeal does not grant stay, someone else will have assumed that office and the issue shall have been overtaken by event. And courts also have various ways of rewarding a party whose right has been contravened. And for example, in the event it shall have been overtaken by event, in future the Court of Appeal could grant damages or other remedies that it deems as a relief. But Michelle, from where I sit, when I look at the issue in terms of what has happened and how our constitution has been drafted, this is a political process. It's a procedure that was given to our parliament. Both houses have pronounced themselves in terms of the choices they want to make. A deputy president was formerly a deputy or a running mate to someone who wanted to clinch the seat of presidency. As we know, Gachagua was the choice of President Ruto over Professor Kindiki at the time. Right now, in as much as we have elected them, we are the same Kenyans who have given our houses the right to make that particular decision for us. If they have followed a specific procedure and have impeached him, and now Gachagua is trying to challenge that in court, even as we await the finding of the court, or assuming the worst happens in terms of him being taken back to office by the court, or if the court declares that particular procedure as unconstitutional, what stops the same parliamentarians who are given that particular mandate to re-engineer the same procedure? What I'm just saying on my part is, when I look at both sides, the aspect of the impeached DP Gachagua struggling hard to stay in office, especially at a time when he has gone against the place of the government in as far as the programs are concerned, or this particular regime, what it's focusing on, because he has come out clearly. In the event the courts keep him in that particular office, for him to continue being a deputy president to President Ruto, it shall require massive or huge political reengineering, which he has unfortunately lost. We know that that particular political relationship has been deeply lost. And this is a political office that you will be serving your president as his PA. And you are a person who, again, will be subjected to in terms of scrutiny or removal by our National Assembly or the Senate. Let's come now to the question on timeline. In as much as the Constitution has not given us a specific timeline within which this particular petition has been determined, this is a matter of public interest. That's why we can see this three-judge bench is not looking at any other issue save for this particular issue. We have the Supreme Court of Kenya that our Constitution has given 14 days to make a determination of presidential election petitions. And we have always managed that particular procedure. I can assure you, in terms of what and how I've seen this particular three-judge bench proceeding, because the day before yesterday, they were able to take a very short time, and yesterday they were able to make a determination on the question of the DCJ's empanelment. Today, I think this particular well and able three-judge bench shall be able to determine the question of recusal and the question of consolidation. And you know, courts can also give a direction in terms of no further applications that can be filed. We have seen courts sometimes giving a certain issue a priority. In short, ultimately, if this does not happen tomorrow or today, something in terms of whether or not this particular court order shall be staying in force for a time or not, by next week, we shall have an outcome in terms of what is happening in our courts. That's a reality we have to live with. Okay. Because these three-judge bench, they are there. They are not sitting for all other cases. No, these particular three were told, can you preside over this case? You know what that tells you? It shows you how much of a public interest issue. It's an issue of massive public interest. Okay. And they're giving it a priority. The councils, we saw them submitting even beyond 5 p.m. The judges spending even the evening working on a ruling, coming early in the morning, giving a ruling on specific weighty issues that were raised by the councils. This is telling you how much of a priority the judiciary is giving this particular issue. And if not tomorrow, maybe by next week, there shall be an outcome on what is going on before our courts.
Right, and of course the public interest is very high, even on the nomination of Kithure Kindiki himself. And there had been questions previously as to whether there would be need for or space for public participation, whether the public would have a say on the nomination of the candidate itself. And it appeared then that Parliament, decided to do away with public participation.
And also the question of clearance by EBC and what have you also.
Exactly. So Titus, that being said, and we're talking about gaps in this process, okay. Is it a miscarriage of law or justice then that there was no public participation, but that the president purported to vet, nominate and present the candidate without a substantive IEBC, whose job really is to verify the validity of the candidate?
Michelle, looking at the whole process, first of all, the process of impeaching Gachagua is being done in a rush. It's being, someone seems to be so determined to get rid of him very quick. And that's where they have started this process by making mistakes. And that's why so many Kenyans were surprised that Kindiki was able to be cleared by close to 12 relevant authorities that have been given the mandate to clear anyone for the position of deputy president nominee in less than 12 hours. Then the other question that comes in, and which is very fundamental, is that if you have been nominated for the position of deputy president, you are supposed not to be holding any public office at the time of your nomination. So the question that most Kenyans are asking is, at what point did he resign or relinquish his current position in quotes as the CS for Interior? And at what point did IBC clear him? Because we saw in the letter by the president insinuating that it appears that IBC also cleared him. And we know very well that IBC has not been in place. And in fact, the courts have rendered a recent judgment just around 2 or 3 days ago, saying that IBC needs to be constituted ASAP. So amid all these issues, which are very fundamental, and if all these issues are considered in court, clearly the impeachment process and the nomination of Kithure Kindiki, there is a likelihood that the court is going to set aside all these processes that have been engineered by the politicians. And I wouldn't be surprised if we are back again to stage number 1, where we are required again to start the whole process. And it is on that basis that the counsels for Gachagua need to, if I were them, and if I was sitting as a judge, I would simply ask the counsels and the parties that are prosecuting this impeachment case is, now that we have conservatory orders in place, in order to expedite the petition, why can't we dive straight into the substantive issues? Because that way, the court will be able to get rid of the preliminary objections. Because remember, there is a ruling that has been delivered on the issue of constitution of the bench. Now, what will become of this process? And we have seen counsels for Gachagua intimating that they will be moving to the Court of Appeal to challenge that decision. And we know that when you file an appeal or you show intention to file an appeal in the Court of Appeal, the most imperative thing that you need to do is that the first thing is you have to seek an order of stay. And the threshold in the Court of Appeal, Michelle, is very low when it comes to granting an order for stay. As opposed to the High Court, where the discretion of the High Court is fettered. In the Court of Appeal, the discretion to grant stay is unfettered, which means you just need to demonstrate two things. That number one, you have filed an appeal or you intend to file an appeal, and that if the stay is not granted, then the whole appeal which you intend to prosecute is going to be rendered nugatory. So you can see the threshold is very low. And many a times, you will see the Court of Appeal granting that stay. However, if the High Court proceeds and lifts the conservatory orders without Gachagua's counsels having obtained a stay in the Court of Appeal, then the substratum, much as it wouldn't have been lost, but it will be an exercise in futility because the government will quickly move in and swear in Kithure Kindiki.
All right. I mean, it seems like a merry-go-round, really,
Yes.
in the legal profession. But I'm glad you brought up the issue of IEBC, and I'd like to hear your thoughts on this, Suleiman, because the reconstitution of IEBC has been pending for far too long. We have constituencies and wards that have been without representation for well over a year, which is against their right to representation as per the Constitution. But we see politicians, we see Parliament itself really fast-tracking issues that are of interest to them, like this very political process of the impeachment of Rigathi Gachagua, the very fast process of the finance bill of 2024 as well. What are your thoughts on the prioritization? Do you feel that Kenya's politicians, especially parliamentarians, have their priorities wrong in the matters they fast-track in Parliament?
You know, one time, previously, around the 10th Parliament, I happened to be one of those who worked at the National Assembly. What I'll tell you is the kind of resource that our parliamentarians have been given just to make sure that their legislative duties are made as easy as possible for them, you'll be surprised, and how they're not even able to take advantage of that. When you look at how this particular impeachment process has been undertaken from the National Assembly up to the Senate, in our country, we have never ever had a public-centered issue, be it health, be it water, be it education, that has been handled as such. You know, when you look at how our parliament has been managing itself all along, and every term, from the 10th to the 11th to the 12th to the 13th, we always have one word that says our parliament is state-captured. That is a common issue we talk about. Even our current president, at the time he was campaigning, he was alluding to the fact that our parliament is an appendage of the executive. That tells you whatever sails through that particular house must be having the blessings of that particular top house. In short, what we can also deduce or deduct out of that, or the inference we can borrow, is that even this particular impeachment must be having the blessings of that particular top house that we have in our country. That's a reality. Because anything that you see that has been rushed or that has gone through, whether or not it is in the interest of the people of Kenya or not, once it has the blessings of the president or those around the president, they're always able to support that. We are yet to have one or two leaders who have come out strongly to question certain issues. For example, our constitution anticipates the question of boundary delimitation.
Right.
That ought to have been taken within 8-12 years, which are constitutional timelines. Forget about that. Forget about the constitutional requirement or the constitutional obligation that is supposed to be met. That very IEBC that is supposed to have undertaken these particular core duties is not formulated. And you know, we have a finding by the courts that when we talk about the constitutional bodies, when we talk about them, it is the commissioners that form, or that when you talk about IEBC, IEBC is about the commission or the commissioners, the chairperson and the members of that particular commission. The secretariat, in as much as we have in the secretariat, that's why we cannot have by-elections and key issues that are going on in our country. In short, for example, the people of Mandera, the people of various constituencies or wards in our country are yet to have their representatives, and they're losing out so much in terms of resources just because we do not have an IEBC that is in office. You know, in our country, again, we have about 1 million young Kenyans who are sitting for the KCSE examination. No conversation by our parliamentarians or our leaders on that particular issue. We have serious takeovers by foreign companies of our key assets. That is not a serious issue according to them. In short, what is the end issue? The end issue is these are the same people who we have chosen and will be forced to live by it. That is it. The blame squarely falls on the people of Kenya because the Constitution ideally gives us 5 years to audit them so that we're able to make certain choices. So if these are the same people that the people of Kenya have chosen, and these particular choices that they're making for us, if we are not comfortable with them, if you cannot be proactive enough to challenge these particular illegal or unprocedural decisions in court, you will be forced to live by it, sit back, wait for your time. Again, the Constitution shall give you an opportunity to audit them. That is the time you'll be able to make a decision, which is why when you look at the TIFA polls and various other pollsters who are undertaking their research, it tells you that a huge chunk of these particular parliamentarians, or even both at the parliament level, that's the Senate and National Assembly, and also at the wards, majority of them shall not come back. It is because they have not met the expectation of the people of Kenya, because they're always losing the point. They're losing the focus. And they also don't know how to multitask. They don't know how to prioritize certain interests. They cannot debate or argue on the question of the impeachment of the DP, at the same time not forget the question of the Adani takeover, or the question of our Ketraco, a huge chunk of it in terms of what's happening with our transmission electricity lines. Right. These are serious issues of concern that they have actually forgotten. So we just see all of them, and we're being told that money is being circulated within the houses. And now, Michelle, I'll be honest with you, even when the the parliamentary committees, when the select committees are calling for a parastatal head to ask him serious questions, there's a lot of bribery and unfairness that happens there. Right, and I'm telling you this as a person who was able to work with them closely and who was able to experience firsthand in terms of what happens within the corridors of those houses.
Right, and that's an interesting revelation because Titus, then the question becomes, is it that members of parliament are forgetting these very crucial responsibilities that the electorate expect them to perform, or is it that they benefit from grey areas? During the Finance Bill 2024 protest, the conversation now turned to recalling members of parliament who did not represent the will of the people. But you realize you cannot recall an MP without a properly constituted IEBC, which then the MPs were meant to come and constitute. So is it an issue of wrong prioritization, or just that members of parliament, perhaps politicians, benefit from these grey areas at the end of the day?
For me, it's the failure to have IBC in place. It's very deliberate. It's very deliberate in the sense that, and it's good that you've been able to see the main reason why it is becoming very elusive and difficult for us to have an IBC. Because there was a lot of clamor that most of these MPs have been rendered into voting machines. Because I remember the president told them that the finance bill has to pass. Then after the protest, the president calls all of them and lines them, and they flag him, and he tells them the finance bill has to be rejected, and they're there clapping. So that enraged people, and there was a lot of clamor to recall these MPs. But the MPs understand that for any recall process to be kicked in place, IBC has to sanction it by way of processing through signatures and so on and so forth. So it is very deliberate, and as you rightly put it, politicians benefit from the lacuna that we are witnessing. Anytime there are gaps within our systems, they explore that to their advantage, in the sense that if the gaps afford them benefits, can afford them more time in office, can afford them more time to seek, to influence and attribute advantages based on the processes that have been given to execute mandate by the Constitution, then they do that. So the issue of MPs and our representatives failing to execute their mandate where they are required, it's not that our systems are not working. It is by design, it is very deliberate, it is meant to advantage them. So that's why you can see like a good case of, in the good case of the IBC not being in place, they know very well that as soon as IBC is functioning, the next thing is that Kenyans will be recalling them. And I think now the bar has been set very low that any person can be recalled. The deputy president has been impeached. The next people on the chopping board are the representatives, the MPs who need to be recalled. So it's by design that they do not want IBC in place. And this issue of Parliament being declared unconstitutional did not start even with the Gen Z's protest. Remember, there was an advisory by the CJ some time back during the tenure of Chief Justice Maraga. He did advise the president that having failed to enact the 2/3 rule as regards the gender issue, on the issue of representation, this parliament is unconstitutional and needs to go home. So they have never complied with that directive, and any time that directive can be brought in place and be enforced, because even this current parliament has not complied with that. So they will do everything possible to obstruct and to prevent any such move. So it is by design, it is very deliberate.
Right. The phrase state capture comes out many times when you're talking about parliament. But many would begin to wonder, Suleiman, whether it is the Mwananchi, Wanjiku, that has now been captured by members of parliament. Because without IEBC, which members of parliament need to sit and reconstitute, then you cannot recall your member of parliament. You cannot really hold them accountable. So what recourse does a citizen have at the end of the day?
Well, it's true that the people of Kenya expect to have a fully fledged and functional IEBC. I know there are several court cases that are now pending before the High Court, whereby the citizens of our country are seeking for a determination or a pronouncement in terms of what should happen or how are we going to constitute our IEBC. You know, Michelle, in light of what is happening, a very important discussion is now going on, in the sense that we have our president and we have, quote-unquote, a deputy president. In the event, God forbid, anything happens to our president, it is the deputy president who assumes that particular office. The situation we are in at the moment, in the event anything happens to our president, quote-unquote, again, we do not have a substantive deputy president. In short, we may have the Speaker of the National Assembly assume that particular office of the president for a limited number of days for IEBC to conduct elections. Yet, we do not have an IEBC in place. Yet, the president has his own place in terms of the constitution of IEBC. Do you see, even the situation we are in, just because we lack IEBC, how problematic or the situation our country may find itself in, just because the president and the parliamentarians are not even so much keen or serious about the formulation or the establishment of the Independent Election and Boundaries Commission. So just by the sheer lack of it, in the event anything happens to the office of the president or to the president himself at the moment, we may find ourselves in a very bad scenario, especially in light of the fact that at the moment we don't have a substantive or a proper, as I may put it, deputy president. Let me also raise this, Michelle. When our elections are over, the ruling party ends up forming the government. Now, the likes of Raila, who lost that particular election, end up becoming the opposition. The essence is for these particular members of the opposition to raise serious questions to ensure that certain constitutional requirements are met, certain constitutional bodies are met. They are supposed to act as check and balance on the government. If we had a proper substantive opposition, the question on IEBC, this will have been a very serious issue that will warrant as a national discussion, so that until we see to it that the same is formed. But what do we see? We see a scenario whereby we end up having a cocktail of an opposition and a government. Now we have the opposition that has subsumed itself right in the midst of the government. We have the members of the opposition who are rightfully supporting the strategies and the wishes of the ruling government. Now these are serious issues whereby Kenyans are finding themselves in a parliament that we have given a lot of powers in terms of what they will be doing on behalf of us. Yet, that same parliament that is supposed to act as check, forget about even those members of the UDA and what have you, but at least members of the ODM and WIPA and the rest who are forming the opposition, these are the people that we expect them to raise serious questions in terms of what is happening there. Right now, once we have had Baba and the rest cross over to the side of the government, we don't know who is the opposition and who is the government. We have one parliament. President Ruto says, pass this, the same is passed. I think it is time for Kenyans, and it's also time for our parliament and the president to be serious, in the sense that if we continue lacking the IEBC, as I've said, in the event, God forbid, happens to our president at the moment, we will find ourselves in a place whereby our president and the parliament have deliberately chosen for us. And it will be a very, very bad situation that we shall find ourselves in.
What briefly are your thoughts on the fact that Kithure Kindiki was, purportedly vetted and nominated without the IEBC in place? Could that pose a major challenge legally
All right, Michelle, let's put it this way, that indeed there are serious questions about the clearance process. But again, when you look at the Constitution anticipates Parliament to vote on that particular party who the President shall nominate. That is the wording of the Constitution. Right. However, if we give the Constitution a purposive approach, we expect this particular person to have met certain tests in terms of clearances by the IBC and the other requisite bodies. That's also not in question. But again, there's an argument that is fronted in the sense that if there are certain clearance issues that are supposed to be granted, the Secretariat is able to take care of that. Again, that there will be a debate in terms of who can do what. Is it the commissioners, or in the event we are lacking the commissioners, can the Secretariat clear a certain party? Now, away from that, we need to distinguish or contradistinguish the two or the issues that are before court. The issue before court on the question of Gachagua, if the court determines and find him to have been validly impeached procedurally without any constitutional contraventions, the question on how the nominee or how the deputy president designates who the parliament has approved is a different question altogether. In the event his designation or his approval by the House is rejected by the court for various reasons, we'll be able to address that in a different forum, whereby the president again shall have an opportunity of coming up with a name, and certain processes can be complied with easily. I think we need to contradistinguish the issues that we have before our courts. So there is the issue of Gachagua in totality in terms of how he's been removed from office. And if we look at the question on how the designate, who is just awaiting assumption and swearing in into office, has been nominated or has been approved by our parliament in terms of the vote that they've undertaken as required under the Constitution, that is a different ballgame or different issue altogether. And in the event there are flaws, it will be very easy to remedy that. It is about, again, nomination, and again, certain requirements or checks being complied with by himself. And that is not so much complicated, or it will not be, the situation will not be as topsy-turvy as we are finding ourselves within the Gachagua's case. So, in essence, let's just wait, have a determination on how the whole Gachagua thing goes. That issue on how that particular person has been validly, whether or not he has been validly cleared by certain bodies or not, is a different question altogether. But we have to be alive to the question on the constitutional wording. The Constitution talks about our parliament shall vote. It is not about the question of approvals and whatever. It's about a vote or a choice our parliament shall make on that particular nominee, as shall be fronted by the president.
Right, right. And on the flip side, of course, Kindiki's nomination has sparked intense lobbying for the position of Interior Cabinet Secretary, which is expected to be declared vacant. We'll be discussing some of the names that have been fronted there in the course of this as we look at who will replace him. But Titus, with Gachagua's impeachment process, and of course, even with the questions Suleiman poses, I mean, should the court decide that he wasn't properly impeached and he remains in office, where will he really serve? Where will he really fit? The president is not for him, parliament is not for him, and so we've seen quite an interesting situation. What are your thoughts on Kithure Kindiki's deputy presidency and whether he will manage to break what has been termed as the curse of the DP? Because the fallout between President Ruto and Gachagua is pretty much irreparable from what we've seen. But will Kithure Kindiki be the guy or in the line of deputy presidents to break what has been called the curse of the deputy presidency? Okay,
Michelle, the impeachment process of Gachagua raises two issues. From a philosophical point of view, it raises two issues. There is the moral question and there's the legal question. If the courts decide that Gachagua continues to remain in office, then the question that most people are asking is, where does it leave him? On one hand, legally, he is supposed to be accorded and afforded the privileges and the pact that come with that office, because it means by virtue of the law, he is in that office. And nobody is supposed to pull strings in such a way that disadvantage him in the execution of his role. He's supposed to be given his role. He's supposed to continue chairing the IBEC. He's supposed to be given his budget. His security details are supposed to be reinstated. He's supposed to enjoy all the privileges and the pact that come with that office. So that is the legal question. And the law as it is, as they say, the deputy president and the president, as a matter of law, they do not need to love each other. They do not need to like each other, but they have to respect the constitution. By the mere fact that they're in the office, they can execute their mandate without liking each other, without loving each other. Now, on the moral question, it will be practically very difficult for them to work together because clearly their relationship has been tainted and it's almost broken down irretrievably. This is like a marriage. It's like forcing two individuals to stay in a marriage, whereas the substratum of the marriage has been broken down irretrievably. So if the law says that they have to work together, they have no choice. As to whether they should like each other, it is a moral question. It is there that will just impact on the perception that the public will be getting. So that is from a philosophical point of view. Now, on the issue of whether Kindiki will be able to break the curse of the deputy president, I cannot really tell. But what I do know is this. I do remember very well that when President Uhuru and Deputy President Ruto were appointed for the first time, there used to be a lot of bromance between them, and nobody will ever have imagined that they will fall out. They even used to put on matching ties and shirts. They seemed like they will never disagree.
Serious.
Yes. And then fast forward, we saw how their marriage ended up. It was a bit messy and noisy. And then again, we see the same scenario repeating itself with Gachagua and Ruto. And in fact, Gachagua has come out saying that when other coalition members of the Kenya Kwanza were signing agreements and shareholding agreements, he decided not to sign anything because he trusted the president. But fast forward, you can see how their marriage is ending up being. It's messy, it's very noisy. So I cannot really say that Kindiki will be unexceptional and break this curse of the deputy president and being very subservient. Because one thing for sure, you know, Michelle, and it's by design, it's by virtue of our constitution. Our constitution seems to impact certain notions on every person who holds the position of the deputy president. And the president knows, and the deputy president knows. And I'm not talking about Ruto and Gachagua or Kindiki. Any president and any deputy president in the world, much as they may want to say that they like each other, in the fullness of time, their real aspirations will come out, because it is always the prayer of any deputy president to become president. And it is the prayer of the deputy president that anything should anything happen to the president, I'll become the president. And it is the worry of the president all over the world and through this structure that presidents always worry that should anything happen to me, this person is going to be the deputy president. So this pull and push, these antagonistic positions will always exist. And therefore, having such a scenario, it's very difficult for you to say that a president and a deputy president coming into power, they will always like each other in the fullness of time. Along the way, they will always disagree because of these ambitions and because of these ambitions that have been set in the stage by the Constitution.
All right. Suleiman, there are those who say then that these ambitions, especially for a deputy president to want to become #1, may be the beginning of the problems for any deputy who gets into that seat. It's a position very close to power. But what factors, in your view, have made the deputy presidency such a precarious position?
Well, Michelle, if you may allow me, let me first clarify on something. You see, I'll get to that question, but on the issue of the deputy president being in court or challenging this particular process, what is his end objective? Because it's crystal clear that in the event the courts make a finding of an illegality or unconstitutionality in terms of how the impeachment process has been undertaken, what will come of him, or what will happen to him, or how is he going to serve the office of the deputy president? Michelle, the essence or the main reason as to why he continues fighting in court is that there are certain legal consequences when you stand impeached. So what he's doing is he wants the courts to make a finding in terms of the impeachment proceeding as has been undertaken by the parliament. If that particular impeachment process is challenged and his position is supported by the court, or it makes a positive finding, those particular legal consequences in terms of his eligibility to hold future public offices shall stand challenged, and he'll be able to hold future public offices. So I think that's an important point to clarify in terms of why he continues challenging the impeachment proceedings in court. Which is why I'm saying, in the event the court order is lifted and Kindiki, the professor, the good prof, is sworn into office as the deputy president, we are going to see a scenario whereby the Honorable Gachagua is going to continue challenging the impeachment proceedings, not just at the High Court, to the Court of Appeal, up to the Supreme Court. Why? Because he would want to have a sanity of name, to ensure that he will be fighting to find for the courts to make a finding, a certain finding of a negative one in terms of how the impeachment process has been undertaken. If that happens, that particular legal consequence in terms of him being eligible to hold public office shall be okay.
But he remains impeached from the seat of deputy president.
Yes, he'll not be going back to a particular office. So if the court makes that particular finding, the court is also going to make a certain award or reward in terms of monetary compensation or any other form of damages or compensation as the court shall deem fit. But his end goal or his end take home must be a finding to have these particular proceedings to have been a sham of a process, or it must not have been complied with a certain procedural fairness or procedural fairness as required. Away from that now, and I think it's good to make it clear as to why he continues fighting. So his fight in that particular court is not just to come back and assume that office. On the flip side, if the High Court agrees with him and says, look, the Honorable Gachagua has been irregularly impeached, or certain processes were not complied with during the impeachment process, and that whole impeachment process is a nullity, and the court orders that he goes back to his office in this particular court, one of the political issues we might see in future is when he assumes that particular office, he has the option of resigning and leaving that particular office honorably. And again, that will protect his name in terms of the eligibility question, because he shall not have been impeached. Rather, he shall be back into office and he shall have...
Does he still have time for that? Has that not been overtaken by events by now?
Which is why I've said, if this particular court makes that finding, if he goes back to office, yes. If the court makes a finding in terms of how the impeachment process has been a sham of a process, he can go back to office and do an honorable thing in terms of putting in his resignation letter. I think his fight in court is not just to resume into that particular position, but rather to ensure that the sanity of his name, the constitutional requirement in terms of his future holding of a public office or his eligibility is protected. I think that is what his clamor is about. So we are going to see a huge legal battle, even as we are going to have, in the event we have a new deputy president. Alongside that, he shall be in a position to challenge any findings from the High Court to the Court of Appeal up to the Supreme Court. And I think that is a wait-and-see issue. Let's now come to the aspect of what is happening to deputy presidents. You see, Michelle, from history, all our deputy presidents, when they assume office, the Constitution requires them to be the principal assistants to the president. And this is the second most powerful person to the president. And you know, politics is a game. When someone assumes an office, he or she will be interested in going to that particular higher office. And the person who is at that particular top office of being the president shall be able to watch you politically. So I think that's a political issue that shall be determined within that political circumstance, whether or not we are posing as a political threat or not. But however, in our country, in as much as the process is provided for constitutionally, especially in Kenya, we know how powerful our presidents are and how much of a control they get to be over their parliament. The moment you pose to be a risk to them, in the history of our country, you may end up, as he has become, you might end up becoming the second deputy president, because we have had one vice president who was removed from office previously who shall stand impeached. And you know, this shall end up having a far legal ramifications in terms of his career as a politician. Because all along, I think if you were following the media, especially this particular media house, you guys were trying to look at the various options that the DP was having prior to this particular process, which is why I'm saying it is not yet over for him. It is a long process, and he has the chance on whether or not to clear his name. Now, Michelle.
All right. Let us take a break, Suleiman. We'll be back with more. Let's take a break here on NTV. We're bringing you live coverage ahead of the court resumption of Justices Eric Ogola, Frida Mugambi, and Anthony Murima, who will be determining the consolidation of cases challenging the impeachment of Rigathi Gachagua. Over 36 cases having been filed so far, more cases still being filed in different courts across the country, and that will determine the direction that this impeachment or the court process of this impeachment case takes. We'll be giving you more and more coverage as and when it develops. Do stay with us here on NTV.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Enjoy all-in-one payment solutions for your business with Network. Accept multiple payment methods and process all your business transactions on one device. Whether it's M-Pesa, Airtel Money, Visa, MasterCard, Apple Pay, or Google Pay. Network does it all. It's faster, it's better, it's smarter. Get it for your business today by calling 0730-847-847.
Are you ready?
Lete king'ari ni kusitie kifuaka. Niko na dem, mwenye kuna dem pia. Masa flani ikifika na wachangamkia. After scene kabaridi sezi nkatulia.
Tunakubali. Gateka.
Kashpop za Nyandaro ni mawaru.
Only on NTV. Reach your audience instantly and make a lasting impression with Nation Sema. Affordable bulk SMS at 0.3 Kenya shillings. Own sender ID for 10,000 Kenya shillings plus 10,000 free messages. To sign up, please call 0728434979 or email us on mkibunja@ke.nationmedia.com.
What's happening in your life is demonic machinations, is satanic attacks which are attacking you. So they are downsizing you to make you feel you are useless. You are not useless. In heaven, when God is looking at you, He's seeing a millionaire, He's seeing a president, He's seeing a businessman, He's seeing a leader, He's seeing a visionary, He's seeing a great man, a great woman. May you be the one in Jesus' name.
Please don't ask or remind Nikolai about the wedding. We don't want him stressed.
Let me be clear to you, Kelly. No matter how you look or what dress you wear, no matter what dishes you cook, you can never be like her. You will never be Adele.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Welcome back to NTV. It is just about 10-15 minutes to the top of the hour as the country awaits that three-judge bench of the High Court comprising of Justices Eric Ogola, Frida Mugambi and Anthony Mrima to discuss the consolidation of several petitions challenging the impeachment of Rigathi Gachagua. The court was to sit at 9 a.m. this morning. We are still waiting on the proceedings. We'll be giving you live coverage, live pictures as well from the court as we await those three judges, a monumental decision there as they determine those more than 36 petitions really challenging the impeachment of Rigathi Gachagua. Later in the afternoon, the court was expected to debate on the issue of recusal of the three judges from this case following allegations of bias from lawyers representing Rigathi Gachagua. But much more continues behind the headlines, especially within the political scene. And in studio with us is Titus Mahanu and Suleiman Bashir, both lawyers, looking to put into context what really is happening in the country this morning. And Titus, let me begin with you. The court was to sit at 9 a.m. It's just about 10 a.m. We haven't seen that yet. But we had lawyers of the impeached Deputy Rigathi Gachagua signal that they will appeal that ruling yesterday that found that the Deputy Chief Justice Philomena Mwilu had properly appointed the three-judge bench to handle the petitions touching on his ouster. So this moves from the High Court to the Court of Appeal. How is this likely to impact the proceedings of the entire case moving forward?
Michelle, in litigation, there is something called strategy, so that we end up with strategic litigation. If you are a party and you obtain the favors of the court in the first instance, to the effect that you have conservatory orders that advantage you over your adversary, you now bring in strategic litigation in the sense that you ensure that the conservatory orders continue to be in place as you try to frustrate the other side. And it's allowed. That's being tactful because you can justify that position. So the lawyers of Gachagua intimating that they will be moving to the High Court, they know very well that they have conservatory orders which keep Gachagua in office, and they want to use now court procedural law to tire down the government's advocates and the government's side, in the sense that if they move to the Court of Appeal, the first thing they will be seeking is stay of proceedings in the High Court. The effect of that is that the whole impeachment process of Gachagua, as well as the anticipation of the assumption of office by Kindiki, will be halted until the Court of Appeal can hear and determine an application challenging the reconstitution or constitution of the bench. Now, that will be counterproductive to the counsels of Gachagua if by any reason they fail to get stay in the Court of Appeal and the High Court vacates the conservatory order. But if the counsels for Gachagua are able to get a stay of proceedings from the High Court, from the Court of Appeal, then we are looking at probably another 1 month or 2 months before now we can come back to the High Court. Now remember, as I said before, the threshold for grant of stay under Rule 52B of the Court of Appeal rules is very low. The Court of Appeal in granting stay exercises unfettered jurisdiction. You only discretion. You only need to demonstrate two aspects: that you have filed an appeal, and that if the stay is not granted, then your appeal is going to be rendered nugatory. So that threshold is very low. So those are the implications that we expect in the event that his lawyers go to the Court of Appeal.
All right. And Suleiman, of course, earlier on, you'd brought up very crucial issues of the amount of bribery, really, that can happen as we talk about state capture. And as Gachagua's team seeks to prove that the impeachment process did not happen as per the law, we've seen members of parliament allied with him, the likes of Kiambu Senator Kanungo Thangwa, come out and allege that there was, bribery and outright corruption of members of the Senate to influence the outcome of the vote. Now, these are allegations that NTV cannot authoritatively substantiate. They were words of Senator Karungo Thangwa. Are allegations like this likely to cast doubt in the court or within the bench that really this process did not go as per the law?
Well, you see, those are now allegations, and the court is one of record. If those particular allegations are supposed to be relied on by any party, they must adduce the requisite evidence. You must come up with an evidence showing how people are being bribed to achieve a certain political outcome. So I think to that extent, I think it will be treated as hearsay without any evidence, and the court will not be listening to that at all. In terms of what is happening with our parliament, it's true. A lot happens there. I think we are in a scenario, or we are in a period whereby I always argue that the judiciary is the only arm of government that's alive. It is the only hope of the people of Kenya in terms of what should happen within our systems, in terms of the protection of the rights and freedom. This is actually the only arm which is also, quote unquote, fairly corrupt. It's good to be also honest on that part, but it's better than the other two arms of government. So today, even as we follow these particular court proceedings, you see, Michelle, up to this particular point, we have not gone into the substantive issues on what are the key questions that are being raised in terms of the procedural unfairness that are being alleged or insinuated. These are the issues that we are waiting to have, how do I put it, so that we appreciate it and we have a look at it. But for now, what we continue being fed with are a flurry of applications at this preliminary point in terms of how the court should proceed, in terms of which judge should recuse himself, in terms of whether or not the bench is properly empaneled. You see, we are yet to get into the main issue. But I'm saying if we proceed slowly and get into the main issue, there are certain issues that the people of Kenya will learn from this particular proceeding. They will get to know what are the key issues that the Honorable Gachagua is raising at this particular juncture. Whether these are issues that are supported, whether these are issues that are making sense, and what will be the finding of this three-judge bench. And you see, Michelle, we're in a time whereby this is a very open court. The media is following. The people of Kenya are able to see word for word what this particular court is doing and how it's able to operate. It's a court that is happening during the day hours. It is unlike the Moi regime when certain courts were able to even proceed in the evenings. So the media is doing a good job in terms of bringing to the people of Kenya at their doorstep what is happening within the court corridors. And you know, that tells you how much of a magnitude of public interest centered this particular case is. Also, how much these three-judge bench have to conduct themselves in this particular matter so that they attract and ensure that the people of Kenya have continued trust and faith in these court cases. And you know, it's a monumental issue, as I've said. So even as the people of Kenya are following, when we get into the issues of substance, issues of questions that the Honorable Gachagua is raising in this court, which most likely are questions of fair hearing because he was not afforded that particular aspect in terms of his absence from the Senate and what have you, we want to see what the court will make out of that. We also want to see what the Solicitor General and the Attorney General are raising, the question of the jurisdiction or whether or not the court should entertain these kind of petitions. It's a very important thing. Is the court going to say, look, Parliament has a role, and we also have a role in terms of how these particular constitutional provisions are complied with. So these are the issues of final outcome in terms of how we are going to see things are going to proceed. What I'll say is how this particular petition is handled, how the impeachment process has been handled, how this particular challenge by Gachagua is entertained in court is going to be a very important litmus for us as a country in the event we shall have an impeachment of a president. You know, it is even important that we have started with the impeachment of a president so that we're able to build our legal foundation or the knowledge in terms of how the court is able to conduct itself and also how our parliament is able to conduct itself. Because these are offices of very senior positions. Imagine today, had we started with the impeachment of a president, all of a sudden, let's say our president was impeached. And it's a very important stage whereby we have never been faced with such an issue under our 2010 constitution. So it's a learning curve for us. It's also good for the judiciary. It shall build its jurisprudence. The students of law are also following, the media, the people of Kenya are following, so that in the event a president misbehaves or contravenes the law and our houses decide to also impeach him, and someone, let's say, challenges that in court, we shall be having a lot of fodder in terms of content and knowledge to borrow from on how the outcome of this particular process shall be. So today, today is a very important stage. the question of consolidation, the question of recusal, then the question of key directives in terms of how the end application to have these particular conservative orders to be lifted shall be, at least directions shall be given on that. And that shall set the pace in terms of how the next court proceedings shall happen. And you know, yesterday I saw the Senator Ojenda, who is representing the Senate, who actually said, look, Your Honor, we only seeking for 30 minutes to submit on the part of the National Assembly, the Senate, so that they're able to bring it out why they think this particular court order should be lifted or set aside. So I'm saying it's not an issue that in my view is going to take so much time. Rather, today is a very important stage because these preliminary applications, the question of recusal, this question of consolidation shall be determined so that now we're able to proceed on to the germane issues in terms of what is before this court. We are yet to appreciate and see that. Okay. So when we see that, it shall be an issue that we will be keenly following and we'll await the final outcome of this particular court proceeding. But most importantly, it's also important that we don't persuade the people of Kenya to lose their faith in the judiciary. It's a very bad thing in terms of when now we talk about unfairness or biasness. That's also a very bad issue because at all times, these two gentlemen and the lady, we know that they're up to task. We know that whatever outcome or determination they're going to bring is very open. When they're reading, the media is following. If you lose it or if you're not comfortable with it, you can pursue your line of appeal at the Court of Appeal. So if our country's democracy has been nurtured to that extent, it is not fair for the people of Kenya to be fed with vitriol in terms of how our courts are not being faithful or being honest in terms of how they're conducting themselves.
Titus, just borrowing from that, what in your view so far in this process are the lessons that the country ought to have learned? Because it was definitely a legal first, not just in Kenya, but really on the continent. What are the lessons that we ought to have learned so far with regard to the impeachment of a deputy president, perhaps even a president?
Now, political processes and political issues definitely will lead to legal issues. And what the take-home lesson that Kenyans and every person that holds any public office needs to learn is that when you embark on a political issue, for instance, if you want to remove a deputy president, a president, a governor, you have to ensure that you are complying with what the law says. Fidelity to the law is not an option. It has got no exception. You have to ensure that you comply, because if you don't do that, then the legal process will kick in and you'll be tired down, and at the end of the day, everything that you have done can be declared null and void, which will now take you back to the position that you ought to have started rightly. So anytime you engage in any political issue, ensure that there is compliance with the law, and most importantly with the Constitution, so that everything you have done does not end up being a mere misfire. Yes.
Politically, of course, we've spoken about the possible shake-up within parliamentary positions, but within the UDA party, there's talk of a plan to oust Gachagua as the UDA deputy party leader, which of course he isn't, as he fights for political survival, of course trying to ensure that he can run for elective office after this impeachment saga. How do you see this playing out, considering that Gachagua does have quite a huge, support base consolidated within the Mount Kenya region?
Now, the process of removing Gachagua as the deputy party leader within the chains and ranks of UDA is another legal process that has to be commenced according to the constitution of UDA. And I do believe that UDA as a party has a dispute resolution mechanism by way of tribunals that sit within the party. And if there is that intimation to remove him, then cogent and sufficient reasons need to be adduced before he can be removed. And even before his removal, he has to be given a chance to defend or to give a rebuttal as to whether he wishes not to oppose his removal or he wishes to oppose his removal. And at any point, again, the law, the constitution is not adhered to, the issue may find itself again in the court, in the High Court, because remember the party tribunals do have a jurisdiction to listen to such kind of causes of action in the first instance. But any aggrieved party still has a right to approach the High Court to challenge any decision if they so feel that the process or the decision has been reached in an irregular and unconstitutional manner. Yes.
And even as this happens, of course, the question of Kithure Kindiki, whether he has resigned as Interior Cabinet Secretary, still lingers. It's not a resignation that has been announced, or something that has been announced to the public. But there is already talk on who is likely to fill the seat of Interior CS should he be sworn in as the Deputy President. Suleiman, what are your thoughts, first of all, on the Interior docket, Kindiki's tenure in it, and who is likely to succeed him should he be sworn in as Deputy President?
Well, you see, Michelle, when you look at our Constitution, Article 149, where arises a vacancy in the office of the Deputy President, we have given that particular choice to the President. He's the one who is making for us that particular choice. That means it's a political choice. That means he has the leeway or the opportunity or the chance of coming up with the person who he thinks shall serve as the Deputy President of our country. In the event, the case of Gachagua, in the event, if we look at the side of Kindiki, there's an opportunity or a vacancy that shall arise within the Ministry of Interior. Again, he shall have the opportunity of coming up with who fills that particular docket. So it's a choice that we have given and power. It's a choice and power that we have donated to the President to be able to exercise on our behalf. But now, in terms of how that particular power is exercised, is subject to certain checks, including at the parliamentary level. In other words, he cannot just wake up one morning and name a certain party and that person just goes and sits in that office. No. There's a reason as to why the Constitution has given him the power to nominate and our Parliament the power to offer certain checks over that particular choice and nomination of that particular individual. So when it comes to the docket of both the Deputy President and the Interior Ministry, it is our National Assembly that is supposed to vet and at least have a look at, consider this person. Is this person worth holding this particular office? Does this person have the requisite resume in terms of how he or she is going to discharge this mandate? Does this person meet the requirements or tests under Chapter 6 of the Constitution? So it tells you it is not an absolute power that can be exercised by the President. Rather, it's one that there are certain checks or there are certain persons or bodies that have the final say over his choice and decision. So if our Parliament says, no, you cannot hold this position, that is it. If, for example, the bodies that are mandated to clear this particular nominee, let's say the ACC, says that, no, you do not meet Chapter 6 of the Constitution on integrity, it means this person shall not proceed as required. In other words, our Constitution is one whereby it anticipates or expects institutions that are very strong that shall undertake their powers and mandates according to the law as required. The aspect of independence in terms of decision making is what our Constitution envisaged, in the sense that if you nominate someone to be the Interior CS, we expect the EACC not to clear this person if there are certain integrity issues. We expect the CRB, if there are certain issues, to have a look into this person. So these particular bodies that we expect to offer certain checks and ensure that this person meets the test on integrity is one that our Constitution anticipated, so that if this person doesn't meet those particular requirements, the President can be told, look, this person doesn't meet the threshold, can you bring us another person, an alternative, until we get the person who is most suitable to hold that office. So it is also our expectation that with time, even as our democracy matures, that we shall get into a stage or a scenario whereby these particular independent offices shall be independent enough to undertake their functions. This particular independent office I'm talking about includes the IBC, includes the ACC, very important offices, and also our Parliament. So if we have very clearly defined roles or institutions that understand their mandate, that can tell the President, no, you are wrong on this particular choice, we will be somewhere as a country, not institutions that just rubber stamp whatever the President brings in. You see, the biggest regret that we have is when we were faced with the impeachment of the Honorable Gachagua, even when the impeachment motion was brought to the National Assembly, we as a country, we were at a point whereby we were asking ourselves, who is going to assume this particular office of the Deputy President? It's very unfair. This person is yet to be tested. This person is yet to stand his trial at the Senate.
Right.
We are yet to have a serious finding on this particular person, yet we already know, or we are already anticipating a new person from a certain region, and that particular person, when he leaves that docket of interior, who is going to fill the interior, you see, that is where we are as a country. But I'm saying we are hoping, or we are hopeful, that we are going to find ourselves in where the Constitution has expected or envisaged that we shall be as a country.
Mm-hmm. And a lot of politics over the deputy presidency or the seat being filled by a person from a particular region. We'll be discussing that. But Titus, the president, William Ruto, right now, finds himself with mounting legal and political battles, many of them in the court. The impeachment case against the DP is one. But later today, we'll actually have the courts make a pronouncement on the matter touching on the Social Health Insurance Fund. We also have a case in court challenging the decision to lease JKAA to Adani Group. We have a case in court challenging NGCDF, which was declared unconstitutional. MPs really pressuring the president to have it entrenched. What do you make of the state of President William Ruto's governance of the country at this time, especially with the mounting legal battles?
Now, it's sad that the president has found himself fighting so many battles, which effectively have moved him away from the mandate that Kenyans gave him. Because when Kenyans gave him the mandate, they expected that he's going to turn around the economy, he's going to bring down the cost of living, he's going to make life bearable in this country. Sadly, I don't know what happened in between, because he has found himself in a situation whereby he's now dealing with issues which are not even part and parcel of his manifesto. The issue of the DP being impeached, the issue of allegations that foreigners are taking our key infrastructures, and that the government seems to be pushing that agenda. So amid all these issues, it is unfortunate that he has found himself in very difficult times. And I hardly, I doubt whether he's going to succeed in implementing anything that he promised Kenyans. And just like we have seen in history before, Hitler lost the war because he started fighting on so many fronts. He started fighting the Russians, he started fighting the Britons, and in the end, his enemies regrouped and they were able to bring him down. So amid all these issues, it's going to be very difficult for the president to focus on what he promised Kenyans, particularly now that it appears he has cut so many deals, including even with the opposition, because you can see now it is not by accident that the opposition is now demanding for more positions in government. It appears they cut a very serious deal to ensure that the deputy president is ousted. And that can be confirmed by the fact that in the Senate, we saw a lot of footprints of ODM pushing for the impeachment of the deputy president. So it's a very precarious position that the president finds himself. And unfortunately, if these issues continue, they are going to mount pressure on the electorates. It's going to mount pressure on the voters. Remember, he has never addressed any issue that the Gen Zs did raise. And these people are waiting for him in 2027. So in view of all this that is happening, and this is the truth, it's going to be very difficult for the president to get re-elected unless he turns around and performs some miracles, which I highly doubt he's going to do.
And he just likened the president to Hitler.
Yes, he actually likened the president to Hitler.
Interesting
analogy. But earlier, Suleiman, you brought in the issue of the fact that Kenyans have 5 years to audit their elected members of parliament. Interesting debate coming up now, especially from supporters or allies of Rigathi Gachagua, is talk of perhaps increasing Kenya's term limit to 7 years, and not just for the presidency, but for other elective positions as well. And we've seen this with the Senator Cherargei, and it's elicited quite a lot of debate. Then we've had others coming and saying, we actually should reduce it to 4 years instead of the 5 years that we already have. What do you make of this term limit debate, and why is it coming up now in the middle of this impeachment process?
Well, you see, these are classical examples of legislatures who may not really understand the crucial role that the people of Kenya expect them to undertake in that house. But Michelle, if we follow or haven't followed that particular debate of extension or reduction of the presidential or other elective positions term limits, there are those who, like the likes of Cherargei, who are fronting for the 7-year term. I mean, the 7-year term limit. And also, the other ones who, the likes of Karungo Wathangwa, I think he's trying to reduce it to 4 thereabout. You see, one thing we are forgetting is that this is not something that the Senate per se can do. It is a protected provision when you talk about, or when you touch on the term of office of someone in the stature of, for example, the president, or our parliament, or that of the Senate, the governor's office. All these are protected clauses that it's only the people of Kenya who can undertake that particular referendum on this particular question. So I think they're doing this for the gallery. They may be doing this for the attention of the media, or it may even be a scenario of trying to take away our attention from crucial issues that we are following up as a country. Because this is a monumental moment when we are looking at the question of Adani, the question of takeover of our crucial airport, the question of our energy sector. These are the serious issues that the issues we are following up on, the new health insurance fund. You know, let's not be taken away from the real-time issues into issues that are not of substance at all. These particular bills or proposed amendments are dead on arrival because ultimately it's the people of Kenya that have the final mandate. But again, if you look at the likes of Cherargei, you know, we say every dog has its owner. You know, now look at them, see who is behind it. Is it about testing the people of Kenya with this question of extending the term limit? Especially in light of this particular scenario when we don't have the IEBC. Is someone trying to toy with the idea or with the mind of the people of Kenya to say, look, guys, in the event we form IEBC a year to the election, it might need time to build itself as such? Or is that person trying to see our reaction in terms of extending the term of office from 5 to 7? One thing I always like to explain is that when you look at the developed nations, their terms of office are between 4 to 5 years. And equally, the drafters of our constitution have given these particular holders of offices a period of 5 years because they believed 5-year term is a fair time for you to impact the lives of the people of Kenya. It's enough for you to make changes. It's enough for you to implement the policies and the manifestos that you have shared with the people. It's a very reasonable time because it's an average term in terms of how you're going to use it to serve the people of Kenya. But now if you come back to us and now bring in the discussion on let's extend the term from 5 to 7. If I look at the example of President Ruto, I think he's so far been into office for a period of more than 2 years. But you know, the gentleman has just been a total mess in terms of how he has been steering the affairs of the country. When you find every issue that you front is being challenged in court, governance questions are brought up, the question of transparency, accountability, and openness are issues that are flouted in court. You know, they are serious issues that you must ask yourself as a person. So it's a failed regime, but the question of seeking for extension of the time limit is neither here nor there because it's the people of Kenya that shall have that particular power in terms of a referendum. Which referendum is supposed to be undertaken by the IEBC, which IEBC, Parliament and the President have deliberately ensured that it's not in place. So we can't even discuss that at all.
All right, perhaps we're looking at a different definition of state capture altogether. We have live pictures from the Milimani High Court there, where the 3-judge bench is expected to begin the deliberation and the consolidation of the more than 30 petitions challenging the impeachment of Rigathi Gachagua. We are following closely and we'll take you there live once the proceedings begin. But Titus, I'd like to get your thoughts on that term limit debate and why really it is coming in the middle of this impeachment debate, do you think?
Now, this issue of term limit has been in the public for debate for quite a while. And very conspicuously, Cherargei has been pursuing that aspect for quite some time. It has not started now. But most importantly, whatever Cherargei is trying to push, definitely there is someone behind him. Because I know Cherargei very well, way back from campus. And all that he's trying to do is, as my colleague here has rightly said, it appears it's a diversionary tactic. Why accelerate the issue of term limits, yet we have very serious issues that the country is facing? The issue of Adani, the issue of our health sector, the issue of the cost of living, the issue of, trying to ensure that our economy is stabilized, which things the president and his regime have not taken any deliberate steps to ensure that they remedy. So for me, I find it as a serious gesture. It is a joke. It is a diversionary tactic, which is meant to take away Kenyans from the serious issues that they are now facing. And a good example also is a reaction by the Senator of Kiambu, now trying to say that because Cherargei is proposing this, 7 years, I'm also going to propose 4 years, based on the fact that at the moment he is sensing that the position that he holds in the Senate is going to be taken away. I will ask a question. Would he have brought that proposal if there was assurance that he is going to continue holding his position? Definitely not. So these are theatrics and these are gestures that we do not need to allow ourselves to fall into, because these are not serious issues, but most importantly, they are not going to see the light of the day because Kenyans have to decide whether they want to extend the presidential term limits or not, through having had the process through IBC, which they themselves have deliberately refused to put in place. So for me, these are sideshows, these are diversionary tactics, which are aimed at dissuading Kenyans from the real elephant in the room.
All right, and many, of course, looking at President William Ruto with regard to the future of the governance of this country, because the message or the idea that Kenyans had been given is that Rigathi Gachagua is the problem within the Kenya Kwanza administration. And so now that they are weeding out the problem, Kenyans are looking at the Kenya Kwanza government with what then? With what next in terms of delivery? But what, in your view, Suleiman, does this entire impeachment say about William Ruto, the politician? Because insiders say this impeachment was planned in secrecy months ago. And when the plan went rolling, we saw it done at record speed, very well coordinated. The inter-institutional coordination is unlike anything we've seen in Kenya before, when we need institutions really to work together. What does that say about Ruto, the politician?
Well, you see, generally, an impeachment is a tool that has been given to Parliament to invoke when they abhor the conduct of someone who is in a certain high office. But again, we have all agreed that this particular impeachment has the blessings of the president. That is not in question. It has the political support from the top boss up there. But now, the other issue is, what does it say about our president? It's a very important question in the sense that our president was the deputy to our former president, that's President Uhuru Kenyatta. Especially during the second term, he has had a serious fallout with the office holder at that time, that's President Uhuru. Did President Uhuru initiate such a process in terms of having him removed from office? No. Has President Uhuru tried to undermine the place of his deputy at that time? No, he just left his deputy to do whatever he was doing at the time. But now, towards the election, and I've seen these particular interviews many times that are being played by the media houses, we have seen a scenario where our president kept on saying that I shall not treat my deputy the same way I was humiliated by my former boss, which is okay. That's a political statement. But now, come to the persona of someone called Rigathi Gachagua. In terms of who steers the affairs of our country, is a deputy president a specific person who our constitution says, can you do a specific role? No, not as such. He's merely the personal assistant to the president. I do not see how we will be of an impediment to a very efficient president, if we had any. I do not see how he will be of a thorn within the flesh of the president, which I don't see as such in my personal view. So what I'm just thinking is, this is just political enmity that has emanated between the two persons. It is an issue whereby our president could no longer be patient with his deputy, either for political or for personal reasons. If he has decided to use his parliament to remove his deputy, it's a very new scenario to the people of Kenya. And again, when he removes him, are we looking at a scenario whereby he's now telling us that I'm going to replace this person from the mountain with another person from the mountain? Where does this place us? Is he also being a bit scared of in terms of how the mountain is going to shift politically? In essence, true, it is, because many are already arguing that the mountain is gone. But in terms of how he has treated the deputy, you see, Michelle, out of all those particular 11 grounds, when I had a casual look at it, I could not pick out one that is gross. And this is why the question or the wording of the word gross has been used in our constitution. When you look at the famous case of the former Embu governor, Martin Wambora, the court has tried to give some meaning to the question of gross. And it has actually hugely borrowed from a very famous Nigerian case in terms of what should constitute gross. Because there's a reason or there's an essence as to why the Constitution talks about gross misconduct, gross violation, gross contravention, what have you. Have all those issues that he has done, do they meet that particular threshold? Indeed, our parliament, that's the National Assembly and the Senate, were not able to discuss that very important question. I expected the senators and the National Assembly members to say, guys, are these particular 11 grounds that he's said to have violated, is any of them gross? So in short, I do see a deputy president who has been taken through a political process of an impeachment, which has had its final endings, which is having its final death, and which will give the president his new choice in terms of a deputy. And we know that the president has close to 3 more years to be in office. And we know that the president cannot come back to us and tell us, guys, in 2027, he can't at that time tell us that I wish I had served the people of Kenya in a certain way or in a certain fashion, but I was frustrated by my deputy. No, that's not how the law has been drafted. The deputy doesn't have the powers to put you in a certain scenario as to affect how you serve that particular office. In short, we do see a president who has been impatient with his deputy, who has gotten rid of him, who now will have possibly a deputy of his choice. But if he runs things the way they are, I always say that President Uhuru's regime has been a problem, but I find this particular regime to be horrible, for lack of a better word. But I know that this regime again has 3 years to go, close to 3 years. It's a good time for them to do a turnaround and affect and improve the lives of the people. But in essence, you find the people of Kenya always having one darling in terms of protection. That's the court. Chief is in court. The question of Adani is in court. The question of the energy sector takeover is in court. The other day, the housing issue was in court. When you find every step in terms of your constitutional governance is being questioned by the people of Kenya, you have to at least re-engineer yourself. Ask yourself serious questions. Raise key issues. When you find the young boys and girls, those who are educated, the elites, who are protesting, who are attacking our parliament, you approach them, address the media, fire your entire cabinet. A week after, you reinstate 3/4 of your cabinet. What kind of a president or what kind of an image are you sending to the people of Kenya? Which is why I'm saying the people will have their opportunity to audit him when the time comes. But now that we are forced to live by him, and now that we don't have a parliament that will also remove him, because he seems to be in control of that, we expect our president to at least do something about how he steers the affairs of our country. At least things will be better for the people of Kenya, because it's a very lovely and special country that is at the heart of the people of Kenya. They don't expect someone in that office to mess it up, which is unfortunately doing. You don't bring in foreigners to take over your national key assets, and you don't kill your own people. You don't engineer or you don't promote the aspect of enforced disappearances. I was watching this particular media house last night. How many cases of deaths of people who were killed in very strange scenarios were reported? How many Kenyans are missing? Do we have a serious report? Now, the KNCHR does its own report. You are a president, you come to the media, and now you try to attack that particular institution. So it's a very, very grim situation that we have lived with, but let the president at least re-engineer his politics, his economics, and let him give the people of Kenya a better economy in terms of how he does or how he runs the country.
And Titus Suleiman says President Ruto will have his day when the people of Kenya get to audit how he has steered the country over the last few years. But I guess the big question then in this whole impeachment saga would be, what is the true value of the deputy presidency in Kenya's politics? Is it a position that can wield any meaningful power? Is it a position, though envisaged in the Constitution, is it a position that the country really needs?
Obviously, the position of deputy president is important in the aspect that and the Constitution has given the definition of the role of the deputy president. Role number one of the deputy president is to deputize the president, or in the absence of the president, then the deputy president assumes office. So it's a it is a position that has been envisaged in the Constitution deliberately to provide transition. In the unforeseeable instance that the president is not there, then the deputy president takes over charge of the country as the president. So we can't really say that that position does not serve any purpose, particularly now that by the very nature and definition that has been given to us by the Constitution, that the deputy president has to wait for duties to be assigned to him by the president, or to wait until when the president is not there. it is something that gives a picture, a picture of what happens in an unforeseeable instance where the president is not there. So it is important, and all over the world, we have borrowed, comparatively, we have borrowed from other jurisdictions. The position of the deputy president is indeed important for Kenyans.
All right, and we have live pictures on the screen there from the Milimani Law Courts as that three-judge bench is expected to begin the hearing, or at least discuss the consolidation of the more than 30 cases challenging the removal of Rigathi Gachagua. However, the hearing of those 30 cases had been delayed as Gachagua's lawyers continued to question the empaneling of the judges, a decision that was reached at yesterday, with the judges saying that they were properly empaneled. But as we speak right now, Attorney General Dorcas Oduor, as well as Parliament, did urge the court to hear their application, which seeks to set aside an order preventing the Interior Cabinet Secretary Kithure Kindiki from assuming the DP position. And the argument is that the three-judge bench empaneled there by DCJ Mwilu was empaneled solely for hearing the application seeking to lift the order to block the swearing in of Professor Kithure Kindiki. And this is a legal battle that we're expecting to play out in the Milimani Law Courts today, even as the judges are expected to debate on the issue of their recusal from the bench for alleged bias by lawyers representing Rigathi Gachagua. So that's what you need to know so far this morning as we wait for those three judges to make their decision. In the studio with us, lawyers Suleiman Bashir and Titus Mahanu, looking to put it all into context for us. We'd like to invite your comments as well. Do speak to us on our social media channels at NTV Kenya. We'd like to hear your thoughts on the impeachment process so far. What concerns do you have? What questions do you have on this process as well? And even as, you know, we wait for the three judges to come out, Suleiman, like you mentioned earlier, this is a huge litmus test for the country as a whole, because it's a learning moment. But for the judiciary, it is an especially, you know, serious litmus test. Many, of course, had looked at Martha Koome really to make a decision when it lied with her. How do you think this entire process is likely to influence the perception of the public with regard to the judiciary? Well,
we know it's a good time when the people are able to follow live what is happening in our courts. Cameras are there, things are open. The only thing that they will not be able to see is when the judges retire back to do their rulings or judgments. Which rulings, which even if they do it at the back there, they come back and read it before the media, for the people to consume. And those particular rulings and judgments must have reasons or basis upon which they shall have reached that particular decision. So I think it's a very good time for the judiciary to also prove and stand up to the point and test and show that indeed as a judiciary we are being fair and we are doing our process, our jobs or our work as required. Again, one thing that is also important to explain is when we talk about the question of those particular ones, especially from the government side, especially the Parliament and the Attorney General, who are hell-bent on having these particular orders lifted, it is a practical issue to explain in the sense that when one goes to court and you get a court order, the other party can come back to the same court, do an application, explain to the court why that order should not be in place. And in explaining that, that particular person must explain the problems or the challenges, that the unfairness, the prejudice that that order will cause. And I think that is what the court is trying to look at. So the side of the National Assembly and the government, the Attorney General, the Solicitor General, they're just trying to tell the court, for as long as this particular court order is in place, it is not fair to have it. Put it aside, vacate it, then we can proceed with this case. That's what they are trying to prove. And the court will hear them. It will also give some time to the side of Gachagua and the rest, in the sense that they'll be asked, do you agree, or why do you want your order to still be enforced? They will also have to explain in the sense that these orders are the ones that are now preserving the status of the office of the deputy president, in the sense that if someone new assumes it, it will be an issue that shall be overtaken by event. Then once both sides submit, the court shall be able to retire back, compare the two arguments, and make a final determination. And this being three we know it's a very odd number in the sense that they'll be able to note down their rulings. They have their own mechanism and ways of working together. When they emerge and appear back to the people of Kenya, we shall know what position they shall have taken, and we shall know what grounds or basis they must have predicated the arguments upon. And when that is now evaluated, it's an issue that the people of Kenya shall be following from the start up to the last. And I've noticed actually that because in every forum that we even ourselves as lawyers find in, we find Kenyans now debating the question of the deputy president, the impeachment process, the legality, the possible outcome of court. So this tells you it's a very live issue, and it's very important in the sense that the people of Kenya are alive to what's happening. They know what the constitution talks about. They know what they expect. There are certain expectations in terms of faith and trust and rationale in terms of how this particular decision shall be reached. But what is very important, again, to the people is, even as we follow them, this particular decision is going, some will be happy with it and others will be uncomfortable with it. Those who are not comfortable with it, at the end of the day, are supposed to also exercise some restraint in the sense that they know that this is the position of the 3-judge bench. And if we are not comfortable with this, the appellate procedure is open to us. So in short, it's a learn and also being patient process. It's a process whereby you know that if you're not comfortable here, you can try your luck upstairs at the Court of Appeal. It's a process whereby you know that in the event it goes the way of the government, the Attorney General, or the Parliament, we know that we shall have a new deputy president. So it's a wait and see game. But I most sincerely appreciate especially the role that the media is playing in bringing these particular live issues to the people. It's a weighty issue. The people are following. They can see what's happening. So they will be able to judge that for themselves. And they'll be able to know who argued well, who made sense to them, and how these particular judges were able to make their final determination or decision on this particular issue. Yes.
All right, and of course, we are to understand what's causing the delay with the judges at the Milimani Law Court. We have live pictures for you there on the screen. Titus, just before we take a break, what are your expectations from the proceedings today? Because, even as we speak, anytime, Tom, Dick and Harry really can walk into any court and file another petition, and they have the right to have their petition heard if it has to do with the impeachment of Rigathi Gachagua. So what are your expectations for the court proceeding today? Are we likely to move forward, or is it just the legal ping pong we've seen play out for the last 2 days?
And I think that is that question, that the issue that you raise is one of the issues that probably we may start to ask ourselves whether there is a lacuna in the Constitution. Because remember, in the presidential elections, after every general election, there is always a time frame within which any aggrieved party is required to file their petitions or references in the court. But this is a very a new situation we are dealing with, very unprecedented in our country, because for the first time we are having a deputy president being impeached.
All right. Titus, I'm sorry to have to interrupt you. I understand we have to cross over live to Nakuru, where President William Ruto is attending the groundbreaking for the Menengai 3 geothermal project. He is live in Nakuru. Let's cross over and listen in.
Vehicles that use fossil fuel, and we will be using more of our generated energy from geothermal and other renewable resources to power our transport sector, our cars, e-mobility, and all the other interventions that we are working on. So kwa watu wa Nakuru, nataka niseme asante sana kwa kutukaribisha hapa leo. Nataka niwahakikishie yale mambo yote tumepangana pamoja na nyinyi, tutayasukuma isonge mbele. Hii program ambayo ni uhusiano kati ya private sector na serikali ni ya muhimu. Najua bado mnangojea kwamba kutoka hapa kwenda Nairobi bado ni shida kubwa sana, kwa sababu ya barabara imejaa msongamano wa magari, kwa sababu magari imezidi. Mimi nataka niwahakikishie ile kampuni ya Ufaransa ambayo ilikuwa imepatiwa kandarasi ama ilikuwa imetoa PIP yake kutengeneza hiyo barabara, wamekwama, na sasa tumewaambia waondoke ili tuweze kutafuta kampuni nyingine, kwa sababu barabara kati ya Nakuru hapa Mau Summit na Nairobi lazima tuifanye iwe dual carriageway, ndio watu wa Nakuru na watu wa Western Kenya waweze kwenda nyumbani bila ya matatizo ya jam ambayo sasa tunaona imezidi katika hiyo barabara. Mimi nitashirikiana na viongozi wenu wa county katika kutatua jambo hilo, tuweze kutafuta kampuni mpya ambayo itatusaidia kupeleka kazi yetu ya maendeleo mbele. Kwa hivyo asanteni sana, nimeshukuru sana kufika hapa siku ya leo, na mimi nataka niwaulize sote tuweze kushirikiana na kufanya kazi kwa pamoja. Tena, when are we signing the agreement? Now. Haya, mimi nataka kuona hiyo agreement kwa sababu nangojea fertilizer. Mimi ni mkulima. Nataka hawa wakulima wengi wanangojea hii fertilizer kutoka geothermal itafika lini. 24 months tutangojea na tunahesabu kutoka leo. Very good. Asanteni sana na Mungu awabariki. Thank you very much.
Tumpongeze Rais tafadhali. Your Excellency, the signing will be happening there. We'll request that you'll witness. So at this point...
There is President William Ruto live from Nakuru speaking at the groundbreaking of the Menengai Geothermal Power Project, an ongoing energy development project at the Menengai crater in Kenya, which has the potential to generate up to 1.6 gigawatts and is anticipated to be the largest geothermal field being developed in Kenya. We'll be bringing you more details on that, even as the controversy surrounding Adani's deal with Ketraco and the energy sector in Kenya still continues. But in studio with us, we have Titus Mahanu as well as Suleiman Bashir, lawyers, helping us put into context the legal showdown going on at the Milimani Law Courts today with the impeachment of Rigathi Gachagua. Gentlemen, I'd like to take a short break, but let's get your final comments. Titus, I'm sorry I had to interrupt you there. Your final comments on what you're expecting and whether the legal ping-pong is likely to continue for the rest of the day.
Now, as I was saying, we have found ourselves in a situation where there are no time frames within which anyone can file a reference in the event that they are aggrieved by this process of the impeachment of Gachagua. And make no mistake, any Kenyan out there who feels aggrieved by the impeachment process can file a petition against the whole impeachment process. So it's not just Gachagua himself. So that is the lacuna that we find ourselves in. And I will be keen to see how the court will be able to handle the whole issue, particularly if now we have fresh petitions beginning from tomorrow that are raising the same questions. And those parties also have the right to be heard. But most importantly, I think the lesson that we have also learned from this whole process is that courts in Kenya are the only active institutions that are working. And anytime you hold a public office and you come out and castigate, you know, you impute improper motive on courts, be rest assured that the time will come when you will run to the same courts. We know very well that Gachagua has been on the forefront with his onslaught against the court, you know, castigating the courts, being full of people who are not doing justice, especially if the courts rule against them. So it is a high time that Kenyans also understand that we need the courts and we need to support the courts. And when the courts ask for further funding from the government should do that, because today it could be Gachagua, tomorrow it could be the president himself being impeached, and he will be running to these courts. We saw it with the former president. At one point he said that the courts are full of wakoras, but when his children had issues in court, he ran to the same courts. So we need to learn to support our institutions and have faith in our institutions. That is the lesson that Kenyans need to understand. Particularly these people who are in government right now, holding big offices. They need to respect the courts.
All right, I'd like us to take a break. We still are following up on the situation at the Milimani Law Court as the three-judge bench is expected to come out and begin the process and deliberation of consolidation of more than 30 cases later today. We'll be keeping an eye on those developments and give you updates as and when they develop. You're watching NTV. Take a short break to stay with us. Much more still to come on the other side.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Babies play around and then, oops, Morphix ina-absorb like whoop. Imagine, haiwezi leak in 50 different movements. Makofi to both babies and Morphix. Renewed Morphix, ultimate quality.
Sema ukweli. Pauline needs to know, and she deserves to know that her mother is alive.
Okay, basi Pauline yuko wapi?
Ndio huyu hapa.
Hai.
Acquisition contract of Lil Rose. Dana amepata pesa wapi?
Twende wapi? Twende ba. Wewe, twende. Hey, enough. Umenitaka unionyeshe vile you can cause a tantrum or what? Wewe umesahau ID yako? Sijasahau.
Where did you come from?
Come with me. So this is where the magic happens. This is for you kids.
Taste the magic with our festive cakes from DPL Festive Bakery. Delight with every bite.
Just to try and explain who God is in our lives. As you can tell in the lyrics, I've captured different creatures and how they, acknowledge who God is. He is God all by himself. He created everything. I even talked about the stones, me not giving the stones opportunity to praise him, yet I'm alive. Okay, so I'll use every strength I have in my lungs to praise him. Amen. The Skiza chord, kindly subscribe to it and get to Tukuzwe as your Skiza tune. Thank you so much for your support.
Skiza, Nan Nation.
My name is Elias Kemboy Chelimo, a champion 2022 Nairobi Standard Chartered. I will be competing on this year edition. Watch NTV live.
Please don't ask or remind Nikolai about the wedding. We don't want him stressed.
Let me be clear to you, Kelly. No matter how you look or what dress you wear, no matter what dishes you cook, you can never be like her. You will never be Adele. I can never marry you.
All right, then don't marry me!
Are you two fighting again?
Huh. Well, it's because Adele over here is blaming me for what happened to Nikolai.
It's me, okay? It's me. It's me. I'm the one to blame for this. Okay, are you both happy now?
Where did you come from?
Come with me. So this is where the magic happens. This is for you kids.
Taste the magic with our festive cakes from DPL Festive Bakery. Delight with every bite.
Unahitaji msomaji habari aelewaye matukio na matokeo ya matukio?
Michezo hutegemea hewa safi.
Msomaji habari mweledi wa majimbo.
Pastor County ya Turkana.
Msomaji habari mweledi wa masuala ya kanda.
Nataka nisikie vile wewe kwanza unasikia.
Msomaji habari mweledi wa masuala ya ulimwengu.
Hapa jijini New York nchini Marekani.
Msomaji wa mtagusano, mvuto, mnato na haiba ya kuaminika. Habari zako za NTV ya dhuhuri zimepata sura mpya.
Mimi ni Lois Wangoi. Kila siku, kila wiki, kila tukio. Saa 7 adhuhuri kwa taarifa kuntu, tendeti na za kuaminika ni NTV adhuhuri.
Want to know the biggest story of the week? Do not worry. The Weekly Review got you covered. For in-depth analysis of politics, business, governance, as well as social issues, the Weekly Review covers it all. For well-researched, exclusive and investigative content, read the Weekly Review every Sunday in the Sunday Nation.
What is happening in your life is demonic machinations, is satanic attacks which are attacking you. So they are downsizing you to make you feel you are useless. You are not useless. In heaven, when God is looking at you, He's seeing a millionaire, He's seeing a president, He's seeing a businessman, He's seeing a leader, He's seeing a visionary, He's seeing a great man, a great woman. May you be the one in Jesus' name.
Kwa majina naitwa Ronald Kemele Korkat. Ninashiriki Standard Chartered hii mwaka on 27. Naomba watu wa watch live on NTV.
Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Good morning and thank you for staying with us here on NTV as we bring you live coverage from the corridors of justice as the more than 30 cases challenging the removal of impeached Deputy President Rigathi Gachagua are set to continue at the Milimani Law Courts this morning. This even as lawyers representing Rigathi Gachagua plan to appeal the ruling by judges Eric Ogola, Anthony Mrima and Frida Mugambi yesterday with regard to the empanelment of the bench by Deputy Chief Justice Philomena Milu. At the same time, the Attorney General Dorcas Odwor, together with Parliament, have urged the court to hear their application seeking to set aside an order preventing Interior Cabinet Secretary Kithure Kindiki, now the Deputy President-designate, from being sworn in and assuming the Deputy President position. And on top of that, even as Gachagua's lawyers say they will appeal the decision by the three-judge bench, they have insisted that an application seeking the recusal of the bench is heard and determined before any other matter proceeds before the court. The court was to see it from 9 a.m. this morning. It is just about 11 a.m. and the judges have not appeared yet, although there is some activity in the court with the lawyers representing both sides present at the court ready to debate the matters. We'll be bringing you live coverage of those proceedings as soon as they began. But let's touch base with what Kenyans feel of this, about this entire impeachment process that is now dragging on in the courts. Our reporter Judith Cherono joins us live from Kisumu. Cherono, thank you for joining us this morning. The entire impeachment debate has elicited varied reactions across the country. What do residents of Kisumu have to say this morning?
A very good morning to you, Michelle. I'm coming to you live from Kisumu City, and I'm joined by residents who are eagerly waiting for the ruling of the court case on Gachagua, that is the ousted Deputy President Rigathi Gachagua, which is ongoing now in court. And without wasting time, let us now go straight to this so that we can hear the reaction of residents from this Kisumu City. Sir, welcome to NTV. I would like you to introduce yourself and give us your views on the case that is going. What is your anticipation, or what are you looking to see after the ruling that is ongoing right now regarding our ousted Deputy President Rigathi Gachagua? Thanks.
Thank you so much. My name is Isaiah Onyango. I'm a resident of Kisumu. I've been a leader here. First, I would say that the issues of Rigathi Gachagua, the former vice president, one, even if we decide that Honorable Gachagua goes back to his work, he will not work with this boss because of the issues that has arisen. One of them is he anticipated that he wanted to be killed. So somebody who wants to kill you, you cannot work together again. So that marriage is gone. Two, even if he goes back, he's too tribalistic. He has channeled the other tribes as if they are not Kenyans. He's working as if he is the only tribe. And that one makes other Kenyans very furious with him. So I would ask the court, if I were the judge, I would say, remain a Kenyan, remain a loyal citizen of this country, look for another job, so that the country can move. Because we are at a crossroad now, this country cannot move. People doesn't know if we have a vice president or if we don't have a vice president. But even if he goes back, he will not work. All the workers in his office have been closed out. So it means let him look for another job and wait for 2027. All the things will be all right. If he is good, if he is truthful as he is alleging, then everything will be good. Lastly, let him respect other leaders. I heard he was talking very bad with Raila when they were in Nyeri. If I were the MP, I would have, by now Gachagua would have not been there. I would have voted for him to be impeached. So let Gachagua go home.
Thank you very much for your view. Sir, thank you for joining NTV. What in the event that the judges ruled on Deputy Gachagua's favor, what would be the reaction according to your views? Start by introducing yourself.
My name is Jojo Kwach. I'm a businessman in this town, come politician. What I can say concerning if the court can rule that Gachagua can continue with being a deputy president, then it is not bad. But what I know, they will not work, because deputy president is not a deputy governor. When the president doesn't want to work with his deputy, you can't force him to work with somebody he doesn't want. At the same time, Gachagua has proved himself to be a tribalist, because the way he was talking, as if Kikuyu are the only tribe in this nation, that is not good. We are all Kenyans, and all of us, we are taxpayers. I can remember one time Gachagua told the Minister for Infrastructure not to make roads in those who did not vote for them. So the contractor was removed from our road of Mamboleo to Moroni Road because of Gachagua instruction. So Gachagua is a Kenyan, he's our son, we love him, but he should take his time and think what he should do. Thank you.
Thank you very much. Sir, listening to what your colleagues have said, what is your own view on this ongoing case?
In this ongoing case, my name is Peter Mondowar, and I'm the Speaker of Kisumu County Information Network, and I'm a business here in Kisumu. The only thing I can say for now, as we speak, as a nation we are in a crossroad because of the things that are happening. And my opinion is that Gachagua should know that it's not only him, he's a Kenyan. We have so many Kenyans who can be in that office. Because Gachagua was given an opportunity to serve the people of Kenya. And the way he was behaving was like he's only the one who must be in that office. Because Gachagua was talking as if he's in heaven and we are here in Kenya. And Kenya is just a small thing in the world. So we are telling him, please, in fact he could even have resigned long time ago, because there's no way that they will work with the president of this Republic of Kenya. Do the things that are in the table. It is not possible. They will not work. So let him swallow his pride and resign, so that Kindiki can take that seat and we continue as a nation. Because there's a thing we heard that kufa dereba, kufa abiria, kufa dereba, kufa nini, kufa makanga. Kufa dereba and kufa makanga. And in that vehicle, there's passengers. So if you tell us kufa dereba, kufa makanga, it means kufa, those who are in that also. And we are the Kenyans. So if you say that kufa dereba, kufa makanga, it means you want all people living in this country also to die. You don't care of other people. So if there's a way that Makanga can die and leave Dereva and the people of Kenya to remain safe, so be it. So we are supporting his impeachment as the people of Kisumu. Thank you.
Thank you very much. Yeah. Sir, what is your own opinion? Maybe you can start by introducing yourself.
Thank you. I'm Gilbert Obuya, mkaji wa Kisumu, kwa biashara wa Kisumu. Kwangu mtachanganya kidogo. Kwangu kwa Gachagua na kesi yake, Gachagua angesenda kitambo. Unajua kuna vitu za kuharibu time ama kuharibu masaa, kama jana ulisikia kama wanaongea vitu za ati deputy chief justice hawezi chagua majudges wale wanaenda kuongea kwa kesi yao. Hiyo ni kama lawyers wanalazimisha ile kitu wenyewe wanajua inawezekana. That's why somebody has deputy. Na kama una deputy yako anaweza fanya, unaweza kumassign kazi yako afanye hata kama huko. Sasa nawaambia lawyers wasijaribu kuharibu time, wasijaribu kuharibu masaa. Hakuna haja ya kwenda kotini. Gachagua alisema impeach, sasa kwa impeach kwa parliament, kwa senate, sasa tuwameenda kwa court. Court jana pia walisema Philomena Mwilu alifanya vizuri kuwatoa majaji watatu wafanye kazi. Naonelea kwamba Gachagua angesaa aenda, kama angekuwa mtu mzuri angesaa resign hata before akuwa impeach. There's no need to waste time tuingie kwa vitu vingine. Wakenya wanataka wafanyiwe kazi, na kama hawatafanya kazi, attention yetu tumedivert kwa kesi ya Gachagua. Tunaona kama Wakenya it's a waste of time. Gachagua ende nyumbani, hawatafanya na Ruto, manake sasa watapigana. Usaisa mwingine ni muaji alikata kuua. Sasa mtaishi namna gani? Au utafanya kazi namna gani? it's a waste of time. It's a waste of time. Gachagua, go home. Thank you.
Thank you very much for your views, sir. Those are just a few views from the residents of this region. Michelle, we will keep our eyes glued on the television even as the ruling unfolds, and we will bring you more details during our subsequent bulletin. Back to you in studio.
Many thanks, Judith Sharon. They're live for us from Kisumu. Residents of Kisumu giving their views on that long-drawn impeachment saga that seems to have stalled in court with the several petitions coming up. So the High Court will today decide whether it will lift the orders barring the swearing-in of Deputy President-designate Professor Kithure Kindiki today. The government side has already made an application before the three-judge bench seeking to have the conservatory orders issued by a court in Kerugoya set aside. And as NTV's David Mudhoka reports, should the High Court lift the orders, Kindiki could be sworn into office on Friday, a move that will force impeached Deputy President Rigathi Gachagua to fight for his political survival while effectively out of office.
In the next few hours, Deputy President nominee Professor Abraham Kithure Kindiki, whose swearing-in ceremony at Uhuru Gardens was stopped in the 11th hour last Friday by a court in Kerugoya, will know his fate. A three-judge bench comprising of presiding Judge Eric Ogola, Judge Freda Mugambi, and Judge Anthony Mrima has received an application from Attorney General Dorcas Oduor that seeks to set aside orders issued by the Kerugoya court blocking Kindiki from taking his oath of office, and will on Thursday afternoon from 2:30 p.m. decide whether to set aside the orders or keep them in place. But before determining whether to pave the way for Kindiki's swearing-in, the three-judge bench will hear another application from impeached Deputy President Rigathi Gachagua's lawyers that calls for the recusal of the three judges. Rigathi's lawyers have insisted that they will submit the application even after the three-judge bench on Tuesday afternoon ruled that it had been properly empaneled by Deputy Chief Justice Philomena Mbete Mwilo.
As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government.
Kindiki's side will be hoping that the judges will throw aside the application for their recusal and further set aside the conservatory orders that slammed the brakes on his relocation from the office of the Ministry of Interior to the adjacent office of the Deputy President along Harambee Avenue. Almost a week after the National Assembly rubber-stamped President William Ruto's selection of Interior CS Professor Kithure Kindiki as his next deputy, leaving Kindiki with one hurdle to skip before assuming the second most powerful office in the land, and which is his swearing-in ceremony, Kindiki is likely to know tomorrow whether he will be sworn in soon or he will still have to keep his champagne on ice. David Mudhoka, NTV from the Milimani Law Courts, Nairobi.
All right, and that report by David Mudhoka sets the stage for the proceedings at the court, the Milimani Law Courts today, even as the impeached Deputy President continues to fight for his political future, with one of the implications of the impeachment being that he cannot run for state office after his impeachment. But even as Gachagua fights on, his allies, parliamentarians who have been vocal against his impeachment and openly criticized President William Ruto, have not been spared. Sources indicate that Ruto's majority side has orchestrated what has been termed as a parliamentary purge, targeting Gachagua's foot soldiers in parliament and are said to be removed from critical House leadership committees. And this is, of course, a situation that could further make the situation worse, really, within the Kenya Kwanza coalition and the frosty relations there. And some of the DP's allies in the National Assembly who had held positions in committees include the likes of the North MP James Gakuya, who chairs the Powerful Trade Committee, and They are among 44 lawmakers in the National Assembly who voted to save Gachagua, as well as those within the Senate, including Kiambu Senator Karungo Thangwa and his Muranga counterpart Joe Nyutu, who now say are marked men. They say they have received several threats even before the voting within the Senate to vote against the impeached deputy president. Additionally, sources indicate that a plot has been hatched to kick Gachagua out of the UDA party as the deputy party leader, a move that could now render him partyless. And it is, of course, a situation that will have an implication on Gachagua's political future. The political price here being that the ex-DP will be barred permanently from holding effective public office. Many thanks for joining us here on NTV as we bring you live events in the country and, of course, following up on that all-important court proceedings at the Milimani Law Court with regard to the impeachment of Rigathi Gachagua. But let's take you live to Nakuru, where President William Ruto has just spoken at the groundbreaking for the Menengai 3 geothermal project in Nakuru. Our reporter Ruth Sermoe Chesenge now joins us with the views of residents of Nakuru. Ruth, good morning. The speech by President William Ruto at the groundbreaking of the Menengai 3 geothermal project comes just days after that Adani Ketraco deal worth 90 billion Kenyan shillings. What do residents of Nakuru have to say with regard to the questions, especially of public participation, and how this will impact the country moving forward?
Well, Michelle, I am joining you from the Menengai power plant here in Nakuru, where the president has just left after the groundbreaking ceremony of the All Power 22 power plant, which is expected to produce 35 megawatts once it will be completed. But I'll be joined here by some of them, Eric Wamanji from GDC, who's going to tell us more about this project. Maybe you can tell us how much money has been pumped into this project and when do we expect it to be completed?
Okay, thank you so much, Ruth. For this 35 megawatts project, the investor is going to pump in around 90 million USD. That's around 12 billion Kenya shillings that will come into investing in the geothermal project in Kenya. Yes.
And how important is this for the power production in the country? Because I understand at the end of it, how much money do we expect this electricity to be sold to Kenya Power?
This is a very significant milestone for Kenyans. Number one, it has brought in foreign investment financing into a big project. Number two, the power is going to reduce the cost of power in this country. Power from this project will be trading with around 8 shillings per kilowatt hour. If you compare that with the power from diesel or fossil fuel, which is 22 shillings per kilowatt hour, then you realize that this project will significantly lower the cost of power in this country. Beyond that, it's going to advance Kenya's green credentials. Geothermal is green energy, it's renewable, and therefore it's one of the most critical energies sought all over the world. But thankfully, it's only Kenya that we are really advanced in this project in Africa with this technology. Yes.
So when do we expect this project to be complete? And maybe you can also tell us about the 2 other projects that are ongoing and their progress. Do we have some of the energy already channeled into the power grid or not yet?
Okay, at this moment, the contractor, who is Kaishan, running the All Power 22, has promised that this project will take 14 months. So we are talking about early or mid 2026. We'll be having this power on the grid. We are also having two other projects here, two power plants. One is Sosian Menengai Power. They're already generating 35 megawatts of power, which is already going into the national grid. The next one is Globlek, again an IPP, a private investor. They broke ground last year, and now they are under construction, around 30% complete. And we are expecting that this power will get to the grid around 2025, the end of 2025. So basically, we are saying the groundbreaking today has brought to completion what we call the Menengai 105 geothermal megawatts project, and that is a very big milestone for Kenya, and especially for the energy sector in the country.
Last year we saw that you were using some of the steam to produce cement. Maybe you can bring us to date. How far is that project?
Exactly. The Geothermal Development Company, GDC, is excelling in the innovative development of geothermal in this country. We are spinning off from power generation into direct utilization of the heat from steam. Now, last year we entered into an agreement with Karsan Ramji. They are the producers of Ndovu cement. And what we are going to do with the steam, they'll use it in the manufacturing of cement instead of, say, using fossil fuel, diesel, or any other source which will be very expensive. So this way we are actually advancing the industrialization of this country through the use of affordable, reliable, and green geothermal electricity from our projects here at GDC. Yes.
Thank you very much. We also understand that while the president was speaking, he really emphasized on the importance of public-private partnerships. And we're going to speak to one of the representatives from Kaishan to help us, and who's investing into this project. Maybe you can tell us how much money you are bringing into this project, and what, other than producing power, what other use of the steam do you look to invest in?
For this project, we're going to bring $80 million to complete the power plant here. So we are talking about today, we're trying to use geothermal to generate the green electricity, and also use the green electricity to generate the green hydrogen, and from hydrogen to generate the green ammonia. So that's why Kenya agriculture is going to benefit from the green ammonia, so fertilizer, right? So and we're going to bring about 540 million US dollars to this green ammonia project. That's going to be a huge project, and we're going to use a lot of steam and also wells, and also build first green and fertilizer plant in Africa.
Maybe help us paint a picture. In the next 2 years, we expect this also project to bring in employment to people. So maybe how many people are you looking to employ?
For the project here, we estimated we're going to need 300 local employees to work on this project for next year, end of this year, next year. And for that project, and we're talking about a green ammonia project, well, that's really big, and I don't know, going to be thousands. I don't have the idea yet right now, but definitely 1,000 jobs for the local people to complete the whole project.
Well, thank you very much, Michelle. There you have it. They've talked about that this project is costing about 12 billion shillings, and it is expected to be complete after 2 years. Earlier on, while the president was speaking, he supported Adani, who has invested in the power transmission lines, where he's investing 95 billion shillings. This is what he had to say.
The Adani Group are investing in the transmission line, their money, 95 billion. We would have otherwise gone to borrow that money, burden the people of Kenya. This is now a private sector investment, the same way Kaishan here is a private sector investment, the same way Sosian is a private sector investment. We will pay for that transmission line using a wheeling charge that has been negotiated. And it is important for us as a nation to appreciate that a partnership between public and the private sector gives us a win-win outcome, where we can deliver public services and public goods using the efficiency of the private sector, investment of the private sector, as a way of supporting overall development in our country. I urge the Geothermal Development Corporation to develop and sustain a high capacity to offer effective leadership in driving Kenya's energy transition.
Well, Michelle, that has been the situation here at the Menengai power plant here in Nakuru. So we'll be giving you more details in our subsequent bulletins.
Many thanks. That is Ruth Senmoe Chesenge joining us live from Nakuru, where President William Ruto attended the groundbreaking of that 35-megawatt power plant in Nakuru. President William Ruto also taking the opportunity to defend the government's decision to partner with the Adani Group, among various other private partners in Kenya's development agenda. And that's how we wind it up here on NTV as we bring you live coverage of events taking place across the country. Do stay with us after this break. We'll be giving you more coverage in Swahili as we anticipate that court proceeding at the Milimani Law Court with regard to the impeachment of impeached Deputy President Rigathi Gachagua. Many thanks for watching us this morning. My name is Michelle Ngele Odhiambo. Do enjoy the rest of your viewing.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu. Kenyans will be shocked. Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Kuna mbomu 15,000 nachukua mbomu. Zinakwenda. Nahitaji diaper.
Kimeumana.
39 40,000 shillings. Namba 3. King Kong. Na 50,000 Kenya shillings. Grand mega
Kwa majina naitwa Ronald Kemele Korkat, ninashiriki Standard Chartered hii mwaka on 27. Naomba watu wa watch live on NTV.
Get ready to have your mind blown.
Hey, what's up, my good people? This is your girl, Avril.
We're bringing you the hottest show in town.
The king of gospel, and I represent for Kwetu Mix.
Yo, Butrus, aka the sharp god up in the mix, you know what I'm saying? NTV, shout out to you, bro.
From exclusive interviews with the biggest names in the game.
Wache kuleta wasanii tunawalipa 30 million. Msanii wa Kenya mpo Kisu.
And snippets from your favorite live performances. Don't miss out on the fun. Tune into Kwetu Mix every weekday from 5 to 6 p.m. only on NTV.
New Panadol Extra Soluble dissolves twice as fast versus standard paracetamol tablets.
I'm aware that I haven't been a good father to you.
Father.
Kelly, please. You can't let them lock me up.
And what you lose is not only water. We say water is not enough. So we complement water with electrolytes through the ORS tablets. Most also, this is a platform for awareness to everybody who takes part in this, that the hydration tablets, that you can hydrate better, and also to support just generally the active lifestyle of Kenyans through the marathon. The beauty about our activation at marathon is that we are in 12 stations. Throughout the marathon, at least within every 3 kilometers or so, you will get a stand with ORS. So we'll keep the runners hydrated throughout, and at the finish and at the end at the village, we'll be there now to explain about ORS. If you want to taste all the flavors that you have not tasted along the route, we'll be there to ensure that you taste and sample and get all the information that you need about ORS. My name is Tenorin Wasike from Kwal. I head marketing at Kwal, and we are very, very proud to partner with Stanchart on the upcoming marathon with Heineken Zero. We always, of course, market our brands based on a deep consumer insights. Some of the people who are coming for this marathon, we know we are looking at about 25,000 people coming from all walks of life. Some of those consumers are actually consumers of Heineken, and they have expressed the need to enjoy, not just responsibly, but guilt-free, to be able to enjoy the same occasions, shared moments with their friends, and all this without really the effects of alcohol. We also know that there's a growth in terms of consumers looking out for health alternatives. They are very conscious, they're active, and anchored on the back of this, we felt it's a big opportunity for us to come and be able to be part of this great initiative. So yes, we are saying with Heineken you can drink without feeling the effects of alcohol. You can drink responsibly, and you can enjoy Heineken Zero at any time of the day, whether it's at lunch with your friends, after the run, or whatever time you want. Yeah.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures.
Salamu za asubuhi mtazamaji wangu, nikukaribishe kwa moyo mkunjufu kwa meza hii ya NTV. Najua si mgeni, ulianza na Michelle, sasa amenipokeza kipenga. Siku zote Waswahili wanasema shingo haipiti kichwa. Lakini katika muktadha wa taifa hivi sasa ni kwamba shingo na kichwa zinapambana kujua nani atakuwa kichwa na nani atabaki shingoni. Kichwa kinasema simtaki aliye shingoni, na shingoni anasema nataka kuendelea bado kukusitiri. Sijui hayo yatafikia wapi. Ndio maana tumefika hapa kwa minajili ya kujua hatma ya taifa kufuatia kung'atuliwa kwa naibu wa rais Rigathi Gachagua, na ambaye bado anapambana mahakamani, huku naye Kithure Kindiki Kundrathi ambaye ni naibu rais mteule akiwa tayari na suti, viatu ameandaa pale, tai akingoja kuapishwa. Sijui itakuwaje, lakini mwongozo unatolewa na mahakama siku ya leo. Karibu kwenye meza yetu, unaweza kufanya mtagusano nasi, lakini tuanze kwa taarifa hii ambapo mtu anapokuwa kiongozi wa pili cheo cha juu kwa chama mamlaka kutokana na msukumo wa siasa baada ya hayati Daktari Joseph Karanja Gachagua ameondolewa afisini baada ya mbunge wa Kibwezi Magharibi Mwengi Mutuse kuwasilisha hoja bungeni ya kumfukuza kazi kwa ukiukiaji katiba. Na je, swali wanasiasa jasiri waliotoka kutumia bunge kuang'oa rais na manaibu wake ni kwa nini? Mhariri Paul Nabiswa na taarifa zaidi.
By that particular announcement.
Watangulizi wa Mutuse katika mipango kama hii wanajumuisha aliyekuwa mbunge wa Embakasi David Mwenje, ambaye alikuwa kapanga kuandaa hoja ya kumuondoa mamlakani aliyekuwa makamu rais wa Moi mwaka 1989 Daktari Joseph Karanja kwa kudharau afisi ya mkuu wake, ambaye alazimika kujiuzulu kabla ya kutekeleza alichokuwa amekusudia. Baadaye Karanja aliyekuwa mbunge wa Mathare wakati huo alihamia upinzani katika chama cha Ford Asili cha Kenneth Matiba hadi alipofariki mwaka 1994, wakati huu akiwa mbunge wa Githunguri.
Na tutaondoa serikali ya Moi na mikora yake.
Mrithi wa Karanja alikuwa Profesa George Saitoti ambaye pia alijipata katika tafrani ya Goldenberg ambapo Kenya ilipoteza zaidi ya shilingi bilioni 5.8.
Vijana msilale, bado mapambano.
Na katika uzi huo mbunge wa Mbita wakati huo Gerald Otieno Kajwang mwaka 1999 alianza mapambano ya kumtaka Saitoti ajiuzulu kwa kuwasilisha kura ya kutokuwa na imani naye bungeni, japo alishindwa baada ya chama cha KANU kuungana na kile cha DP cha Mwai Kibaki na kuporomosha hoja hiyo. Hata hivyo mwaka 1998 mbunge wa Ugenya wakati huo James Orengo katika tukio la kihistoria aliwasilisha hoja ya kutokuwa na imani na Rais Daniel Toroitich arap Moi kwa kusema kuwa alikuwa kashindwa kuongoza nchi kwa maadili na ufisadi ulikuwa umekita mizizi. Jaribio hili lilishindwa kwa wingi wa kura za KANU.
That the government can be brought to account, and whatever happened today is a show that Parliament has got power, and that's what I should say now.
We are happy by the enthusiasm and the interest that Kenyans have shown in this motion.
Yamkini Orengo anapenda mambo haya, kwani hata kipindi hiki cha kumtimua Gachagua amekuwa wakili mkuu wa bunge la taifa likisukumwa chini kwa chini na wandani wa Rais William Ruto.
These proceedings are time bound. It's not so much about the situation in which His Excellency the Vice President finds himself.
Hatua ya kuwatimua wakuu wa nchi kupitia katiba ya mwaka 2010 na vinginevyo bila shaka inahitaji ujasiri wa moyo, fikra tunduizi, hali kadhalika ufuasi usiotikisika. Paul Nabiswa, NTV.
Na kauli yake nadhani kidogo ningependa kukupa kauli tofauti kidogo tu, kwa sababu ninavyotazama hiki ni kiti. Unajua wakati ambapo anazungumza kuna wakati ambao tulikuwa na katiba hii ambayo tuko nayo ya 2010 na kuna ile katiba tunapenda kuita katiba ya Moi, na nyakati hizo tofauti zina mambo tofauti. Kwa hivyo kama sasa wakati huu tuna naibu wa rais ambaye ameshtakiwa ama ameshutumiwa kutumiwa kiti chake vibaya, na ni kiti ambacho kinaonekana kumpa kimeleta mali ama ameshtumiwa ameweza kujilimbikizia mali na utaji mkubwa. Alikuwa na azma ya kuwa kiongozi wa Mlima Kenya. Kwa hivyo sidhani ni kiti kina shida, labda wanaokalia hicho kiti wana malengo tofauti na anayewapa wadhifa huo ambao ni rais.
Wanapata kiti hicho lakini wanataka mguuni ponye wakitaka kiti kingine.
Nadhani ni shughuli ya kutofautiana na azma ya kiongozi, yani rais na naibu wake. Kama malengo ni tofauti.
Tushikilie papo hapo Jared. Mtazamaji wangu, naomba tuelekee kaunti ya Nyeri. Ni kaunti muhimu katika siku za hivi majuzi, manake ni kaunti nyumbani pake naibu rais aliyeng'atuliwa kupitia bunge Rigathi Gachagua. Mwanahabari mwenza Margaret Kimathi yuko tayari kusema na wenyeji wa kaunti hiyo. Margaret, uwanjani wako. Je, wa Kenya kutoka upande wa Nyeri wanaendelea kufuatilia siku hii na pengine wana matarajio kwamba leo huenda kesi hii kaamuliwa kikamilifu na taifa kusonga mbele?
Naam, Lois, ni siku tulivu hapa katika kaunti ya Nyeri. Shughuli zinaendelea kama kawaida, ila wakazi wana ghadhabu, wanafuatilia mazungumzo ambayo yanaendelea kotini kwa hamu na gamu ili kuweza kujua hatma ya mwana wao. Na moja kwa moja ningependa kuzungumza na baadhi ya wakazi kutoka hapa kaunti ya Nyeri. Hebu anza kwa jina lako, halafu tupe maoni yako.
Mimi naitwa Kirome Madege, na maoni yangu ni kuwa hii koti sioni ikileta kitu yote, kwa maana kutoka mwanzo hao watu wamekuwa Bwana Gachagua akileta kitu hao watu watatoa. Kwa hivyo hiyo kitu haiwezi kuwa kwa njia ya justice. Kwa hivyo ile tungetaka kuomba ni kama serikali tuiwapatia kura wakaja kanisani, mimi ni mhubiri, walikuja kanisani na tukawaombea. Tulipowaombea wakakuja na Biblia. Saa hii tunaona hakuna justice. Sasa tunauliza Bwana Ruto abadilike, kwa maana Mungu anaona, na yale yote ambaye mnafanya Mungu anayaona. Mungu anafanya mambo yakiwa anaonekana. Mungu huwezi ficha Mungu. Kwa hivyo Bwana Gachagua, kesi yake ipeanwa kesi mzuri, na justice iwe justice ambaye ni justice ambaye itatocha kila mtu, na mtu akisikiliza hivyo mambo yote yatakuwa mema. Kwa hivyo naomba serikali, kwa maana naonekana kutoka zamani wamekuwa pamoja na koti. Kwa hivyo tunaomba hawa watu watumie justice, kwa maana Mungu aliye mbinguni anaona, na tutaomba na mambo yatafanyika.
Naam, shukrani sana. Pengine tuzungumze na wewe, maoni yako ni yapi?
Asante sana. Mimi kwa majina naitwa Finance Wedhuku, na mimi ni mwanasiasa hapa eneo ya Nyeri. Na mimi maoni yangu ni koti iendelee kutoa uamuzi venye itatoa, na mimi naona huo uamuzi wote na vile tunaendelea ni kwa haki. Ile kitu mimi nasema, Deputy President Gachagua alikuwa amepewa nafasi ya kuwa naibu wa rais.
Konrathi, wenyeji wa Nyeri, tutakuwa tunarejea baadaye, manake leo siku bado ni ndefu. Mtazamaji wangu, ni kwamba mahakama ya Milimani, mahakama kuu, tayari imeanza kikao, na moja kwa moja tuweze kupata ambayo yanajiri pale. Tutasema mengi baadaye.
And constitutional petition number E522 of 2024 became the lead file. The impeachment process then moved to the Senate, where His Excellency Rigathi Gachagua was eventually impeached. Subsequent petitions were filed and conservatory orders issued. Those petitions were also consolidated by an order of this court, and constitutional petition number E565 of 2024 became the lead file in the series. Several other petitions that further variously challenged the said impeachment process were later filed, and this bench has accordingly been empaneled to also deal with the said petitions as well. On 23rd of October 2024, all the petitions on which this bench was empaneled to deal with were mentioned before court, and proposals on the way forward by learned counsel and parties were received, especially on the aspect of consolidation. This bench then adjourned the proceedings to today so as to give comprehensive directions in the manner in which all the petitions before this bench will be dealt with going forward. The bench also fixed all applications seeking the recusal of the bench for hearing at 2:30 p.m. today. This bench has gone through all the petitions before the court. We have no doubt that there are principally two sets of petitions. The first regiment are the petitions that challenge the impeachment process before the National Assembly. We shall hereinafter refer to such petitions as those in cohort 1. As said, those are the petitions that were consolidated, and constitutional petition number E522 of 2024 became the lead file. These petitions were fixed for a mention on 29th of October 2024 for the parties to decide on the way forward, depending on the outcome of the proceedings before the Senate. As it is, the Senate proceedings ended with the impeachment of H.C. Rigathi Gachagua. As a result, several other petitions challenging that process were filed. We shall hereinafter refer to such petitions as those in cohort 2. Those are the petitions that were consolidated, and constitutional petition number E565 of 2024 became the lead file. Having considered the nature of the petitions before us, and with a view of conducting those proceedings in an orderly manner, we hereby issue the following further directions. 1. All the petitions shall forthwith be dealt with as those in cohort 1 or cohort 2, respectively. 2. Court shall, pursuant to Rule 17 of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedures Rules 2013 on its own motion consolidates any other petition referred to this bench either into any of the two cohorts. 3. For clarity, the petitions are hereby consolidated under the two cohorts as follows. Petition in cohort number 1, Nairobi petition number E522 of 2024, that is the lead file. Then we have Nairobi petition number E506 of 2024, Nairobi petition number E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, and Nairobi petition number E541 of 2024. The petitioners in those consolidated petitions are as follows. 1. Rigathi Gachagua. 2. Obuli Namea. 3. Kennedy Kamithiu Gachege. 4. Dennis Okumu. 5. Simon Muchangi. 6. Peter Maina. 7. Gema Watho Association. 8. John Mugo Kiragu. 9. Njomo John. 10. Caroline Wambui Mwangi. 11. Dr. Clarence Eboso Mwaresa. 12. Wanjiru Mwangi. Those are the petitioners in cohort number 1. Respondents in that cohort are 1. The Speaker of the National Assembly of Kenya. 2. The National Assembly of Kenya. 3. The Speaker of the Senate of Kenya. 4. The Senate of Kenya. 5. The Deputy Speaker, National Assembly. 6. Honorable Moses Masika Watangula. 7. Honorable Amason Kingi Jeffa. 8. Honorable Attorney General. The interested parties in that cohort are 1. William Samoei Ruto. 2. Law Society of Kenya. 3. Mount Kenya Jurists. That is cohort number 1. Petition in cohort number 2. Nairobi petition number E565 of 2024, that is the lead file. Nairobi petition E550 of 2024. Nairobi petition E570 of 2024. Nairobi petition E572 of 2024. Kerugoya petition E013 of 2024. Kerugoya petition E014 of 2024. Kerugoya petition number E015 of 2024. The petitioners in those cohort 2 are as follows. H. Rigathi Gachagua, number 1. Number 2, Thomas Kimotho Maingi. Number 3, John Hon Jane Njeri Maina. 4, Hon David Munyi Mabenge. 5, Peter Gichobi Kamotho. 6, Grace Mudhoni Mwangi. 7, Clement Mchiri Murioki. 8, Edwin Munene Karioki. 9, Sheria Mtani na Shadrach Wambui. 10, Father Eddie Waiguru. From 10, you note that Father Eddie Waiguru is in the list of E570 of 2024, and there are 32 petitioners. So from Father Eddie Waiguru, we add all the petitioners in that petition, which come to 32 and ends with Gema Watho Association. Respondents in the court 2 are as follows. Speaker, National Assembly. National Assembly of Kenya. 3, Speaker, Senate. 4, Senate of Kenya. 5, Hon Attorney General. 6, H.E. William Ruto. 7, Clerk of the National Assembly. 8, Deputy Speaker of the National Assembly. 9, Hon Mwengi Mthure. 10, United Democratic Alliance. 11, Orange Democratic Alliance. 12, Kenya Kwanza Alliance. 13, Ford Kenya Party, 14, Amani National Congress, 15, Register of the Political Parties, 16, Independent Electoral Boundaries Commission. In that cohort, the interested parties are follows: the Law Society of Kenya, Professor Kithure Kindiki, Wiper Democratic Party, Jubilee Party of Kenya, Katiba Institute, Mount Kenya Jurists Association. And then lastly, Kituo cha Sheria. Pursuant to those, we direct that all filings and service of documents shall be done electronically through the court's electronic portal in the respective court's lead files. Parties shall accordingly ensure that they are duly marked into the system. The Honorable Deputy Registrar of this division shall assist if need be. Any counsel or party appearing in these petitions shall, before the start of any court proceedings, record such appearance in the quorum forms that shall be provided by the court assistants in this bench. Those appearing virtually shall as well log in and register their presence through the court assistants. As directed on 23rd of October 2023, any application in either of the cohorts seeking the recusal of the judges in this bench shall be heard today at 2:30 p.m. Those directions can be accessed in this court's electronic platform. These directions can be accessed in this court's electronic platform in the respective lead files. This court shall give further appropriate directions in the respective cohort's lead files as and when necessary. Thank you very much. The directions, subject to amendments which have come from you, will amend it and then upload it.
Yes, my Lord, with your kind permission, if we may be allowed to address the court. My Lord, we are guided by the directions issued by the court. We, however, have one concern from our side, my Lords. My Lords, there are interim orders that were issued in Kerugoya, and in our understanding, from our interpretation, once the file was referred to this court, the orders expire today. That's our understanding. And my Lord, we are going to seek the court's guidance on the hearing of our application dated 18th October. Of course, we understand that there's a recusal application today. But given the fact, my Lord, that our interpretation is that those orders would expire on the appointed date, which is today, when the matter was meant to be mentioned, our colleagues' understanding, my Lord, is that the application, in the public interest, be prioritized so that we are able to hear the application for setting aside of those orders. In any event, my Lord, the orders in question were issued by one judge. The matter has now been referred to a 3-judge bench. And their nature is problematic, as mentioned by the court. And we would pray that in terms of aligning the hearing or scheduling the applications to be heard in cohort 2, that if possible, my Lords, we do not want to do anything outside the law. We would request, my Lord, that we be heard today if it's possible, because the orders expire today. I think my Lord Friend Gumbo would just want to add something on that.
My Lord, very briefly, I wouldn't want to repeat what... my Lord, I just wanted to indicate that I would not want to repeat what learned Senior Counsel Professor Tom Ojenda has indicated, but just for completeness of record, there are 2 applications. There's one by the Honorable the Attorney General and one by the National Assembly dated the 18th of October 2024. We are ready for them as soon as you direct, my Lord.
My Lord, with your kind permission, Daniel Manzo, appearing for the Law Society of Kenya and also for Wiper and Democratic Party who are interested parties. My Lord, if the orders are to expire today, then that will be at midnight. My Lord, the day is not yet over. We have applications in the afternoon. We are also affected by those orders. And my Lord, I suggest after the applications today, then we can discuss that matter before the court adjourns. I thank you, my Lord.
My Lord, Kibe Mungai, on behalf of the petitioners, there are two issues. You can see the senior, the team leader, Honorable Paul Muite is not with us in the council. That is the first thing that we deal with it in the afternoon. And as far as we are concerned, the matter is premature and the hearing and determination of that applications for the simple reason that the issue and an order had already been made that would be first dealt with by the court after its ruling of yesterday was the application for recusal. The other matters that relates to how we shall deal with the petition and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, if it continues, or by any other bench. And therefore, the issue, my Lord, of a back and forth on what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have started a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, Paul Muite is in the afternoon, it will be dealt with in the afternoon. But my Lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my Lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the Mutunga rules, the rules of procedure that are applicable. My Lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday, and the ones that were filed even on Friday last week, are maturing their last dates for responses. My Lord, as we sit here, we are yet to receive any substantive responses to those petitions in either boards from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the Mutunga rules to the full. My Lord, the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last petition so that they are not termed as academic. So that, my Lord, towards that, the petitioners, including in the petitions where I'm participating, we had requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents will indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses. Because, my Lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because as we have said, these are interim directions. And number three, in order to be able to determine issues for determination, and these are issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties, that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, will complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we are ready in the afternoon. We are most obliged.
Just before leaving.
Senior, because I'm on the same side, perhaps so you can have some response on it. Okay. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of Council for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kiruga, Your Lordship, was categorical that he granted prayer number C. Even as we await Senior Counsel Paul Mojo to come in the afternoon, the wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and determination, of this application inter parties, this Honorable Court be pleased to grant the orders that were granted. That is therefore to mean, Your Lordship, that question that Senior Counsel was raising has no sitting in the pleadings before you. Number two, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I have heard the advocates for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file their replies. Your Lordship, I hope you are following.
Following.
He doesn't seem to be following.
Why do you say that?
But
why do you say that?
But let me leave it at that.
Thank you. I think that is... Sorry, gentlemen. You cannot talk forever.
My Lord, on a very small issue, we do confirm that for His Excellency, the Deputy President, Rigathi Gachagua, as the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for the filing of responses, because as we speak now, we have not received those responses from the respondents. Then number two, my colleague Senior Kibe has raised issues on filing of responses, so that in 522 we had given an indication that we might require to amend our pleadings, so that before the ruling that was delivered by this bench, there was indication that we might require to amend the pleading. That is in petitions in cohort number 1, so that if the court can grant us leave, within 3 days those amendments can be done. And thereafter, this can also probably affect in some petitions cohort number 2. So it is important that we get that particular direction. Finally, my lords, this proceeding, because of the nature, the way they are proceeding, would request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding again at any time, those can be availed for purposes of good order. That is all.
With due respect to Council, we did not intend to make today this hearing a long hearing. We have been courteous enough. We have read our directions, and I think you should let us wait for proceedings in the afternoon.
So, I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to when actually it should be the amendments that should come first and then responses follow? Number two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, that it is actually aggrieving the respondents and should be set aside, the Kerugoya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the ex parte conservatory orders. Therefore, that agency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
I apologize. We are ready to issue. I do apologize. When I made an application for the court, they said, let me join. My Lord Justice Okola, you are very kind now. You promptly allowed my application. The court said I was to be joined. And also I was to be joined by my name. You are not very good. If you would be kind enough.
In which petition?
Yeah.
In which one?
Which
cohort?
This, I'm sorry I don't have papers in this one.
Okay. We'll enjoy you. In your own name?
Yes, in my own name. John M. And of course it was
So you are petitioner number 8?
No.
Interested party number 8?
Yes. That's all. Thank you very much.
Thank you, my Lord. We just want to restate the position that the urgency in this matter cannot be gainsaid or cannot be lost, my Lord. Under the contention that the replies have not been made, that we have not made replies, is not correct because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empanelment of these churches will actually be lost, because then we would be going back and forth, and at the end of the day, my Lord, we will not have served the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my Lord. We would urge that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings. But one thing which I can assure you, that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. No party will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles. We meet at 2:30.
Very keen on this setting aside.
Mtazamaji wangu, hayo ndiyo yanayojiri katika mahakama ya Milimani, ambapo Jaji Eric Ogolla, Anthony Mrima na Freda wamekuwa wakitoa mwongozo kwa mjadala wa asubuhi ya leo, ambapo wametoa mwongozo kwamba hizi kesi zote ambazo mawakili wa naibu rais Rigathi Gachagua walikuwa wamewasilisha na maombi kadha wa kadha, tumehesabu hapa na mgeni wangu studioni, karibu yafike maombi 28, wamesema wameweza kuyapanga katika faili mbili. Faili ya kwanza itakuwa ni kesi ya kubanduliwa kwa naibu wa rais Rigathi Gachagua dhidi ya bunge kuu. Faili ya pili ikiwa ni kesi ya kubanduliwa kwa naibu wa rais Rigathi Gachagua dhidi ya bunge la seneti. Hivyo koti imetoa mwongozo kuwa faili ni mbili, kesi ni mbili, na wote ambao walikuwa wamejumlishwa katika kesi hizo, ambapo tunaona kulikuwa na rais, spika wa bunge, Kenya Kwanza, chama cha UDA, chama cha Amani, chama cha Ford Kenya, alafu vile vile kulikuwa na kituo cha sheria, vile vile chama cha Wiper na Kithure Kindiki naibu rais mteule. Hawa wote koti imesema waweze kuwekwa katika maswala mawili ama faili mbili na kuendelea mbele. Faili hizi mbili ndizo ambazo zitakuwa zinatoa mwongozo wa mkondo wa kesi mahakamani. Vile vile tumeona mawakili wa naibu wa rais wakifika na maombi mapya mbele ya mahakama kuu. Tumemwona Kibe Mungai akisema wanaomba waongezewe siku 3, mtazamaji wangu, ili waweze kupokea majibu, wakisema upande wa upinzani, manake hawa ndo walalamishi, wanasema hapa serikali, ofisi hizi zote ambazo tumeziandikia maombi hawajaweza kutupa majibu, wanataka wapewe siku 3 ili kupata majibu hayo. Vile vile wamefika na maombi mengine, mtazamaji wangu, ambao tutakuwa tunasema pindi tunavyoendelea. Lakini sasa ni kualike Jared, tulikuwa tunatarajia kikuu zaidi ni kuweza kujua, je, kesi hizi zitajumlishwa ama zitasikilizwa moja moja? Tumezihesabu kwa pamoja ni zaidi ya 25. Pengine ni mwafaka ama imekuwa ni mwongozo mzuri wa mahakama kuu kusema hizi kesi sasa zitakuwa katika faili mbili?
Nadhani vizuri pia tuelewe, kesi hizi ni nyingi na zitachukua muda kusikizwa. Na maombi ambayo mawakili wanayoomba kwa niaba ya aliyekuwa naibu wa rais na wengine wengi ambao wamewasilisha kesi zao, kila maombi ni hayatofautiani sana. Kwa hivyo kumbuka kesi pia, kwa sababu hatuna majaji wengi pia, na kesi hizi zinaweza chukua muda mrefu na pia ni kazi nyingi. Haimaanishi kuwa jaji mmoja hawezi keti akasikiza kesi. Lakini kama unavyoona, kama mawakili ni 30 kesi ziwe 30, naona kumpa jaji moja kazi hii ni kazi ngumu. Kwa hivyo jopo ambalo limeteuliwa likaona maombi ambayo yameletwa mbele ya koti hii kulingana na stakabadhi yanafanana. Kwa hivyo tunaweza kusikiza kesi hii na kuweka vitengo aina mbili. Kitengo cha kwanza, kesi ambazo zinashtaki bunge, na kesi kitengo cha pili, kesi ambazo zinashtaki seneti. Naam.
Na kando na hilo, tumeona upande wa naibu wa rais Rigathi Gachagua walikuwa wamewashtaki watu wengi sana. Tunaweza kuona walikuwa wamemshtaki rais, kwa mfano. Hilo linakubalika kisheria?
Wajua, mawakili wanapokwenda kotini, kila mtu amepanga jinsi kesi yake atakavyoiwasilisha kwenye koti ili kuishawishi koti ikubaliane na maombi unayoomba ama koti ichukue mkondo tofauti. Ingekuwa ni mimi, labda ningefanya tofauti. Na ningependa kuwapa heshima wale ambao wamewasilisha kesi zao kwa njia hiyo. Sidhani ningepatiwa kesi kama hiyo ningefanya, ama ningekuwa kiongozi wa kikundi hicho ningefanya hivyo. Lakini labda kwa mtazamo wao wanavyoona jinsi ya kumsaidia naibu wa rais ni kufanya kesi 28. Labda kuna jambo ambalo wameona labda sijaliona. Na kufanya kesi hizi mingi. Kumbuka hata wale wanaowasilisha haswa si naibu rais yeye mwenyewe, wanawasilisha kwa niaba ya kwa hivyo wanaowasilisha maombi haya pia ni wengi na labda pia wana malengo yao tofauti. Kwa hivyo ni tofauti za jinsi mawakili wanavyofanya kesi zao. Hivyo ndivyo tunavyoona sasa hivi, kwa sababu mrengo ule mwingine unafanya kesi yao tofauti.
Na bila shaka mtazamaji akiwa pale nyumbani, hata mimi nilikuwa nina mwongozo kwamba Rigathi Gachagua aliyebanduliwa naibu wa rais amefika pale kwa malalamishi pengine dhidi ya rais, dhidi ya bunge la seneti au hata bunge kuu. Lakini pindi wametajwa wale wote ambao wanataka waweze kuwekwa ndani ya kesi hii ni watu wengi, ikiwemo vyama vya kisiasa. Kwa mfano chama cha Wiper, chama cha ANC, nashindwa kutathmini mbona alifanya hivyo. Utakuwa unatueleza kuhusu hilo. Je, walikuwa wanalenga nini hawa mawakili wa Rigathi Gachagua? Hakika watu hawa wote katika kesi hii wakitaka majibu. Lakini kwa sasa naomba tuelekee katika kaunti ya Kisumu, mtazamaji wangu, ambapo mwanahabari wetu Judith Cherono yuko ange kabisa na Wakenya kutoka kaunti ya Kisumu. Bila shaka ni miongoni wa wale wanaofuatilia masaibu ya naibu wa rais Rigathi Gachagua aliyebanduliwa mahakamani. Judith, ikiwa unanipata, uwanjani wako.
Asante sana mwenzangu kutoka upande wetu wa pili hapo studio kwenye Nairobi. Na kujia toka moja kwa moja toka mjini wa Kisumu, katikati wa mji wa eneo hili. Na sasa tumejiunga na wakazi wa hapa ambao wanataka kupeana maoni yao kuhusu kung'atuliwa kwa naibu rais Rigathi Gachagua ambaye amepeleka kesi yake kotini na inasikizwa saizi. Na sasa bila kupoteza wakati, hebu tujiunge nao tusikize wana maoni gani. Ndugu yangu, karibu sana kwenye runinga yetu ya NTV. Naomba ujitambulishe kwa majina kisha utupe maoni yako kuhusu hii kesi ambayo inaendelea katika mahakama kuu ya Nairobi kuhusu anayeng'atuliwa kwenye kiti chake cha unaibu rais Rigathi Gachagua. Anza kwa majina. Thanks.
Kwa majina mimi ni Vincent Ofafa, mfanyi biashara hapa Kisumu. Hii maneno ya Gachagua mimi naona ni waste of times kabisa. Manake tangu atoke hata sisi hatujui. Kenya imekuwa inaendelea vizuri sana tangu Gachagua atoke. So sijui anataka kurudi mbona. Sisi tunategea kama tunaweza pata deputy president mpya, na kama ikiwezekana sisi tunaomba ile wheelbarrow yenye walifaa kupeleka nayo Raila Bondo ndio watusaidie tusukume huyu jamaa Central. Juu sisi hapa Kisumu hata hii mambo sisi ndio nyinyi ndio mmetukumbusha. Hatukuwa tumejua hii mambo. Tulijua huyu jamaa ameshaenda kitambo. Tunafikiria tu mambo ya kupiga sherehe kila weekend hapa Kisumu. Mambo ya Gachagua hatuwezi fikiria sahi. Mambo ya kubai vitu za December na sherehe ndio tunaona hapa sahi. Gachagua atupilie hiyo maneno mbali, time ishapita. Nguruwe inajikaranga na mafuta yake na amejikaranga. Sasa sisi tunaona ni waste of time sana.
Asante sana ndugu yangu. Na sasa maoni yako ni gani kuhusu hii changamoto ya deputy rais?
Kwa majina mimi naitwa Josephat Duel. Kulingana na mambo ya wanaibu wa rais wa nchi, hizi mambo ni wasting time. Hao wabunge wana wasting time for the people. Kuna vitu mingi ambavyo wabunge wakaa chini wajadiliana kwa sababu hata sahi mambo ya airport iko hapo wamenyamaza.
Saizi ni kesi kwenye koti kuhusu kubanduliwa kwa kiti wa naibu wa rais. Naomba tuzingatie hayo.
Kama kesi yake iko kwa mahakama, tutangoja mahakama akiamua atakuwa wa naibu wa rais. Koti akisema yeye ameshatolewa, well and good, but mimi ningependa kumwambia Gachagua kama ana sense danger atoke hapo, aunde chama yake mapema, hata kama ni leo atoke, resign immediately. Hakuna kitu anafanya hapo. Asante. Asante
sana. Na ndugu yangu, karibu kwenye runinga yetu. Naomba ujitambulishe kisha utupatie maoni yako kuhusu changamoto hili.
Okay, kwa majina naitwa Gordon Ochieng. Historia ya Gachagua sioni kenye naniletea. First of all, hii historia wabunge kuharakisha ama Senate kuharakisha kwa hii mambo. Wangetuletea kitu ingine very important, like sahi tunateseka, wagonjwa wanateseka, hauwezi tumia hiyo sha yao. I don't know what is that. First, hiyo sitting allowance wenye walikula, hiyo pesa ilitosha wa Kenya wengine kwenda hospitali. Sasa story ya Gachagua kila siku mara nini, yeye si unga. Alitolewa aende. Tujua alikuwa na prideness ingine hapo, anatutusi. Are you getting? Alikuwa anatutusi sana sana sisi watu wa Jaluo. Sasa watu wasikie tu ile pain. Tulikuwa tunasikianga wakati wanasema sijui Raila mzee ule mtu wa mganga. Sasa yeye ni nini? Kama alikuwa anatumia maombi. Si maombi msaidie. Mwenye lisaidia wakina Musa, Noah, amsaidie. Sisi hatuna hiyo nini ati tukae tuangalie Gachagua anatolewa ati arudi sijui Nyeri. Aende tu na kama anataka kuenda kotini, hizo ni waste of time. Kenya nimejua ukipigana na bwanako, alafu uende useme zile maneno za uongo. Alafu bado mama ya msana anasema ati rudi tu ende ukae na ule bwanako. Unaweza? Sasa Gachagua aende tu baba.
Asante sana kwa maoni yako. Sasa baba, karibu. Naomba jitambulishe kisha utupatie maoni yako kuhusu kesi ambayo tayari inasikizwa kwenye kotini kuhusu naibu rais.
Kwa majina naitwa Tenga, mimi ni mkaaji wa Kisumu. Ile kitu ambayo nilikuwa nataka kusema, hata sisi kama wananchi tunalea hii kesi inamaliza muda. Tunataka kotini wamalize hii kesi, Gachagua aende nyumbani. Kwa maana hata akirudi wawezi fanya kazi saizi na Ruto. Kwa maana tayari saizi wasikilizani, hata mtu haizi ongea na mwenzake. Gachagua kesi hisa, Gachagua aende nyumbani. Kwa maana unaona hii ulimi inaweza choma dunia. Gachagua ili kitu imeuza Gachagua ni ulimi yake. Anaongea mambo machafu hata hizi saidia watu wa Kenya. Kama wewe ni vice president wa Kenya, unaongea juu ya mlima kila saa. Huwezi ongea juu ya Nyanza, Western, Rift Valley, unaongea juu ya mlima. Hiyo kitu ndio imeuza Gachagua. Gachagua aende nyumbani, ama kama anataka aingie kanisani tuhubiri na yeye, hata mimi pia ni mhubiri. Tuende kanisani tuhubiri na yeye, aache mambo ya siasa. Kwa maana mambo ya siasa Gachagua ameisha, aende nyumbani, atulie polepole.
Asante sana, na tukijiunga pia na mama kwa mara ya kwanza, labda tupatie maoni yako ni yapi? Je, ni tofauti na yale ambao wanaume hapa wamezungumza? Naomba ujianze kujitambulisha kwa majina.
Kwa majina naitwa Priska Nyango, mimi ni mkaji wa Kisumu hapa. Mimi kwa upande wangu na Gachagua, sioni kama Gachagua anafaa kwenda nyumbani. Gachagua siende nyumbani. Ama watu walikuja kufanya kazi pamoja, wafanye kazi, walete amani kati yao. Gachagua malize kazi yake. Masaa ni machache, muda ni machache, miaka ni miaka 2-3. Tafadhali president, fanyeni kazi pamoja, msikizane. Hii mambo ya kurusha Gachagua nje nini iishe. Mtu ukosa na mtu anasema ashaomba msamaha. Tafadhalini umsamee Gachagua, aendelee na kazi yake, afanye kazi yake. Asante sana.
Asante sana kwa maoni yako hayo. Kama unavyosikiza, maoni ni mbalimbali. Kuna wale wanaosema Rigathi ama naibu rais angolewe tu kwenye mamlaka aende nyumbani, lakini mama wa mwisho hapa kuzungumza amesema yeye maoni yake angependa tu rais labda amsamehe tu naibu wake ili waendelee kufanya kazi kwa pamoja. So ni hayo tu, lakini tutazidi kuwaletea taarifa mbalimbali kama itakavyojiri hapo wakati mwingine, labda wakati wa saa 7 kwako studio.
Asante sana Judith. Mtazamaji wangu ni kwamba kutoka Kisumu ni mama mmoja tu ambaye anamhurumia naibu wa rais aliyeng'atuliwa Rigathi Gachagua, huko wanaume wakisema Rigathi anachelewesha sherehe ya Kithure Kindiki. Sijui mtazamo wako Jared ni upi? Wanasema mahakama pia ama mahakama isiweze kukubali kukuwe na muda mwingi wa taifa kuweza kungojea mwongozo, wakisema sherehe inachelewa, lakini kwa kweli ni kwamba wanataka pia mwongozo wa taifa kuweza kusonga mbele.
Nadhani ni vizuri pia kuelewa Wakenya wengi haswa tunavyofanya hizi kesi. Ni mara ya kwanza tumefanya kesi ya impeachment ama kubanduliwa kwa naibu wa rais. Kwa hivyo kuna hisia kali, kuna kila mtu anangoja, kila wakati kila mtu anangoja, anatazama runinga, anaangalia je nini kimetokea, nini kimefanyika kotini. Kwa hivyo sidhani Wakenya wengi wanafahamu kuwa jambo hili linaweza kuchukua muda mrefu, na ni vizuri kila mmoja tuwe na subira, kwa sababu kama umesikia koti ilivyosema, tuko hapa kufanya haki. Hata kama kesi zimefika 28, hata zingine zikiongezwa, kila mtu ana haki ya kuwasilisha kesi yake na kusikizwa.
Naam. Aha. Mtazamaji wangu, nataka sasa tuelekee kaunti ya Uasin Gishu, maeneo ya Eldoret, ambapo mwanahabari wetu Steve Keteriko ange kabisa kusema na wana kaunti wa Uasin Gishu. Keter, sijui upo wapi, unasema na Wakenya upande huo wana maoni gani? Wanafuatilia vipi hatma hii ya naibu wa rais aliyebanduliwa Rigathi Gachagua?
Naam Lois, kwa kweli wakaazi wa jiji hili la Eldoret, kaunti ya Uasin Gishu, wamekuwa wakifuatilia kwa makini sana mchakato mzima wa kumbandua Rigathi Gachagua kama naibu rais, na walikuwa wakifuatilia shughuli hii kuanzia ilipoanza hadi kufikia sasa. Mapambano yamefika kotini. Wacha tutupate maoni yao kuhusu hadi kufikia sasa shughuli nzima imefika kotini. Wewe kama mkaazi wa Eldoret waonaje hili?
Okay, kwa majina kamili mimi ninaitwa 64 Live. So tumefuatilia vile mambo ilikuwa inaenda kwa vyombo vya habari, tulikuwa tukifuatilia kwa TV. So kwa maoni yangu nataka niseme kwamba si mbaya kwa hiyo hatua ambayo wamechukua. Hizo cases zote wamefainiwe petition 2. So wakienda pale nataka niseme kwamba Rigathi Gachagua ambaye alikuwa naibu wa rais wa Kenya, sisi tukiwa Rift Valley tukukuwa na tatizo lolote. Nataka tu niseme kwamba Rigathi Gachagua yale mambo ambayo alifanya yeye akiwa na president na wote wa ndani wa serikali, sijui ni wapi walifanya makosa, lakini sisi kama wananchi tuwezi kulaumu tuseme Rigathi Gachagua alikuwa na makosa. Lakini licha hiyo yote ni kwamba Rigathi Gachagua imeonekana kwamba finally ataenda nyumbani, maana ninaangalia vile lawyers mambo zinaenda, lakini tunaona kwamba finally Rigathi ataenda nyumbani. Nataka niseme kwamba hata kama Rigathi Gachagua ataenda nyumbani, nataka tu niombe wa Kenya peace. Mahali kutakuwa Kenya mzima yote tuwe na amani. Kwa sababu gani niseme hivyo? Hii Kenya ni kubwa kuliko mtu mwingine. Hii Kenya iko beyond hata president mwenyewe. Nataka niseme kwamba kulikuwa na changamoto kweli, tumefuatilia vile mambo ilikuwa inaenda, pengine kulikuwa na haki umefanywa ama haki haijafanywa. Lakini niseme finally kwamba judicial mambo ya parliament imeamua na senate imeamua na finally iko kotini. Nataka niseme kwamba Rigathi Gachagua mambo itapotoka kotini, ninaomba unisikize mimi 64 Live nikiwa Eldoret, maana watasema kesi imekatwa hivi ama ikatwa hivi. So ninabidi ukubali ndio watu wengine wafanye kazi. Sisi pia kama tukiwa bonde la ufa hapa, tunashukuru rais ambaye ni president wetu William Ruto, maana tunasubiri kwamba tukiwa hapa Silver Line tukielekea sehemu za Nandi, tuliona machines zikikuja, tunaambiwa kwamba pengine tutaundiwa hii njia ya kwenda Kapsabet. Tumesikia mambo kama hiyo. So tunafurahi. So hiyo ndio kazi tunasema, Kindiki ukiingia kwa ofisi kuja anzia hapa, panua hii barabara iwe kubwa vile tuliambiwa. Na mambo ya Eldoret kweli kuna vile tuko na shida kidogo, lakini shida ambayo tuko nayo ni za barabara na mambo ya mahindi. Bei ya mahindi kidogo imekuwa shilingi 50 kwa gorogoro kwa sasa. So nataka niseme kwamba rais umejaribu, mimi ninakupa pongezi, umejaribu. Licha kuna changamoto, nataka niambie wale wa Kenya wengine wanaona kwamba if wewe ungekuwa rais leo, ama wangeweka baba yako awe rais, ama waweke mama yako awe rais, mambo ingekuwa vipi? Tusilaumu rais. Kuna changamoto, kuna mambo mengi, nataka uangalie ingekuwa ni wewe ungefanya jambo livi. So sisi tukiwa maeneo za Eldoret tunataka tushukuru na tunaenda namna hiyo. Deputy President ambaye atafika Kindiki Kinduri, tutakupea congratulations na tunakupa support na tunajua wewe ni loyalty, unaamini rais. So tunasema kwamba mubarikiwe. 64 Live, God bless you.
Naam, ndio maoni ya kijana. Tupate maoni kutoka kwa mzee. Anza kwa jina lako.
Bas, kwa maoni mimi naitwa Henry Moshin kutoka Uasin Gishu County. Siku ya leo ningependa kutoa maoni yangu, na ni maoni yangu, sio maoni ya wengine, ni maoni yangu. Na maoni yangu mimi nataka niseme tumeona tulikuja public participation, tumemaliza. Kotini jana tukaona yao, wamesema mambo inamlalia deputy president, na tunataka sasa tuende mara moja, kwa sababu watu hawafanye kazi, watu wamesimama hawana mahali pa kufanyia kazi. Na tunataka, na unajua mtu mmoja akiwa pending Kenya yote iko pending. No, so tunataka hata hiyo kitu iweze kuwekwa hata Supreme haraka sana, na Supreme waweze kukata haraka sana, kwa sababu tunangojea tu Supreme Court. Na tunataka Supreme Court waweze kukata hiyo kitu haraka sana, na tupate deputy president mara moja na kazi iendelee, kwa sababu unaona saa hii kila kitu imesimama. hata ngawaje tunafuatilia na sisi watu ya bonde la ufa, tuko nyuma ya rais, hatuko nyuma ya mtu mwingine, tuko nyuma ya rais wetu President William Ruto. Mahali Ruto anasema tulalie, tunalala hapo mara moja, hatuwezi lala nje, na tunataka kama ni kuendelea hiyo kesi iwekwe Supreme haraka na ikate na tuendelee mbele. Na tunaona Supreme haiwezi kalalia mahali ingine, tunaona mahali rais ako, tunafuatilia na tunaona, na sisi tunasema bonde la ufa, rais wetu tuende mbele. Bei ya mahindi imeenda chini, tuwekee bei ya mahindi. Saa hii tunatoa mahindi tuwekee 14,500. Hatuna maneno ingine, asante sana. Alafu hapo ingine tutaona.
Naam, ni maoni ya mzee Moshina akisema maoni ni yake binafsi, si ya mtu mwingine. Tupate mzee mwingine hapa. Anza kwa jina tafadhali.
Kwa majina mimi naitwa Kairo.
Takushikia.
Na ni mwenyeji wa hapa Uasin Gishu, ya kwamba sisi watu wa Uasin Gishu tunaona hii maneno ya taniboi na dereva. Dereva kama hataki taniboi, dereva ashuke na aende. Sisi ile kitu tunangoja ni sherehe, sababu vile iliamuliwa na bunge, na sisi ndio tulipeleka hao wanaume wenye wako bungeni. Kama wamerudisha kwetu, sisi ndio tajiri ya dereva na taniboi. Kwa hivyo taniboi ashuke, dereva endeshe lori ifike Malaba na kazi iendelee. Mwenye atarudi kama ni Kindiki, sherehe ianze hata kama ni saa hii. Sisi tunashukuru hiyo kitu ya mahindi na ngano ndio mambo sisi tunataka. Mnaona condition ya hewa na mvua, tupewe bei ya chakula tuendelee sisi. Nashukuru.
Naam, ndio maoni ya mzee Kairo. Wacha tumpate kijana hapa. Hamna kijana yote hapa. Haya, ndio kijana hapa. Tuanze na jina lako. Umesikia wazee wanavyosema. Lakini wengi wametupa ile tetesi kwa bei ya bidhaa ambazo zinapatikana huku kama ngano na mahindi, bei iko chini. Wangependa iweze pengine kwa rais aweze kuangalia. Wewe maoni yako ni gani?
Mimi naitwa Robert, mimi ni mkazi wa Uasin Gishu County. Maoni yangu ni kwamba hii kesi ya Gachagua, Gachagua is wasting time. Gachagua atoke aende nyumbani, Kindiki ashike usukani ya kuwa naibu ya rais, serikali iendelee mbele. Maneno ya bei ya mahindi ni kwamba wakati wazee wetu ama wazazi wetu walinunua mbolea na bei ambayo iko juu. Kwa hivyo tunaomba serikali ya William Ruto, kwa sababu hiyo ndio kiteka uchumi hapa Uasin Gishu. Tunaomba yeye ahakikishe kwamba bei ya mahindi ni bei ambayo itahakikisha wazazi wetu wanalipa school fees January ikifika, wazazi wako na pesa ya kujitibu in case kuna maneno ya matibabu, kwa sababu tunaona hii maneno ya SHIF haifanyi vizuri. Wazazi wetu wanategemea mahindi. Jambo lingine ni kwamba bei ya mahindi inasaidia kwa sababu wakati huku Uasin Gishu wakati wa Disemba kuna sherehe mingi na wazazi wanategemea hiyo mahindi kusimamia maneno ya sherehe na mambo mengine. Kwa hivyo tunataka Mheshimiwa Rais hata akikuja Uasin Gishu hakikishe kwamba bei ya mahindi ni 5,000 kwenda juu. Sio bei ambayo imeanza. Najua kwamba hawajafungua siri, lakini hivi karibuni wahakikishe kwamba bei iko juu. Maneno ya impeachment iishe haraka. Hii ni sarakasi. Unajua tukiendelea na kesi kotini hakuna maendeleo serikali itafanya. Kwa hivyo ni muhimu kwamba kesi ya Gachagua iishe, aende nyumbani. Gachagua anajaribu kubuy time, lakini cha muhimu ni kwamba hiyo kesi iishe, Kithure Kindiki apate kuwa deputy president, serikali iendelee na mikakati yake. Asante.
Na tumpate kijana mwingine. Wapi kijana? Baadhi ya maombi kutoka kwa mawakili wa upande wa serikali ni kwamba mahakama iweze kutoa lile agizo ambalo liliweza kusitisha kuapishwa kwa Kithure Kindiki kuwa naibu wa rais. Pengine hadi kufikia sasa waona sheria imefuatwa vilivyo, ama maoni yake ni gani? Anza kwa jina tafadhali.
Kwa majina naitwa Kevin Kiblaga Truto. Mahakama ambayo imefanyika, mambo mengi yameendelea mahakamani, ni kwamba Kithure Kindiki ajilasalimisha tu aende nyumbani ili haache serikali ya uhuru ya President wetu William Ruto iweze kuendelea mbele pamoja na naibu wake Kithure Kindiki. Maoni yangu ni kwamba wacha wapatie serikali ifanye kazi. Kithure Kindiki naibu ambaye atachaguliwa kuwa naibu mkuu Gachagua apewe nafasi ili kazi iweze kuendelea mbele. Asanteni.
Shukrani. Tumpate mwingine. Haya, anza kwa jina tafadhali.
Kwa majina ni Jeremiah Kibet Sawe, mimi nikiwa mkaaji wa Uasin Gishu, nikiwa chairman ya UDA.
Sisi tunasubiri mambo ya kotini ifike saa 8. Hakuna kazi yenye tutafanya saa hii, lakini tunataka kotini ifanye haki, na tunataka tu Rigathi Gachagua ambaye alikuwa naibu wa rais atupe tu hii kesi juu wa Kenya wanangojea kufanyia kazi, kwa sababu wakitupeleka kotini ata waste time na wakazi na Wakenya wanahitaji kufanyiwa kazi. Kuna kazi mingi ambayo ingekuwa imeendelea, lakini hii mambo ya kesi itatuletea shida. So tunaomba tu Rigathi Gachagua atupe tu hii kesi, kwa sababu hii Wakenya wanahitaji kufanyiwa kazi. Wewe Rigathi Gachagua, tupa hii kesi mara moja.
Mwingine tumpate jamaa wa bodaboda. Anza kwa jina tafadhali na utupe maoni yako.
Naitwa Oscar Rashe, ndio jina langu. Mimi ni mkazi wa hapa wa Sindikisho. Mambo ya kesi vile imekuwa ikienda, mambo ya Rigathi pamoja na Kindiki, ni wazi kuwa mambo hii ni kupoteza muda. Maanake tayari tulisi tunajua naibu wa rais wa Kenya hii ni Kindiki. Tayari alichaguliwa na bunge. Maanake bunge likishamaliza kumwimpeach mtu, malafu senate iweke rubber stamp. Ni kusema huyu jamaa hata akifanya nini kwenye kesi, hakuna mahali anaenda. Tayari ni kutetea tu ajiweke safi, lakini hawezi kufanya kazi na rais mwenye yako, maana tayari washakosana. Lakini kingine cha pili, yeye mwenyewe ameamuka kwenye ugonjwa akitoka akasema hii mimi mara nataka kuuawa, mara nini, kumaanisha sasa uhusiano wao imeisha. Yeye kama Rigathi aelewe serikali lazima iende mbele, ajiweke kando, tunangoja saa 8 waapishe Kindiki. Hiyo ndio mama tunaweza kusema. Kitu kingine mingi ya sarakasi na maloya kufanya story hiyo, wanakula pesa ya Rigathi bora. Wana buy time. We don't need it. Sawa, asante, wewe na wakati mwema.
Sasa kijana mmoja tu kwa ufupi, kijana mmoja kwa ufupi sana.
Sawa. I can talk in English.
Kiswahili.
Sawa. Ni asante sana kwa fursa hii tumepata. Tukuje tuchangie maoni ya Rigathi na Kindiki. Kwa maoni yangu naona vile kwa majina yangu kwanza naitwa Kiprono, mimi ni mkazi wa Wasingishu, niko hapa Eldoret. Sasa kwa maoni yangu kwa ufupi ni kwamba Rigathi aache hii kesi kufuatilia. Juu sasa kama boss wake ameamua kwamba Kindiki ndo anakuja kumteua kuwa naibu wake, aache hii kesi, atupilie mbali, tuanze kufanya kazi, waanze kutufanyia kazi. Asanteni.
Naam, shukran sana Lois. Ndio maoni tu ya wakazi wa eneo hili la Eldoret, kaunti ya Uasin Gishu, na wewe mwenyewe umekuwa hapa kwa muda mrefu sana, na wajua awangewacha fursa hii ipite bila kurusha ombi moja au mbili kwa rais kuhusiana na bei ya ngano au mahindi. Kwako Lois.
Asante sana mwenzangu Steve Keter. Bila shaka Uasin Gishu ni marafiki zangu sana. Hivi niseme ni kama familia yangu, walikuwa marafiki zangu sana. Wasalimu na rais, nina imani anatazama NTV ama wandani wake wanatazama, na wameona wakulima wangu kutoka kaunti ya Uasin Gishu wanaomba mahindi bei iwe 14,500 kwa gunia la kilo 90. Tutasubiri hilo. Tuelekee kwako Jared. Umesikia hisia zilizotoka kaunti ya Uasin Gishu nyumbani pake Rais William Ruto. Hisia ni mseto. Kuna wale ambao tayari wamemsindikisha Rigathi hadi Mathira. Kuna wale ambao wanasema mahakama kuu ifanye haraka tuelekee mahakama ya upeo. Wengine wakihoji kwamba swala hili limefanya wasisonge, wanashindwa kuendelea na biashara zao, taifa limesimama.
Na msidhani taifa limesimama. Kama unavyoona kuna maduka hapo ambayo yamefunguliwa. Kuna nadhani ni hamu ya watu kujieleza, kusema jinsi ambavyo kubanduliwa kwa rais kumewafanya kusikia kama wananchi, na ni haki ya kila mmoja kujitetea na kusema ambavyo ameathirika na kesi hii ya Rigathi. Manake ukienda na county tofauti unapata hisia zinabadilika. Na ni vyema pia kuona, nadhani nchi haijasimama. Sidhani uchumi umesimama, lakini kuna ile hamu
tu. Kisumu wanasema sherehe imesimama.
Kisumu wanasema sherehe imesimama. Wanasubiri profesa achukue uongozi, aendelee. Nadhani wanampenda, labda ni mtu anayemfahamu. Kwa hivyo hisia ni tofauti na kali, lakini hoja kubwa ni kwamba hamu ndio kubwa nchini.
Jared, turejelee Milimani ambapo muda mchache uliopita tuliona Jaji Eric Ogolla akitoa mwongozo wa mahakama ya juu kuhusiana na mawili matatu ya leo. Kikuu zaidi ni kesi hizi za naibu wa rais zilizokuwa zaidi ya 20 zimejumlishwa na sasa zimewekwa katika sehemu mbili. Kando na hilo, tumeona mawakili wa Rigathi Gachagua wakileta maombi fresh ama maombi mapya katika mbele ya mahakama. Tumemwona huyu wakili Kibe Mungai akiomba mahakama kuu kuwapa siku 3 ili wote ambao walikuwa wamejumlisha katika malalamishi yao waweze kuwapa majibu. Tena majibu anasema anataka ambayo yamenakiliwa kikamilifu. Maoni yako kuhusiana na hilo ni lipi? Je, tunaona mawakili hawa Rigathi Gachagua kila siku ya Mungu wakija na maombi tofauti mbele ya koti, ingawa kikamilifu ni haki yao, Jared?
Naam. Nadhani tunatazama mitindo tofauti ya mawakili. Kila mtu analenga jambo tofauti kesi inavyosonga. Kuna mrengo ambao unalenga kusimamisha Profesa Abraham kutoa uongozi. Na kesi inavyosonga ama jinsi kesi inavyosonga ndivyo profesa hata chukua uongozi. Kuna wengine wamekuja kotini wanataka orders zilizo pata Kerugoya. Nadhani ni Jaji Richard Mungo alikuwa ameketi Kerugoya. Wanataka kesi hiyo isikizwe leo, na nadhani azma yao ni kuwa wapate nafasi ya kumwapisha Profesa Abraham. Kwa hivyo kama malengo ni hayo, basi mitindo itakuwa tofauti ya mawakili.
Kweli.
Kwa sababu unapowasilisha kesi yako petition, kuna sheria tunazofuata kotini kama mawakili unapowasilisha kesi. Niruhusu nikupe mfano. Unapowasilisha kesi yako petition kotini, anayefaa kujibu ama unayemtaja kama anayefaa kujibu ana siku 14 kujibu. Bas, lakini jambo ambalo unaona kuna kesi petition ambayo nafahamika kama main petition substantive hearing. Lakini kuna applications ambazo zinawasilishwa kotini ili upate uamuzi wa koti kwa mambo ambayo tuseme yanaendelea yanaweza kudhuru unavyoendelea na kesi. Hizi application ndizo zinasikizwa mwanzoni kabla turejelee kwa kesi. Kwa hivyo labda unavyoendelea, sijui kama alikuwa anamaanisha apate majibu ya the application ama the main petitions, lakini hivyo ndivyo unavyoona mitindo ya mawakili. Lakini jambo muhimu kwa wasikilizaji wako ni kuelewa ya kwamba koti imesema. Kumbuka hawa majaji pia ni wanasheria.
Kwanza huyu Eric Ogolla amewaambia sio nafasi ya mimi kama jaji ama wewe kama wakili kumshurutisha mshtakiwa, tumuite mshtakiwa kwa minajili ya mtazamaji wangu, ikiwa nimekukosea na umenipeleka mahakamani na umeomba nitoe nijibu. Nikose kujibu katika muda ambao umenakiliwa kisheria. Huyu jaji Eric Ogolla anasema sio nafasi ya koti wala mawakili kumshurutisha mshtakiwa kuweza kujibu. Hivyo basi amesema kama hamjapata majibu, njoo mbele yetu mseme tulimshtaki fulani fulani lakini hatujapata majibu. Sasa sijui hapo itakuwaje, watakubali ama bado watasisitiza wanahitaji siku hizi 3?
Na sheria pia ambazo umesikia zikitajwa za Mutunga zinakubali koti kuendelea kama koti mtu hajajibu mashtaka ambayo yamewasilishwa kotini. Kwa hivyo nadhani jaji pia wanapoangalia hawa mawakili wanahisi kwamba kwa sababu kila mtu ana malengo tofauti, kuna vile wangetaka kuchezea koti shere kidogo, na koti linaonekana kukerwa na hoja hiyo sana. Na kwa wanasheria kama sisi
ndo mitindo yenu. Pengine hata tukipata kotini, Jared,
Mimi mimi ningechukua mtindo tofauti. Na si vyema kama mwanasheria kufika kotini kushurutisha jaji, hata kama una ombi ambalo ungependa kuwasilisha ambalo linaweza kumfanya jaji kusikia upande mmoja ama mwingine, ni vizuri kuwasilisha na heshima. Usikae ni kana kwamba mnapigana na koti.
Tulimwona yule wakili Njeru ambaye vile vile ni mmoja wa mawakili wa naibu rais aliyekatiliwa Rigathi Gachagua akimweleza jaji, mbona hujamakinika, ni kama ambaye unisikilizi unanisikiliza.
Naam. Ni jambo kama ulivyoona lilikuwa limekaribu kumkera jaji Eric Ogolla. Lakini kama nilivyosema ni mitindo ya mawakili. Mimi ningekuwa kotini labda ningechukua mtindo tofauti, kwa sababu najua anayeketi mbele yangu ni mwanasheria kama mimi, amefanya masomo ya sheria, ana ubabe wa kusikiza kesi hizi za kikatiba. Kwa hivyo hata anapokusikiza yeye pia ana ufahamu kuhusu kesi yako ama maombi ambayo ungependa mahakama kukukabidhi. Kwa hivyo ni vizuri hisia ambazo unazisikia kwa wananchi unaziona kotini, kwa sababu wanasheria pia ni binadamu kama mimi na wewe. Kwa hivyo unaziona pia kotini, ingawaje ni zinafanywa kulingana na sheria za koti. Lakini koti imesema hakuna mtu atakubaliwa kuchezea koti sheria, na ni jambo ambalo nakubaliana nalo
na huyu jaji Eric Ogolla. Swala lingine ama maombi mapya ambayo upande wa naibu rais aliyengatuliwa Rigathi Gachagua wameweza kuwasilisha mbele ya koti. Kuna huyu wakili, bado sijapata jina lake, alikuwa amevaa suti nyeupe hivi. Anasema wanataka stakabadhi waweze kupoa stakabadhi ambazo zinanakili yote ambayo yamekuwa yakifanyika kuanzia siku ya Jumamosi hadi siku ya leo. Sijui wameomba hilo kwa minajili gani, lakini amesema hayo ni baadhi ya masharti yao pindi wanaposonga kikamilifu katika kusikiliza kesi muhimu ya saa 8 mchana. Wanasema wataka wapewe stakabadhi ambazo zinanakili yote ambayo yamekuwa yakiendeshwa kotini kufikia mchana wa leo.
Nafahamu kwamba haya ni mambo ya kawaida. Unapotupata kotini ni mambo ambayo tumezoea kufanya. Kwa hivyo si ombi geni ama ombi la kustaajabisha sana. Kuwa wangependa nakala ama rekodi ya koti wapase kupata. Lakini unajua pia nakala hii kwa wakati mwingine inachukua muda kupata. Lakini mwishowe unapata unapotayarisha kesi ama almaarufu submissions kotini, muda huo utakapofika. Lakini nadhani kwa sababu amewasilisha ombi, koti litaamua ni muda upi ambao atakuwa anapatiwa nakala hizi. Kwa sababu pia kumbuka wafanyakazi wa mahakama pia sio wengi. Kwa hivyo wakati mwingine tuna matatizo hayo wakati mwingine kotini kupata kwa muda, lakini mwisho unapata ili kesi yako uitayarishe vizuri na uwasilishe mbele ya majaji.
Aidha wametoa mwongozo kwamba pia wanataka kurekebisha baadhi ya stakabadhi ambazo waliweza kuwasilisha mbele ya mahakama. Je, hilo lina umuhimu gani katika kesi hii? Maanake ifahamike mwendo wa saa 8:30 kuna mengine yanatarajiwa. Lakini wanasema kando na nyinyi kuweza kutoa mwongozo, kuna vitu vingine ambavyo tunaomba kurekebisha. Na hii ni sheria. Hivyo pengine wataleta masuala ambayo ni mapya ama ushahidi upya.
Wafahamu kwamba jopo litakaporejelea nadhani ni saa 8:30 litakuwa utasikiza uamuzi wa kesi 3 za kujiondoa ama kubanduliwa kwa jopo. Haya mambo yanafanywa awali kabla kesi kuanza. Kwa hivyo kumbuka nilikuwa nimekupa muda ambao mtu anaruhusiwa kujibu mashtaka.
Ulisema siku 14.
Kuna siku 4, that is the petition kulingana na sheria za mtunga.
Siku 4 ama 14?
14. Naam. Na kuna ile inaitwa appearance kama wewe sio mwanasheria mkuu wa nchi ama kuja kotini kama wakili wa kitengo chochote cha serikali, una siku 7 kufanya appearance, kujiwasilisha kotini rasmi, lakini siku 14 kujibu. Lakini nadhani wanataka majibu ya applications hizi ambazo umezisikia zinakuja under certificate of urgency. Nimetafuta lugha ya Kiswahili kapotea kidogo. Kwa hivyo hapa ndipo unatazama wangependa majibu, lakini kama koti ilivyosema, si mahali pa koti kueleza mwanasheria jinsi atakavyopeleka kesi yake. Na kama ungependa kurekebisha, unarekebisha pia na ruhusa ya koti. Kwa hivyo kurekebisha pia si ombi geni ama si ombi ambalo la kustajabisha.
Inakubalika.
Wanapowasilisha ombi, koti itaangalia na iwape ruhusa ya kurekebisha maombi yao ama kwenye stakabadhi zao.
Tuje upande wa washtakiwa. Tumemwona huyu wakili George Murugara ambaye ni mwenyekiti wa JLAC akiomba mahakama kujisitiri kwamba waweze kushughulikia kesi ambayo ilikuwa ya Kirugwa na Milimani ambayo ishajumlishwa. Akisema haya mengine sasa ni vigezo na tunapoteza muda.
Sasa huo ndio mtindo wa upande huu. Kama unavyoona, wao pia wana mtindo wao wa kuwasilisha. Nadhani wao wanajizuia hisia zao kali zisionekane sana kotini, kwa sababu pia wanaonekana kugadhabishwa na huu mrengo wa aliyekuwa naibu wa rais, jinsi ambavyo wanaonekana ni kama kuna vurugu kidogo kotini. Ama wangependa kesi iende mwendo wa kobe kidogo.
Lakini pia wamekuwa wakisema na ni mwongozo ambao utapata saa 8. Pia hawataki majaji hawa 3, wanaomba wajiondoe.
Ni kwa hivyo mambo haya kwa kawaida kama nilivyosema sio mambo ambayo ni mageni kotini. Wanasheria tunakumbana na mambo haya. Kwa hivyo ombi hilo pia ni ombi la kushawishi koti. Utakaposikiza ombi la kujiondoa, la jopo kujiondoa, tungeomba kama mtabaki tuendelee na ombi letu
mzima
moja kwa moja bila kupoteza muda, ndivyo tuweze kumaliza. Manake kumbuka azma yao kubwa ni mahakama ilipoamuru mambo Profesa Abraham asichukue uongozi, basi haja yao kubwa ni mahakama iondoe orders kama hizo, ndipo waweze kumwapisha. Kwa hivyo ni azma hapa na wanasheria kidogo utapunguka, lakini haja kubwa yako na kwa watazamaji ni kuona kila mtu ana lengo tofauti.
Tuangalie sasa upande wa majaji ambapo walikuwa wanasikiliza. Aliyesema kwa niaba yao ni Jaji Eric Ogolla. Cha kwanza amesema hawakunuia kesi hii kuchukua mkondo mrefu sana, ikizingatiwa umuhimu wa mashtaka haya. Manake kwa sasa taifa halina naibu wa rais.
Kumbuka walipofika jana kotini, walikuwa wamepatiwa mwelekezo wa jinsi koti itakavyosikiza kesi zao leo. Asubuhi wakaambiwa tutakuja kukusanya kesi zote nyingi na kuzipanga kwa pamoja. Saa 8 tutakapokuja tutasikiza kesi ambayo imewasilishwa ya jopo kuondolewa. Kwa hivyo nadhani jaji pia hakutaka kusikiza maneno mengi. Kama nilivyokuambia, mimi mwenyewe nimeona kuna hisia za kukerwa ambazo naona kwa majaji, na ni vizuri pia kuwapa heshima yao, kwa sababu kama wao pia ni wanasheria, wanafahamu ni nini haswa ungetaka kotini, ni vipi ambavyo unaweza kuwasilisha kesi hii, na je unaiwasilisha kwa njia ya heshima, unaheshimu koti, unaheshimu wanasheria wenzako. Kwa hivyo ni mambo ambayo kwa kimombo tunasema it's a delicate balance, na ni kazi gumu, manake chochote anachokifanya kinatazamwa kwa makini zaidi kushinda kesi ambazo angezifanya kwa kawaida. Na pengine uzani ni sawa na kesi hii, lakini kwa sasa macho ni kwa makini zaidi
kwa hawa jaji watatu.
Naam.
Kwa majibu yake aliweza kusema haya mambo yote baada ya mawakili wa Rigathi Gachagua kusema yao, mawakili wa serikali vile vile kusema yao. Huyu jaji Eric Ogolla amesema sasa tusubiri saa 8.
Naam.
Hayo ndio maneno yake ya mwisho.
Naam.
Wao wakitaka kuongeza, hawa wakitaka kusema tusubiri sana. Pengine endelea.
Ni kwa sababu ushawasilisha ombi kwamba jopo lijiondoe. Kwa hivyo kabla tusikize chochote, tuamue tunasonga mbele ama Jaji Martha atateua jopo lingine kusikiza kesi hizi.
Au hivyo basi hawezi kujadili haya masuala ya siku 3, haya masuala ya stakabadhi mpaka wajue kama hili jopo linaendelea.
Na ndivyo ambalo nilisema, na kwa kimombo nasema preliminary ama nafanywa awali kabla kesi ambazo wamewasilisha kusikizwa. Manake pia kama ulivyosema, na ni kweli hizi kesi pia ni nyingi, na zote ukiziangalia zina jambo linaitwa applications. Kwa hivyo tunasikiza applications kabla kusikiza the main petitions. Kwa hivyo ni jambo ambalo nahurumia hao majaji wana kazi, kwa sababu pia mawakili ambao wamewasilishwa pia unapoona mawakili 30 kotini, ni vizuri kuelewa ya kwamba hapo kutakwaruzana kidogo, kutakuwa na mshike kidogo, na ni jambo la kawaida, lakini mwishowe tunatazamia kila mtu kwamba haki itafanyika.
Bila shaka ilinishtua ama ilinishangaza kuona hata wakili akiwaambia jaji, jamani makinika kama umezubaki
na kama tulivyozungumza, kwangu nisingesema hivyo. Si vizuri kumshurutisha jaji kwa kesi ambayo ungependa akupe akubaliane na maombi ambayo unataka mahakama ifanye. Sio kwamba hata kufanyia haki, ni kama nasema presumption, rush to judgment ni kama kumwamuru pia sikiza navyosema. No.
Na awali tuliweza kuzungumzia swala hili la upande wa naibu wa rais aliyeng'atuliwa kupitia bunge Rigathi Gachagua kuweza kuwa na mashtaka dhidi ya watu wengi. Kwa mfano, kuna wale ambao wametajwa ikiwa ni vyama vya kisiasa, kwa mfano chama cha UDA. Hicho tunaweza kuelewa, manake ni basi ambalo waliabiri pamoja na William Ruto hadi Ikulu. Lakini vyama hivi vingine, kwa mfano Amani National Congress, Wiper na Ford Kenya, umuhimu wake ni nini kuweza kujumlishwa katika mashtaka haya?
Ufahamu kama ambavyo tumeeleza hapo mwanzoni, ni jambo la busara kuangalia kwamba wanaofanya kesi hii, wanaounda kesi hizi, wanaoziandika stakabadhi hizi, wana mitindo tofauti, skuli zao ni tofauti, walifunzwa na mawakili tofauti. Kwa hivyo sielewi, manake pia kesi ni nyingi, sijapata muda ya kupitia zote, nikupe kwa ufasaha. Hivi ndivyo wangependa kushtaki UDA na chama kingine ambacho wangependa kushtaki. Kwa hivyo kwangu nadhani kesi ambayo ni kubwa ama hoja ni kubwa ni kwamba naibu wa rais angependa uamuzi wa seneti ugeuzwe. Hiyo ndio hoja kubwa. Atamkwe kwamba yeye bado ndiye naibu wa rais nchini, na na uamuzi wa seneti koti iamue kwamba uliambulia patupu ama ni kama tuanze mwanzo tena. Hizo ndizo hoja kubwa. Hizi zingine unajua unapofanya kesi yako kuna mambo mengi yanayopitia kichwani. Kuna ile naita strong points, na kuna zile zingine ambazo una uhakika sana lakini unaweka tu ndio kesi uwasilishe kotini. Na hii inatupa fursa pia kuangalia kwa makini, na tutazidi kuchunguza kesi hizi. Je, ni nani aliwasilisha kesi iliyo na nguvu? Na tutakapoanza kusikiza, utaona jinsi wanavyowasilisha kesi yao, ama tutakapofika kwenye hearing, main petition, tutasikiza ni kesi gani ina uzito, hii inaegemea. Kama kesi ingekuja tuseme kesi hii haingekuwa inahusu naibu wa rais, tuseme ingekuwa ya gavana. Je, ina uzito upi ndio upate uamuzi ambao unataka?
Na pengine Jared, swali ambalo kila Mkenya anajiuliza hivi sasa ni kwamba je, mahakama ina nafasi ama ina uwezo wa kubatilisha kisheria kung'atuliwa kwa Rigathi Gachagua? Je, wanaweza sema wakafika huyu bwana hakusikilizwa, hivyo basi yeye anarejea kuwa naibu wa rais? Wana hiyo nafasi? Manake kikatiba bunge la kitaifa na seneti lina kila nafasi ya kuweza kumng'atua. Fikiria kuhusu hilo, utakuwa unatupa jibu. Lakini sasa mtazamaji wangu, ni kupeleke moja kwa moja hadi maeneo ya Pwani ambapo mwanahabari wetu Kevin Mutai yuko tayari kabisa kusema na wanapwani. Karibu Kevin.
Na mtazamaji, ni mstakabali wa mahakama unasubiriwa kwa hamu na gamu ili kuweza kujua hatma ya Rigathi Gachagua baada ya kubanduliwa ama kuondolewa mamlakani, uamuzi ambao utaweza kuweka bayana uongozi wa taifa hili iwapo Gachagua atatemwa nje au atarejea ofisini. Lakini kwa hakika ni hali ambayo imekuwa ikifuatiliwa kwa kina sana na Wakenya kutoka pembe zote za taifa hili la Kenya. Na hapa Mombasa pengine tuweze kupata moja mawili kutoka kwa wakazi kuweza kupata tu mtazamo wao kuhusu yale ambayo yanaendelea mahakamani. Kwanza kabisa, ukianza kwa majina, waitwa nani, alafu tupe kauli yako, mtazamo wako kuhusu haya yote ambayo yanaendelea kuhusu kung'atuliwa ama baada ya kung'atuliwa kwa naibu rais Rigathi Gachagua.
Sawa, kwa majina yangu anaitwa Douglas, mbunge katika bunge la Borana hapa Mombasa. Mimi kulingana mimi na ya jana, tuliona jana kulingana na raising concern about the lawyers and Gachagua, there is a very concerned issue. We have not seen where Chief Justice mwenyewe ameappoint Deputy Chief Justice kujagua panel ya kusikiza kesi. Hatujaona mari anasema whereby tumeona.
Lakini uamuzi uliotolewa tayari na majaji walisema kwamba wale ambao wanasikiliza kesi hiyo saizi ni halali. Uamuzi ulishatoka tayari.
Kulingana na hiyo, kulingana na Wakenya wengi vile sasa tunaongea na sisi tunaangalia hiyo constitution, haikuwa halali because wale wajaji wangesema sisi hatuko halali, kwa sababu wao ni kama walikuwa wanataka kujifuta kazi. Kwa hivyo ya jana kitu kinaendelea sasa hii mpaka sasa hii tunaendelea ni ile sisi wenyewe executive na judiciary wana violate the law and the constitution of Kenya.
Asante. Pengine ukiweza pia kwa majina, hebu tueleze kuhusu vuta ni kuvuta ambayo kati ya mawakili wa Rigathi Gachagua na wale upande wa serikali.
Asante sana. Kwa majina anaitwa Charles Ojuang, chairman bunge la Polana. Kitu cha kwanza nataka kusema kinachoendelea pale kotini ni kwamba wale maloya wa mheshimiwa Rigathi Gachagua ni watu ambao wanatetea unga. Hakuna kitu wanamsaidia nayo mheshimiwa Gachagua. Na mimi pia nataka kuwaumiza wale ambao walianzisha huu mchakato. Ukiamua piga ua, usiangalie uso. Wamalizane kabisa na hii kesi na uhakikishe kwamba wamefuata sheria kikamilifu ili itumike baadaye kwa wale ambao kidogo pia watapatikana na makosa kama haya mheshimiwa Gachagua. Kwa hivyo sisi tuko hapa tunatazama yale ambayo yanaendelea pale, lakini tunahimiza kwamba sheria ifuatwe ili baadaye hiyo sheria ambayo imetumika leo itumike tena baadaye kwa wengine. Na pia tujue kwamba rais na naibu wake wale ni kama bibi na bwana. Tukisema tunafuata hii njia, leo tunatoka kwa dirisha. Mtu asijifanye yeye ni mjanja, anataka kutokea kwa mlango. Watu wote watoke kwa dirisha, hata kama ule mlango uko wazi, lazima tufuate pale. Ndio maana yule anaitwa principal assistant wa rais. Rais akisema tunafuata hapa, lazima afuate hapo. Kama hataki, ajiuzulu, rais atafute mwenye anaweza kufanya naye kazi. Kwa hivyo rais akiona ni vizuri Bwana Gachagua kae kando, huyo akubali kwamba kwa sahi services zake hazitakikani pale kwa serikali. Rais atafute mwenye ana uwezo wa kufanya naye kazi. Akisema ni Mheshimiwa Kindiki, tumruhusu Mheshimiwa Kindiki na Mheshimiwa Ruto wafanye kazi pamoja ili tupate maendeleo. Kwa sababu hatuwezi fanya kazi mwingine rais akisema tuende hivi, yeye anasema hii mimi sitaki, mimi sitaki. Alafu anakuja na vizingizio vingine kwamba kule Kisumu kuna watu walikuwa na, kwani lazima taje ni Kisumu ndio alikuwa anawekewa sumu. Hii uhasama bado tunajaribu kumaliza uhasama baina ya Wajaluo na Wakikuyu, lakini yeye sasa ndio amepata mwanya ya kuongeza ule uhasama. Kwa hivyo tunaomba Mheshimiwa Gachagua, kidogo yeye ni kiongozi, bado yeye ni kiongozi hata kama ametemolewa, lakini saa zingine tunapoongea tutumie akili kidogo.
Asante. Pengine pia tumeweza kusikia matamshi ya mawakili wakisema kwamba huenda kesi hii ikachukua muda zaidi pengine miaka miwili. Je, pengine itaweka vipi hatma ya taifa la Kenya ama sura katika uongozi wa taifa hili itakuwa vipi? Huenda kesi hii itachelewa.
Kwanza ni bunge la mwananchi hapa. Ndio chairman hapa. Porana, kwanza kwangu mimi, Mheshimiwa Rais William Ruto anacheza siasa, hataki kusaidia mwananchi wa kawaida. Hii ni sarakasi. Hii kesi ya Samaris hata miaka 5. Nitufumilie ukaa na Gachagua kwa sababu tulichagua wakiwa wawili. Bibi na bwana. Hatuwezi leta bibi mdogo huyu atumhesabu, huyu ajulikane. Kwa hivyo mimi nikiangalia vizuri, Mheshimiwa Rais kama kasi imekushinda, unaruhusiwa kusema ambia wa Kenya kasi imenishinda, baada ya kuleta vitu vingine unatuletea sasa hivi mnatuambia miaka 7 tena mnaanza upya. Hii nchi ni mbaya. Hii Mombasa sasa hii inakaa kama Jumapili. Badala ikae kama siku ya kazi. Watu hawana kazi, watu wanahangaika, wanajirasimisha tu. Hii kutuficha mambo ya Gachagua. Gachagua hakuna mahali anaenda. Katiba tumesoma vizuri. Kumuondoa Gachagua, kwanza hakuna IBC. IBC haiko. Hii ni sarakasi. Hata kama hujasoma hii katiba vizuri, ni kazi ngumu. Kwa hivyo ni sarakasi ya Mheshimiwa Rais anafanya.
Pengine mwisho kabisa, unaje pengine uteuzi wa Profesa Kithure Kindiki kuweza kujaza lile pengo la naibu rais wa taifa la Kenya?
Mimi naitwa Steven Ndonyi kutoka Mombasa, ni mwananchi. La kwanza, mimi ninaona hapa kuna mchezo wa kutaka kuharibu katiba. Katiba tunajua kwamba rais yuko mamlakani yuko na deputy wake. Na kuwa unamuimpeach, tunajua kwamba lazima aimpeachwe na parliament, aende senate, aende high court, aende court of appeal, alafu Supreme Court. Supreme Court approve kama alikuwa na makosa aende nyumbani. Lakini hii tuliona ya kwamba anaimpeachwa mara moja huku na parliament, ni kama hawana haja na yeye, wanachuki, wanampeleka haraka aende. Kesho yake wako kule senate. Kutoka senate kesho yake already senate inaendelea, kuna mtu amenominatiwa na rais Kindiki, kesho yake ende andevitiwa katika parliament, enda kaapishwe. Tunaona hii serikali President Ruto, tunaona yeye ndio tunamtarajia kama rais wetu, lakini naona kuna mahali yeye anataka kufunja katiba ya Kenya. Na ya pili, Rais President William Ruto, kama sisi wa Kenya unatukosea. Nafikiria ukiwa rais wa Kenya, ujue kuna wasomi kama wewe, wako ground. Kwa hivyo tunaomba ufate katiba, na hakuna mtu yako juu ya katiba, wewe na kila mtu.
Asante. Mtazamaji, kwa hakika ndio baadhi ya maoni ya wakazi wa hapa Mombasa, na sina la ziada, naomba nikome hapo, nikuregeshe kwake Lois Wangoi katika studio zetu za pale Nairobi.
Asante sana Kevin Mutai. Wape shukrani zetu wasomi kutoka Pwani kwa sentensi moja Jared. Wanasema wao ni wasomi pale ground na wanahisi kwamba kesi hii haitokamilika siku ya leo, huenda ikafika hata miaka 5. Inawezekana ikamilike leo, iwezekani. Ama wasomi pale Pwani wanaelewa haya mambo.
Ni vizuri nafurahia Wakenya wanajihusisha na mambo ya uongozi. Na ni vizuri kubanduliwa kwa rais kuna saidia Wakenya kuchangia hoja. Kama wakili Gamino walivyosema, kupona waliojeruhiwa, kupona pia. kesi kukaa, unajua
kwa sentence moja.
Kesi kukaa ni lengo la upande moja, lakini pia koti hatujui kama itasema amri zilizotolewa tumebatilisha.
Media saa 8. Naona wewe unapenda tuendelee kuwa na wengi kubanduliwa ili Wakenya waendelee kujielimisha. Kuna fununu kuna mwingine karibu anabanduliwa. Si hoja mtazamaji wangu, tunakwenda kwenye mapumzikoni mafupi na porejea na kuletea taarifa za hivi punde kabisa, huku tukisubiri hatma ya Rigathi Gachagua pale mahakama ya juu Milimani. Usiende mbali.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu. Kenyans will be shocked. Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua. 291 members of this National Assembly pended their signatures.
I'm aware that I haven't been a good father to you.
Father.
Kelly, please.
Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures.
Mtazamaji wangu, karibu kwa meza yetu ya NTV Adhuhuri. Mimi ni Lois Wangoi. Majaji watatu wa mahakama kuu wamesema kwamba kesi zote zilizowasilishwa mahakamani kuhusu kuondolewa kwa Gachagua zitaorodheshwa katika makundi mawili. Majaji hao hata hivyo watarejea mahakamani mwendo wa saa 8:30 kutoa uamuzi wa maombi kadhaa yaliyotolewa na upande wa Gachagua. Tunaungana moja kwa moja ama tutaungana baadaye na David Muthoka kutoka maeneo hayo, lakini kwa sasa hebu tuweze kusikiliza ni yapi ambayo yalijiri katika mahakama kuu ya Milimani muda mchache uliopita.
Having considered the nature of the petitions before us and with a view of conducting those proceedings in an orderly manner, we hereby issue the following further directions. 1. All the petitions shall forthwith be dealt with as those in cohort 1 or cohort 2 respectively. 2. Courts shall, pursuant to Rule 17 of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedures, Rules 2013, on its own motion, consolidate any other petition referred to this bench either into any of the two cohorts. As directed on 23rd of October 2023, any application in either of the cohorts seeking the recusal of the judges in this bench shall be heard today at 2:30 p.m. Those directions can be accessed in this court's electronic platform. These directions can be accessed in this court's electronic platform in the respective lead files. This court shall give further appropriate directions in the respective cohorts' lead files as and when necessary.
Mtazamaji wangu, kama ilivyo ada hapa NTV, vile wanahabari wenza wako ange katika kila kona ya taifa kuweza kukuletea mawili matatu kuhusiana na hatma ya Gachagua siku hii, ambapo muda wa saa 8:30 unasubiriwa pale mahakamani. Kwa sasa naomba tuelekee kaunti ya Narok ili tuweze kusikiliza wananchi kutoka kaunti ya Narok wanasema nini, wanafuatilia kwa karibu, wanahabari mwenza ama wanayapi ya kusema kuhusu hatma ya naibu rais aliyeng'atuliwa Rigathi Gachagua. Karibu.
Naam, asante sana Lois kutoka studio. Hapa nilipo hivi sasa ni katika kaunti ya Narok, na vile ambapo hatma ya naibu wa rais iko mahakamani hivi sasa. Sijui wananchi kutoka upande huu wako na maoni gani. Hivi sasa nimeungana na wananchi kutoka kaunti hii ili niweze kupata maoni yao kulingana na hatma hiyo ambayo iko kotini hivi sasa. Ndugu yangu, hasa na jina lako alafu upate kuniambia ukiangalia kamera maoni yako ni nini?
Jina langu Saitaba Mtet, nimetoka eneo la Narok County. Katika hii shughuli ama kesi hii ya Gachagua pamoja na Rais Ruto, kwanza wacha niseme rais wetu ni mtu ako na hekima. Walichaguliwa pamoja na Gachagua, na tayari mchunguza mwingine ameona kama ni mtu anaweza ndamana na yeye kuwafanyia wa Kenya kazi ama sio yeye. Hatima ya rais ni kwamba hawezi andamana na Gachagua ama kuwafanyia wananchi wa Kenya kazi. Na hivyo sasa hiyo kesi ikapelekwa pale parliament, wabunge wameondoa, ikatoka hapa ikaelekea Senate, wabunge pia wameondoa. Na najua kwamba wabunge na maseneti ni watu na ni wananchi pia wa hii Kenya, kwamba wameona dosari. Labda rais ameona dosari hapa, akasema wacha nimuondoe huyu mtu, nimuondoe Gachagua ili atafute mtu mwingine mwenye atafanya naye. Hivyo basi akaja na Kindiki. Na kama rais ameona ataweza fanya na Kindiki na waendeleze Kenya vizuri, itakuwa sawa. Mimi nasema basi Gachagua aondolewe. Naomba kotini jambo hili kwamba limefika kufanya, mkuwe fair, mfanye haki. mkuje na suluhisho ambayo itatusaidia sisi wananchi wa Kenya. Sio msikuje na suluhisho ambayo itatuadhiri kimaisha.
Asante. Mwingine pia ni okay, niambie pia maoni yako kulingana na kesi ambayo iko kotini.
Haya, kwa majina yangu kamili naitwa Chris Sironic kutoka Narok County, Narok West. Na kwa maoni yangu kulingana na kubadiliwa kwa Gachagua, mimi ningeomba naibu wa rais, nasikianga Waswahili wakisema asiyekubali kushindwa sio mshindaji. Kwa hivyo mimi naona kwa maoni yangu seneti wamefanya kazi, pia wabunge wetu wamefanya kazi, na ningeomba former naibu wa rais akuwe na roho ya kukubali yale imetokea, kwa sababu Kenya ndio kubwa kuliko yeye mwenyewe binafsi. So ningeomba former naibu wa rais akubali yale imetokea, kwa sababu wabunge ndio wale watu ambayo tunaamini ya kwamba wanafanya sheria na wamefanya kazi yao vizuri. Kwa hivyo akubali maneno na akubali matokeo, ndio Kenya iende isonge mbele. Maneno ya unga ishughulikiwe, maneno ya sukari ishughulikiwe, na Kenya iendelee. Asante sana.
Asante sana Louis kutoka huku katika kaunti ya Narok, na kurudishia kwako studio. Asante.
Okay. Asante sana. Tuondoke Narok tuelekee hapa Milimani ambapo mwanahabari wetu David Muthoka yuko tayari kabisa. David, muda wa saa 8:30 ndio muda ambao taifa litakuwa limekusanyika, macho yote yakielekea Milimani tuweze kujua je, jaji hili ama majaji hawa watatu watakuwa wanatoa mwongozo upi katika mahakama ya juu. Awali Muthoka, tuliona Jaji Eric Ogolla akiweza kusema na taifa na kuweka kesi za naibu wa rais aliyeng'atuliwa Rigathi Gachagua katika masanduku mawili. Mchana wa leo ni yapi ambayo yanasubiriwa kwa hamu na ghamu zaidi kuhusiana na hatma hii ya Rigathi Gachagua mahakamani? David.
Na kwa siku ya 3 mfululizo sasa tumekita kambi katika mahakama ya Milimani, na leo hii tunatarajia kesi 2 kuwasilishwa mbele ya jopo la majaji watatu, jaji mmoja akiwa ni Eric Ogolla, mwingine Freda Mugambi pamoja na Anthony Mrima. Na kesi ya kwanza itakuwa ikiwasilishwa na upande wa mawakili kutoka upande wa Rigathi Gachagua ambaye aliondolewa ofisini katika ofisi ya naibu rais, na wabunge pamoja na maseneta, na upande huu unaoongozwa na wakili Kibe Mungai, Paul Muite pamoja na Ndegwa Njiru unatarajiwa kuwasilisha kesi inayotaka jopo hilo la majaji watatu lijiondoe na pawe na jopo lingine la majaji ambao watakuwa wakisikiza na kuamua hatma ya Rigathi Gachagua. Na ni kesi ambayo tunatarajia kuchukua kati ya saa 1 na saa 2. Tunatarajia upande huu kuweza kutoa malalamishi yake kuhusiana na jopo hilo linaloongozwa na Eric Ogolla, kisha ule upande mwingine wa serikali na haswa upande wa ofisi ya mwanasheria mkuu Dorcas Odor utakuwa ukitoa majibu yake, na baada ya hapo tunatarajia uamuzi kutolewa iwapo jopo hilo litajiondoa au litasalia na kukaa kuendelea kusikiza na kuamua hatima yake Rigathi Gachagua. Na baada ya hapo kuna kesi ambayo inasubiriwa kwa hamu na hamumu, na ni kesi ya iwapo yale maagizo yaliyotolewa na mahakama ya Kerugoya na haswa jaji Richard Mwongo na pamoja na jaji Chacha Mwita wa mahakama hii ya Milimani, maagizo ambayo yalisitisha kuapishwa kwake Profesa Kithure Kindiki kama naibu rais mpya wa taifa la Kenya. Tunatarajia upande wa serikali kuja kutaka maagizo hayo yawekwe kando na serikali ruhusiwe kumwapisha Kithure Kindiki, na tunatarajia kuona upande wa serikali na hii inahusisha ofisi ya mwanasheria mkuu pamoja na kutoka bunge la kitaifa pamoja na mawakili kutoka seneti wakiweza kujaribu kushawishi jopo la majaji watatu iwapo litakubali kuendelea kukaa kusikiza kesi zinazohusiana na Rigathi Gachagua. Tunatarajia upande huu ukijaribu kushawishi jopo hilo liweze kutupilia mbali agizo hilo na kufungulia fursa serikali kumwapisha Kithure Kindiki. Lakini upande huu mwingine unatarajiwa bila shaka kupinga vikali kuondolewa kwa maagizo hayo. Wanataka maagizo hayo yazidi kuwepo hadi pale kesi zote zinazohusiana na Rigathi Gachagua zitakaposikizwa na kuamuliwa. Na hivyo basi hapa mahakamani kuanzia saa 8:30 tunatarajia makabiliano ya aina yake, makabiliano ya kisheria kati ya mawakili kutoka pande zote, na tutazidi kukita kambi hapa kujionea jinsi itakavyokuwa ikikwenda na kuona ni kina nani mwisho watakuwa wakishinda hapa kotini. Kumbuka jana upande wa Rigathi Gachagua ulipata pigo haswa baada ya mahakama kushikilia kwamba jopo la majaji watatu hawa ni Eric Ogolla, Anthony Mrima na Frida Mugambi lilibuniwa kisawasawa na naibu jaji mkuu Philomena Mbete Mwilu. Kumbuka upande wa Gachagua ulikuwa umesema ya kwamba Philomena Mwilu hafai kubuni jopo la majaji na kwamba hilo ni jukumu tu la jaji mkuu Martha Koome, na pia kusema kwamba kubuniwa kule kwa jopo hile kulifanywa nje ya masaa ya kazi. Lakini mwishowe tuliona jaji Eric Ogolla, jaji Anthony Mrima na jaji Frida Mugambi wakijitokeza kimasomaso na kusema kwamba hakuna sheria yoyote iliyovunjwa wakati wa kubuniwa kwa jopo hilo, na hilo likawa pigo la kwanza kwa upande wa Gachagua tangu kesi hizo zinazohusiana na kuondolewa kwake ofisini zilipoanza kusikizwa siku ya Jumanne hapa katika chumba nambari 18 katika mahakama kuu ya Milimani. Hivyo upande wa Gachagua bila shaka utakuwa ukijitahidi kuhakikisha kwamba haupati pigo lingine, lakini nao upande wa serikali nao unatarajiwa kujizatiti vilivyo kuhakikisha kwamba wanaendelea na kupata maamuzi ambayo yanawapendelea na yanawafurahisha na yanalingana na kile ambacho wanataka mahakama wakubalie kufanya. Kwa hivyo basi letu tu ni jicho hapa kuona itakuwa ikikwenda vipi, kuona mwishowe ni nani atakuwa akipata maamuzi ambayo yako upande wake. Ni macho kumbuka taifa nzima limeweka macho yake hapa, manake huenda leo ni siku ambayo yale maagizo yanayomzuia Kithure Kindiki kuapishwa yakaondolewa, na hii huenda ikafungua ile fursa yake kuapishwa hata kesho. Kwa hivyo tunasubiri kuona maelekezo na maagizo ambayo yatakuwa yakitolewa na mahakama ya Milimani hapa. Kwako studio Lois Wangoi.
Asante sana David Muthoka, na bila shaka maagizo hayo yatakuwa yanalipa taifa mwangaza kujua ni nani naibu wa rais wa taifa. Je, ni yule ambaye aliyeng'atuliwa ama ni yule ambaye ameteuliwa? Mengi zaidi ni hapo baadaye. Tukisonga mbele ni kwamba Rais William Ruto kwa mara ya kwanza katika umma ameonekana kutambua uwepo wa kampuni ya Adani inayowekeza katika sekta mbalimbali humo nchini. Akizungumza katika uzinduzi wa kampuni ya Kawi Menengai 3, Ruto amesema kwamba kampuni hiyo itajenga laini ya umeme pasi na kutumia mikopo yoyote kwa upande wa serikali.
I'm very happy that for the first time in Kenya today, we will have a transmission line from here in Menengai that will go to Olkalau, that will go to Nanyuki, supply power to that region all the way to Meru. They will for the first time access geothermal power from Menengai. That investment is being made by the private sector. The Adani Group are investing in the transmission line. Their money, 95 billion. We would have otherwise gone to borrow that money, burden the people of Kenya. This is now a private sector investment, the same way Keshan here is a private sector investment, the same way Sosian is a private sector investment. We will pay for that transmission line using a wheeling charge that has been negotiated.
Tukisonga mbele ni kwamba kiongozi wa walio wengi bungeni Kimani Ichung'wah amehimiza Wakenya na haswa wakazi wa Kikuyu kujisajili na mpango mpya wa afya SHA, akisema serikali imeweka mipango mipya ambayo itasaidia Wakenya kuliko ile ya NHIF. Akizungumza na wakazi wa Kikuyu kaunti ya Kiambu, Ichung'wah amekemea wanaopendeleza siasa potovu kuhusu SHIF na SHA, akisema kuwa Wizara ya Afya itatoa maelezo zaidi ili Wakenya waweze kujiunga na mpango huo bila tashwishwi.
Vile uko na pesa mingi unalipa zaidi, ili tusaidie mwenye yako hapa kijiji hayuko kazi, hana source of income, yeye alipe 300 na anatibiwa akiwa mgonjwa. Wazee wetu wale wakongwe, wale wako cash transfer program, the very needy in our society, hawatalipishwa, serikali iwe inawalipia. So kama uko kwa cash transfer, wewe ni shosho ama guka mzee, you have no source of income, uko kwa cash transfer program, serikali hata hiyo 300 inakuambia serikali ya Kenya ndio itakulipia.
Chief, I know there's a lot of incitement, a lot of misinformation. We have asked the ministry to sensitize Kenyans and be able to inform them on the benefits of this program, because it's more beneficial to Kenyans than the old NHIF. And therefore we will continue to plead with Kenyans and appeal to them and inform them and sensitize them on the need to register with the Social Health Insurance Fund, because it is to their benefit.
Tuelekee pwani sasa, ambapo wakazi wa kaunti ya Kilifi sawia na viongozi wa eneo hilo wametaka hazina ya NGCDF na NGAAF kuhalalisha kikatiba, wakisema kuwa maeneo mengi yamenufaika kimaendeleo kupitia hazina hizo. Wakizungumza katika hafla tofauti, wakazi hao pamoja na viongozi wa usalama wa serikali kuu na viongozi wa kaunti wamesema kuwa miundo misingi kama vile shule, afisi za machifu, vituo vya polisi, fedha za masomo na ruzuku kwa vikundi vya vijana, kina mama na walemavu ni baadhi ya manufaa ya hazina hizo mbili. Katika eneo la Rabai, kiongozi wa wanawake kaunti ya Kilifi Gertrude Mbeyo alisema kuwa wanafunzi wengi kutoka familia maskini wameweza kupata elimu kupitia fedha za masomo kutoka hazina hizo mbili, na pia makundi mengi yamenufaika na pesa za ruzuku kutoka hazina ya NGAAF ambayo imepelekea makundi hayo kuanzisha biashara na kujikimu kimaisha.
Na semi-arid land kwa mfupi ASA, ili hawa wakazi wa Rabai waweze kupata chakula mpaka mvua itakapokuwa inakuja.
Tutatoa wapi madarasa kama yale NGCDF ikitolewa? Tutatoa wapi? Wazazi mtatoa pesa za majengo wakati huu mgumu? Mtaweza kutoa pesa za kujenga mjengo kama ule? Public participation mimi nakufanyia tayari Mbeyu. Wale wanataka NGCDF na ngafu ibaki ndani ya Kenya milele na milele. Hebu nyosha mkono pale huko. Ndio peke yake imeweza kusaidia kulipa basari ya watoto, kujenga majengo mazuri kama yale kila shule ndani ya Kenya.
Tuelekee sasa kaunti ya Kakamega, ambapo hali ya huzuni imetanda katika eneo la Silungai katika kaunti ya Bungoma kunradhi, baada ya mtu mmoja anayedaiwa kuwa mhalifu kupigwa hadi kufa na wakazi waliojawa na ghadhabu katika soko la Tombo Malava baada ya kutuhumiwa kuwa mwizi wa kuku. Akithibitisha kisa hicho, chifu wa Silungai Harrison Jacob Muyondo alidai kwamba tukio hilo lilitokea tarehe 16 mwezi huu na kuwasihi wazee wa nyumba 10 kuwajibika haswa visa kama hivi vinapojiri.
Laani kitendo, hata kama alikuwa amekosa, ni vizuri mngeshika yeye na afike kwa mkono ya serikali ili tuone sheria itachukua mkondokani.
Wizara ya Elimu imehimiza kuwekeza katika ujenzi wa madarasa zaidi kwa wanafunzi wa shule za sekondari za County JSS na kuajiri walimu wa kutosha ili kukidhi mahitaji yanayoongezeka. Akizungumza katika shule ya msingi ya Mumia Central, Gavana wa Kakamega Fernandes Barasa alikiri juhudi za serikali katika kukidhi mahitaji ya wanafunzi wa JSS, lakini alionyesha kuwa bado kuna kazi kubwa ya kufanya. Wito huu unakuja katika kati ya juhudi zinazoendelea za kuimarisha mpango wa JSS baada ya uzinduzi wake, huku shule nyingi zikiwa na changamoto kama vile madarasa yaliyojaa na upungufu wa walimu.
We need more infrastructure. We also need more teachers in our junior secondary, kwa sababu walimu ambao wako hapa kusaidiana na walimu wengine, they are less than the required number. In fact, they are less than 50%. So I want to call upon the Ministry of Education to expedite employment of more teachers for our junior secondary schools.
Tukisonga mbele ni kwamba waziri wa maji Eric Muga ameitaka halmashauri ya kuhifadhi maji nchini kuweka kando mizozo ya uongozi ili kuhakikisha kuwa utendakazi wake unaambatana na malengo ya serikali kuu. Akizungumza katika uzinduzi wa mpangilio wa mwaka wa 2023-27 ya halmashauri hiyo, waziri Muga alisema kuwa atahakikisha kuwa kuna suluhu ya kudumu kwa mizozo hiyo, huku akitaka uongozi wa halmashauri hiyo uzingatie kukamilisha miradi ya mabwawa nchini na mipangilio mingine ya kuhakikisha taifa haliathiriki na mabadiliko ya tabia nchi.
Different name brand played in the Ivy Leagues in this country. You are the cream, top of the tire, sat at an elevated pedestal as an institution. But in the recent past, you are a shadow of your former self. You have lost the trajectory and you have nosedived. You have been knocked off your perch by agencies that have been commissioned 3-4 years ago. That is also part of my responsibility.
Kampeni ya wiki moja ya kutoa hamasisho kuhusu manufaa ya usafi wa mikono inakamilika leo. Kampeni hiyo ilizinduliwa Oktoba tarehe 15 na Katibu wa Afya na ililenga zaidi wanafunzi kuzuia mchakato wa kipindupindu na maradhi mengine ya homa yanayotokana na uchafu wa mikono katika shule. Kampeni hiyo iliendamana na kukamilika kwa muhula wa 3 wa shule za elimu ya msingi. Kauli mbiu ya mwaka huu ni kutathmini manufaa ya usafi wa mikono katika kukabili maradhi miongoni mwa wanafunzi. Kunawa mikono ni njia mojawapo ya kuzuia maradhi ya homa na vilevile maradhi ya tumbo. Wadau katika sekta ya utalii wameitaka serikali kuhakikisha wageni wanaozuru nchini wanapata usalama wao ili kuinua sekta hiyo. Sekta hiyo inaripoti ongezeko la wageni wanaozuru nchini haswa kwa mikutano na hivyo basi kuchangia mapato. Katika pwani ya Kenya, baadhi ya hoteli zinaelezea kwamba kuna wageni ambao tayari wamepanga kuzuru eneo hilo msimu huu wa sikukuu, wakitarajia pia uwepo wa watalii wa ndani kwa ndani ambao wanazuru mbuga za wanyama. Wametaja kwamba ipo haja ya kuweka mikakati mwafaka ya kuuza Kenya zaidi katika nchi za kigeni ili kuwavutia watalii zaidi.
This has been able to help us, push the numbers and volumes into our country and also into our hotels.
Well, you have Big Five, you have incredible weather, you have incredible people. You have a great hospitality, you have all of the elements, great beaches, mountains, you've got everything.
Mtazamaji wangu, taarifa hiyo ya pwani inatupeleka kwenye mapumziko mafupi. Tusiende mbali, tunarejea na mengi zaidi ikiwemo taarifa za michezo.
My Club. It's day 10 of My Club Festival Nakafu with exclusive offers, massive discounts, irresistible prizes, big savings, bigger rewards. It's more than loyalty. It's crazy offers every day. Nakafu.
Dawa, tu vitu tudogo lakini hesabu mingi. 1 times 4, 3 times 2, 2 times.
Umepitisha limit ya dawa.
That's a tough pill to swallow. He's now wondering why he doesn't have Shwari medical cover. Una access full limit kutumia unavyohitaji. Ukiwa na Shwari, utawaisikia umepitisha limit ya dawa na bado kuna pesa imebaki. Bonyeza *371# kuchukua Shwari medical cover leo.
Introducing Festive Cakes.
We have some delightful snacks for all of you.
The Festive Siambella Cake. Indulge in the pleasure of a cone-shaped cake that's bursting with flavors.
Where did you come from?
Come with me. So this is where the magic happens. This is for you kids.
Festive cupcakes.
Thank you.
Perfect treat to share with friends and family.
Now for your kids' school snacks, hakuna stress.
Festive pink cakes. The perfect blend of sweetness and softness.
And now this is for you, Dad, and your office mate.
Festive pound cake. This sumptuous cake will leave you craving for more. Taste the magic with our festive cakes from DPL Festive Bakery. Delight with every bite.
Karibu viwanjani. Rafinha alifunga mabao matatu na kusaidia Barcelona kuinyuka Bayern Munich mabao 4-1 katika mechi ya ligi ya mabingwa Ulaya iliyokuwa Estadio Olimpico. Rafinha alifunga ukurasa wa mabao dakika ya kwanza kabla ya nahodha wa Uingereza Harry Kane kusawazishia Bayern katika dakika ya 18. Robert Lewandowski alifunga goli la za marudiano ya robo finali ya ligi ya mabingwa ya Naivasha zitachezwa katika nyuga mbalimbali wikendi hii. Kwa upande wa wanaume, Fantasy itapambana na Oserian Youth uwanjani Aquila siku ya Jumapili, nayo Huruma itamenyana na Jungle Porters. Kuhusu kinadada, Celtic Queens itacheza dhidi ya Maimahiu Queens, wakati NYS Queens itakwaruzana na St Andrews kwenye uwanja wa shule ya msingi ya Kinungi. Ligi hii inayohadimiwa na wakili Njoroge Ngigi inanuia kukuza talanta za wanasoka mjini Naivasha, kaunti ya Nakuru. Mtazamaji wangu, tunakamilisha yote tuliokuandalia katika meza yetu ya NTV Adhuhuri baada ya michezo. Lakini kumbuka, bado mgeni wangu studioni, mwanasheria Jared Mugendi bado yupo. Unaona amepata kahawa kidogo. Hivyo basi ana mengi ya kusema tu kuhusiana na hatma ya naibu wa rais aliyeng'atuliwa Rigathi Gachagua na ambaye anapambana pale mahakamani. Tunaenda mapumzikoni madogo tu, lakini naomba pata maji, pata cha mchana, alafu jiunge nami muda si mrefu tuendelee kuweza kujua je, hatma ya Rigathi Gachagua itakuwa ni ipi. Narejea katika upande wa pili wa studio, siende mbali.
This is NTV.
Usiachwe nyuma. Join us at the Standard Chartered Nairobi Marathon. Register by visiting www.nairobimarathon.com and help us move Kenya forward. Standard Chartered Nairobi Marathon. Run, embrace possibility.
Unahitaji msomaji habari aelewaye matukio na matokeo ya matukio?
Michezo hutegemea hewa safi.
Msomaji habari mweledi wa majimbo.
Pastor County ya Turkana.
Msomaji habari mweledi wa masuala ya kanda.
Nataka nisikie vile wewe kwanza unasikia.
Msomaji habari mweledi wa masuala ya ulimwengu.
Hapa jijini New York nchini Marekani.
Msomaji wa mtagusano, mvuto, mnato na haiba ya kuaminika. Habari zako za NTV Adhuhuri zimepata sura mpya.
Mimi ni Lois Wangoi. Kila siku, kila wiki, kila tukio. Saa 7 adhuhuri kwa taarifa kuntu, tendeti na za kuaminika ni NTV Adhuhuri.
Kuna mbomu 15 pounds. Nachukua mbomu. Zinakwenda. Nahitaji diaper.
Kimeumana.
39 40,000 shillings. Namba 3. King Kong. Na 50,000 Kenya shillings. Grand, mega.
Get ready to have your mind blown.
Hey, what's up, my good people? This is your girl, Avril.
We're bringing you the hottest show in town.
The king of gospel, and I represent for Kwetu Mix.
Yo, Butruse K, the shop.
Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona.
291 members of this National Assembly pended their signatures.
Karibu tena mtazamaji wangu, tunaendelea na makala yetu ya hatma ya Rigathi Gachagua. Kumbuka huyu ni naibu wa rais aliyebanduliwa kupitia bunge la kitaifa, vile vile bunge la seneti. Ikawa ni safari yake ya kupambania wadhifa huo na baadaye kaelekea kotini mahakamani. Kikuu zaidi, kwanza weekend iliyopita aliweza kupata maombi ya kuzuia naibu wa rais mteule Kithure Kindiki kuweza kuapishwa na kuchukua wadhifa wake. Baada ya hapo imekuwa ni siku baada ya nyingine katika mahakama kuu ya Milimani, naibu rais aliyeng'atuliwa Rigathi Gachagua akiendelea kupambania wadhifa huo. Baadaye mida ya saa 8 mchana tunatarajia mwongozo ambao utakuwa muhimu sana katika mahakama ya Milimani. Nitakuwa na kuchemsha bongo nikukumbushe ni yapi tunatarajia hapo, lakini kwanza naomba tuandamane hadi kaunti jirani ya Nakuru ambapo nafahamishwa kwamba mwanahabari mwenza Ruth Sarmoi Chisenge yuko ange kabisa kunena na wakaazi wa kaunti ya Nakuru. Ruth Sarmoi, na kusalimu, ni vizuri kuona mchana wa leo. Pengine tueleze wananchi kutoka kaunti ya Nakuru wanayapia kusema kutokana na mchakato huu ambao unaendelea na ambao unatazamiwa kuweza kukamilika pale kotini Milimani. Sarmoi.
Naam, Lois, tutasikiza tu kwa wananchi kuhusiana na mambo ambayo yamekuwa yakiendelea kotini, na jinsi mwenzangu Mudhoka alivyotueleza ni kwamba mahakama inatarajiwa kutupa mwelekeo kuhusiana na zile kesi mbili ambazo zilisimamisha ama zilisitisha kuapishwa kwa Kithure Kindiki ambaye alikuwa ameteuliwa kuchukua usukani kama naibu rais mpya. Kwa hivyo maoni yako ni yapi kuhusiana na, ama unatarajia yapi kuhusiana na yale mambo yanaendelea kule kotini? Utaanza kwa majina.
Okay, I'm James Bogwa, activist in Nakuru town, and I was vying for MCA Biashara Ward. And me as one of PWD na mkaaji wa Nakuru, na bado mimi ni kiongozi marida tu. Kwa kiongozi mimi naonelea ama maoni yangu na soza Gachagua, most of time kama wananchi tunafuatanga venye siasa inasema. But kwa saizi as a reader, mi kama ningeulizwa serikali hii haikuwa wakati wa kutuletea story za impeachment, story za Rigathi aende nyumbani, of which things zenye zinahusu mwananchi, the real things, issues that common mwananchi is facing, they are not considering. Tukiangalia kasa hizi koti na ama viongozi wanastahili kukua wakituambia aje, what is she, what is chief, what about education, na about the economical crisis. No, sasa hapa hivi wamekaa na impeach Rigathi. Okay, hapa hivi wanataka tu uongozi. They are only fighting about powers.
Lakini kando na licha ya kwamba tumeona viongozi wametekeleza haya masuala ambayo umeyataja, na ni kweli Wakenya wanahisi ya kwamba ni muhimu yatajwe. Sasa ni kama maji yamezoleka na mahakama ndo tunasubiri watupe hatma ya haya mambo. Matarajio yako ni yapi, na umekuwa ukifuatilia haya mambo ambayo yanaendelea kule mahakamani?
Nimefuatilia mambo ya Gachagua wa deputy from the day aliimpeachiwa, even wakati wa process hiyo yote yake ya kuimpeachiwa, even about public participation of which haikufanyika venye inastahili kufanyika. And then after impeachment on that night, wakati aliimpeachiwa, the morning tukaamka tukapata Rigathi ako impeached. Okay, my opinion, and as a citizen of this country and my motherland, mimi naweza sema kitu ya kwanza, na niambie Mr. Ruto and Mr. Rigathi Gachagua and all officials, government officials wenye wako pale, tafadhali sorry, okay, hata Rigathi akirudi pale hivi tunaweza sema anaweza rudi, yes, na ametetewa na koti, arudi akuwe deputy, well and good, but akirudi pale atatusaidia na nini? Hiyo ndio kitu ya kwanza. Tuache kufurahia ati Rigathi anarudishwa atarudishwa tu pale kwa kiti yake as a deputy president. But the good issue and the strong issue here is akirudi matakwa ya wananchi kama venye sisi tunataka kufanyiwa, ataenda atekeleze. For honestly, tuache kuriria mtu, tuache kusema aje huyu mtu ni wa mlima, si hivyo? Huyu mtu ni wetu. Huyo mtu wenu anakusaidia na nini? Let's talk about our nation. The things that are facing our country, but not about the issues that facing personal interest. So naona. So if kama honestly Rigathi atarudi pale na atarudishwa kulingana na venye maybe kwa njia yenye ilitumika kuimpeach haikuwa halali, kama koti sure itaona amenyimwa haki yake na weze kurudishwa pale, mimi naweza omba kitu moja. Rigathi, deputy Rigathi, story za kuendaga pale kutuambia story za shares, sijui sharing nyinyi, sijui kila mtu akona share yake, gojeni hata nyinyi mtakula. No wenye waliwekelea wa kwanza wache. So that person is not fighting about our country. That is about self interest. Gojea nimalizie kidogo. Simeniita nikuje niongee. So let me talk and finish. Sina hivyo. Mama kama ile hivi. Tuende tumuru akuja atuambie. Yes, nimerudi. Na mimi enyewe nilikuwa na impeachiwa because I'm saying this and this. I'm saying the truth about Adani, about education, about she and Sha, sijui she hata she na Sha hata tujui dikina nani hawa. HNF, NHIF. Sinaona something like that.
Kuna swali ambalo mwenzangu kule studio ameulizia, unafuatilia kivipi haya maendeleo pale kotini na kuhakikisha kwamba unaweza kufanya kazi zako za kila siku na pia kufuatilia yale mambo yanayoendelea humu nchini?
Okay, kama kiongozi naweza fuatilia kwa sababu moja, I want to see if the Kenyan justice is practiced, and kama katiba ya inafuatiliwa, kama sheria zenye ziko kwa katiba are they followed, zinafanyishwa kazi. So naona not the moment naweza sema yes job first because hapo ndipo napata lishe. No, lakini bado nchi ndio kitu ya maana, because without this country we can get even that food you are saying I'm fighting, you see. So
wacha tusikize mwingine. Matarajio yako ni yapi kuhusiana na, kwanza umekuwa ukifuata haya mambo ambayo yanaendelea pale kotini, na matarajio yako ni yapi? Utaanza kwa majina.
Nimejaribu kufuatilia kidogo, lakini kulingana na kuona kwangu, kitu ya kwanza, maoni yangu ni kwamba dunia hii mwanadamu aliyezaliwa na mwanamke, Biblia inasema hakuna mwanadamu hatakayetenda mema na asitende maovu. Na Mungu akalete kitu kinaitwa msamaha. Na makamu wa rais halikubali makosa yake. Akaenda kanisa akakubali makosa yake. Na akasema naomba msamaha kama nimekosea kila mtu. Kwa hivyo kama Kenya inataka amani, ingefuatilia msamaha wa makamu wa rais. Ili kama kuna kitu kiko mbele, serikali iangalie, iondoe kitu ambacho kinaweza leta shida kwa nchi ya Kenya. Lakini kama mtu ameomba msamaha na amefikishwa kotini na anasukuma mpaka mbele, ile kitu ambao tunangojea kama wananchi wa Kenya ni chaji mkuu Martha Koome ndiye ataokoa Gachagua. Huyo ndiye ataokoa nchi yetu ya Kenya. Juu sasa hata tukiongea, hata mkituuliza, imeshaamuliwa. Kila kitu imeisha. So hakuna vile tutasema, ila kama kesi itasonga mbele, hiyo ndio Martha Koome atatuokoa. Na kwa sababu makamu wa rais ako na wajumbe wake na ako na wafuasi wake, hawatasikia vizuri mtu wao akisulubiwa. Hata rais wetu hata mtu mwingine hatasikia vizuri rais wetu akisulubiwa. Paka lazima wawe na umoja na ushirika kama nchi ya Kenya, ili tuwe na amani katika nchi ya Kenya. Na kama kuna jambo ambalo linaweza sababisha Kenya ikose kuwa na amani, heri serikali ifuatilie hiyo, iondoe Kenya ikuwe na amani. Asanteni sana.
Haya, utafika kwa ufupi tu tueleze maoni yako ni yapi na matarajio yako na yale mambo ambayo yanaendelea mahakamani ni yapi?
Kwa majina naitwa Samuel Kuria. Maoni yangu ni kwamba bunge walimaliza kasi yao, wakakimbiza hii motion ya impeachment kwa haraka, usiku na mchana walikuwa wanakimbizana nayo. pia na sisi tuna maoni hapa kama wananchi ya kwamba kama vile walivyokimbiza motion ya kuimpeach Gachagua kwa upesi, kama hivyo ndio wanafanya maendeleo kwa haraka, tungekuwa tumefikia nchi zingine ambazo zilitu overtake na tulianza tulipewa uhuru pamoja. So tunaambiwa bunge wetu hivyo vile mlikimbiza usiku na mchana mpaka mnataka kulala bunge juu ya impeachment ya mtu mmoja. Maendeleo yetu ni muhimu sana kuliko mtu mmoja. Sasa ile kitu niangaambiwa wa bunge hivyo wameimpeach Gachagua kwa haraka kwa kukimbia, wahakikishe ya kwamba maendeleo ambayo barabara zetu zimekwama, maendeleo yetu yamekwama, kahawa imekwama, majani imekwama, pia wakulima waharakishiwe mbolea haraka, waharakishiwe pia huduma za hospitali kwa haraka. Sasa tunaambiwa ya kwamba SHA inaleta shida. Na hiyo SHA inaleta shida, hao bunge tuoni wakikimbia haraka kuwanusuru wale wameadhirika ambao wako na kansa. Hii saratani inaumiza watu. Tunaambiwa, niliona rais akisema ya kwamba watu wagoje. Mtu ambaye iko na saratani hawezi gojea. Utagojeaje ate nini mitambo itakuwa mzuri, itarekebika na mtu likufa anakufa. Sasa wale ambao wanakimbiza hii impeachment kwa haraka, wahakikishe ya kwamba kuna wanusuru wale watu ambao wanakufa na saratani. Wengine wameumizwa na hiyo SHA because ya kwamba unakuta wengine walikuwa wafanywe dialysis, lakini saa hii kuna hiyo kutoa pesa, maana SHA haifanyi nini. Pia kitu ya mwisho nataka kuongeza, tunagojea mahakama yetu ambao tunaiamini ya kwamba saa hii macho yote iko katika taasisi za mahakama ya kwamba.
Asante sana. Muda unatupa kisogo, na nafahamisha kwamba mwenzangu Daniel Mudhoka anatarajiwa kuzungumza nasi kula mahakamani, lakini jinsi ulivyosikiza macho sasa ama hoja hili limeweza kufunua mambo mengi kuhusiana na yale mambo ambayo yanaendelea bungeni kuhusiana na wanasiasa na jinsi walivyoharakisha swala hili kuhakikisha kwamba Gachagua ameweza kubanduliwa. Kwa hivyo wananchi wanatarajia kwamba mahakama itaweza kutenda haki, na tutazidi tu kufuatilia hali hii ama mambo ambayo yanaendelea, na tutazidi tu kuwajuza pindi matukio yatakapochipuka. Lois.
Asante sana mwenzangu Rod Sarmoi. Moja kwa moja tuondoke Nakuru na turejelee hapa Nairobi, na kumbuka mwanahabari mwenza David Muthoka vile yuko ange pale katika mahakama kuu ya Milimani, ambapo bila shaka anafuatilia kwa karibu yote ambayo yatakuwa yanajiri. Tayari tumempata Muthoka kwa kuungana nasi tena. Ni mchana ambao wa Kenya wanaosubiri kwa hamu na ghamu, kikuu zaidi ikiwa ni jopo hili la majaji kutoa mwongozo kuhusu wao kuweza kujiondoa katika kesi hii, kama maombi yalivyowasilishwa na mawakili wa naibu rais aliyeng'atuliwa Rigathi Gachagua. Lakini baada ya hapo sasa ndio tunaingia katika kesi iliyo na uzito na kesi ambayo inasubiriwa na kila mtu, ambapo tutaangazia je, mahakama hii ya juu itakuwa inatoa vizingiti ambavyo viliwekwa na mahakama ya Kirugoya pamoja na ile ya Milimani ya kuepusha kuweza kuwekwa ofisini rasmi naibu rais mteule Kithure Kindiki. Hayo ndio matarajio ya Kenya na wetu hapa vile studioni. Sijui ni yapi yanajiri kutoka upande wako Muthoka, uwanjani wako. Sema nasi.
Na bila shaka ni wazi kwamba macho yote ya Wakenya, sio tu wafuasi wake Rigathi Gachagua ambaye aliondolewa ofisini na bunge la Seneti pamoja na bunge la kitaifa, bali pia wafuasi wake Profesa Kithure Kindiki ambaye aliteuliwa na Rais William Ruto juma lililopita kurithi mikoba yake Gachagua. Ni wazi kuwa macho ya Wakenya wote yako hapa katika mahakama ya Milimani, ambapo itakapogonga saa 8:30 tunatarajia jopo la majaji watatu linaloongozwa na Jaji Eric Ogolla na linalohusisha Jaji Freda Mogambi pamoja na Jaji Anthony Mrima kuja kusikiza kesi ambazo zitaamua hatma sio tu ya Gachagua bali pia Kindiki. Na hili kuelewa ni kipi haswa kinachotendeka hapa mahakamani, pamoja na kuweza kubaini mbivu na mbichi kuhusiana na hatma za Gachagua na Kindiki, ninaye wakili tajika hapa Danstan Omari ambaye atakuwa akitupa taswira ya kiwakili kuhusiana na swala hili nzima. Asante kwa muda wako, na tukianza tu Wakenya wote wanatazama kuona ni nini kitakuwa kikifanyika kuanzia saa 8:30. Kwa mtazamo wako, tutarajie maamuzi aina gani labda, na tutarajie kuona kipi haswa pale katika mahakama mbele ya jopo la majaji watatu?
hii kesi ilipofika mahakamani, jambo la kwanza ilikuwa juzi tumetatua swala la ni nani ambao watakuwa parties. Leo asubuhi wale parties wameunganishwa, petitioners waka pande moja na respondents pande ingine. Leo kuna swala la tatu ambalo linaulizwa. Je, hawa majaji waendelee kusikiza hii kesi ama waondolewe? Application ya petition Rigathi Gachagua pamoja na wengine wameweka motion kali zaidi. Wameweza kutoa sababu 11 ambazo ziko pale. Sababu ambazo zingine ni kwamba majaji wale pengine wao wameteuliwa kwa sababu wana urafiki na watu fulani. Wale majaji pengine mabibi wao wanafanya kazi na serikali. Kwa hivyo yale mambo ndio yanaulizwa leo. Hivi kwamba wao ule Rigathi Gachagua na upande wetu hatuna imani na hawa majaji. Kwa hivyo wale majaji wameshtakiwa. Ni sawa, ile motion ya recusal ni kama Gachagua aliposhtakiwa pale bunge. Ijapokuwa hapa katika motion ya recusal jaji asimami kujitetea. Kwa hivyo sisi tumeshtaki majaji. Majaji wale tutatoa ushahidi ya kuonyesha kwamba wao hatuna imani na wao. Kisha wataamua kama kweli watakubaliana na sisi. Iwapo watakubaliana na sisi, basi watajiondoa. Wakijiondoa, ile file bado itarudi kwa Chief Justice, panel mpya iweze kutengenezwa. Wakenya bado masuala ya impeachment hayajafikiwa. Hatujafikia kiwango cha kuuliza kama Rigathi alitolewa kihalali ama bado. Iwapo tutashindwa kwa hili ombi ambalo tunaweka sasa, basi aidha kesho ama siku nyingine ndipo tutaambiwa kwamba kuna application ya serikali ya kuondoa zile order za Kerugoya zilizomzuia Kindiki kuchukua hatamu za kile kiti. Kwa hivyo bado mambo ni marefu. Ndiposa nilisema taratibu za koti ni tofauti na taratibu za bunge. Hapa kabla ya maamuzi juu ya kesi ya kuondolewa, application zote zile zitakazowekwa lazima tatuliwe kabla ya kesi ya Rigathi. Ndiposa nilisema huenda vile mambo yameanza, huenda tukapata kwamba hizi kesi zitakuwa mahakamani mpaka mwaka 2027.
Wapo wanaosema kwamba baadhi ya kesi ambazo upande wa Gachagua unaleta ni za kujaribu kuchelewesha mchakato wa kumrithi Gachagua. Lakini upande wa Gachagua unasema kwamba unahitaji kupatiwa haki ya kusikizwa. Lipi ni lipi?
Kuna pande mbili. Kuna wale wamelipwa na serikali. Argument yoyote inayotoka kwa upande wa kina Gachagua, wao watasema kwamba ni ya kupoteza wakati. Kuna wale sisi tumelipwa na Gachagua. Hatujalipwa na serikali. Hatutafanya kazi kulingana na vile wao wanataka. Kwa hivyo sisi ni timu moja, wale ni timu nyingine. Bora tu sheria inasema kwamba yote yanayofanyika mahakamani ni halali. Tutazidi kutumia mbinu zote za kisheria ambazo wewe Mkenya ulizipitisha. Ile katiba uliipitisha mwaka wa 2010 ndiyo inatupa silaha za kumsaidia na kumtetea Gachagua. Wale wa serikali walikuwa na nguvu kule bunge. Tulipowaambia vizuri kwamba bunge ni tofauti na kotini. Koti hapa ni procedure. Kwa hivyo mimi na imani kwamba Kindiki ni mwalimu wangu. Hatuna shida na yeye. Shida ni kwamba anataka kupewa jukumu la kuwa naibu wa rais kwa njia ambayo si halali. Sisi tunatetea sheria. Mawakili waliomo kotini kwa upande wa serikali wanatetea sheria kulingana na instructions za ule aliyewaajiri. Sisi upande wa Gachagua tunamtetea Gachagua kulingana na zana, zile weapons wa Kenya walizotupa katika katiba na sheria za taifa. Kwa hivyo hayawi huwa mbwembwe bado itaendelea. Nimekwambia tusubiri, angalia NTV radio na television hizi ngoma zitakwenda mpaka 2027 pengine Machi.
Kuhusiana na Kindiki, tumeona mawasilisho kutoka upande wa serikali wakisema kwamba kuna yale maagizo ambayo yalitolewa na leo labda yanafikia siku ya mwisho. Je, ni sharti leo mahakama itoe maagizo mapya labda kuhusiana na yale maagizo ambayo yalimsitisha kuapishwa kuingia ofisini?
Kuna oda ya kusema hawezi apishwa. Ile oda bado haijatolewa. Wengi waliokuwa watoto wakati kesi ya BBI ilianzia mahakama ya High Court ilisukumwa mpaka Supreme Court. Hii kesi kumalizika kwake inasukumwa kwenda mpaka Supreme Court. Sisi kwa upande wa Gachagua tuko tayari kutumia sheria ambazo Mkenya alitupa. Vidaraja ni vitatu. Kidaraja cha kwanza sio vitano. Kidaraja cha kwanza kilikuwa bunge, Gachagua alibwagwa. Akachukuliwa Senate, Gachagua akabawa. Tuko kwenye daraja ya 3, High Court. Tukitoka hapo kuna daraja ya Court of Appeal. Tukitoka Court of Appeal kuna daraja ya Supreme Court. Kwa hivyo daraja ziko hivyo. Hakuna mtu atakayesema kwamba lazima ile oda itolewe leo. Ile oda haitatolewa mpaka isikizwe. Na kumbuka sisi tunasema kwamba leo wale wamefanya application. Kuna main petition. Ile main petition tunataka wale walio swear affidavit wasimame pale waulizwe maswali. Tunataka Gachagua wasimame pale aulizwe maswali. Ili Mkenya aweze. Hili sio swala rahisi. Gachagua, unapozungumza mambo ya Gachagua, unazungumza mtu aliyepigiwa kura zaidi milioni 7. Usi MCA, unavuruga hivyo, lazima taratibu na katiba ifuatwe. Wale wana hamu ya kufanya, Gachagua anashtakiwa kwa kuvunja katiba. Haiwezi kuwa tena mahakama ivunje katiba. Lazima ile mahakama ifuate katiba. Kwa hivyo hayo ndio tunayoangazia leo mahakamani.
Tukimalizia tu swali la mwisho kwa kifupi, kumekuwa tuna baadhi ya Wakenya ambao wanasema hatuna naibu wa rais. Na pengine kitu huenda kikafanyika tu pale juu. Na huenda tukajipata katika hali ambayo ni tatanishi sana ya kisheria. Unaonaje?
Swali moja tu nawauliza. Rigathi Gachagua hajafanya kazi ya naibu wa rais kwa zaidi ya mwaka moja. Amekuwa tu amekaa pale. Kwa hivyo hakuna tofauti, taifa limeendeshwa na rais peke yake. Kwa hivyo waendelee. Pili, IEBC haiko. Nani ambaye anateua IEBC? Hivi leo Gachagua ama Kindiki na rais wafe, IEBC haiko, nini itafanyika? Kwa hivyo rais amesababisha hii confusion. Hawezi sasa kurudisha kutuambia kwamba hii confusion ni ya Wakenya. Confusion si ya Wakenya. Kwa hivyo ambia rais wa Kenya, anasikiza NTV, IEBC commissioners wakwe in place. Kabla kuna wabunge, kuna eneo wabunge walifariki, walitolewa kazi, ma-MCA mpaka saizi hawajateuliwa kwa sababu ya IEBC. Ni Gachagua amezuia IEBC isiteuliwe. Samahani, niruhusu niingie kesi ya MCA pale ambapo tunaangalia mambo ya MCA ya Wajiri. Tukutane kotini.
Asante sana, na matumaini tutapatana kule kotini. Bila shaka huyo ni Danstan Omari, wakili haswa wa upande wa Rigathi Gachagua, akitupa tu taswira ya jinsi mambo yamekuwa na jinsi mambo yatakavyokuwa katika siku zijazo kuhusiana na hatma yake Rigathi Gachagua, ambaye sasa yuko nje ya ofisi baada ya kuondolewa na bunge la Seneti na kabla ya hapo bunge la kitaifa. Kwako studio.
Asante sana David Mothoka, bila shaka unatuipa taswira ya mambo ambayo yanaendelea kuendelea katika kesi hiyo ya mahakama kuu maeneo ya Milimani. Mtazamaji wangu, turejee studioni na karibu tena Jared Mugendi, mwanasheria ambaye ni mgeni wetu siku ya leo. Jared Mugendi, kabla ya kuenda katika meza ya NTV adhuhuri, kulikuwa na swali ambalo tulikuwa tunataka utufafanulie kama mwanasheria. Je, mahakama ina nafasi kisheria ama kikatiba kuweza kubatilisha yale yanamkumba Rigathi Gachagua baada ya kung'atuliwa katika bunge la kitaifa na seneti?
Nadhani ni swali ambalo limeulizwa kwa muda mrefu kufikia hatua ya seneti kumng'atua mamlakani. Na kwa hakika ni kama kuuliza koti. Seneti na bunge lilifanya kazi. Tunakuomba ufanye kazi yao upya. Na hilo ni jambo ngumu kufanyia koti. Manake, angalia rais alikuwa amekabiliwa nayo. Kwa hivyo, si jambo rahisi tunavyodhani ati kumtoa mtu ofisini. Kuunganisha wabunge hao wengi na kutafuta hizo kura sio jambo rahisi. Ama kuwashawishi. Hilo ni la kwanza. La pili, jambo hili la kumbandua naibu wa rais si jambo ambalo katiba ilitabiria kwamba litarejelea kotini baada ya bunge kukamilisha kazi yao. Si jambo la kawaida. Hata tunapoangalia nchi zingine ambazo zina katiba karibu sawa na yetu, si jambo ambalo linarejelewa kotini baada ya bunge kumaliza kazi yake. Na kwa kimombo tunasema not amenable to judicial review, not justiciable. Kwa hivyo, kwa sababu kazi ya bunge ni kazi ya kisiasa, it's political in nature, na inahusu uongozi wa kisiasa. Kazi ya koti ni kazi tofauti. Tutaangalia, je, kuna haki za aliyekuwa naibu wa rais, je, zimekiukwa? Na kama zimekiukwa, je, tutaendesha vipi kubanduliwa kwa miaka ijayo ama siku za usoni? Basi hayo ndio maneno, na najua kuna wale wana kauli tofauti, wanasheria kama mimi wanasema bado naibu wa rais ndiye naibu wa rais, na ni haki yao kusema hivyo, lakini unapoangalia kwa kina, kwa makini, kubanduliwa kwa naibu wa rais si jambo ambalo linarejelewa na kotini kumrejesha.
Aha. Na pengine swali lingine na ambalo liliangaziwa hapo jana ni swala hili la jopo ambalo linasikiza. Tuna huyu Jaji Mrima, Ogolla na Bi Freda. Mahakama iliweza kutoa mwongozo wake hapo jana na kusema sisi tupo kazini kikamilifu na kisheria, na kwamba hata ingawa tuletwa kwa pamoja na naibu jaji mkuu Philomena Mwilu, sio lazima tungekuwa kwa pamoja na jaji mkuu Martha Koome. Pengine fafanua hilo kwa minajili wa Kenya, manake tunaendelea kusoma tu.
Naam, ni jambo ambalo lilikuwa limeleta utata kidogo jana. Kuna kauli mbili kwa kikatiba. Ni jaji mkuu Martha Koome ambaye anapaswa kuunda jopo hilo. Kumbuka jopo aliundwi tu, kesi ilitoka mahali na koti ilitoa amri ya kwamba ningependa kesi ipelekwe kwa jaji mkuu ili aunde jopo, na wangesema ni jopo la majaji 3 ama 5. Waliteuliwa 3. Sasa koti jana ilipoketi, unakumbuka wanasheria walipokuwa kotini, kuna wale walikuwa wamejaribu kushawishi koti na kusema kwamba kikatiba jaji mkuu peke yake anapaswa kuteua jopo hili. Lakini waliokuwa kwa mrengo wa seneti wakasema sio kweli. Hata kesi iliyowasilishwa kotini na upande wa aliyekuwa naibu wa rais ilitafsiriwa tofauti na waliokuwa kwa mrengo huo wa seneti na bunge. Wakasema kwamba koti mwishowe ikaamuru ikasema seneti kunradhi, jaji mkuu anafanya kazi yake kikatiba, lakini kuna kazi anazozifanya, kwa kimombo tunasema administrative issues, ambazo anakubaliwa pia kumkabidhi naibu wake kufanya wakati ambapo hayuko ama wakati ambapo circumstances allow. Kwa hivyo ni jambo ambalo limeleta tashwishi kidogo, kwa sababu ni tofauti ya kuelewa kesi ambayo ilitajwa jana na mawakili wengi, kesi ya Lina Konchela, na pia kuelewa katiba kipengee 165 4 kuwa jaji mkuu ndiye anayeteua. Sasa tunaelewa vipi kipengee hicho? Kwa hivyo nilivyosema awali, Wakenya wanazidi sasa kusoma, kuelewa uongozi wao ulivyotabiriwa na katiba.
Kuna swali hapa kwako wakili. Huyu Wafula kutoka maeneo ya Eldoret anasema muulize wakili, je, huyu deputy, yani huyu naibu jaji mkuu ana uwezo wa kuweza kumpa rais kiapo pindi anaposhinda katika uchaguzi ikiwa jaji mkuu atakuwepo?
Wajua, ni jambo la busara kwanza. Najua swali hilo ni swali ambalo kujibu linaweza kuleta tata, kwa sababu tunataka kuelewa, je, kikatiba ni nani anayempa kiapo naibu wa rais anapoteuliwa na kuchukua uongozi? Kikatiba ni jaji mkuu. Lakini tunapojiuliza, na ningependa pia ninapoeleza masuala ya katiba huwa sipendi kuwapa watu majibu, napenda tuelewe kwa pamoja. Kama jaji mkuu hatakuwepo na hatuoni hatima ya kwamba hatakuwepo, je, kutakuwa vipi? Hatuwezi kuteua naibu wa rais? Hivyo ndivyo ninavyosaidia watazamaji kuelewa mambo ya kisiasa yanavyoelewa. Unapoelewa hivyo, unakuwa na muda rahisi kuelewa kwa kisheria. Hatutazami katiba kwa kimombo nasema a narrow vision. Nasema a purposive interpretation. Yeah.
Sasa Jared, mchana wa leo miongozo ambayo tunasubiri pale milimani ni miwili. Mwongozo wa kwanza, hawa mawakili wa Rigathi Gachagua, naibu wa rais aliyebanduliwa, wanataka hili jopo lijiondoe kikamilifu katika kesi hii. Wameweza kutoa visababu vyao ambapo nitakuwa ninaelezea mtazamaji wangu muda usiokuwa mrefu. Lakini je, itakuwaje? Maanake hapo jana hili jopo lilisema tuko hapa kisheria na kikatiba. Sasa ikiwa wameomba, wanasema nyinyi hatuna imani kwamba mtaweza kutupatia mwongozo mzuri. Itakuwaje? Na je, wakijiondoa tunaanza wapi? Sasa jaji mkuu anaunda tena jopo lingine, ama tena anamuomba naibu jaji mkuu, alafu inakuwa ni kizungumkuti tena?
Unajua, kesi kama hii tunafanya mambo ambayo tunafanya kotini yakae mambo mazito makubwa. Na ninapenda kusema hivyo kwa mara nyingi ndivyo Wakenya waelewe. Ni mambo ambayo tunapitia mara kwa mara kotini. Jaji anapojiondoa, jaji mwingine anakuja kwa niaba, anakuja na anachukua nafasi hiyo. Na kwa kawaida mnaanza mlipo simamia, mnaanza upya, kwa sababu kesi kama hii, hebu tuiangalie kwa makini. Kuna amri ambazo zimetolewa na zipo sasa hivi kusimamisha waziri Kindiki kuchukua uongozi
kama naibu rais.
Jopo hili likijiondoa, ni nani ataiondoa amri hiyo? Hakuna. Naona kuna amri zingine ambazo zimetolewa, na kuna mrengo mmoja ambao umesema amri hizo bado zipo. Kuna wengine wanasema bado si aliyekuwa, yeye ndiye
naibu wa rais.
Naibu wa rais. Naona. Kwa hivyo tutarudia tena mwanzoni, kwa sababu hayo yote ambayo yamefanywa na jambo hilo ni koti ambalo limekuja linawapa wanasheria mwongozo. Kwa hivyo wanakuja wanaangalia na wanawapa mwongozo, tumefika hapa, tuko hapa. Jinsi ambavyo Jaji Ogola na jopo lake wanafanya, wanawapa watu mwongozo kulingana na kesi ambazo zimewasilishwa kwa jopo lao.
Na sasa tuangalie ama tumjibu Mkenya, ili huyu jaji aweze kujiondoa katika kesi hiyo, ni mambo yapi ambapo mlalamishi mara nyingine huweza akatoa na tukaona kweli hapa kuna ukweli fulani, ama huyo jaji mwenyewe akajiondoa? Na miangalia stakabadhi hii ya maombi ya wakili wa Rigathi Gachagua, Ndegwa Njiru, maombi ambayo ameweza kuwasilisha mbele ya jopo hilo. Ni maombi 14. Ombi la kwanza hadi la 6 hivi ni maswala ya yaliyojiri siku ya Jumamosi, lakini hapo koti ilipa mwongozo hapo jana wakisema wanaweza kuketi muda wote. Lakini kuna sehemu ya 10, sijui kama unaiona. Sehemu ya 10, 11, 12 hadi 13. Hapa tunamuona wakili wa Ndegwa Njiru ama tunamuona Rigathi Gachagua. Manake haya ni maombi kwa niaba ya Rigathi Gachagua, akisema huyu jaji mmoja Anthony Mrima ana uhusiano wa karibu na naibu wa rais mteule Kithure Kindiki. Anaendelea kusema kwamba hilo huenda lilichangia ama hilo huenda likafanya jaji huyu akose kutoa uamuzi mwafaka. Wanasema huyu Justice Mrima ni rafiki, tena wanasema rafiki wa karibu, a close associate of the proposed deputy president Kithure Kindiki, and that the said judge failed, refused or neglected to disclose that fact to the parties at the inception of this trial. Hivyo anasema pale kesi ilipokuwa ikianza, jaji Mrima angesema huyu ni mtu wangu, kulingana na Ndegwa Njiru. Hiyo ni sababu kamilifu ama hayo ni baadhi ya mambo ambayo yanatojwa pale mahakamani, mtu akitaka jaji fulani ama wakili fulani ajiondoe katika kesi?
Unajua, kama mwanasheria unapowasilisha kesi yako na uone kwamba huoni kana kwamba utapata haki, waweza kuweka ombi hili la kujiondoa kwa jaji. Na ni vizuri pia tuangalie kuna mwongozo unaoongoza majaji katika utendakazi wao. Kwa kimombo tunaita Judicial Code of Conduct. Ukiangalia Rule 5 inakupa mwelekezo. Kuna mambo 4 ambayo yanaangaliwa kuona kama mtu anaweza kujiondoa katika kusikiza kesi. Kwanza, almaarufu kwa kimombo personal bias. Naam. Ya pili, huyu jaji anayesikiza alikuwa tuseme mwanasheria wa mmoja wa wale ambao wamewasilisha kesi. 3, ana uhusiano wa karibu na wanaowasilisha kesi hizi. Naona. Na tuseme jaji ama hakimu anayeketi kwenye kesi hiyo ana azma ya kifedha.
Umesema hapo uhusiano wa karibu.
Uhusiano wa karibu.
Na hapa Ndegwa Njiru anasema kwamba huyu Justice Mrima ana uhusiano wa karibu na Kithure Kindiki. Sasa hapo kwa uhusiano wa karibu utadhihirisha vipi kwamba watu hawa wawili wana uhusiano wa karibu?
Wajua, kotini kotini ni mahali tofauti. Unaposema kitu lazima uhakikishe na ushahidi.
Una ushahidi wa kutosha.
Ushahidi lazima utoshe. Na kumbuka upande ule mwingine pia una nafasi ya kukanusha mashtaka ambayo yamewasilishwa ya majaji kujiondoa.
Shikilia hapo Jared Mugendi, mwanasheria wetu ambaye anaendelea kutusaidia katika masuala haya ya hatma ya Rigiji pale Milimani. Mtazamaji wangu, nataka pia wewe uende katika mapumziko mafupi, pata kikombe cha chai, nyanyuka, najua umeketi sana, umetusikiliza sana, alafu tunarejea muda si mrefu na mengi zaidi.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu. Kenyans will be shocked. Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua. 291 members of this National Assembly pended their signatures. Tafuta na shida mingi sana. Hatuwezi kubali mtu haribu. Kenyans will be shocked. Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua. 291 members of this National Assembly pended their signatures.
Karibu tena mtazamaji wangu. Kabla ya kwenda mapumzikoni, tulikuwa tunaangalia hoja ya kwanza ambayo itakuwa inatolewa mwongozo katika mahakama kuu ya Milimani, ikiwa ni ombi la Rigathi Gachagua kupitia mawakili wake kuweza kuondoa ama kufanya jopo hilo la majaji watatu, Eric Ogolla, Anthony Mrima na Freda, kuweza kujiondoa, akisema hawahisi kwamba majaji hawa watatu watakuwa wanawapa haki. Sasa hawa mawakili wa Rigathi Gachagua wameweza kutoa maombi ama mambo ambayo wanataja kama kigezo cha kusema kwamba hawana imani jopo hili litaweza kusikiliza hatma yao kwa njia huru na ya haki. Jared Mugendi, tulikuwa tunasema nawe tukisema baadhi ya mambo ambayo mawakili wa Rigathi Gachagua kupitia mawakili wake wameweza kuorodhesha. Kuna hilo swala la Justice Mrima kuwa rafiki wa karibu wa Kithure Kindiki ambalo tumezungumzia. Vile vile katika nambari 12 hawa mawakili wa Rigathi Gachagua anahoji kwamba, ama nambari 11, kwamba Jaji Eric Ogolla, mke wake, ameweza kunufaika na serikali ya Kenya Kwanza, ambapo Rais William Ruto aliweza kumweka kama katika bodi ya Kenya Water Towers Board. Hivyo basi wanaona kuna uhusiano wa karibu katikati ya Jaji Ogolla na Rais William Ruto, na pengine hilo wanasema hilo linaonyesha hawataweza kupata haki katika kesi hii. Sasa watadhihirisha vipi mahusiano haya? Maanake ulisema mahusiano ni muhimu, mtu anaweza kusema mahusiano haya na ikakubalika kwamba haya mahusiano ni ya karibu sana. Unadhihirisha vipi?
Kudhihirisha ni ushahidi. Unajua, unaposema mtu amenufaika, sasa kunufaika huko kuna husiana vipi na kesi yenu? Na kesi yenu, jinsi ambavyo kesi imesikizwa kutoka jopo hili liteuliwe. Je, uhusiano huo umeonekana kuadhiri? Naam. Na sisi mawakili tunapo funzwa shuleni jinsi ya kuendesha kesi zetu mbele, kwa kawaida tunapewa wosia kama huu: unapoweka kesi ya jaji kujiondoa, ni vizuri kuelewa ya kwamba ushahidi utakaotoa usiwe ushahidi ambao ni rahisi. Namba moja, kukanushwa rahisi na upande ule mwingine.
Naam.
Na usiwe tu ushahidi wa kukera tu koti. Manake kama nilivyokuambia, malengo hapa ni mawili. Kila mmoja angependa kesi hii, kuna mmoja anayetaka kesi hii isonge kwa kasi, kuna mwingine angependa kesi hii isonge kwa polepole. Na wosia mwingine ni kuwa isiwe kuwasilisha ombi la jopo kujiondoa liwe jambo lako la kufanya kesi liende polepole.
Naam.
Hawa pia ni wanasheria, kwa hivyo wanajua,
lazima wanajua. Na manake huyu Kithure Kindiki ni profesa wa sheria, wa masuala ya sheria eti. Alafu huyu jaji, hata tusitumie Mrima, tutumie pengine wewe, Jaji Mugendi pia ni mwanasheria. Lazima katika shughuli moja ama nyingine wamepatana, pengine darasani, masomoni,
kanisani, hospitali, kwenye maeneo ya burudani. Unajua tunapatana kwa mengi.
Alafu hawa wote wawili ni walala hai, hatuwezi sema hawajikimu kimaisha. Pengine wanacheza golf pamoja.
Tunapoenda kwa kimombo LSK annual conference kule Diani, kwa mara nyingi wanasheria wengi wanapatana kwa pamoja. Kwa hivyo ningependa kuona watakavyowasilisha hoja hiyo mbele ya koti. Nitasikiza kwa makini zaidi, nielewe vipi uhusiano huo unahusiana na uwezo wa jaji huyo kusikiza kesi. Sijamwona Freda ametajwa pale.
Freda anaonekana ni mweupe kulingana na Freda ni mweupe kama pamba.
Sijamwona ametajwa, lakini ningependa kusikiza kwa makini ni vipi Mrima na Jaji Mrima samahani na Jaji Ogolla watashindwa kufanya kesi kwa sababu ya mashtaka ambayo yamewasilishwa ya kujiondoa.
Hapo kwa Ogolla, huyu Njeru anasema ingekuwa mwafaka ikiwa Jaji Ogolla angeweza kutoa ama kusema waziwazi kwamba pindi naposikiliza hii kesi huyu mke wangu aliweza kuteuliwa katika kazi fulani na rais wa sasa William Ruto. Jue nyinyi kama wanasheria ni lazima hili kufanyika, ikiwa kwa mfano utakuwa katika mahakama alafu niwe pale utasema samahani, jana tulikuwa na Lois Wangoi studio, ni lazima?
Swala hili ni swala ambalo huwa naliguzia kwa umbali kidogo, kwa sababu ningetazama huyu ni mtu ambaye hangependa maneno ya kinyumbani yatajwe kwa uwazi. Ndio maana nilieleza unayeoa ama anayekuoa si jambo la kuletwa kotini. Na kama linaletwa kotini, je, linahusiana vipi na uwezo wangu kusikiza kesi yako ama mada iliyo kotini? Lisiwe tu jambo kama majaji walivyojaribu kuwakanya wanasheria jana. Isiwe tu mambo ambayo yanatajwa si mambo ambayo hayahusu kotini. Pengine wanazungumzia walio nje ya kotini ili waweze kuangalia jopo hilo kwa macho ya kejeli, ama kuangalia kwamba hapa haki hatutapata. Kwa sababu ya 1, 2, 3.
Nakumbuka hata kabla ya jopo hili kukubalia upande wa Rigathi Gachagua kuweka maombi hayo rasmi, walipoyataja tu, huyu Jaji Anthony Mrima alichukua muda wake mwingi sana kuwaambia msiwe na wasiwasi. Sisi ni majaji, lakini hata wakati mmoja tumekuwa mawakili, tumeona visa kama hivi kwa muda mrefu. Nyinyi leteni kesi yenu na ushahidi wenu, na bila shaka hili jopo lipo hapa kuwasikiliza na mtapata haki.
Ndivyo tamka awali, ndivyo hivyo. Hawa majaji kama hawa wamekaa kwenye mahakama kwa muda mrefu, na kumbuka kuna kesi zingine nyingi ambazo zimeleta hisia kali zaidi, kama ulipoona wakati wa BBI napofanya kesi ya uchaguzi wa rais kwenye mahakama ya upeo. Hisia hizi huwa unaziona wakati kuna cheche kama kwa mambo ya kawaida yanafanya kuwa mazito na makubwa zaidi. Lakini ningependa tu hata tunapoenda kutizama kesi itakayowasilishwa na mrengo wa aliyekuwa naibu wa rais, ni vizuri hata wasikilizaji kuelewa, unapowasilisha mashtaka kama haya unawasilisha kwa hakika kabisa. Yasiwe tu mashtaka ambayo ni ya kumpaka tope mtu bila ushahidi wa kutosha. Na tutaona kama wataweza kutekeleza wajibu wao wa kuwasilisha ushahidi
wa kutosha.
Pili, kumbuka Wakenya wanashuku kwa hivi sasa maneno mengi. Kuna shauku kwa mahakama, kuna shauku kama rais wanafanya kazi vizuri, bunge linafanya kazi vizuri. Kwa hivyo jambo lolote linaloleta shauku ni vizuri liwasilishwe kwa njia ya haki pia, kwa sababu haki pia tu haitoki kwa jaji. Haki pia inatoka unavyoiwasilisha kesi yako na unaweka ushahidi wako, ili tuone ya kwamba hujakuja tu kumpaka mtu tope, iwe tu umekuja tu kuwasilisha kesi yako ndivyo tujue kumbe hii haikuwa hoja ya kotini, ilikuwa hoja ya kwingine. Na tutaona jinsi watakavyo iendesha hiyo.
Sasa tupe mifano, tutadhihirisha vipi? Huyu Lois ni rafiki wa Jared kiasi kikubwa. Nakumbuka hivi majuzi kulikuwa na kesi moja taifa la Marekani ambapo kuna mwanamtindo mmoja anaitwa Sean Combs ama Puff Daddy ambaye alipatwa na matatizo kidogo ya kisheria. Sasa tulikuwa tunaona wana mitindo ambao ni marafiki zake, kila mtu akikimbia katika mitandao yake ya kijamii na kuanza kutoa picha ambazo walipigwa kwa pamoja kwa wakati mmoja. Sasa huu ushahidi ni picha, ni kuwasiliana kwa simu, huu ushahidi utakuwa wa mbinu gani?
Kwa kisheria na utaniruhusu nizungumze kimombo tu kwa sababu maneno ya Kiswahili kwa evidentiary matters.
Usiogope, ndakuwa mkalimani wako.
When you have an evidentiary issue, you look at the probative value. It is not for you. It is for the court to determine that your matter has weight. That is why affidavits ambazo zinawasilishwa kotini, you annex your evidence. Kama ni picha, nasema picha hii nilitoa kwa simu fulani, kuna cheti ambacho tunaweka kwenye affidavit. Sema certificate of electronic evidence. Unasema nilitoa picha hii hapa muda fulani, chombo ambacho nilitumia ni hiki, hivyo hadi chini. Kwa hivyo ni ushahidi ambao hata wewe unapousikiza ni ushahidi ambao ungesema mimi sio jaji lakini hapa kwa kweli kuna uhusiano wa karibu. Na ni mbinu moja ya koti kuamua kama wanaweza kujiondoa. Kama mtu wa kawaida akisimamia, akisikiza ushahidi wako, je, ataamua kwamba kesi yako imetosha mimi kujiondoa? Kwa hivyo ni mbinu moja ya kuangalia ushahidi huo. Kwa hivyo si kusema tu. Naam.
Alafu hapa huyu Njeru, wakili wake Rigathi katika pointi yake ya 14, niruhusu nisome kwa kimombo alafu utueleze kuhusu hilo. Anatumia maneno ambayo ningependa tuyazungumzie. Anasema that from the foregoing the petitioners tangu mwanzo, the petitioners are apprehensive that this bench will not act or conduct these proceedings. Kwamba tangu mwanzo sisi kama walalamishi hatuna imani kwamba mtasikiliza kesi hii in a fair, just and impartial manner, and that it is incapable of dispensing with substantive justice. Yani maneno hapa ni makubwa. Incapable, kwamba baada ya hayo yote sisi tukiketi tunaona hamtoshi mboga katika kusikiliza kesi hii na kutupa haki kama watu wa Rigathi. Kama mwanasheria hayo maneno yanakushtua ama ndo kawaida yenu?
Si kushtua, ni kuangalia jinsi ambavyo sielewi ni nini haswa huu mrengo wa naibu wa rais ungependa kuonekana. Manake kabla ya kwenda bunge walisema tuna imani na mahakama. Sasa umewasilisha makaratasi ukasema hatuna imani na mahakama, na singependa kuwafanyia kesi yao. Lakini kuna utata kidogo jinsi wanavyoelekeza maoni yao, kwa sababu Wakenya walio nje, kumbuka, sio kila mtu wakili. Kwa hivyo wanavyosikiza, kuamini kwake ni kwa mtu ambaye amemwona kwa mara nyingi na nyingi na nyingi na nyingi. Kwa hivyo unapowasilisha na useme kwamba leo mahakama ni nzuri, kesho hatuna imani na mahakama, na unaweka karatasi, unaona ni jambo la kutatanisha watazamaji na wananchi. Ndio maana tunasema ningependa hata mimi kama Mkenya mmoja nione hii kesi ya uhusiano wa karibu itawasilishwa vipi. Kwa sababu ni jambo ambalo linaweza kupaka tope mahakama yetu. Nakumbuka kwamba kuaminika kwa mahakama ni jambo ambalo nimesema Wakenya wengi kwa hivi sasa tunatia shauku serikali yetu kwa vitu vingi ambavyo vinafanya.
Na katika mapendekezo yake Rigathi Gachagua tumeona amesema jopo hili hana imani 100% kwa 100. Hana imani na Jaji Ogolla, Jaji Mrima, vile vile Daktari Freda. Je, ni kinaya kwamba ni jopo lote ama mara nyingine manake hajatoa ushahidi kulingana na stakabadhi tuliyoiona. Masuala ya Daktari Freda ametoa ushahidi wa Eric Ogolla na Anthony Mrima.
Ukiondoa jopo umbakishi mtu.
Wanaenda
kama
wote.
Unabandua jopo kama umeona stakabadhi alivyowasilisha anataka jopo lote liende nyumbani. Kwa hivyo si ati sasa Freda atawachwa kwa sababu hakutajwa kwenye kesi. Na wanataka jopo lote liende nyumbani.
Ni mtego wa panya.
Ndio maana nasema hata mimi ningependa kuona ni vipi ushawishi huu wa karibu upo na ni vipi Mrima hawezi kaa kwa hii kesi kwa sababu ya uhusiano ambao anao na Profesa Abraham aliyeteuliwa kuwa naibu wa rais. Kwa hivyo kama nilivyosema awali, hata mimi najaribu kutafuta ni nini hiki ambacho wanasheria wa mrengo huu aliyekuwa naibu wa rais ni nini haswa wanalenga na huu mtindo wao wa kuwasilisha kesi. Kwa sababu kwa kawaida ni jambo ambalo mimi kama mwanasheria ningepeleka kesi yangu tofauti.
Pengine wawe na bahati kando na hapo jana ambapo walijikoa kisheria kwa maombi yote walipoteza. Pengine mchana wa leo wawe na bahati na jopo hili liseme haya tumekubali hata sisi wenyewe hatutaki. Hatutaki. Itakuwa ni nafasi gani? Pengine sasa tutamwona jaji mkuu akitoa mwongozo ama ni taratibu gani ambayo itafuatwa kisheria kuunda jopo lingine?
Ningependa tusubiri kwanza tuone. Lakini nadhani koti jana iliweka wazi na ikaweka sawa kuwa jaji mkuu anaweza teua jopo, na kama hayupo, kwa sababu hili ni jambo kwa kimombo tunasema administrative issue, inaweza pia likafanywa na naibu wake. Nakumbuka lugha inayotumiwa ni assign. Huwezi kufanya jambo ambalo hujakabidhiwa kufanya. Kwa hivyo tutasikiza kwa pamoja tuone ni vipi koti itaamua. Lakini leo kutakuwa na moto kidogo kotini. Naona wako tayari kabisa, unajua wamesha shiba kutoka chakula cha mchana. Kwa hivyo najua wako tayari kupambana pale kotini.
Naona wanaongozwa na senior counsel Haminwa. Alisema akisimama wengine mlikuwa mnanyonya, kwa hivyo mkae chini. Na kando na ombi hilo la hili jopo kuweza kujiondoa, ombi lingine kuu na ambalo ndo la siku ni lile ombi la koti hii kuweza kuondoa vizingiti vya kisheria vilivyozuia naibu rais mteule Kithure Kindiki kuweza kuwekwa mamlakani. Ikiwa jopo hili kwanza litasema tunaendelea hatujiondoi, kisha waseme sasa pili tunaondoa vizingiti ambavyo viliwekwa, ni mkondo upi wa sheria ambao tunaweza kutarajia? Pengine tutaona huyu naibu wa rais akitoka katika mahakama kuu akielekea ile ya upeo, ama tutaona serikali ikifika kwanza pale mahakama ya upeo kuweza kupinga vizingiti vingine kutolewa katika kumpa kiapo naibu rais mteule Kithure Kindiki.
Wajua, wakisema jopo linaendelea, kumbuka sasa kesi zinaendelea kulingana na zilivyowasilishwa na ambazo zilizokuwa awali na ambazo zina ile cheti ya sijui tutasema vipi agency. Na kwa hivyo nadhani tutapata mwelekeo, kwa sababu koti pia inaweza amuru baada ya kusikiza ombi hili la kujiondoa waweza patiana mwelekeo tukuje kesho tuendelee kusikiza kesi hizi. Naam. Kwa hivyo ni mwelekeo ambao tutapata, manake hatujui tutachukua muda upi sasa hivi kusikiza pande hizi mbili. Manake mawakili pia ni wengi. Tujui kama watapatiwa mwelekeo wa usiwasilishe kesi yako kupita muda fulani. Kumbuka kisheria jaji anakubaliwa kupatiana mwelekeo huo, na kwamba kesi yako usipitishe dakika 10, usipitishe dakika 15. Kwa hivyo kila upande utapatiwa nafasi ya kuwasilisha kesi yao. Lakini kwa sasa manake kama unavyoona hata mambo madogo ambayo tulikuwa tunatarajia ni madogo yanachukua muda.
Yanachukua muda sana. Kama hilo swala la naibu jaji mkuu, kila mtu alifikiria nyinyi kama wanasheria mtashika katiba.
Tashika katiba tusome.
Tuende kipengee fulani ikuwe rahisi.
Naam. Na kwa kawaida kwa kimombo nilisema hapa siku fulani, sheria sio kizungu. Usisome sheria kama unavyosoma kitabu cha kawaida, kwa sababu sheria inasomwa na kipengee hiki ukifananisha na kingine, unasoma pia kwa kijumla, na kuna sheria ambazo tunafuata za kutafsiri kipengee fulani. Je, kinasema hivi? Je, tukisoma hivi tupate mwelekeo huu, ni mwelekeo ambao katiba ilikuwa inatarajia utatokea? Na hivyo ndivyo sheria ilivyo. Sio jambo tu la kusoma unasema kizungu umesema iko hivi, basi tufuate hivi. Kuna mambo mengi yanayokuja katika kutafsiri na kuleta mwelekeo ambao katiba imeweka.
Bila shaka. Na huyu Rigathi Gachagua ikiwa atajikwaa kotini siku ya leo, kumaanisha sasa atatoka kuwa naibu wa rais, akienda kawa naibu wa rais aliyebanduliwa, alafu akawa raia kama mimi na wewe hivi. Na swali, ikiwa bado atataka kuelekea katika mahakama ya juu zaidi, pengine mahakama ya upeo, kutafuta haki ya kusikilizwa kama wanavyohoji mawakili wake. Sasa akifika pale bila hiyo naibu wa rais aliyeng'atuliwa, pengine Kithure Kindiki awe ameapishwa, nafasi ambayo anapewa pale mahakamani kusikilizwa pengine inatokana na ofisi yake na ofisi ambayo ipo na utata katika taifa. Akiwa ndo amekuwa Wanjiku, ndo amekuwa mwananchi wa kawaida, je, ataweza kupata nafasi sawia na ambayo anapata kisheria katika kusikiliza kesi yake?
Unapowasilisha kesi kotini, kesi yako unasikizwa kwa usawa. Koti haibagui kusema kwamba wewe tutakusikiza kwa sababu una wadhifa tofauti na huyu mwingine. Wanasheria wanaowasilisha kesi yao ndio wanaopewa tofauti hizo, na ni kuwasilisha kesi tu. Ulisikia ni jana aliyekuwa mwanasheria mkuu alisema kama wewe ni wakili senior counsel unazungumza mbeleni. Ni sheria ambazo tunazo, isipokuwa mwanasheria mkuu wa serikali, lakini senior counsel anazungumza
kwanza.
Naam. Kwa hivyo wenye kesi hawabaguliwi na vitengo hivyo. Mwenye kesi anapatiwa fursa kamili ya kuwasilisha kesi yake, na koti inatoa uamuzi kulingana na kesi uliowasilisha na kulingana na jinsi ulivyoishawishi koti kukubaliana nawe ama kukataa ushawishi wako wa koti.
Moja tupate maswali hapa yako kutoka kwa Kenya. Kuna huyu Lewis Scott anasema they are just pushing it but the fate of Gachagua is predetermined. Mawakili wawache kutuzungusha. Mwakili mnatuzungusha, mtuzungushi kwa hii kesi.
Unajua wakili anawasilisha kesi ya client. Naam. Uwezi unawasilisha kesi ambayo umepatiwa. Kwa hivyo tunaona jinsi ambavyo kesi anayewasilisha kesi anampa mwelekezo wakili wake, hivi ndivyo ningependa uwasilisha kotini. Naye wakili anafuata sheria na anasema kulingana na jinsi ninavyotafsiri sheria, hivi ndivyo kesi yetu ilivyo, na ningeomba mahakama kukubaliana na mimi.
Kuna huyu mwingine ana maoni pia, ni swali. Anasema ikiwa Rigiji atafaulu kotini, fate ni ile ile, atarudi parliament ang'atuliwe, arudi senate ang'atuliwe.
Kama nilivyosema, sitarajii kuwa mahakama inaweza kusema na tumrejeshe katika itakuwa inafanya kazi ya bunge. Na si jambo ambalo ni la busara koti kufanya. Na kulingana na jinsi katiba yetu ilivyopanga.
Kwa hivyo kesi ikisema huyu Rigathi asikilizwe, ni kwamba atasikilizwa, lakini wembe ni ule ule.
Lakini unajua huku huwezi kujibu jinsi mahakama itakavyosema, lakini jinsi tunavyoangalia ramani ya katiba, hatuoni kuwa jambo hili la kubanduliwa ni jambo la kurejelewa kotini ili kumrejesha kwenye kiti.
Asante sana Jared Mugendi, maneno yake ya mwisho mtazamaji wangu akisema hata ingawa kesi ya Rigathi Gachagua inaendelea kusikilizwa ama inaelekea kusikilizwa sasa, hamna nafasi kisheria kwa mahakama kuweza kumrejesha kama naibu wa rais. Pengine kikuu anaweza fanya ni kumfanya asikilizwe, lakini hatma itakuwa ni ile ile. Huenda ataanza darasa upya pale bungeni, ang'atuliwe tena na tena kwenye seneti. Ndo masuala ya sheria. Na sasa moja kwa moja tuendelee katika koti kuu ya Milimani, ambapo picha unazotizama mtazamaji wangu ni za moja kwa moja ya hali ilivyo pale katika mahakama kuu hiyo. Tumeweza kuona mawakili hawa ambao ni mawakili wa naibu rais aliyeng'atuliwa Rigathi Gachagua, na bila shaka jopo lipo tayari, majaji Eric Ogola, Daktari Freda na Anthony Mrima. Sasa uwanjani wao, tuwasikilize wote, usiende mbali. Tunakamilisha masuala ya Kiswahili. Pindi watakapomaliza, mwenzangu Michelle Ngele atawasili kwa lugha ya Kimombo na mengi zaidi kuhusiana na yatakayojiri Milimani. Tusikize.
One in consolidated petition lead file 565 and the other is consolidated petitions lead file 522. I think because the responses are the same, we will do them separately, but the responses will be the same. So I'll call petition number 5E562 H.E. Rigathi Gachagua versus the Speaker of the National Assembly, petition number E565 of 2024.
My Lords, may I request, with your kind permission, if we could allocate time so that we structure the presentation, and for our part, on the part of the respondents, we will respond together, and whatever time you will allocate to us, we will use together.
For our part, my Lord, because we have to do the job of convincing the court, I believe we will agree for the first application that we want to deal with it. I believe 30 minutes to present my application.
You need how much?
30 minutes.
My Lord,
yes, my Lord, I say that speaking for myself. I believe the other people will speak for themselves.
My Lord, with your kind permission, for record purposes, I wish to bring to the attention of the court that we shall no longer be acting for the sixth respondent in this matter, and to that effect we have filed a notice to cease acting on account of the Supreme Court decision that determined that the President cannot be subject to civil proceedings. So in that regard, we will not be able to act contrary to an express court order, and we have therefore filed a notice to cease acting, and we ask the court to deem that to be a sufficient notice that the person named as the sixth respondent is now unrepresented in these proceedings. Thank you, Dr. Kamotho. However, we are not inclined to do anything this afternoon except the business of the two files before the court. After that, we can take directions as may be necessary. Most obliged. As far as time allocation is concerned, this is how we'll allocate time. The main applicants will give you 15 minutes each. The main applicants, we will give you 15 minutes each. Supporters of the application, we will give you 5 minutes each. If you are supporting the application, we'll give you 5 minutes each. Respondents will give you 7 minutes each. Interested parties will give you 5 minutes each. Rejoinder by main applicants will be 7 minutes each. We ask the court assistant to observe time strictly.
Can you permit me to say something? This is our first impeachment case since we became impeachment cases. I mixed up with all sorts of things like law, politics, security of the country, and etc. My very humble submission is so far as possible, let people say what they want to say. It's a healing process. And coming up with 5 minutes, 10 minutes, 7 minutes, my Lord, it does damage not only to ourselves, but the entire nation. It is a nation we are concerned about, all of us. When things are down, the normal just advocates take different positions when you have a matter before the court. But when it comes to impeachment cases, we are all concerned about the safety of the state, to save the states. Let people say what they want to say. They should not be taken. That's my view. And may I thank you most respectfully. I am coming to this matter on behalf of the Security Syria. We stand for the rule of law, the supremacy, and for preservation of the state of Kenya. Let people say what they want to say. Let us not come up with 5 minutes, 10 minutes, or 20 minutes and so on.
My Lords, Your Ladyship, I appreciate the matter before this court is the recusal of the judges. But please, I urge you to be a little bit more flexible on the issue of time, particularly 5 minutes. My Lord, no council enjoys making an application for recusal of judges. It's a very weak thing. So please, allow us a little bit more flexibility.
Dr. Kamuna has submitted that he needs unlimited time, meaning that he can argue this case even until tomorrow. Mr. Mwite, how much time do you require for yourself?
I would say for those supporting at least 10 to 15 minutes. It's just relaxation that I'm asking for, so that the issues are wholly articulated.
My Lord, may I suggest that we stick to the time you have allocated us, and you have the discretion to allow anybody, including my learned senior, the Honorable P.K. Moite, any flexibility.
I think that's what we did last time. We allocated times, but we were flexible enough to add time whenever it became necessary. So with those submissions in mind, we'll give you the time allocations which we have given, but with the latitude to grant more should it be necessary.
I was going to request about that because we are prosecuting this application, that we just say that officially so that I don't feel pressure. I have 30 minutes. This is the kind of case, my Lord, that if you do not argue it, inevitably, this case will somehow have that. I don't want anybody to accuse me. I did not argue this or the other when I had an opportunity. 30 minutes will not bring levels down. It is only 15 minutes to enable me to do the job, not for myself.
Yes, my Lord, here we go again. Here we go again, my Lord.
Let me speak. This
this is a court of law. I respect you very much, Council, Senior Council, and all the Council here, but please let us appreciate that this is a court of law. And when directions are made, please let's respect those directions. I'm making this direction. We have allocated time. Should it become necessary for one party to ask for more time, we will consider that. Thank you.
My Lord, the first application in which we have filed these documents in the file officially called petition number E015 of 2024 is an application dated 21st of October 2024. It is supported by an affidavit that has been sworn by this affidavit has been sworn by the Honorable David Muni Madenge. It is further supported by a supplementary affidavit that is 21st, a supplementary affidavit of 24th of October 2024 by the Honorable David Madenge. In addition to that, we have filed a bundle of authorities which I believe that they have been furnished to the court. My Lord, looking at my watch, it is 3 p.m. I am certainly going to require some additional time, but let me start and see how best we can manage the time that has been allocated. My Lord, in a ruling that you delivered yesterday, you made a significant point that this is a matter of extreme public importance that deals with the most weighty issue that can be conducted, both with regard to the office that it relates to and to the issue of political succession. My Lord, the issue of political succession countrywide is an existential issue of the state. Existential issue of the state in the sense that this is an issue that when you read Professor Namwebe, Ben Nabweze, and when you read all these cases from Pakistan, they are the most weighty constitutional issues that can appear before any group of judges. And my Lord, for purposes of this country, we are saying that for the 2010 Constitution, the matter before you, and that is why has informed the filing of this application, is one that is an existential issue for purposes of the 2010 Constitution. Your Lordships, I say
Your
that...
Honor, sorry for interruption. You have been muted. I am unable to follow proceedings. Okay. Now it's okay.
Yes, my Lord. So I was submitting and saying that it is an existential issue for two reasons, my Lord. My Lord, most of us who are at least for 20 years are aware of two provisions of the former constitutions of Kenya. We used to have a section 23 of the Kenyan constitutions in which all executive powers were vested in the president. That position radically changed under the 2010 Constitution. We used to have Section 30 of the Constitution, in which Parliament meant the president and the legislature. My Lord, those positions changed. The change of those positions, which is the submission that we are making, the impeachment proceedings would have the consequences, if it goes the way in which it has gone, of effectively bringing back to life Sections 23 and Sections 30 of the former constitutions.
Now, the second issue that I need to emphasize on the existential issues of the Constitution is this. My Lord, from the standpoint of the Constitution, and to safeguard constitutionalism, there is these issues that is called security of tenure that certain offices enjoy, particularly with regard to the questions of removal. My Lord, the two offices that enjoys the greatest tenure are the office of the President and the office of the Deputy President. My Lord, why is that the case? Because they are legally protected that to remove a president or a deputy president, you need impeachment. They are also secured by the electoral process. That those two people, to get to those offices, they must be voted into those offices by the people. But the significance of this is this. Every other holder of the offices, from constitutional office holders to judges and everybody else, doesn't enjoy political tenure. It is only legal protection for those particular offices. So that, my Lord, the point is this, that the true weight of this matter is this. If it were to turn out that an office that enjoys the greatest protection, like the office of the Deputy President, can be called, the removal can happen as we are alleging it happened in this case. My Lord, the whole scheme of constitutional tenure and protection that is necessary to protect our democracy would effectively be null and void. This would mean if you have numbers, you do not like the speaker of the day, you can get him out. Numbers in a democracy, and that is why you write the constitutions, numbers must be controlled by law. If we reach a position where numbers cease to be controlled by the law, my Lord, that would effectively have negated all the constitutional gains that this country has made. My Lord, having made that point of the nature of the issues that we are dealing with, let me come to the issues before you. My Lord, the petitioners, or in those cases, in those affidavits, in the applications, are saying a fairly simple issue. They are saying that as a result of events that occurred in Kirinyaga, that are partly the subject of yesterday's decision that was made, and as a result of other matters that is the subject of the supplementary affidavit, the petitioners feel, and the petitioners are of a strong opinion, that a case of this magnitude is not the kind of case that should be decided by a bench in which they do not enjoy full confidence in. My Lord, the basis of that, since this is highlighting, would be four. My Lord, on the first issue is that the petitioners, and in the applications that they did and is a subject of overruling, they pointed out certain issues that brought into question the issues of the transparency, the proper accountability for purposes of the handling of that particular file. The affidavit is there. And then, according to the petitioner, that brought into them some doubts, the manner in which the handling was done, as to the impartiality of this particular bench. The petitioners goes on to issues number 2. They said that whereas they put in an affidavit setting out the reasons why there was a problem in the manner in which those issues were done, the respondents did not respond to challenge those particular set of facts. But, my lords, the petitioners are saying that now that the respondents did not challenge their set of facts, the contrary issue that happened is this, that in the ruling that was read yesterday, we got a copy 30 minutes ago, there was a section that was called Other Issues. In the sections that was called Other Issues, the petitioners are saying that this court answered factual and evidential issues that relates to that application. And the consequences of that is that although they had been agreed, to them that would amount to this court entering the arena of conflict between the parties, the petitioners and the respondents. And my lord, the old principle applies that a judge, one cannot be a judge of his own cause, and in any matter that they are dealing with, it should be a matter that they are absolutely neutral as far as the facts and the evidence are concerned. My lord, in our African societies, I've talked to my parents, I talked to Mr. Ogata, he said his community had the same set of issues. According to my community that I came from, in any those cases that used to be done traditionally, the first thing that would arise was this, and Article 159 says we respect our customs. It was to ask those who will be able to determine this case, are all the parties satisfied with this group of wazes that will be deciding the case? If any of the parties
my community does not do that.
I don't know about yours. I say mine and Okada. Mine is...
Okada is mine.
I don't know. Okada will talk for himself. But let me have some peace. I think he wants to destroy my train of thought. So that the point I was saying, I can be happy. Okada can defend himself what he told me. But my lord, I'm saying, at least for my community, that issue would arise. Does any of you have a problem with any of these wazes who will decide the issue? My lord, if the issue arose that a party says, we don't want that wazet to be there or that other one, invariably, and this is communal justice, that person would pull out and get a mzee, another mzee, that everybody feels comfortable with. So that, my lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. My lord, when the petitioners were speaking about what they said they feel, like is a three-judge bench, one in which they expect fair and square justice. That was a terminology in the case of Gerongori that we have attached on our submissions. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one, to the cause, or to the individual in which you are in dispute with. My lord, why is that important? That, my lord, is important because since Saturday of this week, in fact up to yesterday, but the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phones because they have seen me on television, where we have such a scenario that repeatedly they keep saying we are going to have what is it called? We are going to have a swearing in as soon as these three judges give to those particular orders. But that cannot create confidence, because assuming it is not this case, every party, and we have very many cases here, if somebody you are drinking in a bar says, no, you are going to lose that case before the persons we are appearing before, that, my lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge, huge problem as to whether actual justice is possible. And it might actually be, my lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. My lord, if that is the case, and that may actually be the case before you, but my lord, the scenario that is backed and that is prevented by the law is a scenario where the parties lose. Because they will say, well, you have Ahmed Nasir told us, Oscar Suki told us, Kariket told us, and all these individuals who are saying it was called drama. We are here for entertainment. My lord, if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, my lord, there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of the supplementary affidavit. In this notice of appeal, your lordship, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. My Lord, the second last issue that I want to say is this. The issues, my Lord, is, and we expressed that concern yesterday, we were not sure whether we would even file a notice of appeal as counsel. But we were told, you cannot file this one because it is the issue, as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery, as a result of the accusations and indictment that we are playing to the gallery. What effectively ended up being glossed over is the question of is a question of our own submissions. And my Lord, the basis, and therefore the accusation, and we are saying we were not treated in a temperate and judicious manner. The petitioners and their advocates. Then, my Lord, we go to the deciding for purposes of yesterday, the core issue. My Lord, the core issue in our petitions, a number of them when it comes, would be the question, does the IEBC have the power to have authorized the president to say that he did it? I'm saying it is in our petition. I'm saying one of the issues that will be coming in for determination.
My lords, I think it is important to just help my learned friend. We are not arguing the substantive application. It's a recusal. Let him stick to the issues.
Let him hear the issue and the answers.
But just do the right thing.
My Lord, the point I was making is this. One of the questions, I want to tie it with 165. And the question is this. The question that would be arising is whether the IEBC without commissioners could have declared Honorable Kindiki to be suitable for this nomination in the letter they did to the president. My Lord, that particular issue is significant because the petitioners are saying that this court, having effectively read Article 165(4) in a manner that amounts to amendment of Article 165(4), they perceive the real danger that when a more important question arises, the same logic would be applied against them. And they are saying, this being a very serious legal issues, the bench cannot be said that for purposes of the issues actually in contention, that the people can be oblivious of such an issue. I need like 2 or 3 minutes. My Lord, having said that, therefore, it is our submissions. And as our Honorable Minister said, nobody extracts any joy to raise this kind of an applications because judges are legal points. But my Lord, the point that we also want to add for purposes of this application, and this is contained, I believe, in the affidavit of my clients, is of course to point out to the issue. But the Honorable, the Deputy President, Rigathi Gachagua, by a letter dated 23rd of October 2024, did file a complaint against all your lordships, and this complaint was acknowledged by the Judicial Service Commission that it has been received. Then there is the issue that required disclosure. According to the petitioners, I wasn't even aware of this, I saw it today. According to the petitioners, is that there is a very close relationship between one of your lordships, the Honorable Judge Murima, and the Speaker of the National Assembly, who is the Speaker of the Senate, who is a member of here. That close relationship, according to the petitioners, is one that ought to have been disclosed so that parties could be able to make up their mind that are you comfortable? And we do that every day. I've actually not proceeded in a number of matters for some of the judges who are my classmates saying, keep your this, you are close, you are friends, you are comfortable. That question ought to have been raised. That issue was not raised, and as a result of that issues not having been raised, and now having come to public notice, the petitioners are of the view that it would not be proper to be able to proceed in this matter. My Lord, in conclusion, what I would like
before
to add,
before my learned friend concludes, I want you to be added another minute. Could he please, to assist us to respond, set out the nature of that relationship and where it is expounded in the affidavit?
well, my Lord, I thought that can actually come during the response, as I say.
No. The duty, the burden of establishing facts is on the person pleading the facts. So we want to know that relationship so that we can respond to it.
Yes, my Lord. I have no problem whatsoever. There is a written affidavit. My Lord, in paragraph 6 of the supplementary affidavit, it reads as follows: whereas I was not aware about the relationship between the Honorable Justice Mrima, who is among the 3 judges handling this matter, and the 4th respondent, that is Kingi, it has been brought to my attention that the Honorable Judge and the 4th respondent, Speaker of the Senate, are very close friends as demonstrated as here under. 1, the respondent attended the wedding ceremony of the judge and he took a photograph with him. Number 2, in a post on social media, he indicated... I thought I should finish. May I say something? May I say something?
Yes.
The position that my friend has taken, in my humble submission, was no support to this. We are not here to destroy professions. Disclosing some of the details may not be the right thing to say. I think one should make a reference in a tactical manner, which the Lordship will be able to appreciate of what is going on. I would respectfully say to you that this is an area where we have also to protect the judiciary, the judges, the magistrates, and the judicial officers. I'm not very sure that we should have an in-depth account of what really what is contained.
Thank you, Dr. Kamino.
Let me explain that, my Lord. There is a new affidavit that has just come online that contains some of these allegations. It wasn't there before, and that's why we sought. Now, you may proceed.
My Lord, I think I agree with Dr. Kamino that unless, because as I say, the source of any of this information or something that came to my knowledge, that I was sticking to what my learned colleague is talking about, unless there is insistence by my learned colleagues. My Lord, I do not see the value of that insistence as for Dr. Kamino's position. It is stated in the affidavit. I will not say anything more on that. The respondents can say we can have a rejoinder when the issue arises. My Lord, and the problem with these issues of somebody not continuing what they are saying is that you keep forgetting the last point. The last point, my Lord, I think that I was making is this. That at the heart of an application for accusal, the authority speaks themselves, the one we have cited, I may not have time to go through them, is these issues that are considered very important. Number 1 would be whether, on the basis of the accusation and apprehensions set out, would one party feel that their rights to fair trial before an independent, impartial, and fair tribunal be upheld? The petitioners on that score are saying their rights under Article 50 to fair hearing, which is absolute, would not be possible in the circumstances of this case. Number 2, There is a question of the right to protection of law under our Constitution. That right to protection of law requires that for it to be protected, there must not be any doubt that that protections would be availed if it is deserved in accordance with the law. The petitioners again say they have reasons to believe, as a result of all matters taken into account, that their rights under Article 27 will stand. Issue, it could not really have been final, but I have to finish. My Lord, the final issue that is critically important for this issue is the old notion, the old principle, that justice must not only be done, but must actually be seen to be done. In the circumstances of this case, it is our submission that apart from the real issues that the petitioners have, whether perceptions, whether substantial issues, the petitioners are saying that, Your Lordships, they are unable to say that at the start of these proceedings. We are confident that these judges are capable of upholding our constitutional rights and to uphold justice equally between us. Lord, we are most observed. Thank you for letting me conclude substantially on what we set out to do. We are most observed.
Thank you. My Lord, before the next speaker goes on, I think there is something we are doing and it is not fair to the court. Because my learned friend was challenged by Professor Miguel to tell you what is the specific thing. Then they take the posture, assisted by the senior, that we don't want to go there. You cannot eat your cake. The reason they don't want to go there, my Lord, is because it is frivolous. Now, the misfortune we have is this. The world is watching these proceedings. They said we don't want to go there. And the typical person watching things, there is something very serious about the integrity of the court that they have raised. When as a matter of fact, going by the list he had begun is that the judge attended the wedding. The judge went to a restaurant. In one of the applications, they said the judge went to some law school. Clearly, we are being unfair to the court. We want to paint a picture, hiding that we don't want to go there, so that the world will be left with the impression that there is something terrible about it. My Lord, I think it is Lord Cromwell who said, if you want to paint a picture of me, don't embellish it. Say it once and all. If they have any allegations now that we are broadcasting these proceedings to the world, if they have an allegation of any impropriety against any judge, they can't make the claim. For the gallery, then say, we don't want to go there.
There's something wrong somewhere.
You can't.
There's something going on that's wrong.
That is the gallery. No, this one is the gallery. There must be something wrong with the gallery. So I think it is something technical. If, just a minute, please. No, just a minute, please, Dr. If you are using a gadget, and your gadget could be causing this noise, please just set it properly.
May I make a comment, Madam? May I remind Madam Frank very, very respectfully It's our duty to protect
They are not protecting the court. They are telling the whole world that this court is improper. It has improper motives. They can't have it both ways.
But when they apply for recusal, they go the whole hog. You don't apply for recusal judges.
I think the proper way, Dr. Kaminwa, let parties submit according to the directions which we gave. And again, there is an application supported by affidavit. There are averments in those affidavits, and because some of those averments actually touch on us, but we cannot defend ourselves, we would be satisfied if you read them even verbatim, so that the world knows that these are your complaints against the bench. No.
As your lordship is aware, at times when we are in a court, we not in a court.
Okay, Dr. Kabuna, please say what you want to say.
You will say to a judge or judges that there have been information that I would like to show clearly that it cannot be explained. Can we close the chamber so that I can disclose that? I'm not asking to close the chamber. All that I will say, as lawyers or as advocates, we are also under duty to protect the judicial officers and protect the students.
I think that is okay. That is okay. I think one way of protecting judicial officers is by disclosing in open court like this what is there.
By being blunt.
Exactly.
Be blunt. You brought it yourself.
My Lord, next time, I hope also don't have to say you must tweet within 15 minutes, which is what they were trying, then accusing of not reading everything. Because I have not actually read everything. There are other issues I could have also have read. But my Lord, let me read this. My Lord, hearty congratulations to my long-time friend. That was underlined by there. And the source is Right Honorable Amason Jeffa Kingi, HH. The petitioners said the issue, and that is the issue that I picked during my submission, that there is a long-term friendship between the judge and the party. That long-term friendship ought to have been disclosed. I say that. Then it goes on to say, on the occasion of the renewal of your marriage vows with your beloved wife, this is now there, evidence that they are giving. You are a true testimony to the belief that spouses resolve to stick with each other through thick and thin, great things can happen. I wish the two of you the very best in this long journey, and pray that God continues to bless this union and review with wisdom and the patience that comes with marriage and family life. Hongera kakangu. And below there is the photograph where a gift is being given by the Honorable Mr. Kingi, Senator, to the couple of Judge Rima and I believe his spouse. That is the annexure that was put by the petitioners in proof of the fact that there is a close relationship, a close friendship that under the law ought to have been disclosed, given that Kingi is a very important party for purposes of the case against the Senate that he botched everything and has come here to defend those impeachment proceedings. I believe my job is done, and because that is all that it says, and that is the affidavit of the petitioners. Unless they need me to read something else, I can sit down.
The second applicant.
May it please you, my lords, my lady.
You are in another file, eh?
No, you can't.
Or we take it in another file or the same file?
Yes, my lady.
It's not in the same file. Yes.
I am in 509, where we have the application.
509 is in cohort 1, eh?
Yes, cohort 1.
Give us 5.
Your Lordship, with profound respect, permit me, Your Lordship, to indicate that we are arguing the application dated the 22nd of October with a further affidavit, Your Lordship, having been filed this afternoon through the court's email. And Your Lordship, from the onset, it's with heavy heart, Your Lordship, that we have moved you through these mechanisms. And that, Your Lordship, my submissions are the submissions of my client, and that I'm just a vessel for putting across my client's case. Your Lordship, there is a notice of motion that seeks the recusal of this bench. The same, Your Lordship, is supported with an affidavit and an annexure. Equally, the further affidavit is supported by 2 annexures. In my submissions, Your Lordship, I will heavily rely on the facts contained therein.
What's the date of your application?
The 22nd of October, Your Lordships, my lady. I'll begin by indicating and relying on the Judicial Service Code of Conduct and Ethics Regulation 2020, and I draw the attention of the court to Regulation 47. Regulation 47, Your Lordship, states that a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial officer, 1, is a part of the proceedings, B, was or is a material witness in the matter in controversy, C, has personal knowledge of disputed evidentiary facts concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has personal interest or is in relationship with a person who has a personal interest in the outcome of the matter, F, has previously acted as counsel for a party in the same proceedings, G, is precluded from hearing the matter, H, a member of the judicial officer family, has economic or other interest in the outcome of the matter in question. A recusal by a judicial officer shall be based on specific grounds to be recorded in writing as part of the proceedings. Your Lordship, it is my client's the bench should recuse itself on the ground contained therein. Permit me to begin by indicating that yesterday when the court was delivering its ruling, it indicated actual bias on the part of the parties before you, Your Lordship. The petitioners were condemned in a wholesale, in disparaging language coming from the bench, a language that indicated prejudice or bias on the part of the petitioners. It was indicated by the bench, Your Lordship, that despite the heavy submissions, the authorities that we quoted, we were not addressing the bench, but addressing the gallery. It is so prejudiced, Your Lordship, that such perception on the part of the petitioners culminated into the court not even taking note of most crucial issues that we had submitted on. For example, despite the appeal that is now being launched, the court failed to take into notice of the question of delegated authority. It is to consider submissions, Your Lordship, that had it not been for the bias and the prejudice that the court has on the part of the petitioners, such would not have escaped the mind of the court. Your Lordship, further, the court made further remarks that they take great exceptions with the remarks of the petitioners. When the court indicates that they take great exceptions with the remarks of the petitioners, it's a prima facie indication that the court has descended into the arena of dispute, and that the court therefore becomes or takes a defensive approach in the manner in which the prosecution of the case is being conducted. Your Lordship, a judge must at all particular time be a solemn person, slow to anger, and of good temperaments. Your Lordship, the statement indicates that the court has taken a position as against the respondents, the petitioners. And the position is prejudicial to the petitioners and erodes their confidence to continue appearing and making submissions before this court. It was the observation of this honorable court, Your Lordships, that my client indicates that the court made further findings that the petitioners were not pursuing the urgency of the applications. What a reasonable man, a bystander, a fair-minded person, listening to these statements, internalizing them, will come to a conclusion that the court has taken a hard position on or against the petitioners. The test of a fair-minded person, Your Lordship.
My Lord, we really to intervene, but my colleague, if he is added time for it, it's okay. But let him tell you how, yes, the ruling you issued will be a basis for an application that was filed long before that ruling.
Your Lordship, if he may be patient, he'll have his chance to bite the cherry and respond in that manner he so thinks that he should. Your Lordship, the application has also indicated that Justice E. Ogola is closely associated with his spouse, who serves in the Water Kenya Towers Agency. The averments of our clients, Your Lordship, is that this is a matter that ought to have been disclosed at the inception of the proceedings.
Let me get you right. You mean the judge is closely associated with the wife?
That is not my statement.
Yes, what is it that you said? Repeat for the record.
May I repeat for the record? So that the court may not again misquote me.
Proceed.
Your Lordship, the spouse of His Lordship, one Florence Oluoch Hauma.
You point to that issue?
Yes.
There's a disposition to that
Yeah,
issue?
there is a disposition to that issue, Your Lordship.
That Florence is the wife?
Yes, there is.
Paragraph?
Yes, paragraph. Paragraph 13 of the supporting affidavit, as read with paragraph 11 of the further affidavit. She holds a position in the Kenya Water Towers Agency, an appointment that was done pursuant to the Gazette notice number 7515 of 2013 for and on behalf of the presidency by Siopan Tuya. Your Lordship, it may go on record that the 6 respondent who initiated or made these appointments is a party in these proceedings, and that the parties...
No, my Lord, that's not factually correct.
I'm not getting you right, and I'm sorry for intervention.
Where are you lost, my Lord?
Here. If I'm looking at the same document as you,
yes,
the Gazette Notice 7515 was issued on the 7th day of June 2023 by Soipan Tunya.
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
He's the president.
Then, where is the next?
I'll get there. I'll get there. Your Lordship, the cabinet under the Constitution is constituted of the president, and the cabinet secretaries appointed there rather, and the deputy president of the Republic of Kenya. That Soipan Tuya is an agent of the presidency. Your Lordship, one of the issues that was before the impeachment was that the deputy president, the petitioner herein, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations were to be shared in accordance to that share agreement.
My Lord, that is the reason why his client got impeached. That is not anything that is before you for determination. That is the reason he got impeached.
You'll be given an opportunity to respond. Even if you are itching, Mr. Nyamondi, take your call. Your Lordship, it is my client's submissions that Florence Auma Oluoch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship,
kindly,
we have...
just a minute.
It is extremely unfair and unjust, especially for an advocate to mislead or what you have said to play to the gallery. Can we read paragraph 12 of the affidavit? So that he does, no. Yes. Let's hear it from him, where he says that the said board is chaired by the president, who has... So can he kindly do it properly so that you don't...
I'm sorry, I'm not...
Excuse me. No, excuse me. No.
Hold on.
Your Honors, your Ladyship and my Lords, they will have time, as you said, to respond and say all these things. If he's saying nonsense, they'll stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And
stop bullying people.
And we abhor the condescending nature of the respondents. Everybody here has been instructed by a client either to speak sense or nonsense. So, that being the case, the condescending attitude is completely objectionable. And everybody should take their seat and use their time with sense. If sense can only come from them, they do it during their time.
Thank you very much. Sir, can I finish?
My Lord, may I be protected to urge my application and the respondents be granted an opportunity to respond?
Finish what I was saying.
You will have your time.
I know I will have
to
my
respond.
time, but please, this is the application being presented. Let's not have other things.
It has been served upon you.
You will respond.
Just permit me to say one thing. Just one thing.
Your Honor, if I'm allowed to just say something.
Just a minute, Counsel. Just a minute, Counsel.
Let applicants finish their case and then people will respond. Because this interjections is just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes. Others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
Come to court and say that.
My lords, this is what I want to say.
Order. Can we have some order? Can we please have some order? Harvey, you may proceed.
I judge is first an advocate, second an advocate. We are all here advocates. My plea is we conduct these proceedings in an orderly manner. As Professor Gidu Mugai used to remind us when we were in school, to be an advocate, you are a superior mortal. Can we just be slightly superior and deal with this thing in an intelligent way?
Sandagwa, use your remaining time to conclude.
I am most obliged, Lordship. It may be noted that, Your Lordship, that the chair of this board is directly appointed by the President, the six respondents in this case. Your Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose, and that the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by Senior Counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I would wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
My Lord, may I object to that? Ahmed Nasir is not the law.
Your Lordship.
He speaks not to the law. Ahmed Nasir has also won an affidavit. He is not a witness, my Lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
May I answer that, Your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the president's lawyer says, we cannot receive justice. That is the standard.
My Lord, Ahmed Nasir says that this court will quash the impeachment of Rigathi. No, but the point is, he then speaks in your favor. Pick that line.
Let him respond. You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th, and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rule 47, is of paramount importance and something that cannot be ignored. Why didn't the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that would wish to expunge paragraph 16 of affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Macharia will highlight on the authority, with the authority in support of my submissions and those of Kibe.
Sorry, a slight clarification on the expansion. Paragraphs 10 and 16, if I heard properly.
Yes, that's correct.
Of the supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expunge paragraph 16...
Can you cover it in your response, please?
I may, but if you expunge 16, I have a problem with that. There is no application before you. If you expunge paragraph 16 from the affidavit, there is no application as being urged before you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.
Paragraph 16 of which affidavit? By who?
Whose affidavit?
And 16 is
the applicant's affidavit. That is Obuli Namenya.
This is 10, 16 is
My Lord, permit me with
perhaps, my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason is withdrawing that paragraph 16 is because the claim there is factually false. Because you can't just withdraw and leave the world thinking...
We are not even seeing that paragraph 16. Can you read it, the paragraphs we want to withdraw?
And 10 and 16.
Your Lordship, are you having the same application?
Read as paragraph 10, which we want to withdraw, and paragraph 16, so that we can consider if it can be withdrawn.
It's a lie.
in English, just read it.
We give Mr. Devoa, my lords, your leadership, the opportunity to finish.
Yes, yes. Let him read those paragraphs,
yes,
so that we can sit down.
No, I agree. I'm just saying, protect him from these tutorials that he's getting from this.
Order, please. Order. Please read as paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more in respect to the paragraph.
This is a direction from court. Read paragraph 10 and paragraph 16. Read
paragraph 16. Reads,
paragraph 10 first.
May I have some peace, Your Lordship?
No, listen, please listen.
Who is in conduct?
Listen. Bana Njiru,
Yes, Your Lordship. I'll read.
you have applied to expunge
Yes, Your
paragraphs 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expunge?
Your Lordship, paragraph 16 says that...
Paragraph 10.
It's the code. And Your Lordship, may I take note that these paragraphs have been expunged?
No, we have not expunged those paragraphs. It is your application.
Expunged them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed Deputy President, one Mr. Kithure Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is conflicted as she should recuse herself, as she was Mr. Kithure Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
Professor you will have your time to submit, sir. Stop eating. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
In a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record. Dr. Kamuna, we would appreciate if you want to address us in the course of the, as in your submitting. Is that the position?
Yes, that's right.
Okay, proceed.
My position is that if there is a party,
are you supporting the motion?
I'm supporting my land friends complaint to be able to as my friend is
You need to go.
Thank you very much to my senior. My lords, I'll take about 15 minutes. Mercifully, my issues are issues of law, they will not incite any shooting up from respondents, or should not. My Lords, and your Ladyship, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Virunga Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my Lords and your Ladyship to paragraph 1 of the decision, where the court says as follows, in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared a nullity, set aside, and the appeal had afresh. I invite you now to go to paragraph 9. We've done back-to-back photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talukan Singh Rai. And the court is saying what it held. And it says this. During the pendency, my Lords and your Ladyship, are you there? In the middle of paragraph 9. During the pendency of the applicant's motion and the respondent's preliminary objection, this court, in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear a finally concluded matter. In light of the decision in the Rai case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court was dealing with. Permit me now, your Ladyship and my Lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Joff in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when right-minded people, the right-minded people that Mr. Ndegwa was talking about, go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 66. And this, my Lords and your Ladyship, is what I would be beseeching this court to find favor with when you retire to do your ruling. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5-judge bench saying this in the Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with, the appearance alone. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And they say emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited earlier, I think I mentioned it. This is the case of Agostino Pinochet. It actually begins at paragraph 80. There's a long passage, I'll not read it on account of time. But at paragraph 81, they cite the basis for the reason the two applicants before you have moved you. It's the Latin phrase, nemo debet esse judex in propria causa. No man is to be a judge in his own cause. Then at paragraph 82, Lord Hope, in the same decision, indeed, it may be said of all the various tests which I have mentioned, including the maxim that no one may be a judge in his own cause, that they are all founded upon the same broad principle. Where a judge is performing a judicial duty, he must not only bring to the discharge of that duty an unbiased and impartial mind, he must also be seen to be impartial. Having considered all those, the court, and in that case what the issue was that the late Justice Laka had represented one of the parties previously, not in this matter, but previously. But at paragraph 86, they give a summary of what I've told you, and then go to paragraph 88, and then this is how the court finally resolves the matter. And I would also recommend to you paragraph 90. Let me read paragraph 90 before going to the conclusion. The mere probability or appearance of bias was enough to breach the cardinal rule of fair trial in the administration of justice. Having raised the issue of bias arising from the same circumstances in the hearing of an interlocutory application by the same judge in a matter involving the same parties, we do not understand why the applicant's counsel failed to raise the issue during the civil appeal. That omission notwithstanding, the seriousness of the bias, of the issue of bias, cannot be underrated. As observed in the Benjo case, bias is one of the grounds that would justify review of a previous decision of the Court of Appeal. As I said, this was the first time it's ever happened in the history of the Court of Appeal, and as far as I'm aware, the only time it has happened. So in paragraph 95, this is what the court says. Accordingly, we allow this application, declare that there was a failure of justice in the judgment dated 4th October 2002, and we accordingly invoke the court's residual jurisdiction to correct that injustice by reviewing the judgment and setting it aside with all the consequential orders. Now, my learned friend, Mr. Kibe, has referred you to a passage that my good and learned friends for the respondents insisted must be read. And this is a question of the attendance of a wedding where gifts are shared by a judge who, the gifts are received by a judge by a party who is before this court. We are before this court because the first petitioner was impeached in the Senate. The Speaker of that Senate is a party in this case. In the document presented by Mr. Kibe, the Speaker describes the judge, and there's nothing wrong with having friends, as I should say, I need to say this. He says, my long-time friend. This is what he says. Now, we found a decision, and I've shared it with you. This is the case of Naveen, where on all fours, a similar situation occurred. And I invite the court now to look at paragraph 70, and allow me to read this, because I won't be reading anything else after I read this. This is what the court, this, as I said, is Naveen Kerai versus Virunga Limited and others. I begin to read. I say paragraph 70, please forgive the coloration of the authority. And this is a 2022 decision. So both the Standard Chartered case and the case before you were determined under the current constitution. And as I'll be demonstrating here, they also took into account the Judicial Code of Conduct. I'm reading from paragraph 70. In this matter, the third respondent declined to recuse himself. This was a matter of an arbitrator, appointed under Article 159, declined to recuse himself on the basis that the relationship between him and the counsel for the first and second respondents was a professional one. This court, however, takes judicial notice of the fact that in the Kenyan context, invitations of colleagues to weddings is extended to those that one considers close, and such invites are not extended to all and sundry. Had that been the case, then the third respondent could have as well extended the invite to the counsel for the applicant, who is an advocate just like him. Given the circumstances, this court arrives at the inevitable conclusion that apart from being a professional colleague, the third respondent and counsel for the first and second respondents are friends. And that is the perception that any reasonable, objective, informed member of society would reach based on the circumstances of this case. I continue, paragraph 71. As counsel for the applicant stated, it is common knowledge that there is the custom for invited guests to give gifts at a wedding, exactly as happened in the case Mr. Kibe showed you. In this case, apart from the third respondent and the counsel for the first and second respondents, the applicants and their counsel will never know if the counsel for the first and second respondents was a gift-bearing guest at the traditional wedding or not. In this case, we know, because the photograph depicts a gift. It, however, boils down to the failure by the third respondent to disclose to the applicants and their counsel that he intended to invite the counsel for the first and second respondents to his traditional wedding and seek their views on the same. I need to emphasize that the real issue here is not that a wedding was attended. It is that that issue was not disclosed prior to the hearing and dismissal of an application in this matter and the continued conduct of these proceedings. I continue. Bearing in mind the final nature of arbitral awards, which can only be set aside upon a litigant satisfying the conditions stipulated under Section 35 of the Arbitration Act, the need for disclosure becomes even more critical. Paragraph 72. In S versus Roberts, the court stated that the apprehension be that of the reasonable person in the position of the litigant and that is based on reasonable grounds. I continue at paragraph 73. The counsel for the first and second respondents has stated that since he and the third respondent are arbitrators who have served at the Chartered Institute of Arbitrators, Kenya branch, as chairman and vice chairman of the institute respectively, during the same tenure, they were bound to interact or have interacted in the Chartered Institute of Arbitrators events, trainings, board meetings, and members' welfare gatherings while discharging their professional mandate. I do agree that the above events are professional in nature. However, weddings are personal events where families, friends, and close colleagues are invited. The lack of disclosure by the third respondent that he had invited the counsel for the first and second respondents to his traditional wedding is one that leads to the perception of bias. Due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence that applicants have that he will be neutral when it comes to the hearing and determination of the arbitral proceedings before him involving the parties hearing. In conclusion, this court holds that there was lack of transparency on the part of the third respondent, and he should have done the honorable thing when he was requested through an application to challenge to recuse himself from the arbitral proceedings in nature. This court finds that the justifiable doubts have risen as the third respondent's impartiality and independence, and the same have been proved by the applicants. This is a decision, and the only one we could find, that addresses on all fours the issue that confronts this court. I ask this court to find favor with this decision, to recuse itself, and I do so with tremendous, tremendous respect. It's just that the nature of the matter, the nature of the issues, and the perception as such as are captured in that decision. Recusal would be the only thing that would do justice to not only the applicant before you, but to the court itself. Thank you for the privilege of your attention, for your time. Unless you have any questions, I'll rest at that point. I said it, soft copy, you have.
Dr. Kamuna, you can proceed.
My humble submission that your Lordship must exercise flexibility. The usual case law making recusal is inapplicable in this case. As a matter of fact, I will say to you very, very respectfully, if there are parties indeed there are, who do not want, who do not wish to see you hear this matter. Please walk out. You are not the only judges in the country. Let another panel of judges be appointed to hear this matter. My Lord, if I may say so very respectfully, to refer to my own history. When you reach my age, you keep on looking at your history. I remember there were one or two expatriate judges, colonial judges. The moment you say to him, to him, to your Lordship, I would like you not to hear this matter. I want you to recuse yourself. His response was, okay, Hanima, if you don't want me to hear this case, let another judge hear it. That is the attitude that you take. Those of us who have had the advantage of receiving higher education know when you're giving introduction to philosophy, you are taught that perception, the first course you take is perception and reality. Perception and reality. When you're studying philosophy, perception is a very important concept when it becomes the arena of politics. Reality may be completely different. And indeed, I believe it is different in the case before your Lordships. I appear before you very often. I've never entertained any idea about your standing in relation to justice. But the perception now that has been painted by my able, learned friends, clients, Mr. Ndegwandiru, Mr. Kibe, and Mr. Macharia, that there is a sizable portion of the Kenyan population which will not be happy to hear you sit and listen to this case at all. And may I remind your Lordship very respectfully, impeachment is politics of the country. There is no way you can move away from that at all. I would respectfully refer you to a book I've taken the trouble to read.
Your Honor, sorry for the interruption. We are muted again. Perhaps you could be unmuted so that we follow the proceedings.
I wonder why it has happened in respect of Hamid. Can I speak now? Can I speak?
Yes. You know.
Yeah.
Yes. Your Honor, there is a book here, Politics of Presidential Impeachment. Politics of Presidential Impeachment. I've taken the trouble during the weekend to read this book. Impeachment is politics of the country. There's no way you can remove it from the politics of the country. And that's why I'm saying very respectfully that as you have been told, there are some people who feel very strongly that it should not be this. Get out. Let them get other judges to hear the case. You have no vested interest in the matter. There's no reason for you to remain in the case when other people do not want you to hear the case at all. May I remind you, my lords, when you are hearing impeachment cases, advocates will be able
to think broadly and bring to your notice the culture of the people that you are serving. There is a little song that is sung by a little girl in Kenya. To those of us who listen to the Kenyan radio may have heard of it. She says in Kiswahili, Kenya ni nchi ya watu akili kidogo. She sings very beautifully. Kenya ni nchi ya watu kidogo. Na wanataka kitu kidogo ndio wafanye kitu. Majority of our people are not the people who are in this country before. Majority of our people are people who have not had the advantage of receiving the education, the training that the judges and the advocates, the members who are in this room for. And as one of my learned friends very aptly pointed out, majority of the people believe that the case before you has been engineered by the politics of the country. And if some of them believe that your lordships cannot hear them, again, I say to you very, very respectfully, you stand to lose nothing. You better leave the case, let other people hear the case, and you will continue to maintain the name. My Lord, to go back to the politics of the impeachment, this matter was first heard in the National Assembly. The National Assembly very overwhelmingly stated that the deputy president had been impeached. It was then referred to the Senate, and the Senate again stated very overwhelmingly that the deputy president was guilty and convicted accordingly. My Lord, the stories that one hears in the streets of Nairobi, the stories that one hears elsewhere, you cannot afford to deny or ignore it. Stories like members of parliament were each given handsome amount of money. That may be so, or may not be so, but it doesn't matter. They have made the point that members of parliament received bribes, and they handed down a decision which majority of people believe that it was a corrupt decision. You cannot afford to ignore that. Now, when you go to the Senate, you are told the same thing, that members of the Senate received money in what is called white fascia or something called white fascia. They received money from known people. Again, you cannot afford to ignore that at all. Now, when they come to the judiciary, they expect the best. They expect people who have got integrity. They expect people who can hear them and whom they cannot suspect at all. But if then they are suspecting some people, whether truthfully, whether honestly or not, it is my humble submission, the natural thing as a judge, if I was sitting where your lordships are sitting, I would say, as Kaminwa, I'm walking out. Do not sit. It is the judiciary that people have got confidence in. That's why I may remind your lordships very respectfully. It is the judiciary that people of Kenya actually have respect for. It is the judiciary, the judges, that people think that can do good in Kenya. When we had a program in the year 2007, it is the judiciary that saved the country. When we had a program recently during the time of President Uhuru Kenyatta, and the matter went to the Supreme Court, it is again the judiciary that saved the country. Now, if you find people now are questioning the very institution of the judiciary, it's my humble submission that as a judge, just say thank you, I'm moving out. That does not necessarily mean that there is something wrong with you at all. And as I've said, my Lord, I've spent many years appearing before your Lordship, Mr. Justice Okola in Mombasa. At no time did anybody ever open his mouth and say to me that, Kaminywa, this Justice Okola is this, is this, is this, is this. Nobody ever did it. My Lord, Mr. Justice Moreno, I've had the privilege of appearing before you in many cases. There are cases where you have given me rulings. There are cases where you have not given me orders at all. But at no stage did I ever entertain an idea that there's something wrong with Justice Moreno. We have confidence in all of you. But now, this confidence of perception. There are some people who feel very strongly that Justice Okola should be out. Justice Moreno should be out. And let the judge, may I say, I'm letting you, I'm not discriminating against you. I'm one who has fought for rights of women. And I kept on shouting very loudly that we want women judges. I have not had the fortune of appearing before you very often.
Actually, you have on a couple of times.
Sorry, my memory is letting me down. But my Lord, may I say, I have had the opportunity of appearing before you. And may I say this much, my Lord, if you go and check the Judicial Service Commission records, you will not find a single letter from John Kaminywa complaining against any judge. I have never done such a thing at all. It's because I've got confidence in our judges. I've got confidence in our magistrates that they deliver justice. But I'm just saying you, my Lord and my lady, if at this time we have some people who feel very strongly in the camp because they may not get justice before you at all, please walk out. Don't continue to hear the truth. And indeed, the people who are saying that your lordships or my lady do not hear this case, when they are speaking, you cannot really criticize them. They have got some valid complaints. My Lord, United States of America, which I had the opportunity and the privilege of getting and studying their jurisprudence, they gave me additional legal education. United States of America, which has an impeachment provisions like Kenya, for 200 years, there is no president or deputy president who has been impeached, and impeachment has succeeded. None at all. None at all. Kenya, a young country which got the first constitution involving impeachment provisions, came into operation in 2010, and in 2024, we are now being told the deputy president has been impeached successfully, has been found guilty. Is it unreasonable to suspect there is something wrong? Is it unreasonable to suspect that someone is doing something wrong? Gachagua may be an actor, may not be probably properly educated, but he's a deputy president of the Republic of Kenya. Why should he be the first one within such a short time to be impeached in the country? Can't you suspect there is something wrong? That you are not doing some things properly? That America, which has had impeachment provisions for 200 years, has never successfully convicted someone for impeachment at all a politician.
Thank you, Dr. Kaminywa. Thank you very much.
May I say thank you? May I say with your respect, I would appreciate if you would uphold my submission. Thank you.
Just 2 minutes, my lords. In considering this application for recusal, I plead that you bear in mind the following. One, your brother, Mr. Justice Chacha Mwita, your brother, Mr. Justice Mugambi, your brother, Mr. Justice Mwongo, sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record before, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised against. So for that reason alone, please accede to recusing yourselves so that another bench can be set up to adjudicate those issues. So I thank you.
Very briefly, Your Lordship. My name is Rigathi Gachagua. I would like to talk about just three aspects on the subject of recusal, and I'll be making reference to three materials. I believe they've been circulated. That's a recent Supreme Court decision delivered on 11th of October 2024. Let me make arrangements so that they are brought the copies. Yeah. Your Lordship, on my right and on my left are counsel who are involved in this matter where the Supreme Court was asked to recuse itself.
Which case?
This is Dari Limited and 5 others versus East African Development Bank. Mr. Nyamondi and Senior Counsel Paul Mito on the same side, but today they are on different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that we are being accused of bias and working towards an undisclosed predetermined outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice. At least in the eyes and perception of the appellant stroke applicants. Consequently, and inevitably, each of us, of this bench, does hereby recuse him or herself from further participation in the hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. My Lord, that's a decision that was made just when these petitions were ongoing. So, when allegations of bias and working towards a certain outcome are made, what the Supreme Court recently is it recused itself. My Lord, I have a decision, an Indian decision. It's called State of Punjab versus Davida Pal Singh, which also the question of recusal was discussed at length. And again, I do not want to dwell. The whole decision is a very lengthy one. It's about 400 pages. But at page 9, at paragraph 16, the court set the standard that is applied in determining whether a bench should recuse itself. And the test, I read, the test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. The court went on to say, the court has to proceed observing the minimal requirements of natural justice, i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is a nullity, and the trial coram non judice. Therefore, the consequential order, if any, is liable to be quashed. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resolved in favor of recusal. So that, my lords and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself, that doubt should weigh towards recusal. That decision will be shared. And then the court went on to quash some proceedings which had taken place, an appeal had been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Lego was referring to. My Lord, I want to lay the basis as to where those provisions are obtained from. And those provisions are obtained from the IPA guidelines on conflict of interest in international arbitration. You will find that material is published by the I located it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining situations of conflict of interest. And it has graded conflicts in several shades, the traffic light shades. There's green, there's brown, and there's the waivable, non-waivable, waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties or with a manager, director, or member of the supervisory board, or any person having a controlling influence in one of the parties, or an affiliate of one of the parties, or with counsel representing a party. Going with the materials, if they are true, that was stated by my learned friends, then that situation has already arisen. And therefore, it is a good ground for refusal. I don't want to take much more time that these materials will be circulated. There is much more in these materials that speak towards the situation that is now. Thank you very much, Mr. President.
Sorry, Counsel, does the court have the benefit of the authority that you have referred to, the Punjab case and the IBA guidelines?
The Indian and the Supreme Court case?
Yes, and the IBA guidelines have you supplied?
Your Honor, I wish to say something on behalf of the second petitioner in 565. If I'm allowed to proceed.
Who are you?
Can you see me?
Your name?
I'm virtual. I'm online.
What is your name? What is your name?
Kimodo Teresia Wanjiro Makazi from Chipboya.
Yes, proceed.
Yes, thank you. I just wish to support that application by just submitting that public perception is everything and it cannot be ignored. I wish to rely on Article 47(1) and Article 50, and more specifically in Article 47(1) is where it says that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And more specifically on the part that is procedurally fair. Yeah. If you look at the way the court has conducted itself, of course we are in no doubt that the court is competent enough to handle these petitions, but then again, on the issue of the procedure, we had raised an issue of service, and the court ruled that we should check all documents in the portal. Unfortunately, today, you could not access the e-filing portal. So, what one is meant to wonder is why we were told to access documents online, and when we go to the portal today morning, it's not working. Therefore, there is this perception that perhaps there could be something going on, because at all material times, judges shall be impartial. And the issues being raised currently are that there is an issue. Sorry? Okay. So there are issues that are being raised that are raising issues to conflict of interest, whereby we have been directed by the applicants to note that one of the judge has a spouse who has been nominated or appointed by the President of Kenya, His Excellency William Ruto. And I think that is not a question where we should be giving out affidavits. I think that is a question where the judge, the honorable judge, should just come out and tell us, if this is true, then are you going to feel conflicted? So that we can, as petitioner, say, okay, proceed, or no, let's have a neutral bench. The other issue is the issue of another judge, Honorable Justice Murima, being seen No, not the judge. I'm not saying the judge. I'm saying the spouse of the judge being nominated or appointed. That's the issue that has been raised by the applicants. And so we feel, of course, if this appointment was done, will he be able to attending a wedding ceremony, Kingi? So the issue is, and they are long-time friends, will he be able to disappoint a friend? You know, these are the issues that the public is asking, and it's the perception anyway. So in issues such as this, we say these issues are very important and they cannot be ignored. And there's no point of, if people are saying we don't want the bench, it's not so hard for the bench to say, okay, just let's go back to the Chief Justice, please appoint another bench. There's nothing wrong with that. We know the judges are competent enough, but then if the issue of conflict of interest is arising, then the best thing to do before we go to the substantive issues is to pen everything down and say that go back to the drawing board and appoint a new bench. That's all.
Yeah, please, Your Lordship. My name is Daniel Manzo. I do appear for the third interested party, White Party Democratic Movement Party, together with Mr. Kala. My Lord, I want to say only one short thing, and then allow Mr. Kala to conclude without repeating what has been said this afternoon. My Lord, in 2008, I was involved in a matter which touched the Vice President of the country. I appeared before Justice Paul Kehan, and he immediately told me the second respondent is my personal friend, was my classmate in law school. I recused myself. I was sent to Justice Wendy. I appeared before her, and my Lord, she said, the first applicant, a renowned professor, is my personal friend, and I recused myself. My Lord, I ended up in an out-of-court settlement. I do ask Mr. Kala to conclude.
My lords, my lady, I just make one submission that in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate, we find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute because the question is, and this is a question that respectfully I want to pose to the bench. Will you feel comfortable? Do you appreciate the fact that so far the events that have taken place, whatever determinations that you will arrive in these particular matters, and they are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Murima did not disclose a relationship between himself and Amason King, which is out of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure by itself creates suspicion, apprehension in the minds of the applicants. The last question is, if Justice Murima decides to recuse himself, is it the entire bench that will recuse itself, or only one judge will recuse himself? Because I'm convinced that inevitably Justice Murima must recuse himself. Thank you so much.
Your Lordship and my lady, if it may please you, my name is Akimpa. I do appear for the third petitioner in the consolidated petition. Your Lordship, mine is just to put into context the Supreme Court decision in Dari and 5 others versus East African Development Bank. So, Your Lordship, in that particular matter, I want to say that, first of all, it was before the Supreme Court, and notwithstanding the doctrine of necessity, the Supreme Court considered that the right to a fair hearing by an impartial tribunal was so sacrosanct that the Supreme Court did not even consider the doctrine of necessity. So I just want to read paragraph 26 where the Supreme Court said, what is undeniable is the fact that by resorting to this cause of action, the applicants are unequivocally accusing this bench of lack of impartiality, fairness, and integrity. Such an accusation against a judge goes to the very core of his oath of office. Coming from a party to ongoing proceedings, such an allegation must strongly persuade the judge to recuse themselves. So that is what the Supreme Court said. So, Your Lordship, in that particular paragraph, the Supreme Court is saying that if there is an allegation, especially because this instance is actually almost same to that, because there was a complaint that was lodged against that bench before the Judicial Service Commission. I have heard today that the first petitioner has already lodged a petition before the Judicial Service Commission. Your Lordship, I beg that you are guided by this decision in holding that the right to a fair and impartial tribunal is very key.
Thank you, but I think you should let us know about the petition which has been lodged, because I don't think parties are aware of that.
Your Lordship, I think it is in the further affidavit.
A petition?
No, not petition.
What is it?
A complaint that was
Don't mislead the public. There's a whole difference between a complaint and a petition. Yes. Don't mislead the public.
He's the one who has said petition.
All right.
Yes.
May it please the court. My name is Dr. Eboso. I'm from Vihiga County, and I'm petitioner number 11 in the consolidated petition in the cohort 1. As I sat as a petitioner who essentially had no issue with the sitting of the bench, because when a petitioner files a petition, there is a presumption that the bench is properly constituted, and that Kenyans elected the Constitution of 2010, and in it provided the independence of the judiciary and the conduct of the expected conduct of judges. And therefore, we as Kenyans have trust in the judiciary and the individual judges at the time when they are appointed and during the course of their performance of functions. But as I sat, I agonized over the issues that have been raised, and at the outset, I realized that the recusal application has been made to this bench to recuse itself, or some of the judges to recuse themselves, but as a decision of the bench. And I agonized over whether recusal or the place of recusal proceedings in a setup like ours. And perhaps this was amplified by the back and forth that we saw with regard to the facts that were coming out. And I would wish to be persuaded by Dr. Haminwa that really recusal proceedings and the kind of facts that come to light ought not really be a subject of litigation for several reasons. One, recusal proceedings are really against individual justices, and they relate to the personal conduct, which really lies in the mind and conscience of the individual judge. I would give an example. Suppose we ask the bench for one of the judges to recuse themselves, and two of the justices disagreed with the recusal, but the very judge who we are asking to recuse themselves. Would we then say that this bench has ruled that the judge must sit? So it's really an individual decision of the judge to reflect upon the facts that are before him, the relationship that is being alleged, because why it can't be litigation, and it should be in the interest of all the parties that the judge is not biased. such that when you make it litigious, what happens is one side will be claiming the other side must prove a point, which they are not really very materially cognizant of. And it's really just the judge who knows the actual facts of the issue. And so it really is upon the judge individually to look at themselves and ask themselves whether the facts that are being alleged constitute what would amount to a bias. And when we make it litigious like this, we actually violate the Constitution for the reason that the conduct of a judge is not meant to be subject of any proceeding before court. That is a matter that should be before JSC, that should be before other tribunals. And the Supreme Court has told us that in Bellevue, that the conduct of a judge, because that's what is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of a proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we've proved a case or not proved a case is neither here nor there as relates to this issue. I'd like to refer the court, I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167, United Mine Workers of America in 1945. And there the court, the Supreme Court, found that I think one of the parties was asking for the entire bench to recuse themselves. And I'll just take maybe one more minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that that decision cannot be made by the bench. A question of recusal should be directed at the judge, and it should be the judge to make the decision whether they themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India, Justice Madan also pointed out the same. And finally, I'd like to refer the court to the fact that this is a sensitive matter, but is also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is the aspect of necessity that this matter must be heard. And there's also room for appeal should any person feel they are aggrieved by decisions of this court or the judges herein. And so what I would say is that I would ask that the individual justices, that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.
My lords and my lady doctor, if it pleases you in the matter, my name is Wamboi, Shadrach Wamboi. I speak with the blessings of my senior, Mr. Danstan Omari and Samson Yaberi, on behalf of the 9th petitioner. My lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling to question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and a dance of the blind, to the extent that the petitioners or the applicants making an application such as the one that finds itself before you sometimes refrain from even saying the very grounds upon which they make the application, as you have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they will think the applicant is saying about their conduct or their integrity. So for that reason, my lady and my lords, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that will flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Dari Limited. And there is something that is important that we must highlight. In this application, the Supreme Court was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that had been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lady and my lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application in petition number E015 of 2024, annexure marked DMM2, which is a letter addressed to my colleague Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? My lady and my lords, that should mark the end of my submissions. I shall pave the floor for the remaining minutes to my seniors to also speak some wisdom to what is in issue. Thank you.
My lady and my lords, my name is Sam Nyaberi, for the 9th petitioner in the 2nd cohort. I stand in support of the motion for recusal, and I juxtapose it in this manner. Recusal applications are tantamount to the court being on trial. It's a charge sheet for the court that it then will determine the parameters that have been set and the grounds that have been adduced to find or make a finding whether they merit. And in so doing, the court will not be given an opportunity to make submissions as we are doing. It's the court that is going to now render a ruling. Then the big question that we ought to ask ourselves, whether then the court is going to rebut on the heavy submissions that have been made, because going into the second room of going to analyze what the petition is all about will mean that we as the petitioners will have faith in even opening the second chapter of the proceedings as they are going to happen. So therefore, my lord and my lady, the point we are making is, kindly, there is enough evidence that has been laid before you to make a determination that indeed it is not available for the court to open the second chapter of going into the determination of the petition. I rest my case there. The balance of my time, I invite Omari to finish up and conclude.
My lord and my lady, mine will be very, very brief. One, the court, in determining whether the DCJ has powers to constitute a bench, made a finding that the petitioner was found guilty of an offense of addressing the gallery. His lawyers, all of them, never addressed the court. The lawyers were not addressing you. It is the petitioner who was addressing you. You have already made a decision that the petitioner was addressing the gallery. Will he have confidence to appear before him? Ahmed Nasir Sr., when he was constantly spotted by the Supreme Court that he was attacking the court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the Deputy President have audience before you when the main substantive motion comes before you? You have already made up your mind that his job is to address the public. The rationale for this matter, going live and my brothers and sisters saying it is a public interest matter, is because 55 million Kenyans are waiting to see the free learned judges appear impartial. It is our submission from our client Sharia Mtani that based on that you recuse yourself. I'll give a small analogy. When I went to pay dowry for a friend of mine, we were told that that place, those people were witches. So that religion, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we feared, my lord and my lady, that these guys might destroy us. The petitioner is scared of this page. That's my lord.
Are we through with all parties supporting the application? In that case, Professor, you can continue.
I thank you, my lord, and members of the bench. I will try to be brief. My colleagues and I, I think, would like to be truthful. First, we would like to begin by observing that today is the 10th day since this bench was constituted. It was constituted on the 14th of October. There were petition 522, petition 550, petition 569. Nobody ever complained at all until we came here on Monday. And even then, the complaint was an ambush. The petitioners appeared before my Lord Judge Ogola on the 16th of October. Orders were made in their favor, They were extremely happy. No complaint. The 3 judges of this bench were in the bench in 522 of 2024. No complaint. This complaint is a complaint founded on the fact that on the 18th, the Honorable the Attorney General, for the first time, also got orders. Now, that is when this bench became a bad bench. It was a very good bench for as long as it gave any order to the petitioners. It became a suspicious bench when it gave an order, only an order to expedite the hearing. The Attorney General had wanted many things. They were all declined. I will address you, my lords, on the understanding that we have 2 petitions. There's one petition I call the Kerugoya petition. And there is another petition I will call the Nairobi petition. It is our preliminary submission that yesterday's ruling of the 23rd substantially addresses the issues raised in the Kerugoya petition, and that those issues are now the res judicata. There is issue estoppel. There is issue estoppel, a doctrine of law that states a question that has been resolved by the court cannot be litigated afresh in the same proceedings. It is our second submission that the first limb of the Nairobi petition on recusal that speaks to how the case was handled between the 18th and the 22nd is also substantially settled by yesterday's ruling. And I think my learned friends, most of them, were able to confirm that. And they complained about that.
No.
So what issue is alive? The only issue that is alive is the issue of recusal, allegedly on the grounds that I'm so happy that my lady has been spared any further unwarranted attack as regarding her standing. So I will not make any reference to that. It has been considered that it was made recklessly without any factual basis. And I think that what an ethical advocate of the Honorable Court should do is to start by saying, I apologize to her leadership for these allegations that are contained in a document that bears my signature. But that is not for me to say. So let us proceed to the 2 other allegations. At one point, I was very surprised to hear a submission that said that my Lord Justice Ogola is close to his wife. How can that be? How can that possibly be a bad thing? But a further extension of that argument was equally spurious. A professional person is entitled to an independent professional existence. Be it the husband, be it the wife, be it siblings, be it children, they have independent professional. And I am shocked that that can be a ground. Another ground now made is that the Honorable Justice Murima is a friend of the Speaker of the House. The Speaker of the House was my student. I don't know whether I should recuse myself. My Lord, if I may say this with respect, I have been a law teacher for 38 years. I apologize that that's not very long. There are 3/4 of the lawyers under the age of 50, I have taught them. I don't know whether I should recuse myself each time I appear against, including the Honorable Tom Ojienda here, Senator. Could you confirm that?
I confirm that you're my teacher.
Yes. And Judge Murugaru, Senator, the Solicitor General, the Attorney General. This is the nature of our profession. This is the nature of our profession. The Speaker is a member of the legal profession. The Honorable Justice Murima is a member of the legal profession. How else are we to do our work? Paul Kibugi Muite, Senior Counsel, a personal friend for many years. On the day I got married, he brought me a copper coffee dispenser. Am I never to do any case with him? Should I always tell people? I know Paul Muite from when I was mayor. He came to my wedding. He brought me a gift. It cannot possibly be. That is not how this profession works. Let me very quickly set this, what I believe, we believe, is the standard. The standard is set in the case of the most important of this all, is the right case, which has been talked about. When will you ask for a recusal? And I agree with Dr. Kamino when he says that no lawyer, no advocate should ever make an application for recusal lightly. Indeed, an advocate approached by a client who is making personal attacks against a judge that are baseless must return the brief to the client. That is the honorable thing to do. Now, I have referred you to the right case, but the most important of this all is the objective test that is set in the Rawal case. In the Rawal case, which you are aware of, Rawal versus Judicial Service Commission, the court says there is no basis for a judge to automatically recuse themselves when a bare allegation is made by a party. The allegation must be substantiated. First, they now quote the Court of Appeal. Firstly, it is obvious from the above test that there is no basis for the rather elastic test propounded by Dr. Kaminwa, where a judge must automatically recuse himself or herself upon the making of a bare allegation of any of the parties. We have not come across any authority in support of the proposition, and Dr. John Kaminwa did not provide any. On the contrary, decisions abound that judges must not recuse themselves on flimsy and baseless allegations. It is our submission that a claim that the friendship that may exist between a party and a judge because they went to the same school, because they went to the same university, because they come from the same county, that is baseless. It must be demonstrated, like was said in the case of Kaplan and Stratton versus Z Engineering Construction Limited. If disqualifications issues were to be raised, say, because a judge and a member of the bar belong to the same Rotary Club or the same Lions Club or the same sports club, there would be no end to such approaches. There would be no end. In this case, it has not been demonstrated that there is any way in which the independence of any of the judges here can be said to have been compromised. let me say something relating to the Dari case, because I was involved in that case, again with my very good friend, the Honorable P.K. Moite, on one side, and my friend Paul Nyamodi. They were on one side, I was on the other side. I think that's why Mr. Nyamodi has now come back to my side, because we were the successful party in that case. And as one of my learned juniors here on the opposite side has stated, you need to understand the context of the Dari case. Because at paragraph 24, the court states this: the appellant's applicants herein are seeking a stay order from this court in the most unusual, strange, and dare we say disingenuous strategy. What had they done, my learned friends? We had litigated for a very long time. Litigated in England in the High Court, litigated in England in the Court of Appeal, litigated in the High Court here, litigated in the Court of Appeal here, litigated in the Supreme Court, and their final card, they had made a complaint against the Supreme Court. And what they were asking the Supreme Court to do is stay proceedings as we go to prosecute the allegations we've made against you. And I think the Supreme Court threw the sink at them. And that is why the decision says what it says. Now, I want to wind up by saying that if this court were to accede to this application, it would throw into disarray a critical public interest litigation when the country is in the throes of a serious constitutional crisis. And that is why philosophers like Dr. Muthomi say that cities burn as philosophers are quibbling on whether we need a bucket or a pipe to put out the fire. We are in the throes of a grave constitutional crisis. The court that we have been given to resolve this issue cannot stop sitting on the basis of the most flimsy allegations of friendship between parties, because I don't know of a single representation here that is not related to another. If you opened this door, you will have created a precedent where all a lawyer needs to do, an advocate, all he needs to do is to make a connection. To make a connection. You go to the same church. You go to the same mosque. You used to work in the same chambers. You were trained by the same pupil master. Our connections will never see. Like they say about taught actions. There can never be an end to taught actions, and there can never be an end to the relationships we have in the legal profession. An applicant must demonstrate that because of that relationship, there is reason to believe, demonstrated by either past behavior, past judgment, past ruling, past conduct, that a judge will be biased in any way. But ultimately, as the authorities I have cited to you state, a judge has taken a judicial oath. A judge has a judicial oath. He answers to his conscience and to his oath. And finally, I will say, because I've had the great privilege to sit as an arbitrator in numerous matters, both locally and overseas, I have never found a standard that requires that if a person who has a historical connection with somebody, without demonstrating more than that, can be the basis of recusal. I will now hand over, before Madam Timekeeper asks me to my learned friend, Mr. Boone.
My lords and my ladies, for completeness of our record, we have filed grounds of opposition. We also have filed a list and bundle of authorities, all dated the 22nd of October 2024. My lords and my lady, permit me to start by saying that judges, just like any other judicial officer, have a duty to sit. They sit to determine disputes between parties who come before them. That is what makes us a country governed by the rule of law. In that duty, my lords and my lady, it is important that we ensure there is efficiency in the conduct of that very important responsibility. That is on the one hand. On the other hand, it is important that judges then guard against manipulation of processes. In the context of what we have, proceedings like we have today, the manipulation of process could manifest itself in the form of forum shopping, where we say that I will file this matter before this court, and before this court. In my hope, one of them will give. And that if I run into headwinds in any particular direction, then I must, as of necessity, run away from that court. My lords and my lady, this is a position that has been adjudicated, the fact that the court has a duty to sit, all the way to our Supreme Court. We have in our list and bundle of authorities provided, I cited one of the cases as being a case of Gladys Beausoleil versus the Judicial Service Commission and a second party. At paragraph 5 of that decision, the court says that the doctrine of duty of a judge to sit, though not profound in Kenya's jurisdiction, then there's a spelling mistake. Every judge has a duty to sit in a matter which they should duly sit in. Recusal should not be used to cripple a judge from sitting or to hear a matter. That duty to sit was buttressed by the fact that every judge took an oath of office to serve impartially and protect, administer, and defend the Constitution. In yet another decision, Peter Mwangi Gishuru versus the Attorney General and the Salaries and Remuneration Commission, at paragraph 61 of that decision, the court says, the court has a duty to sit on matters presented before it for resolution and should only recuse itself where circumstances permit, but not where it will create an unconstitutional moment by refusing to hear a litigant's case because the opposite party apprehends bias. In what context then should we understand that jurisprudence? My lords and my lady, it must not be lost on us that when we are dealing with momentous topical issues of conversation in a country such as Kenya, like what we are dealing with, these matters evoke emotions. Just like in our election context, whenever a party loses, it is never so easy to accept the result of that loss. It is for that reason that sometimes people have all manner of aspersions cast against the court, against the independent, let's call it all other independent organs of the Constitution, because a decision has gone one way or the other, in instances not favorable to one party and favorable to another. We must appreciate that we are in an adversarial system where, as of necessity, a decision will be determined or will be made in favor of one party as against the other. That said, my lords and my lady, learned senior counsel Professor Githu Muigai has made reference to the fact that the matter that is before you, though dubbed as recusal, is a matter whose subject matter has been completely determined. There is issue estoppel, and that everything that has been presented before you today are issues that were contained in the ruling that your lordships issued yesterday. As a starting point, I would make reference, my lords and my lady, to the application that was filed yesterday by our opponents. The application seeking to have this, questioning the empanelment of this bench. If you look at paragraph Y of that application, on the grounds on the face of the application, my lords and my lady, the court was invited particularly to recuse itself. It then means that that motion for recusal was a motion that was live before this court. That motion was live between the same parties. It touched on the same issues that were presented before this court. The court pronounced itself on all those issues. What then is the business of bringing those issues through this second court application in the name of an application for recusal? My lords and my lady, if at all, as we now see, the applicants were not satisfied with that decision, the ruling of this court, the option that was available for them was to appeal that decision. Presenting this second application does not in any way open for them a door other than for purposes of delaying these proceedings. And I would say that with tremendous respect to my learned friends from the other side, and so that I am able to demonstrate, permit me to just look at the applications that have been filed and the issues that have been raised in those applications. I'll start with the application filed by my good friend, Dr. Evans Ogada. In his application dated the 21st of October 2024, he raises as ground number one the issues of the certification of these matters on the 18th of October. That was an issue that was before you yesterday. At paragraph 3, so that we understand context, he also says that on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with an order of this honorable bench stating that the first and sixth respondents' applications dated 18th October 2024 was coming up for inter-parties hearing. Again, that was an issue that was before you. At paragraph 4, it talks about the subsequent reference of the matter by the Chief Justice to the Chief Justice on the 18th of October. That was an issue that was before you. Finally, he questions the unclear circumstances that led to the placement of the file of this bench on a Saturday before you without the express directions of the Chief Justice. Again, my lords and my ladies, that was a matter that was before you. In the application by Mr. Njiru Ndegwa, again, the same thing. First ground, that the petitioners have learned that this bench sat on a Saturday, the 19th of October 2024. That was an issue that was before you. Paragraph 2, it says that the petitioners were surprised by the sudden turn of events, again the same language used by the other application, in the other application, a matter that was before you. Paragraph 6, it says that the petitioners are apprehensive that this honorable court has clearly demonstrated that the case for the Attorney General is more important than our petition, yet they are raising similar issues. Again, that issue was before you and it was determined. Paragraph 8. Let me stop first there. How then do we treat all those issues that were before you? And if we're, just so that then we understand that these matters were before you, when you delivered your ruling, which was shared with us this afternoon, from paragraph 73 all the way to paragraph 96, each and every of these issues were responded to. I mean, determinations were made. At paragraph 79, for instance, the court says, but backed by this sequence of events, we take great exception to the petitioner's conduct that when favorable to the petitioners, orders issued outside the normal working hours of a court raise no concern. However, when the same court acts in an instance where it has been properly moved by the other parties and likewise proceeds to deal with an application at hand in the same vein, the petitioners show their indignation. That was a finding that was made. At paragraph 96, you even go further to say that one of the senior counsels went further by intimating that an exercise akin to the radical surgery may be forthcoming, a statement which we perceive as a veiled attempt at intimidation coming from senior counsel. My lords and my ladies, what is left that you're supposed to determine again? It is an attempt to have a second bite at that which has already sailed. If for one moment we were to look at this application by Mr. Ndegwanjiru, he then introduces very strange allegations which he has had to withdraw. Everybody saw his discomfort at making reference to those issues. But as we all observed, these issues around making allegations and running away from them are meant to cast aspersions and indirectly intimidate the court. Permit me to say, or to make reference to paragraph 8, where they say, for instance, that the petitioners have credible information that Honorable Justice Mrima is a close associate to the proposed Deputy President, Mr. Kithure Kindiki, and that the said judge failed, refused, and or neglected to disclose that fact. Really, is that an issue that a party seeking the resolution of a matter that they brought under a certificate of urgency would want to raise to be a reason for a judge to disqualify himself? What is this association that we are talking about? What evidence have we tendered that there is anything that will be considered to be either untoward or that will make it inappropriate for the judge to sit in these proceedings? In fact, they go on to add, in a paragraph that they sought to, one of the paragraphs, at paragraph 10, say that this close association between Honorable Justice Mrima and the proposed nominee for the position of Deputy President of the Republic of Kenya might have caused this court to convene and sit on a Saturday with a view of assisting one party in these proceedings. Is that not outrageous, to say the least? We go on to say, at paragraph 11, that the petitioners are in possession of credible information that Mr. Justice Ogolla, who is the presiding judge in these proceedings, is conflicted as his spouse is a member of the Kenya Water Board, having been appointed by the President of the Republic of Kenya, who has in haste nominated Mr. Kithure Kindiki as his principal assistant. Allow me to pause on that allegation for one moment. What evidence do they present? Absolutely none. Today, let me take one step back. Yesterday, when the court was rising, we did put them on notice that we would seek to cross-examine the deponents of the affidavits that contained these very unfortunate averment. To try and cure that, they've then introduced a gazette notice. In that gazette notice, my lords and my lady, they then seek to say, gazette notices speak for themselves. The gazette notice says, that is gazette notice number 7515, in the exercise of powers conferred by those provisions of the law, I appoint Rose Ombaki and Florence Auma Oluoch to be members of the Kenya Water Towers Agency Board for a period of 3 years with effect from 9th of June 2023. The appointments via gazette notice number this and this are thereby revoked. That gazette notice is signed by the Cabinet Secretary for Environment, Climate Change and Forestry, Soipan Tuya. At what point, my lords and my lady, at what point does it become that it is His Excellency the President who appointed I want to use the words. His spouse is a member of the Kenya Water Towers Board, having been appointed by the President of the Republic of Kenya. When we come with such outright lies, what are we trying to do to the court, to the individual members of the court, to the parties before these proceedings? Is it a case of saying that we will get out of that court by all means necessary, including by peddling lies? My lords and my lady, these are the grounds upon which you're being asked to recuse yourselves. I've also seen there was, just give me 1 second, there was an equally strange averment about Lady Justice Freda Mugambi. Paragraph 16. Okay, let me just get that. Getting that. Thank you. That Lady Justice Mugambi is conflicted as such as she could. Wait a minute. No, it's not this one. But there is an averment to the effect that Lady Justice Freda Mugambi was a student. Okay. 16. Okay. Yes. That Lady Justice Mugambi is conflicted as such she could recuse herself as she was Mr. Kiduri Kindiki's LLM student at Moi University, a crucial issue that she failed, refused, and or failed to disclose to the parties at the inception of a trial. My lords and my lady, the qualifications of our judges are no secret because they're state officers. You only need to go to the website of the Judicial Service Commission and you find the truth. My lord, my lady, when we saw these very strange averments, we took the trouble to go to the website of the Judicial Service Commission and we established that Her Ladyship Justice Wilfreda Mugambi got her LLM from Birmingham University in the UK. How then do we want to bring these lies and feed them to the people of Kenya, feed them to the court, and expect that on account of such flimsy, concocted material, then the court should recuse itself? Again, is it a case of us saying, by all means necessary, we shall not appear before that court? My lords, my ladies, there are clear standards and thresholds that have been established both by the regulations governing the conduct of the court and even case law. That, my lords and my lady, first, you exercise your conscience as to what should make you recuse yourself. Number two, in the event that a party is raising a concern as to your recusal, then it must be a substantial issue. It must be a substantial question that has been brought before you. It cannot be that every frivolous allegation that is brought before the court should make the court down its tools. That, my lords and my lady, will amount or will create or facilitate an environment where forum shopping will be rife. We'll just need to mention anything, that I went to school with so-and-so, that I'll go to church with so-and-so, that I traveled with so-and-so, and that should be a reason for them to recuse themselves. That certainly cannot be the standard. My lords and my lady, I would refer you to one of the decisions in our bundle and list of authorities. That's UNAD, Ex parte CJL 1986, 60 AL JR 528, where the court had this to say, that although it is important that justice must be seen to be done, it is equally important that judicial officers discharge their duty and do not, by acceding too readily to suggestions and appearances of bias, encourage parties to believe that by seeking the disqualification of a judge, they will have their case tried by someone thought to be more likely to decide the case in their favor. My lords, my lady, the question that we'll be asking ourselves is, what is that fundamental question that has been presented? And why this is an important concern is because sometimes such frivolous grounds are raised purely to embarrass the court. On this occasion, I have absolutely no doubt in my mind that the net effect of what these allegations have done is an attempt at embarrassing the court. My lords and my lady, we urge that you resist that invite. You resist that temptation to ask the court to recuse itself on the basis of such flimsy, baseless allegations. Just to further speak to the fact that this is an attempt at embarrassing, if not intimidating, the court. Our friends for the applicant have also indicated that they have simultaneously sent or lodged a complaint with the Judicial Service Commission. Following from the submissions that I made reference to in the ruling about intimidating the court with radical surgery, again going to the question of presenting this application for recusal after the one yesterday, and now going to lodge a complaint to the Judicial Service Commission, is that not an attempt at intimidating the court? My lords and my lady, I would not ask for an answer. That is an issue that anybody, any reasonable person out there would be able to make an indication or a determination about in their own space. My lords and my lady, is it also possible that this could be one of those issues that the applicants, or rather the respondents, have complained of as being a delaying tactic? Because we raised concerns yesterday. We are raising them again today. We have spent a whole afternoon arguing about issues that on the one hand had been completely determined by this court. The second part of those issues are issues that did not have any grounding, any material or in support whatsoever. Are those not meant to delay these proceedings by any means necessary? Having taken cognizance of the fact that we came to you, both parties, under certificate of urgency, these matters must be treated with the urgency with which we came. And so we ask, my lords and my lady, that you dismiss that application with the contempt it deserves. May I now invite my learned friend, Mr. Nyamodi, to speak to a few of the remaining issues. My lord.
My lords, my lady, I wish to commence my submissions in opposition to the application for recusal before you this evening by tendering an unreserved apology on behalf of the members of the bar who have been urging and opposing the application before you today. Despite my relatively few years at the bar, I appreciate that prosecuting an application for recusal, and I have some experience in prosecuting applications for recusal, and it will become apparent in a moment, are not easy applications to prosecute. But the reason that I offer the unreserved apology is that it is my humble and respectful position that however difficult they are, there is no need for them to be prosecuted in as bad-natured a manner as these applications have been prosecuted before you. And for that, I am sorry. The only mistake that your lordships and my lady have made is to serve your nation as judges of the High Court and choose to sit in this matter. We have been told that there is no difference between this matter and any other matter, and I affirm that there is no difference. It is a matter just like any other matter. I wish to start by perhaps completing a submission that was made and not completed by my learned colleague, Mr. Gumbo, who submitted a few moments before. The issue of your recusal was not just an issue in the grounds, in the notice of motion that you determined yesterday, but it was contained in prayer 5 in that notice of motion. And I do not understand why the petitioners complain of bias or any improper treatment by this court. Because again, in my few years at the bar, in my relatively few years at the bar, seldom have I come across an application dated today, heard on the same day, and a substantive ruling running to in excess of 40 pages delivered the next day. So that issue has been dealt with conclusively by the court in yesterday's ruling. I wish to then focus on the authority that was cited in the dairy matter. And again, in my relatively few years at the bar, I have had the the privilege of arguing several matters in the Supreme Court. Many of them are precedent-setting. Dairy is one of them, and I did not know dairy would be one of them. But the ruling of the Supreme Court delivered in the dairy matter on the 11th of October this year has confounded me for a few reasons. I am still trying to understand what the meaning of that decision is. And I will share with your lordships some of my, some of the issues I have with that decision, and hopefully in your ruling you will help me understand them. The decision in dairy is not available as an authority for what the petitioners cite it to be. And one of the issues that confound me with that dairy decision, and if my lords, my lady, when you retire to consider your ruling in this matter, you take a moment and find the original script or the original version, not the one reported in KLR, but the one that is on the Supreme Court's website and was circulated to us on the 11th of this month, you will find that at the beginning of that ruling, Paul Nyamodi, yours truly, is referred to as senior counsel. Now, I cannot insist that I'm senior counsel because the Supreme Court referred to me as senior counsel in that ruling. That is the first issue that confounded me with that ruling. The second issue is that there was no application for the learned judges of the Supreme Court to recuse themselves. There being no application for the learned judges of the Supreme Court to recuse themselves, learned judges of the Supreme Court did not then have the benefit of argument from counsel for either of the parties as to whether or not they should recuse themselves or not. And if you look at that dairy decision, you will not find anywhere.
Perhaps you are disparaging the Supreme Court.
I am not. I am speaking about their decision. If you look at that decision, in the disposition at the end of that decision, the Supreme Court does not declare that it has recused itself. So if you were to extract the order, the issue of recusal would be absent. So in respect of that, I wish to submit that the issue of recusal in the Dari matter is then obiter. Having not been an issue before court, and having not been an issue that parties submitted to, it then cannot become an authority. It cannot then be cited as an authority for recusal. The second issue about the Dari decision, and the second reason why I say that Dari is distinguishable, is as follows. Unlike in this matter, where the issues, where the facts upon which the application for recusal are based have been judicially considered and a decision given, and that decision is contained between paragraph 74 and paragraph 96 in the decision you delivered in this matter yesterday. In Dari, the issues that the Supreme Court then suo moto relied on to recuse themselves had not received any judicial consideration. Yes, those facts went on to become a complaint before the Judicial Service Commission. In the same way, the facts that form the basis of your determination between paragraph 74 and 94 of your decision have gone on to the Judicial Service Commission as a complaint. But those facts now forming your decision, the proper thing to do is not to complain to the JSC, but to appeal. That is the proper thing to do. So to then file a complaint before the JSC and then reach for Dari out of context is wrong. And for those reasons, that Dari decision is distinguishable. And I urge you to distinguish it. The second decision that I wish to urge you to distinguish is the decision that was cited by my good and learned friend, Mr. Tom Macharia, the Navin Premji Kerry versus Virunga Limited decision. And the reason I want to urge you to distinguish that decision is as follows. A true reading of paragraph 5 and paragraph 6 of that decision show that the arbitration commenced on the 31st of March 2021. The traditional wedding, which the judge then took offense to, took place on the 18th of February 2022. So it is clear, and that is clear from a reasonable process of deduction, that the traditional wedding then took place during the currency of the arbitration. That is not the case here. The screen grab that has been produced of Mr. Justice Mrima and the Speaker of the Senate, if we are to believe that it is true, is dated the 9th of October 2021, more than 3 years ago. So this decision is distinguishable on the facts. Judges do not live in glorious isolation. Your appointment as a judge does not mean that you cannot invite your friends to a wedding. On the 9th of October 2021, Mr. Justice Mrima did not know that he would have to go through the torment of sitting on this bench. In respect of the Manchester Outfitters decision, I also submit that that decision is distinguishable for the following reason. Mr. Justice Laka had been an advocate for one of the parties. Again, in an advocate-client relationship, the client pays the advocate fees. And that relationship is not at play here. And for those reasons, I urge you to distinguish that decision. My Lord, there are two pieces or two annexures that we wish to make a specific submission on. And that annexure is the screen grab from Amason Kingi's account and the prophecy by learned senior counsel Ahmed Nasir as to what would take or what is going to happen in this matter. My Lord, those are electronic evidence. And those are electronic evidence I submit within the meaning of Section 106B of the Evidence Act. In the absence of a certificate, required by Section 106B of the Evidence Act, that evidence is not admissible. My Lords, it has been submitted by those who have submitted before me in opposition of the application that the petitioners are guilty of forum shopping. I wish to persuade you whilst on my feet this evening that this application is a further attempt at forum shopping. My Lords, my Lady, you will not, because you are seized with petition number 522 of 2024, that on the eve of the impeachment hearing, the petitioners insisted at an hour not too different from this that you hear their application for conservatory orders. The application was heard, and you, with exceptional dispatch, delivered the ruling the next morning at 8:30 in the morning. My Lords, my Ladies, after the ruling, the learned counsel who are in court for the petitioners engaged you in a lengthy submission, which appears to be their stock in trade, on a request for leave to amend that petition. And the requirement or the request that they wanted, or the reason why they wanted leave, was they envisaged that perhaps after the impeachment proceedings in the Senate, there may have been need to have recourse to court and seek certain orders. But what did the petitioner do? The petitioner, and we are told that he was unwell, as he was unwell, issued instructions for this petition to be filed, for petition 565 to be filed, and conveniently this petition did not come to this bench. This petition went before another court, and surprise, surprise, before that court they got their orders. And it is those orders that they seek to defend here today. A request for you to recuse yourself is in furtherance of their attempt to forum shop. And my Lords, my Ladies, as I take my seat, I urge you to bear in mind the finding that you have already made about these petitioners. Paragraph 98 of your decision and paragraph 99 of your decision rendered this morning, or rendered yesterday, which with your permission, I ask to read. Counsel also insinuated that this bench is part of a conspiracy to violate the petitioner's rights to a fair hearing under Article 50 of the Constitution. These submissions are without foundation and wholly without merit. The court has not issued any rulings or directions that would suggest such an intent. It is apparent that this argument was made for the gallery, and we find it unnecessary to address it further. This is in furtherance of that disposition of the petitioners. This is a serious matter. As has been submitted by my learned colleagues, you have a duty to sit, and we urge you to sit and dispense justice in this matter. I'm most obliged.
My Lady and my Lords, hot on the heels of submissions by Mr. Nyamodi, now Senior Counsel, I wish to state as follows. My Lady and my Lords, the serpentine and sinuous submissions by Ndegwa and by my learned friend, Senior Counsel John Aminwa, just in case he says I was breastfeeding, must be faulted for two reasons, my Lord. My Lord, one, Mr. Aminwa refers to the Richard Nixon impeachment as the first impeachment, when it is clear, my Lord, that in the US, the first impeachment was that of President Andrew Johnson in 1868, coming after he dismissed a war general, Mr. Stanton. The Richard Nixon impeachment was the second impeachment coming in 1974, because you said that was the first impeachment, and Nixon resigned. It's just important for context, my Lord. Yes, my Lord, it's just important for context that in the second impeachment of Richard Nixon, He resigned on the 8th of August, 1974, and thereafter, the next president, Ford, took over for the next 3 years. I think it is striking, my Lord, to refer to this impeachment because of the case of...
Nixon was never impeached.
He resigned. I've said he resigned. After the Watergate scandal, the impeachment commenced and he resigned. And that is what gentlemen do when an impeachment is imminent. My Lord, I want to connect this to my submissions that we shall be relying on the political question doctrine and the finality of impeachments by Senate in a comparative context. My Lord, let me submit that in Gladys Bosch-Sholay versus JSC, this court set out a threshold for recusal. And the threshold is, my lords, that a recusal application must be made in good faith. And if the court listened to the histrionics from the petitioners, the courts will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scuttling the bench and scaring them away from sitting so that they can have open-ended and irregular orders issued in Kerugoya by Justice Richard Longo. Then they went to the second act of actually filing a complaint with the Judicial Service Commission, submitted to Isaac Wamasa and duly acknowledged, so that this court can be scared away and run away. My Lord, then the scheme is not complete. My Lord, Judge Ibrahim, at page 31 of the Gladys Bosch-Sholay decision, stated, my Lord, that the threshold for impeachments cannot, for recusal cannot be solo, and every allegation made of any form of bias must be proved through credible evidence. My Lord, I dive straight to section 11 of the Oaths and Statutory Declarations Act. The petitioner's affidavit. The petitioner made a false affidavit through a deponent who swore to factual issues that the petitioners then attempted to withdraw in court. My Lord, that not only invites a criminal sanction under section 11, but what is more important, my Lord, is that false affidavits are no affidavits and must be struck off. Because the penultimate paragraph in an affidavit, my Lord, swears to the truthfulness of the whole document. Where therefore, my lords, any part of that document is false, the affidavit must be struck off. My Lord, we further submit that to both applications, my Lord, that are before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my lords, that we have cited relevant authority. We have cited the authority in Jackson, Molalu, and others, a Court of Appeal decision on the threshold that learned friend Senior Counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. My Lord, if that were the case, no judicial proceeding would be conducted in this country. And learned friend, Senior Counsel Professor Gideon, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my Lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would accuse themselves, my Lord. No judge, my Lord, would sit on any bench to hear any case, because we are all extracted from the same academic background and a dual trend. Unless my Lord friends are saying that. Oh, yes, my Lord, in response to the suggestion that the Honorable Justice Mrima attended a wedding of the Speaker of the Senate, my Lord, the Speaker attended the wedding of the Honorable Justice. My Lord, the Honorable Justice Amason Kingi, is a peripheral party in the proceedings. Indeed, if you look at the proceedings, my Lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker as a corporate office who is a defendant or a respondent in these matters. But number two, my Lords, the Honorable Speaker Kingi merely presided over the proceedings in Senate and was not a voting member in the sitting of Senate that led to the impeachment of the former Deputy President. My Lord, the Honorable Kingi has not taken part in the appointment of this bench in any form. My Lord, clearly, the petitioners are clutching on straws, and every attempt at ensuring that this court does not proceed seems to be falling by the wayside. I urge the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray, my Lord. My Lord, on the appointments of judges, my Lord, clearly, if peradventure the argument on conflict extended to who appoints, my Lord, the President appoints all judges, and is a party. I think they should have added that ground, perhaps, because the President appoints all judges. But that cannot be a cause for a party seeking a recusal, my Lord, because the President, in performing a constitutional mandate, just like, my Lord, the CS Environment Soipantia exercised her statutory mandate in appointing Florence as a board member, my Lord, cannot be a cause or a basis for seeking or asking for conflict. My Lord, soon parties will then apply for recusal on the basis, my Lord, that two judges or a litigant and a judge belong to the same community. Thank you, my Lord.
Sorry, none of them is quite near me, so I think I will. Thank you. Thank you very much. Just a brief rejoinder to the application, and especially in view of what has actually been disclosed after the arguments. And my lady and my lords, I would be urging you kindly to actually go through these voluminous decisions we have given to you, because part of what some parties are submitting and saying it falls on all fours in relation to the matter before you is nothing far from the truth. And the example that has been cited is that of Erai and Virunga Limited, where it has actually been shown
that that authority cited does not in any way relate to what is before you in terms of facts and the applicable law. It has been clearly demonstrated that here disclosure was necessary because...
Just a minute. We wish to adjourn for 10 minutes. You can take health break for 10 minutes.
Will you say something?
Yeah, I will say something.
You want to
No, I should be there.
And you say it's political.
It's political.
Political.
Public interest. This one is meant to derail. How long have you been?
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
This is NTV.
Karibuni. Hii ndio base ya the best local entertainment.
Tell me where my money is.
You don't know what they do to girls like you. Nakwambia mama Chantel amegeuka kwa mtoto siku hizi. Anabadilisha nguo kama mara 3 kwa siku.
The truth is not governed. The truth governs our beliefs, our faith, the trust we give, the democracy we seek. When held back, it always breaks free. Seek the truth. Set yourself free. Subscribe to read online at epaper.nation.africa. Daily Nation, the truth unfiltered.
Get ready to have your mind blown.
Hey, what's up, my good people? This is your girl, Avril.
We're bringing you the hottest show in town.
The king of gospel, and I represent for Kwetu Mix.
Yo, Butrus aka the Sharp God up in the mix, you know what I'm saying? NTV, shout out to you, bro.
From exclusive interviews with the biggest names in the game. And snippets from your favorite live performances. Don't miss out on the fun. Tune into Kwetu Mix every weekday from 5 to 6 p.m. only on NTV.
New Panadol Extra Soluble dissolves twice as fast versus standard paracetamol tablets.
When I have back pain, I reach for 2 tablets of Panadol Extra for fast relief of strong pain, like headache, toothache, muscle pain, and I'm released from pain to be there for those who need me. Try Panadol Extra for fast and effective relief from strong pain. New Panadol Extra Soluble dissolves twice as fast versus standard paracetamol tablets.
People come to me and they say they get discomfort when they have ice cream. Can you imagine that? Avoiding having cold ice cream. Sensodyne gives you long-lasting protections against sensitivity. And people come in and they're like, oh, it works. I can have ice cream and I'm not in any discomfort. I recommend Sensodyne because it works. It's brilliant.
New Downy perfume collection. Sometimes I need a scent to keep me calm amongst the chaos, or a light fragrance that keeps me fresh in the heat, or a perfume that feels elegant all day and into the night, lasting longer than expensive perfumes. New Downy, lavender comfort, sunrise fresh, and sweet elegance, freshness that inspires confidence. Your dreams have come true. Try it for only 20 shillings.
NTV. NTV, turning on your world.
Ni yajayo katika NTV jioni.
According to the petitioners, is that there is a very close relationship between one of you. One of your lordships, the Honorable Judge Mrima, the Speaker of the Senate.
Mawakili wa naibu rais aliyeng'atuliwa Rigathi Gachagua wataka majaji wanaosikiliza kesi yake kujiondoa.
The Adani Group are investing in the transmission line. Their money, 95 billion. We would have otherwise gone to borrow that money, burden the people of Kenya.
Rais Ruto asisitiza kuwa Adani ataifaa Kenya pakubwa katika kufadhili baadhi ya miradi. Ameona nini rais?
Tunataka serikali itoe majibu ambayo kwamba hao wasichana waliuawa na nani, gari gani ilichukua.
Next time hatujui ni nani, ni mimi ama wengine wetu.
Wakazi wa Eastleigh wajitokeza kulani mauaji ya watu watatu, wanataka serikali kuwachukulia hatua kali wahusika. Na je, mjumbe wa Kiharu Ndindi Nyoro ameenda wapi? Maswala yanaibuka kuhusu upotevu huu usiokuwa wa kawaida siasani.
The averments of our clients, Your Lordship, is that this is a matter that ought to have been disclosed at the inception of the proceedings.
If I'm looking at the same document as you,
yes,
the Gazette Notice 7515 was issued on the 7th day of June 2023 by Soipan Tunya.
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
He's the president.
Then, where is the next one?
I'll get there. I'm sorry, I'm not.
Excuse me. No, excuse me. No.
Hold on.
Your honors, your ladyship and my lords, they will have time, as you said, to respond and say all these things. If he's saying nonsense, they'll stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And
stop bullying people.
And we abhor the condescending nature of the respondents. Yeah. Everybody here has been instructed by a client either to speak sense or nonsense.
Hayo ni majibizano makali ambayo yamekuwa kwenye mahakama ya Milimani hii leo, wakati naibu wa rais amepeleka kesi kule kotini akisema kwamba majaji watatu wasiwe kwenye kusikiza kesi yake. Sasa tuelekee kule Milimani ambako kesi hii inaendelea. Tusikize ni kipi ambacho kinaendelea kwa hivi sasa pale Milimani. Wale ambao ni upande wa bunge la kitaifa, upande wa spika wa seneti, serikali wanazungumza yao. Mapema Rigathi Gachagua na mawakili wake walikuwa wameshazungumza. Tusikize tu kwa kiduchu.
Was that the first petitioner attacked the independence of the judiciary contrary to section 160 of the Constitution. That is material before this court. It is contained in the 9th respondent's replying affidavit. It is not the first time that the first petitioner is making such allegations about judges. He did so in 2023 about your sister, Lady Justice Esther Maina. In the letter addressed to the Deputy Registrar, and I refer you to paragraph 10, he insinuated, in paragraph 10, he says the lightning speed with which the Kirogoya file was grabbed and directions issued seems like a well-orchestrated plan to trample on the rights of the petitioner. They made allegations against the Deputy Chief Justice. In the same letter, they have asked an investigation be done in which they insinuate the conduct of the Deputy Chief Justice, the Chief Justice, so that, my lords, they have made allegations about 6 judges.
Your Lordship, I'm constrained to interject. My learned friend and my very good friend, Mr. Mushemi, is alluding to going to talk about some grounds which he says were before the Senate, but which were dismissed. So,
that is not correct. Ground number 4, to correct my learned friend, was supported by 51 senators out of 67. It was one of the charges that was upheld by the Senate.
My Lord, those are the matters that are in the petition, and that is where we are before you. Let us restrict ourselves to the application. Most obliged.
Yes, my lords, the nexus of this application, the nexus of my response, is that the first petitioner has impugned the conduct of 6 judges. This has never happened before in this country, that one person is unhappy about 6 judges. At the same time, my lords, you have been treated this afternoon to issues of bias. The first petitioner had his day before the National Assembly. In that house, 282 members of parliament voted to impeach him. Out of those 282 members, a majority of them were from his own party, United Democratic Alliance, where he's the deputy party leader. They were not biased against him. The matter went to the Senate. 53 senators, a majority of them from his own party, voted to impeach him. He did not raise the issue of bias. My lords, you have been treated to the issue of weddings. Weddings by the petitioners. I ask this court to take judicial notice that in the National Assembly, and my learned friend Kibe Mungai spoke about our tradition, we come from the same community, the first petitioner last year attended the wedding of a member of parliament, Eric Wamumbi, member of parliament for Madeira, where the first petitioner comes from. That member of parliament subsequently impeached him. If the basis of closeness is the basis of impeachment, how would somebody who have attended his wedding impeach you? But he did not impeach him because of attending his wedding. He impeached him because of serious violations of the Constitution. So that if the issue here is a wedding being attended, the first petitioner himself has attended a wedding, and not just as an ordinary guest. He was the father of that member of parliament in that wedding. But he was still impeached. So that, my lords, I want you to take comfort. Those are matters before the Hansard of the National Assembly, which is evidence before this court. Your lordships should take comfort. The first petitioner in the National Assembly, he impugned institutions. In the Senate, he impugned the Ethics and Anti-Corruption Commission, the National Intelligence Service. He has now impugned the conduct of IEBC. He has now impugned the conduct of the National Assembly. He has impugned the conduct of the Senate. He has impugned the conduct of the executive. So which institution does he have faith in this country? It appears that there is none. My lords, eminent judges, it is a matter of judicial notice that your esteemed colleagues, although the petitioners argue that you are unfit to hear this matter, have elected one of you, presiding judge, to be a principal judge. Your own peers, through a peer review. All judges in the country have elected one of you to be principal judge. Your peers equally have elected one of you to the Judicial Service Commission.
My lords, our application is limited to your lordships and her ladyship, not the other judges. And there are many outstanding judges in this country with courage, with everything. The petitioner has not cast aspersions on judges generally. We've stated our grounds for the application for recusal of this particular bench.
Your Lordship, the character of judges in this session has been impugned by several counsel appearing for their clients, and it is important that we rebut the issue of their character. Proceed, please. Thank you. Your Lordships, my client, the 9th respondent, has also filed a public participation report before this court. 200,000 Kenyans exercise their right of public participation in the National Assembly.
What has this got to do with the recusal? That's the only thing we argued, my lords.
If my learned senior would be patient, I'll show him the nexus.
Yes, if you are relevant, admissible submissions in reply to the issue we argued.
Exactly. Your Honor, let him stick to the application, which is recusal. Not
my lords, I thank my colleagues. The basis of the public participation, and my lords, when you retire, you look at this. 200,000 Kenyans conducted or went through public participation. 65% of them said that the first petitioner should be impeached. That report is in my client's affidavit. And the reason I am saying this, my lord, is that the nexus of this is that the first petitioner has no confidence in all institutions. He has no confidence in 6 judges. He has no confidence in all Kenyans who went through public participation.
Objection.
He has no confidence in anything.
Objection, Your Ladyship, Your Lordship. What is being advanced by Milan and Senior will be discussed at the merits, including the character and the conduct of public participation. Is it fair for him to go on ad nauseam despite various objections? We strongly object to that line.
I think, my lord, it is relevant if a litigant has cast aspersions against the court. Some of them he even wanted to withdraw. It is only fair, and it is actually relevant, that the court be shown this is a person who picks the candidates not just against the court, but against every known agency and institution of the state.
My Lord, I was just trying to just keep quiet because of this intervention.
Finish.
My lords, I was finishing.
Take time and finish, and please sit down. You'll respond.
And I have been very kind to my learned colleagues. I did not even apply that their pleadings be struck out, even when they were fatally defective. I have said let them remain on record. We are not impugning them. So I am being very kind to my friends. Finally, your lordships, if you recuse yourselves, you will do a great injustice to the oath of office that you took, the administration of justice. To allow the petitioners to bully you, to forum shop, they have tried to bully the National Assembly, the Senate, now they are trying to bully the judiciary. Will be a great injustice to this country. That is all, your lordships.
Thank you. The respondents rest there.
Oh, Professor. Sorry. Presiding judge and distinguished members of the bench, Mahat Somane for the IEBC. I think everyone is in the arena, the independent body. No one wants it to talk. I think we have something to say about these proceedings. Your Ladyship, the IEBC's position is the Independent Electoral and Boundaries Commission, the 16th respondent in this second cohort. The IEBC's position is that the court should stick to first principles when it is determining the issue of recusal. We have been listening keenly to the submissions by the various parties, and our position is that the court has a 3-tier constitutional doctrines that it has to satisfy itself. The first one, when the court is determining the application for recusal, is whether there is a reasonable apprehension of bias. The question the court should ask itself is, do the circumstances give rise to a reasonable apprehension in the mind of, number one, a reasonable person, number two, a fair-minded person, and number three, an informed member of the public. So the test is all those 3 criterion has to be met. The second constitutional criterion that has to be met is the presumption of impartiality of judges pursuant to the oath of office they took must be rebutted, and that with probative evidence, not on aspersions, not on allegations, with probative cogent evidence. The third one, which is also a third constitutional doctrine, is judges generally in our constitutional dispensation have a constitutional duty to sit. We give them security of tenure. We pay them from the consolidated funds. they have a duty to sit and to hear all matters. And that duty can only be rebutted when there are valid grounds relating to it. We refer the court to the authority which has been placed before it, Sholei and another versus Judicial Service Commission, petition number 34 of 2014. We refer the court to paragraph 5 of the said decision as relates to the duty to sit in every matter and not to choose on any allegation that is made on it. We refer the court to paragraph 16 of the said judgment, the very analysis done by Justice Mohammed Ibrahim and the dicta of Lord Denning. We refer the court to paragraph 27 as relates to recusal and reassignment. And if the court applied first principles, the position of the Independent Electoral Commission is the threshold has not been met, the matter should be expeditiously disposed by the court. Thank you.
That is the respondent's case. We have nothing further to submit.
Thank you. My lady and my lords, on behalf of the Law Society of Kenya, our duty is to set out what the law is, review of the facts that are before the court. The law, insofar as recusal is concerned, can be well traced in Kenya in the decision of Rai Group Limited versus Kimeto and Associates. We have exhibited this decision in the list of authorities filed before the court. Permit me to set out what was reiterated in that decision. The real question is whether reasonable apprehension of bias was presented which would make an informed and fair-minded person seized of all the information surrounding this matter and the impartiality required of judges by their constitutional oath apprehend bias on the part of the bench. Now, what is the information surrounding this matter? Let us start with the case of Honorable Justice Freda Mugambi. The charge in respect of which recusal is sought is that she was an LLM student of Professor Kindiki Kithure. It has been demonstrated by facts which are not in dispute that the Honorable Judge was not an LLM student of Professor Kindiki Kithure in the Moi University or any university, but instead her LLM was obtained from the University of Birmingham. It is as simple as that. Issue number two, that Madam Florence Oluoch was appointed to a board by His Excellency President William Samuel Ruto. What are the facts? Madam Florence Oluoch was appointed to the board by Sultani Tuju. These, my lady and my lords, are the facts upon which information surrounding this matter are to be determined. The next authority which we rely upon is the case of Eli Valley Mines versus Lee. And the principle set out in that case is as follows. In this context, the reasonable person is not someone who is hypersensitive or unduly suspicious, but rather a well-informed, thoughtful observer who understands all the relevant facts and has examined the record and law. Now, insofar as Honorable Justice Freda Mugambi and Honorable Justice Eric Ogola is concerned, has there been demonstration on the basis of a reasonable person who has examined the record and the law to demonstrate that there is bias, real or perceived? That is the question that this court must answer. What about Honorable Justice Anthony Murima? The charge is that the Speaker of the Senate, the Right Honorable Amason Kingi, attended his wedding. My lady and my lords, there must be meaning to the term learned friends. There are those who have written, including a writer by the name Jess Braille, a book titled Lawyers and Other Reptiles. And there are those who have also written, including Feroz Norji, practicing an honorable profession. Indeed, we are learned friends. A judge is first an advocate and second a judge. A judge does not reside in isolation. And if I may just say, for example, I've had a cup of tea with Justice Anthony Murima. I've had a cup of tea with Justice Eric Ogola. I've not been fortunate enough to have a cup of tea with Justice Breda Muganga. Well, they are my friends. But I appear before these courts, and they rule in favor or against me. It is in that context that we must examine. Is the charge against Justice Anthony Murima one based upon information in the mind of a reasonable person who has reviewed the record of the facts and the law? And if the Lordships and my lady will return a negative answer so far as these questions are concerned, then you must make a decision whether to recuse yourself or to continue handling this matter. It is my humble submission, based upon what you've said, that there is considerable doubt as to whether a case has been made out to warrant recusal. We request this court to dismiss this application. I will allow my colleague to utilize the remaining 2 of our minutes to say something.
My lords and my ladies, Nishuki for the Law Society. My lords and my ladies, I will start off by the submission, clarification of the submission that this application for recusal is the court being called to trial. That cannot be further from the truth. An application for recusal is in its very nature a call for the court to introspect. Given that to assume otherwise would be oxymoronic, as the court would be sitting on its own trial, which is what the recusal motion is. My lord, I move on to this duty to sit. That duty is not one that should be carried lightly. That duty flows from Article 159 and the judicial authority that is vested upon you as judges. To not fulfill that duty is to abdicate a constitutional right that you've been granted. Therefore, in making this decision that you're called upon, you must always at the back of your mind have that clear obligation that has been bestowed upon you by the people of Kenya. My lord, we've heard repeatedly from the prosecuting counsels in this issue, and they've referred to perceptions. And it caused me to check what this word perception actually means. Perception flows from a Latin word, which is percipere, which means to seize or to understand. And the dictionary defines this as the way in which something is regarded, understood, or interpreted. That being said, on the facts before you, could they be perceived to put across actual or even apparent bias? That is a question you have to answer. I will discuss briefly what has been said by my colleague, my senior Mr. Somani, on the test that you must apply. That test is an objective test. That is not in question. Therefore, we call it into question the fact that reliance to show the general public perception of this bench was on a tweet by my learned senior counsel Agwenasi. We urge the court not to take that direction, as it would be then turning that test not from an objective test, but subjective test, looked at from the perceptions as they are held by senior counsel Agwenasi. Your Honor, my lords and my ladies, we ask you, please, do not fall into that folly that the applicants seek to drive you. My lord, lastly, I will discuss one of our cases with regards, and this is particularly with regards to the profession, as has been discussed by my seniors, that we are indeed a homogeneous group. We are all advocates, and this is particularly important when it comes to the allegations as against Justice Murimu. In the case that we have placed before you, of Perry versus Schwarzenegger, it runs from page 62 to 82 of our bundle of authorities, which is duly filed. The court had an opportunity to discuss an issue of recusal that had been lodged as against the judge, simply on the basis that he had a similar characteristic with some of the parties. In this case, the perception of bias is that Justice Murimu is friends with His Excellency the Senator, who is a fellow learned friend. And the court said this: in a case that could affect the general public, based on the circumstances or characteristics of various members of that public, the fact that a federal judge happens to share some of the circumstances and characteristics will only be affected in a similar manner because he is a member of the public. This is not a basis for disqualifying a judge. My Lord, having considered the law and the facts before you, it is readily apparent that this application has not risen up to call for your introspection with regards to empanelment in this matter. That is all.
My Lord, allow me to just seek a procedural clarification that the right to reply is available only to the persons who, the advocates who filed the application, and not the parties who supported that application.
We made that clarification at the beginning.
Perhaps, my Lord, you could also confirm whether it is limited to matters of law.
I said that we made that clarification at the beginning of the proceedings.
My Lord, we could also perhaps confirm whether the reply is limited to legal issues, because if it's another bite at the cherry, we will not have the opportunity then to again come back to redo it.
The reply will only be on issues of law and nothing else.
Thank you.
Dr. Kamino, you can say.
May I say what I Yes. I don't think if I may quote words or so, we're expounding also on a matter that is impeachment. impeachment of the party. I pray that you allow us to say, you allow me to say something.
I said you can proceed.
Oh, thank you very much. Yes. I'll take with that. And God bless you.
Thank you very kindly. I will do part of the reply, then I'll pass over to my senior. And I'm amazed at what level the respondents have gone to misconstrue and misconceive the applicant's case. Your Lordship, in respect to the relationship that were drawn, both for the presiding judge and Justice Murima, the charge is that of deliberate failure to disclose the relationship. That my lords, you are aware at the time of the inception of the case that Justice Murima is closely associated to one of the parties, but he deliberately failed to disclose. Equally well, the presiding judge was well aware at the inception of the case that his spouse is greatly connected to some parties in the proceedings, but again failed to disclose.
My Lord, that is new fact. I think you should not tell which parties. You say clearly, if you can't understand what we are doing, please go to your affidavit and read the affidavit again.
My Lord,
and reply on matters of law. I will not allow you to misrepresent facts. You have an affidavit.
And to embarrass the legal profession.
Yes,
Your Lordship,
you have an affidavit, Mr. Ndegwa. If you can't understand what we are talking about, verbatim, read verbatim from your affidavit.
Your Lordship, may I draw your attention to paragraph 74 of the judgment of the ruling in Navini. The judge says that due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence and the applicants have that will be neutral when it comes to the hearing and the determination of the arbitration. That, Your Lordship, is a confidence that has been eroded. On the question, Your Lordship, on the duty to sit, the duty to sit must be accompanied by transparency and accountability to the parties appearing before a judge. Your Lordship, the duty to sit and the oath of office taken by a judge or a judicial officer must be executed in a manner that breeds confidence to the parties that appears before a judicial officer. Lordship, it's our humble submissions that that confidence has been eroded. Your Lordship, the arguments by Mr. Nyamondi that the parties are forum shopping. Your Lordship, this bench was constituted pursuant to Article 165, Clause 4 of the Constitution. And no petitioner herein has the capacity to direct the Chief Justice who constitutes the bench as to which judge to sit in a particular bench. There is no possibility, Your Lordship, therefore, for an argument that parties are forum shopping. At the inception of the proceedings, Your Lordship, we appeared before you and made arguments comfortably. Little did we know that we would be faced with an application of this nature due to the failure of the honorable judges to disclose those material facts. I invite Kibe to proceed.
My Lord, while during the course of, I guess we've been here for about 5-6 hours when this application has been going on, and there are two things that have been crisscrossing my mind. My Lord, the first issue is the issues of substance, and the issue of perception, the optics. What would be the optics, my lord? The optics, my lord, as we sit here in public view, in the glare of Kenyans, some of whom, if you use the reasonable test, are professionals, people who have studied above Form 4, probably half the populations. The other half of the population are people who are definitely below Form 4. So what's the reasonable person's test here, and what are they seeing? The first thing, my lords and my ladies, that they are seeing is that the petitioners appear to be categorical, for good or bad reasons, that they do not have confidence in the bench. And examinations of the fact may still prove that they may or may not be wrong. But the issue is, the test as far as when you read all these cases, in matters particularly that have some political angles, perceptions is everything. And perception is a big issue. So that, my lord, the issue therefore would be, shall we proceed on the basis where from the word go, the petitioners clearly have appeared to the rest of the country, they have got no confidence. With the same zeal and spirit, the respondents who are being accused for good or bad reasons are saying, we have full confidence in them. That should trouble us. Because at the end of the day, it is the coloration of whatever decision is made. It will be done from the prisms, oh, we told you. We knew this, they were going to do this or the other one. In huge cases like this, it should never be that way. I go to the second issue, the issue of the Honorable Attorney General. I listened to the Honorable Attorney General. The Honorable Attorney General has made an application, one of the applications to set aside the orders. I went back to Article 156. 156, on one hand, suggests the Attorney General is the President's lawyer. There is another clause, I don't know whether it's 11 or something like that. It suggests that the Attorney General is the guardian of public interest. And you ask yourself, the Attorney General, without doubt, when it becomes to the President, he's 100% sycophantic, a President's lawyer.
But my Lord, when it comes, raising a new issue, that
which
issue
is the
was never
issue.
part of the recusal application.
That is not a new issue, my Lord. Let me proceed. My Lord, the Attorney General is the guardian of public interest. What is the public interest in a process of impeachment as we stand here today? My Lord, that public interest must be the country has been treated with an imperfect, I'll not go to the details, with an imperfect impeachment process at the National Assembly and at the Senate. When it reached towards the tail end of this process, the public will be treated to the fact that in processes that presupposed that you would take about 75 to 100 days were conducted within hours. So that the bigger questions, my Lord, would be that there is a complaint that is being made, a serious one, of the right to fair hearing and human dignity. Rights that are not derogatable under the Kenyan Constitution, even during an emergency. My Lord, if you are faced by an Attorney General who, pursuant to one mandate, their conscience has not been touched, that there is some public interest in looking at these things a little bit from the perspective of the Deputy President and those who feel like the Deputy President, that a fair and square deal has not been granted by the processes that have taken place. Your Lordships, that should concern us. I go to the next issue, the main issue that he cannot deny, he did say. My Lord, you are being told that we are in serious danger, we are in the throes of chaos or something like that, and there is some danger. My Lord, the truth of the matter is, the time that has been prescribed, thank God, by the Constitution itself, they are far from over. And the petitioners here keep saying,
And Honorable Muite has told me, tell the court that if the court can be able to hear us from next Thursday when all of us have done responses and whatever amendment, we are ready to conclude that issue. We are ready, we know the timelines. So that, my lady, the connection, therefore, of somebody saying that, oh, the only public interest here, and this is the Attorney General, is that we must swear by hook or crook before the petition has been heard. That also should be a matter of grave concern.
Sure,
because
there was never a submission like that, and I think Council must have some respect for the truth. Nobody said anybody must be sworn by hook or crook. Please let's respect the truth.
My Lord, I think the language always in submissions belongs to Council, but what Professor Gedhu Muigai, my former teacher, said is this, that we are in the throes of instability, something to that effect, because if we do not complete the process that was started by the National Assembly, a huge power vacuum might arise. And that it is why, when I use hook or crook, it is why the only obsession that we hear, oh, it's conservatory order taking out. That is the context. My Lord, I go to the next issue. Who is this who made the oath of office of Professor Ojenda? My Lord, there was the question of CTS. The question of CTS, I believe, had dealt with it, and all those kind of issues, and we pointed out that the issues of CTS, whereas we had talked about them, they appeared for the first time not from the respondent's affidavit, but from the ruling that the court made. I don't need to say anything about it. The respondents had said nothing about them. My Lord, to Professor Ojenda, there is a question of... no, I have to respond. There is a question of the internal memo. The question of the internal memo, again, that was not a matter that was ever placed here in any affidavit, as far as I'm concerned.
That was yesterday's submissions.
I think you were here.
I think these are notes for today.
Those are notes for yesterday.
No, these are notes for today, my Lord.
That was yesterday.
No, my Lord. If they have a date and I had a different notebook, but they would get uncomfortable. Let me pass that. In fact, he's not the main guy I have to deal with. About all these issues, he talked about the internal memo. But, well, if he says he didn't, let me hope I imagined it. I can pass it. But that's what my note says. I don't mind. We can't fight over a memo. And as I said, we are dealing with some other submissions. My Lords, the... My Lord, there is a question of Mr. Nyamodi. And Mr. Nyamodi was talking about the issue of the...
My Lord, this time is up. Just sit down.
Just to confirm, we have not touched his notes.
Allow me to remind him what I said.
No, the only misplacement was this guy.
My Lord, maybe we should correct that as well, because it's been said 3 times. There are no guys in court. They are learned counsel.
My learned colleague, Professor, is the only issue, the reference, senior counsel. Is that doubted? My Lord, the issue that would require the clarification, let's go to Kerugoya. I believe there is no doubt about the issue of Kerugoya. My Lord, the issue that was raised, and I believe this is the last point that Professor Muigai was making, regarded the issue of where it was alleged that the issue estoppel with regard to the issues of Kerugoya that found themselves in the ruling of yesterday. And my Lord, first of all, I wish to point out that there is a notice of appeal that is one of the annexures in the supplementary affidavit and raises specific issues about preempting and the issues dealing with matters that were yet to be handled. I need to clarify that is one of the issues when it talks about the issues of res judicata. And when it comes also to the issues of res judicata, it is important, my Lord, that it is pointed out what was the subject matter of yesterday's application. It was the interpretation and application of Article 165(4) of the Constitution in relations to the powers of the Deputy Chief Justice. The said ruling, anything else that may have been said that was outside that direct issue that was before the court, that was not an issue for that ruling. And therefore, dealing with matters that are outside there and you are be told the ruling has dealt with those matters which it ought not to have dealt with, so it has become res judicata. It cannot become res judicata in our submission. My Lord, with regard to the issue of the friendships, I think this is something that they have been preoccupied with. My Lord, nobody is trying to criminalize friendships, not at all. But my Lord, there are always degrees of friendships. When it is alleged, for example, that a friendships between Kibe and Ndegwa is of such a close proximity that Kibe and Ndegwa ought to disclose that fact to any other person, it would be different, for example, to my friendships with Harvey, somebody we just meet and do a few cases with. So that, my Lord, the issue at the end of the day is one of degree. To what extent are there interactions between these two individuals? Because, my Lord, and we were saying that you may feel that there are issues. Issues could well be raised. That who was so that, for example, was Judge Mrima from the Kenya Law Reports records, as people would be sending materials to indicate that, the lawyer for Mheshimiwa Kingi during the case with Esposito, again the answer would be yes. So this is not a casual friendship. It is a friendship that is over. There have been had client-lawyer relationship, other personal relationships are all there. So that, my Lord, you cannot be able.
Now, how do we respond to that?
Mr. Kibe.
Yes, my Lord.
I had intended to restrain myself.
Yes, my Lord.
From interjecting in these applications. But I think the statement you're making is factually incorrect. In the Esposito matter, I appeared as the advocate for IEBC, not Mr. King.
Thanks for the clarification. My Lord, the issue...
I think if we people can respond on issues of law, it would really help us, rather than going back on issues of facts.
Yes, so that, my Lord, there was a question of forum shopping. Forum shopping, I go with what Mr. Ndegwa has said. If this bench recuses itself, it does not mean that we shall choose any of the judges that may replace this bench. My Lords, on the issue of Mr. Mushemi's submissions, my Lord, Mr. Mushemi's submissions, we start first of all from the premise that Mr. Mushemi did not have a replying affidavit we did not have a replying affidavit. I tried to object. In order, you said I respond. We want just to draw the court's attention that if you want to take factual deposition, you take somebody else's affidavit that has been deposed to on oath and say, this is not true, you did not sign here, you did not do this, you have not subjected it to any examination or anything. That would be completely to go outside the rules of evidence as we understand them. And therefore, for as much as the issues of Mr. Mushemi is concerned, I urge this court to disregard them. There are two other more important issues that we need to point out. My Lord, using the test of the reasonable man and woman in Kenya, it is a question of splitting hair. President Ruto and Tuya. Is splitting of hair for the simple reason that during even the Senate proceedings themselves, we were treated to a situations in which, and one of the principals was indicted, in which political positions at cabinet, board levels, and others were toss-ups for purposes of political dealings. The average knowledge, because that is the standard that you've said, a reasonably informed Kenyans is aware that any new government comes to office with its own appointees to those board positions, permanent secretaries, and others.
Mr. Kibe, you are going beyond what is really necessary for this. I think you have made your submissions. Respect the court and your colleagues. Reply on issues of law, please.
I thought that was an issue of law. My Lord, I finish with the question that was raised by the one without an affidavit by Michael Mushemi. The issue of Mr. Michael Mushemi, where you are told that for purposes of gauging bias, you should be able to look at the MP for Madeira, who did not, who voted against the deputy president, although he was his father or something in the wedding. My Lord, the direct reference to that would also have to be taken from the bar, the way it was also made from the bar, and the direct reference to that is that the wife of this MP...
My Lord, that's a question of fact.
Yes, it was also the same question of fact.
Let him reply to the point of law, my Lord.
We should understand what we mean by matters of fact. Questions of when, who, where, what happened, who did this, who did that. Those are all matters of fact.
My Lord, the only exception, and we said, when we tried to stop, to stand to say that Mushemi is dealing with those issues, you told me, my Lord, you will respond. So I asked that I respond to that issue. That's the last issue. And the response is this, that the wife of that Madeira MP is also on record as having said that I voted against the DP Gachagua because he insulted us and said our wedding will not last. It had nothing to do with the impeachment trials. So that we cannot ignore that is what he said, and it is on public record. So that, my Lord, the long and short of it, so that, my Lord, the long and short of it,
Mr. Kibe,
yes.
How do I record that?
No, my Lord, the way you recorded, I think I saw a record from the other side.
What you are saying?
Yes.
How do I record it?
Well, I don't know who recorded, but he was allowed to say in open court that even his own MP voted against him. So to be able to demonstrate whatever point he was making. And I'm also saying that from the bar, let it also be made clear that the wife to the she's also an honorable MP, said, I voted because the DP said that that marriage was not going to last. Not on impeachment. So that, my Lord, the long and short of it, because we've had a long evening, is that I beseech this...
I suppose the marriage still subsists, right?
It still subsists. and we also hope, my Lord, that when we are that when we are hard with this petition, the tenure of the DP could proceed. So that, my Lord, the last point that we need to make is that there is somebody, I guess, who is a doctor, and something that Dr. Camino has said, a moment of introspection. This moment of introspection is important. Because for you, my Lord, the issue at the end of the day would remain that an important case is up for determination. Besides the information that is here, if your councils were to show what is it that other things that are coming up in the course of the proceedings, that questions of perception is such a huge issue, my Lord, that if you are to apply the old rule that you are being told to apply, that you have a duty to sit, anybody who does not come with a smoking gun, disregard it and sit nevertheless. My Lord, that would defeat the meaning of let justice be done and be seen to be done. But more importantly, it would also affect my reading of chapter 6, the one that would be said that if there is somebody questioning, like the DP, he has written a complaint, it may be right, it may not be right. And it may be upheld, it might not be upheld. But, my Lord, the question is, as we await for that day, should any appeal or anything that results from this case relates to the issue that related to the conduct of the judges, or we deal with the issue of the moment? My Lord, with those submissions, I urge you respectfully, weighty as an enormity of having to argue this application, hold as we have tried to convince you. There are more than reasonable grounds that in existence, that there would be something wrong if one were to say, I will disregard all these issues on technicalities and proceed anyway. I thank you very much, Your Lordships. Evans, oh, sorry. My Lord, Evans, there is an authority. I've been under a lot of pressure that he needed to say something about it. And he's part of me.
What will be, how will others respond to the authority?
No, he's answering the authorities that were used, cited.
My Lord, just note that he has no right of reply.
No, I'm leaving.
We're in the same team.
In the same team.
My good friend, Mr. Wanyama.
Yes, he's actually filed the application, not the...
Thank you to the court. I am fully aware of the long day that it has been, and we don't take it for granted. Thank you very much. I want to respond to the following issues of law. Reference was made to the other side, attaching affidavits to lawyers on this side. Affidavits belong to the deponents, the Statutory Oaths and Declarations Act. Conservatory orders are constitutional orders. They are aimed at protecting the substratum of the case. It cannot be weaponized against this side. Third, the diary case. What should concern this court is the pertinent fact and the act that recusal happened, and what the Supreme Court said about that recusal. That's all what this court is supposed to consider. My good friend, my senior, Mr. Nyamodi, urged the court to ignore certain electronic material that was presented for the lack of a certificate as required by Section 106. I'll urge the court to take cognizance, number one, of the short timelines, the reflex within which advocates were required to make the returns. In any case, we will endeavor to file the certificate. In any case, I want this court to be persuaded by the decision in BBI that formal rigidities should not supervene, especially in a constitutional context, bearing in mind the exigencies and the demand. Because under the Mutunga rules, we can even submit here on non-epistolary basis. Finally, and as I sit to this good court, and we respect each and every of the judges and our colleagues on the other side, 4 things belong to a judge: listen courteously, answer wisely, consider soberly, and decide impartially. Those are the words of Socrates. Thank you, Your Ladyship, Your Lordships.
Are you withdrawing the application?
I think we've come to the end of our proceedings today. We will deliver a ruling tomorrow. Dr. Kamuna, the problem is I don't know whether you are talking as a respondent because you had spoken earlier. Is there something else you want to add?
The matter we're dealing with is under Article 145 and Article 150. We need to approach this matter very closely. Not to